am a towel. Ladies and gentlemen, big day. Big day, bigger day than I can possibly put into words. If you watched yesterday's catch-up stream, you are good and ready to go. We have two dueling trials today. Ladies and gentlemen, we have the Aidan TurtleBoy Kearney trial involving a violation of a restraining order on 2/26/2024 related to named victim Lindsay Gattani. And ladies and gentlemen, we have the Karen Reed and John O'Keefe case. Now, I have thought about this extensively, little towels. I've molded over in my little towel mind, and I think what we're going to do is I'm actively figuring out a pool arrangement for coverage of the Aidan Kearney case. My intentions, ladies and gentlemen, is thus. I intend on covering both trials. We are going to start. There is a motion in the Aidan TurtleBoy Kearney case from Paul O'Keefe. That's the first thing we're going to look at today, little towels. It is a 3-page motion to quash a subpoena. Now, you might be wondering, hello, I hear ice cracking. Hello, all the towel friends. We don't have a lot of time for lollygagging today. We are going to watch a compendium of clips of Towel asking questions to Karen Reed and Aidan Kearney in the pre-show. But before we do that, we have to get ourselves fully caught up. We have to understand why Paul O'Keefe has filed a motion to quash a subpoena, why Aidan Kearney... oh no, I dropped my cup. Why Aidan Kearney is on trial in Dedham District Court today, simultaneous to Karen Reed being on trial in Norfolk Superior Court. This is just the first of Aidan Kearney's multiple criminal trials. This one is in Dedham District Court. It has to do with an incident that occurred on February 26, 2024, outside of a Karen Reed and John O'Keefe hearing, when Aidan had just been released after doing a 60-day bid in jail after having his bail revoked on 12/26/2023. Okay, so Aidan does a bid, gets out a few days later, goes to a Karen Reed and John O'Keefe trial. That image you're looking at on your screen is actually from 2/26/224. Karen completely ignores Aidan that day, and Alan Jackson actually puts his hand on Karen's back to push him away from Aidan. Now, today's hearing, it's a trial. Aidan is going to trial. Lindsay Gattani is the named victim in the case. There is a long, very complex history where Aidan Kearney inadvertently in the fall of 2023, or maybe advertently, I don't know, revealed to Lindsay Gattani that Karen Reed had a direct connection to former U.S. Attorney Josh Levy in the context of the now confirmed as closed federal probe into the investigation of John's death. And then obviously the new DOJ in 2025 switched over, so we're talking about the old administration, very hyper-liberal under Rachel Rollins, Dustin Chow, and Josh Levy. Now, what's very interesting about this, ladies and gentlemen, is Aidan kind of gets pushed out of Karen's inner circle right around this time. I have a text message from March 4th, 2024, showing that Karen said that Aidan was a risk because of what had happened involving Lindsay, both the incident on December 23rd, 2023, when Aidan went over Lindsay's apartment because he found out there was a new grand jury convened after his first 16 charges were indicted in by a grand jury in Norfolk Superior Court. There was another grand jury around December 22nd or later of 2023. Lindsay gets a subpoena for it. Aidan goes over to Lindsay's apartment on December 23rd, 2023. While he's out on bail for the other charges, he allegedly records Lindsay illegally, pushes her into a couch, wants to get notes about what she had been talking about with different people in the orbit of the case, and then Aidan gets charged with witness intimidation on another count of witness intimidation on December 23rd, 2023. He gets charged with assault and battery, I think, and then he gets charged with illegal interception of an oral communication. Two of those three charges, the felony WI and the illegal interception of an oral communication, are bound over to Norfolk Superior Court, and so Aidan at that point is facing all of those, the October 2023 charges and the December 2023 charges. All those felonies are combined, and they're all going forward in Norfolk Superior Court. Lindsay simultaneously gets a restraining order for 1 year on Aidan Kearney under 209A, which is a very serious section involving intimate family or partner violence and things like that. Very serious section of the law. On February 26, 2024, Aidan Kearney goes to a John O'Keefe and Karen Reed trial. Lindsay Gattani also goes to a John O'Keefe and Karen Reed retrial. While Lindsay is, when Lindsay walks into the courtroom, she has a restraining order. She lets the court officers know. The court officers tell Aidan, and Aidan leaves the courtroom. However, Aidan remains outside the courthouse across the street in the bushes near the Registry of Deeds. When later that day, so after Aidan's already been told to leave and knows that Lindsay's there, which is key to the elements of the charges against him. Lindsay's leaving the courthouse, and there's a video of Aidan standing in the bushes and trying to film Lindsay and the O'Keefe friends and family and witnesses in the Reed case walking to their cars. So that's what today's charge is about. Now, if you're wondering why is Paul O'Keefe involved in this? Why is there a motion to quash? Well, Kate Mafia Masshole Peter, who's this kind of like woman who used to work with TurtleBoy until 2019, and then they had a falling out, and then about 4 months after TurtleBoy got involved in the Karen Reed case and was tormenting all the witnesses, I think like some of the witnesses and whatever got Kate involved because like she knew how to use TurtleBoy's tactics. She's kind of like very similar to TurtleBoy. She just happens to believe in Karen's guilt on this case, but she worked for TurtleBoy for a reason. So anyway, Kate Peter, on the day of 2/26/2024, had apparently told the O'Keefe family that Lindsay wanted to come to court to support them that day, which is great. That's fine. But Kate Peter told Lindsay that the O'Keefes wanted Lindsay to come to court to show support for Lindsay. Also fine. However, obviously, Kate Peter was manipulating both sides. Not that it would have mattered. Lindsay would probably have gone to support the O'Keefes, and I'm sure the O'Keefes were happy to support Lindsay. But the thing is, Kate Peter got involved in this for no reason and told the O'Keefes that Lindsay wanted to come to court to show support for them, which was, I mean, she did. But then to get Lindsay to go, Kate was telling Lindsay, oh, the O'Keefes want you to come, Lindsay, to show support for you. So anyway, that's immaterial to Aidan's charges. Why Lindsay was there, whether it was because she thought she was going to, because the O'Keefes wanted to support her, which I'm sure they do, or because she wanted to show support for the O'Keefes, is immaterial. Like Kate Peter, like doing that, it's just embarrassing for Kate, and that's kind of why I think this trial is something that some of Kate's friends don't want to cover. But okay, it is what it is. But it's also immaterial, in my opinion, to the actual allegation against Aidan, because there was this. First of all, Lindsay's motivation for going to the hearing is immaterial. She was either, whether she was going to support the O'Keefes or because she thought the O'Keefes wanted to support her, irrelevant. Because for a number of reasons. One, it's just factually irrelevant. Her motivation for going is factually irrelevant. Second, there was a supervening event. As Lindsay walked into that courtroom and Aidan was told to leave by the court officer, that just completely removes from relevance all of Lindsay's actions before that. Like whether she was going to support the O'Keefes or she thought the O'Keefes wanted to support her. The fact that Aidan was told to leave, knew Lindsay was there, knew the order was active, and stayed across the street. And then, more than just stayed across the street, there's evidence on video of Aidan standing in the bushes walking towards Lindsay and the group she was with to film them. So, you know what I mean, ladies and gentlemen? It's a pretty cut and dry case, in my opinion, but the background of Kate unnecessarily getting Paul O'Keefe dragged into this because she was telling Paul and the O'Keefe family one thing and Lindsay another, when she could have just, Lindsay and Paul could have just talked to each other and said, oh, it'd be very nice for mutual support if you would come. Kate didn't need to be involved. Kate got Paul O'Keefe dragged into this. So just so folks understand the procedural nature of all of this, we have a lot going on. It's going to be a day of chaos. But the very first thing we have to deal with is the Dedham District Court is going to have to deal with Paul O'Keefe's motion to quash this subpoena. Because Paul O'Keefe, Aidan's trying to drag Paul O'Keefe out of the Karen Reed and John O'Keefe trial so that Paul has to go over to Dedham District Court and then argue this motion to quash the subpoena. If Paul wins, then Paul can just leave. If Paul wins in part and Paul's forced to testify but doesn't have to give any records, okay, then Paul has to then wait around in Dedham District Court for the trial to happen today and then testify. Aidan will end up calling him, I guess, on a witness, which means Aidan's lawyer can only ask open-ended questions. That's going to be ridiculous. And then, furthermore, we don't know who else is on Aidan's witness list, or if there's a witness list. It's not on the docket. Is it going to be Kate Peter, Jen McCabe? Is it going to be, etc.? And then also, of course, we have to think about this procedure, right? So the procedure is you have to have this motion hearing on the motion to quash the subpoena. And I would imagine the Chief Judge, Pomerol, will hear the motion because you can't have the trial with an outstanding motion to quash a subpoena for a witness at the trial. So if this motion happened, Karen's trial starts at 9 and this motion hearing is going to start around 9. It's going to be very chaotic. We have to get prepared, friends. Part of the reason why we're going to watch this overview of Towel asking questions to Karen and Aidan for an hour is because I need to breathe. There's something else we'll talk about in a second. But before we even find out if Aidan's trial can go forward, we have to find out if the judge is going to approve Paul O'Keefe's motion to quash. So I know I can sense the intensity of all of your energies. I want everyone to do their breathing techniques. I want everyone to stay calm. This is going to be a very intense day. And the worst part of it is I can't tell you what's going to happen. I don't know, in the sense that it's all very procedural. So the judge could take up this motion to quash and say, well, in terms of this motion to quash, I don't think that that's exactly, sorry, I was just looking at a family member. So it's a motion to quash, and we have to get caught up because procedurally, if the motion to quash is granted, it has to be heard first before the trial. Because if the motion to quash is granted, then there isn't going to be a witness. The Paul O'Keefe won't be a witness. Hold on. Hold on. No. Yes, of course. Of course. I'm so sorry. I missed your messages. Oh, I feel so terrible. Oh, goodness, I'm sorry. I feel... oh, goodness. But ladies and gentlemen, let me just take a breath. This is a day, okay? Tal just has so much going on, and what we have to take a look at, and I have to bring up this motion to quash. So give me 1 second while I bring up this motion to quash. Little Tal's brain is being pulled in 47 different directions right now as I try to facilitate the coordination of this pool feed, and then also determine how we are going to cover this and what the day is going to look like. Because if the motion to quash is granted, then Paul just leaves. If the motion to quash is granted in part and there's no records required, then Paul still has to testify. Then they have to seat the jury in the Kearney case in district court, but it doesn't take that long to sit a district court jury. It's 6 people. They do this in a day or two at most, like the whole trial in a day or two. It's very quick. It's not a superior court trial. So it's like a flow chart. Okay, so Paul motion to quash. Whatever the result is, trial's going to happen, but it will either happen with Paul testifying or Paul testifying and having to produce records. I don't see the latter happening. So Paul testifying. Then they have to seat the jury in Aidan's trial, okay? And so then they have to do jury selection. Then they have to do opening arguments. Then they have to begin the presentation of the case. Then they have to do closing arguments. This is all going to happen in one day. It is not a long... Aidan's apparently going to take the stand. It's just going to be ridiculous. But we're going to cover all of it. There's so many things going on. Ladies and gentlemen, there is just so much going on that I have to pull up this motion to quash, because unless we actually look at it, there's no way that we can reasonably analyze it. So we're going to read Paul O'Keefe's motion to quash. This is the very first thing that's going to happen. I know you want to see the Karen Reed redirect. Don't worry. We're going to watch that while we're waiting to find out if there's coverage of Aidan's case. But I just want you to understand that this is Aidan Kearney's first trial. So this is the day folks have been waiting for. Yes, Drew Drops was here this morning. Eva, you are so good to keep Drew Drops in mind, and we are all so happy that Drew Drops checked in this morning. Drew Drops sent a hello to all their fellow Super Towelettes. We were, of course, worried about Drew Drops yesterday, but I'm pleased to report that Drew Drops checked in, and we were so pleased to see that they're doing better, and we extend our love to Super Towelette Drew Drops from around the world, ladies and gentlemen. Let's see. So here we go. This is what I want. This is Paul O'Keefe's motion to quash. I got it for you. You know why? We have to. No, we're doing both, Deb H, because this is what I'm trying to explain. This is going to be one of those days where we are going to switch back and forth, because there's going to be a lot of breaks in the Aidan Kearney trial. So we're going to watch the key moments of the Aidan Kearney trial as they happen, but we are also simultaneously going to be doing a simulcast of the Karen Cam and we will pause. If there are any pauses in the Kearney case, we will jump to the Karen Reed trial. Now, what we're going to do is, to make sure we don't miss any of the Reed trial, every time we go back to the Kearney case, we're going to pause exactly where we were in Karen's case. So we're not actually going to miss any of Karen's case, but we're just going to, at points, we may fall behind. Now, you might be saying, Grant, what if this trial, Aidan's trial, goes all day? Oh, goodness. And Karen's trial goes all day. Grant, aren't we in a position at that point where we now have to watch, we're going to have to watch the whole Aidan trial, then start the stream over and watch Karen's trial? Yes, we may be faced with that kind of position. We could technically have 16 hours of trial today in an 8-hour time frame. Now, that is a lot. That's kind of, you can see Little Towel is already overwhelmed at 7:45. I can sense the collective energy is nervous. I can sense that there's a lot of unknown variables in this. I can tell people aren't really sure how we're going to be able to watch both of these. I know that this is an issue facing a lot of the media right now. They're trying to decide. I have some requests out. We're trying to decide how we are going to be, as a media apparatus and a pool, be able to cover both of these things. I think, because only one pool camera person can go to the Reed case, there are about 10 extra pool camera people. There are discussions ongoing right now as to getting one of those pool camera people to go over to the district court and cover the motion hearing and then the trial for Aidan. I think we're going to be able to pull it off. I've put in a formal request as a representative of the media for the district court to permit an Aidan cam and also access to a media Zoom feed with credentialed media only allowed to broadcast it for the motion hearing and the Aidan hearing. But I don't have answers. I won't know until around 9 a.m. So we have quite a day, folks. We have quite a day. And I also just want to extend a super towel apology. Someone sent me a DM on Twitter. This is a super towel apology to you. I was absolutely not overlooking you. You are such a dear friend to Towel, and you do not need to apologize. We can have a conversation very soon. This is one of Towel friends on X. I missed some of their DMs. You do not need to apologize. Please, you didn't do anything wrong. And the Kate situation is complicated, and Towel loves you, and you are appreciated. And if you're in the chat, you just join right in, my dear friend. We would love to have you. All right, so let's see. This is Paul O'Keefe's motion to quash. This is the very first thing that's going to be here. They're going to be heard today. We're going to find out right now. You're so kind, Sunny T. Yes, I am going to finish up law school in the next couple months. Obviously, unfortunately, the passing of my father, it was right. He was right at the end of term, and his services were on within 24 hours of graduation. So I don't know. I am going to continue it. I want to teach. It's important to me. So I'm going to finish. I have like one class I have to wrap up, and I'm going to get that done. And I think it would have been important to him. It's important to me. I put a lot of effort into it, and I'm going to finish, and I look forward to it. It will be a very proud Towel day when I finish up that last class. We don't know who the judge is, and the judge that hears the motion, so the motion to quash that we're about to read, could be different than the trial judge. So we're going to read the motion to quash. This is Paul O'Keefe's motion to quash. This is the very first thing we're going to hear at 9 a.m. Now comes Paul O'Keefe, and hereby requests this court quash or modify the defendant's trial subpoena, served June 4th, 2025. This subpoena commands Mr. O'Keefe to appear before the Dedham District Court on the 9th day of June, 2025 at 9 o'clock to give evidence of what he knows relating to this criminal action. The subpoena further commands Mr. O'Keefe to bring with him and provide copies of all text messages, emails, and social media messages between or among Paul O'Keefe, Lindsay Gattani, Catherine Mafia Masshole Peter, and Jennifer McCabe. And so here you can kind of induct what I think Aidan thinks happened, which is that unbeknownst to Paul O'Keefe or the O'Keefe family or Lindsay, it was actually Jen McCabe who wanted Lindsay to come to the hearing that day, but Kate didn't tell Lindsay that. Instead, Kate and Jen Aidan must think that Kate and Jen McCabe had some kind of conversation where they were like, oh, we'll get Lindsay to go to the hearing to keep Aidan away from Jen. And what then happened was Kate went to the O'Keefes and was like, oh, Lindsay wants to come to support you. And then Kate went to Lindsay and was like, oh, the O'Keefes want you to come to support them. You see what I'm saying? So that's what I think. But that is not a defense for Aidan. The fact that Kate Peter was being manipulative is not a defense. It is, I TurtleBoy too. It is just not a defense. Like I'm not a lawyer. This is not legal advice. This is my opinion. But this, if Kate Peter manipulated the O'Keefes and Lindsay as to why Lindsay and the O'Keefes thought Lindsay was coming, that is, and Kate was doing it to help Jen McCabe, that is completely irrelevant to the next series of events, which was Aidan being told Lindsay was there with a restraining order, Aidan leaving the court, Aidan going outside, standing across the street on the lawn of the Registry of Deeds, and then Lindsay walking out and Aidan standing in the bushes, walking towards her and filming her in violation of the restraining order. You see what I'm saying? So yeah, like I agree, Mandy Strong. It was just like Kate was just being a troublemaker, and she wasn't being, in my opinion, forthright with the O'Keefes or with Lindsay. And that now it got all these people caught up unnecessarily in what should have been an open and shut case here, which was Aidan stayed there after he knew about the restraining order and knew Lindsay was there, and then he stood in the bushes and tried to film her when she was walking away later like a few hours later. So it's just ridiculous that Paul O'Keefe has to deal with it, and I think part of the reason this is so touchy and sensitive for a lot of people is that, yeah, it's not like relevant in the sense that it undermines what Aidan did by staying on the lawn of the Registry of Deeds, but it's really manipulative by Kate, in my opinion, and it bears it for the world to see. And that's why I think there's this, like when Kate was asked if she was going to cover this, she laughed. She laughed at the person who asked, and she was like, no. And it's like, okay, well, now I wonder if this is the reason. Hold on. We have some towel comments. Let me read them. Someone said, hello, H Towel. Yes, you keep working hard, Sheffield Flannel. Towel loves you. All the Sheffield Flannels are loved by Commander Towel. I don't really feel like a commander. I feel like a towel. All right, ladies and gentlemen, so let's read this motion to quash, because, again, Kate Peter's the only reason, in my opinion, Paul O'Keefe's suffering. Well, yes, Aidan Kearney actually served the subpoena, but still, if Kate Peter didn't do the stupid, unnecessary thing and just told Lindsay and the O'Keefes to talk to each other so that they could just be like, Lindsay, we'd love you to go for mutual support, then none of this, Paul O'Keefe wouldn't have even been subpoenaed. Now, nothing, regardless of whether Paul O'Keefe testifies and regardless of whether everyone goes up on that stand and says, Kate Peter misled Lindsay and the O'Keefes, that's immaterial to Aidan staying on the lawn of the Registry of Deeds after he knew Lindsay was there and then filming her from the bushes. I'm just trying, I realize it's absolutely ludicrous that I have to say the phrase, he filmed her from the bushes, but yes, he did that. He stood in the bushes. Okay, so legal standard. Rule 17. So this is like the way that you can serve subpoenas on third-party record holders in criminal cases. It's not traditional discovery, which is under Rule 14 in a criminal case, which normally is limited to materials in the care, custody, or control of the state or its agents, the Commonwealth, the prosecutor, or its agents. Rule 17 is a special motion, like when in the Karen Reed case, Hank Brennan tried to get Bill Reed's phone records. That's a third-party record holder motion because the records aren't in the care, custody, or control of the state. It would have been different if a search warrant were served on Bill Reed's phone or something prior to that, but there was nothing like that. Just asking a third party like Verizon to turn over records in a criminal case under Rule 17 is a very narrow scope. It's under something called the Lampron standard, which is really like the least oppressive means standard. Like the court really won't use Rule 17 to compel productions unless the testimony and evidence can't be obtained by any other way on the balance of the factors related to like undue burden or harassment or things like that. It weighs in favor of the plaintiff, which it does not, or the defendant, which it does not here. It doesn't weigh in Aidan's favor. It weighs in Paul's favor. And then furthermore, the Rule 17 standard is much more onerous for a defendant. If you're compelling mandatory discovery or production under Rule 14 from the state, you have a lot more latitude to get a ruling from the court compelling production. When you're moving under Rule 17 in Lampron, the standard is very, very high to get it. And Aidan has already lost a Rule 17 motion in the context of this case. In fact, the video that was taken by one of the witnesses or family member that was walking with Lindsay, one of the Reed O'Keefe witnesses or family members or friends that was walking with Lindsay, Aidan, because that video was submitted into evidence, filed a Rule 17 motion on this docket, on this district court RO violation docket that's going to trial today to try to get the full phones of the people of the person who took the video, the full forensic extraction of the phone. The judge denied it. So I don't see Aidan winning on this Rule 17 motion, but it just should be clear that that's what Aidan's using. The vehicle is what's called Rule 17, which is a motion to compel production of records or a subpoena to a third-party record holder in the context of a criminal trial, and the records are not in the care, custody, or control of the state. I hope we're all on the same page. Yes, we are. That is Kate Peter, Mafia Masshole. Rule 17. Rule 17 provides the court on motion may quash or modify the summons if compliance would be unreasonable or oppressive, or if the summons is being used to subvert the provisions of Mass Rule of Criminal Procedure 14. Mass Rule of Criminal Procedure, paragraph 17A2. Legitimate objections brought pursuant to a motion to quash may be wide-ranging and may properly include objections to the general lawfulness of the command to produce and other issues. Commonwealth v. Sequeira, 63 Mass Appellate Court, 747, Pin Site 751, 2005. It is well settled in Massachusetts that Rule 17 shall not be used as a discovery tool. Compare and contrast with Rule 14. Commonwealth v. Lampron, 441 Mass, 265, Pin Site 269, 2004. Because Rule 17 is reserved for evidentiary materials and not invoked merely for the exploration of potential evidence, the evidentiary standard of relevance applies. So this is MRE 403 and 401. A defendant is required to make a factual showing that the documents sought are relevant and have evidentiary value to the defense. In other words, the defendant must show the documentary evidence sought has a rational tendency to prove or disprove an issue in the case. Commonwealth v. Fayweather, 406 Mass, 73, Pin Site 83, 1989. Rule 17 further requires that the subpoena is made in good faith and is not intended as a general fishing expedition. A documentary trial subpoena is improper if it is burdensome, frivolous, or constitutes unwarranted harassment of witnesses. Commonwealth v. Lamb, 444 Mass, 224, 229 through 30, 2005. That's going to become a big issue here. Argument. Upon information and belief, this instant criminal matter involves the defendant's alleged violation of a restraining order issued pursuant to GLC 209A7 on February 26, 2024, when defendant failed to remain 100 yards away from the complainant, Lindsay Gattani, at or near the Norfolk Superior Court at the time of the alleged violation. Mr. O'Keefe, Catherine Peter, and Jennifer McCabe were also in attendance at the criminal trial of Karen Reed. Kate was not, that's wrong. Kate was not there that day. But, Mr. O'Keefe and Jennifer McCabe were. Kay was just calling people on the phone. While Mr. O'Keefe and others may have observed the defendant's alleged violation of the restraining order, there appears to be no good faith basis for the defendants to subpoena Mr. O'Keefe to appear on the first day of trial and to produce copies of unspecified private communications between or among Mr. O'Keefe, Lindsay Gattani, Catherine Peter, and Jennifer McCabe, which are utterly unlimited in time and scope. This court should quash or modify the defendant's subpoena because there is no demonstrable relevance to Mr. O'Keefe's attendance on June 9th or the production of limitless and undefined private communications which are immaterial to the Commonwealth's allegations against the defendant in this case. First, the defendant appears to be using the trial subpoena as a discovery tool in an attempt to circumvent Rule 14. The defendant has failed to make any factual showing that the documents sought are relevant and have evidentiary value to the defense, or that the evidence sought has a rational tendency to prove or disprove an issue in the case, as the SJC set forth in Commonwealth v. Lampron. With respect to trial testimony, there is virtually no relevant information that Mr. O'Keefe could offer which is not readily available by alternative and less oppressive means. The entire that's the standard. The entire series of events giving rise to the Commonwealth's case was captured on video by multiple sources, and there is no shortage of other witnesses who can correctly identify both the defendant and Ms. Gattani. Second, even if the communications sought have some collateral relevance here, the defendant's demand is unreasonable, oppressive, and unduly burdensome in proportion to the needs of the case. The untailored demand for copies of all text messages, emails, and social media messages between or among Paul O'Keefe, Lindsay Gattani, Kate Peter, and Jennifer McCabe seeks an unbounded volume of private communications without regard to subject matter, relevance, or temporal limitation. I love the word temporal. As framed, the demand will require Mr. O'Keefe to review and produce potentially years' worth of personal and unrelated messages that have no connection whatsoever to the events of February 26, 2024. Such a request is not only borderline harassment, but virtually impossible to comply with given the timing of the subpoena and the start of defendant's trial. Third, the defendant's demand is a blatant attempt to interfere with Mr. O'Keefe's attendance of Commonwealth v. Reed, the adjudication of the murder of his late brother, Boston police officer John Joseph O'Keefe III. During the 3+ years for which Commonwealth v. Reed has been ongoing, Mr. O'Keefe has attended every proceeding in support of his grieving family. The murder case is now on the precipice of conclusion, with the defense nearing the end of its case in chief and closing arguments expected to take place next week, so that means this week. Meanwhile, in the instant case, I would say the instant case at bar, the defendant demands Mr. O'Keefe appear on June 9th, but you really should only say the instant case, on June 9th, the day the Commonwealth begins its case in chief in the Reed case, in the Kearney case. Despite the Commonwealth not listing Mr. O'Keefe as a prospective witness, the defendant has proffered no witness list, so I guess as of that time, and will have no opportunity to present evidence on June 9th. The only plausible explanation for the timing of this demand is personal animus, precisely the unwarranted harassment condemned by the SJC in Commonwealth v. Lamb 444 Mass at 229. A complainant or witness should be forced neither to retain counsel nor to appear before a court in order to challenge potentially impermissible examination of her personal effects and records of her personal interactions. Accordingly, the subpoena should be quashed, or at the very least modified, to avoid undue burden and oppression to Mr. O'Keefe. Paul O'Keefe respectfully requests a hearing on this matter, so that's why I think we're going to start with a hearing today. Ladies and gentlemen, we got a lot going on. We got a lot going on. But you know what I have for you, friends? I got something special for you. I have a compendium, well, because I need to get myself composed. I need to get ready. I have a compendium of towel asking Aidan Kearney and Karen Reed questions. I want you all, I know you all saw, some of you saw this yesterday, but there's no better way for us to get prepared than what is the culmination of 3 years of chaos than to watch Little Towel run into the belly of the beast and ask questions, literally hundreds of them, to Aidan Kearney and Karen Reed. Oh, yes, ladies and gentlemen, today is the big day. We're going to break Towel Stream records. If we're at 332 watching this early in the morning, ladies and gentlemen, let me just tell you, the 9 a.m. start is going to be huge. So, actually, you know what? So I have to ask, do you want to watch Little Towel asking tough questions to Karen Reed and Aidan Kearney? I think we should do that. We've gone over the web of connections between Kearney and Karen Reed so many times. We've gone over it all. Let's watch Little Towel. Let's allow Little Towel to step up on the stage. I'll show you my 3 years of work. I can't tell you, untold. So much. It wore Little Towel's physical body down to the point where I started like collapsing, and I had to stay home a lot. And now I sit in a chair most of the day. But I did it. We are on the precipice of Towel putting together his magnum Towel opus, and I would like to show you all the years and years worth of questions that I had for these two people, Karen Reed and Aidan Kearney, and sometimes their lawyers. And I think, yes, I'm so pleased. All right, we get to watch it. I got permission from the Towel friends. And one more thing, ladies and gentlemen, before we watch this clip, I would like to announce, ladies and gentlemen, we are having a special mock jury for the John O'Keefe and Karen Reed case. Well, Mandy Strong, Kate and Aidan used to work together, so Kate has a lot of insights into how Aidan functions. Aidan and Kate had a falling out in like 2019. She depending on whose version you hear, it was either about money or Kate like wanted to go out and do her own thing, and Aidan wouldn't let her. Whatever. The point is, I don't think it's the O'Keefes. I think it's like people in the orbit of the case who are in the room making decisions were like, all right, we need an insight into Aidan's mind, like, and they use CIs all the time, the state, etc. So Kate's like kind of like Aidan, will use her as a CI, but it just didn't, not like a real CI, like we'll have her work for a PI firm as cover and have her give us information. And like, yeah, that's, I think, how it started. I don't think it was necessarily the O'Keefes, so. But yeah, okay, folks, let us talk a little bit about, and the other thing is, listen, I don't necessarily want to do this, but I think if we're going to talk about Kate Peter, I think we all have to get on the same page. I know it's a little scary, but just to understand the dynamic of who Kate Peter is as a woman, and she could end up being central to this trial today, let's just watch this clip from Little Towel. I put this together, and I just want to let you know, the rumor, okay, there was a rumor in the John O'Keefe and Karen Reed retrial for a very long time that one of the witnesses, named Colin Albert, sold drugs with his family. It was completely false. No one had ever mentioned it, though, ladies and gentlemen. Hold on. No one had ever mentioned it, though, until this video, okay? Now, I just want to point out to people that Kate Peter I think she's positioning herself in like to try to make a Netflix documentary, frame her as the Charlotte of the woman who saved the internet. But I don't think that Kate Peters really benevolent. I think, in my opinion, she was just tactically useful to try to get Aidan. And also, I think the state police who were investigating Aidan and Karen were worried that the feds in August of 2023 stumbled onto the cover-up of Sandra Birchmore's murder by the same MSP unit that investigated Karen Reed. And so they were using the investigation of Aidan and Karen, who they knew were close to the old DOJ, to try to find out what the actual target of the probe was after August of 2023, because I think the state police figured out that it wasn't really about the investigation of John's death. So what could it be about? Sandra Birchmore. How do you find out what the feds are probing? You get people close to Aidan or in his orbit to feed information to you, and who's the perfect cover to do that? Kate Peter. But what's really weird is I think Kate Peter had loyalty to specific witnesses in the case and not others. Why? Well, two reasons. One, we're going to watch this video. Tell me what person who is advocating on behalf of justice, who is doing the right thing, starts a 2-year rumor that no one was ever talking about until she did this, to what? Get revenge on Aidan? Kate Peter planted a fake rumor about Colin Albert and Chris Albert selling drugs for no reason. She just wanted to make Aidan look bad, although I think it was more insidious. I think she wanted to take the heat off Jen McCabe at the time. And ladies and gentlemen, it spread like wildfire. Now tell me, is this the mark of a responsible human? Is this what someone would do who actually cares?
This was 100% a fabrication out of my own mind. It is not rooted in reality at all. I sent this just to fuck with Aidan, to prove that he does not vet information at all. He will run with any sort of gossip that bolsters his claims. And I want to prove this. So anyone who believes him should realize that a lot of this is getting sent out. I just went ahead and I emailed turtleboysports@gmail.com. I wrote, based on a movie plot. This is based on a movie plot. You could do the same thing. He would probably run with it too. If anyone gets their fake stories mentioned by this schmuck, please email me. We'll have a prize for you. Listen to this.
All right. Again, this is an honor. Like, I don't know who this person is, but I'm just going to read the email that I got out loud. All right, bear with me for a minute. Because, hi, I've been really scared to talk to anyone about this. And I know I'm not the only one. But I see you're keeping people anonymous, and I think it's important that people know. The problem that Colin Albert had with John O'Keefe is that Colin Albert sells pills and weed, and John knew about it because he lived across the street from one of Colin's friends who runs Colin. Colin's dad knows, and sometimes the drugs go through the pizza shop, from what I've heard. The whole Albert family makes money from it. I don't know, that's come on, that's what makes it a little far-fetched. Like, you're making the Albert family relies on marijuana sales and what other pill sales. Come on, that sounds. I'm just reading the email from it, and I don't know if his Uncle Brian knows or not, but I think he probably does, and explains why they're really covering it up. I have screenshots of Colin selling drugs because, sadly, I have bought from him before. Well, that's interesting. That's very interesting.
So interesting.
So again, this person asked for anonymity. They will be granted it.
Yeah.
Just to be clear, I have not said your name, and I'm not going to say your name.
Yeah, very trustworthy man.
You are
until you don't dance to what I tell you to dance
Oh,
to.
he said you're safe with me. Well, I don't want anonymity. I sent you that email, you dumb motherfucker.
All right. Oh my goodness. You get what you get? Like, that's ridiculous. They were laughing about it. That rumor did not exist until exactly. And listen, I think if it were just her trolling, I think that's the surface level. Oh, look, Aidan's an idiot. No, did she say that Jen McCabe and her family were selling drugs? No, she said very specifically Colin Albert and Chris Albert. Why? Because it gets the heat off Jen, in my opinion. Huh, Kate? Is that what it was really about? I'm telling you, folks, it's so manipulative. And then look at the Lindsay situation on 2/26/2024. Who ends up, who might Kate have really been talking to? Jen McCabe. Maybe Jen McCabe wanted Lindsay there, but did anyone tell Lindsay or the O'Keefes that was the reason? Apparently not. You see what I'm saying? It's just, there's a theme here, ladies and gentlemen, and it's this weird behavior. And if you look at that rumor about Colin and Chris, it's still being spread to this day. Okay, still to this day, and Kate was the source of it. And how can you laugh about it? How can you laugh about it, ladies and gentlemen? And even how can you say, oh, well, tactically, don't you see? It just spread the heat out a little bit, took the heat off the other witnesses. Are you kidding me? That's outrageous. And then you realize that Lindsay Gattani may have been subject to a similar kind of victimization by Kate and the powers that be. Oh, feed Lindsay. Did you know, ladies and gentlemen, in the context of the criminal investigation of Aidan Kearney, a 15-year cell phone extraction of Lindsay Gattani's phone was obtained by the state police, okay? 15-year extraction. It had pictures of Lindsay giving birth on it. The state police, the then commanding officer of the Norfolk MSP unit, Brian Tully, took that 15-year extraction while it was in state police custody, and right before the Karen Reed first trial started on April 24th, 2024, Brian Tully took that 15-year extraction and hand-delivered it to Aidan Kearney's lawyer by mistake. But you know what, ladies and gentlemen? It was completely unredacted except for two types of deletions. Messages from Brian Tully to Lindsay were deleted, and messages from Kate Peter to Lindsay were deleted from that extraction. So why would the state police, specifically Brian Tully, turn over a 15-year extraction of Lindsay's phone, feeding material to Aidan Kearney that allowed him to to focus on Lindsay, to leak private images of her, to have pictures of her giving birth, to know about her doctor's discussions, all this crazy stuff? Why would the state do that? How convenient. Another distraction. Colin Albert sacrificed to the wolves by Kate Peter as a distraction so people would spread rumors about him, in my opinion, and not other witnesses that Kate favored. Lindsay Gattani thrown to the wolves by Kate Peter and Brian Tully, using his official position, in my opinion, in the same way. So, ladies and gentlemen, don't make me spell it out. It's there. It's black and white. Yes, Ambrim, it's so scary. A 15-year extraction of Lindsay's phone. The state police, never in history I've talked to high-level people about this. No one has ever heard of a victim's 15-year extraction, completely unredacted, with pictures of her giving birth, being turned over to the defendant's lawyer personally by the state police trooper in charge of the unit doing the extraction. Not to mention, literally, they clearly went through the extraction while I was in state police custody to remove messages from Tully to Lindsay and from Kate to Lindsay. But then they just handed over the whole thing, and it provided months. Do you understand? That phone got turned over to Aidan's lawyer on April 24, 2024, the extraction. There was no protective order entered until December of 2024. 9 months that material spread around with no court protective order, even though Tully admitted it was a mistake. He never, quote, he never should have turned it over. Oh, ridiculous, ladies and gentlemen. It was a setup. It was a setup. I'm telling you, Kate Peter, you can call her benevolent, but she's not. She has a specific agenda. Insulate, in my opinion, Brian Tully, insulate the MSP unit regarding coverage of the Birchmore case, and don't let that come up when people talk about Karen Reed and John O'Keefe. And then thirdly, use people as proxies to take the heat off Kate's favored witnesses. And I think two of those proxies were Colin Albert as evidence in that video, and Lindsay Gattani as evidence by Brian Tully leaking a 15-year unredacted extraction of Lindsay's phone to Aidan Kearney's lawyer right before the start of Karen's first trial to give Aidan cannon fodder to distract from the witnesses. And that's evidenced by the fact that the only actual deletions from that extraction were messages from Tully to Lindsay and from Kate to Lindsay during the time the phone was in the possession of MSP. Ladies and gentlemen, I am an incredulous towel. You must understand, my incredulity is justified. I am a righteously incredulous towel, ladies and gentlemen. I cannot help it. It is simply the reality. We need to come to terms with it, ladies and gentlemen. But I also have video of me interviewing Karen and Aidan that we're going to watch, because literally I need to take a breath, because I also should be very clear that there's something else Kate did that I want to talk about. And just to show you what kind of person Kate is when she's not trying to get you to think a certain way about her and showing her real persona. So in about May or June of 2024, there was a day when Lindsay, by herself, I wasn't even with her, had gone up to the court TV producer on the Registry of Deeds steps at the John O'Keefe and Karen Reed trial, because Lindsay wanted to start building her own connections with the press. Well, I was hanging out at Lindsay's apartment later that day with Kate, okay? And I, during a conversation, stood up and said, Lindsay, as Lindsay was telling us about the court TV producer, I said, Lindsay, I think certain people are trying to keep you away from the media to protect Brian Tully. And then I wrote Anjanette Levy's contact information down on a piece of paper, and I get direct contact info, and I gave it to Lindsay. Then, I'll never forget this, ladies and gentlemen, although I didn't find out the full context until later. Kate Peter stood up walked over to Lindsay, and I didn't hear the part, whispered into Lindsay's ear, go along with this when I get back. Kate Peter went outside. Okay, I thought she was just vaping. She came back inside. Do you know what the first thing she did was? She staged a fake double date with Lindsay. Okay, like it was the most manipulative thing I've ever seen. She started saying to Lindsay, oh, I set this double date up for you with this guy from South Boston. He has really good abs. Like, I'm very excited to go with you. And like she had told Lindsay to go along with it. And Lindsay didn't really realize what was happening. I didn't realize what was happening. So Kate clearly knew that I'm not very emotionally developed. So I stood up and I, Kate knew exactly the dynamic there. I stood up and I walked over to Kate and I said, go F yourself. You are a piece of S. And then I hugged Lindsay and then I walked out and I didn't talk to Lindsay for like 3 months. And it breaks my heart because if we had just talked in that moment, Lindsay and I figured out that all happened right after I said, I think people are trying to keep you away from the media to protect Brian Tully. And then Lindsay would have said, oh yeah, well, it was really weird that Kate came over and said, hey, just go along with this. You know what I'm saying? It was an emotional setup. And Kate was trying to break my heart to force Lindsay and I apart because I think Kate was worried Lindsay was going to become empowered if I was in her orbit. That's how dark this stuff is, ladies and gentlemen. It's literally, in my opinion, a dark personality triad that comes out in Aidan and Karen and Kate. And yes, maybe on the surface they know how to hide it, but you see them in an interaction like that, you'll watch it for yourself, ladies and gentlemen, and you'll see it on display. It is devoid of humanity. It is a soul that, whether through heartache or pain or simply because someone was born without the capacity to feel, manifests itself in some of the cruelest, most deliberately intentional, hurtful acts that you can imagine. Can you imagine doing that to a human being? Literally, I was so heartbroken, and it was so malicious, so manipulative. I don't even think Lindsay and I were ready to talk about that at that point. It was forced on us because of what Kate did. It was completely wrong. It totally was an emotionally abusive, manipulative tactic, and it was disgusting. Okay, well, thank you, Abraham. I know I lived it, my dear friend. I lived it. It was a scary, scary time. I didn't even understand the level of emotional manipulation that would be required for someone to think in that moment, oh no, Grant's going to tell Lindsay to talk to the media. That could expose what Tully and what Kate Peter have been up to. Let me stage a fake double date to cause him to have an emotional breakdown and stop talking to Lindsay because he thinks that she wants to go date some guy with hot abs in South Boston. Do you understand how manipulative and how dark your mind has to be to do that in real time? Like, for that to be your tactical plan in real time. First of all, it's incredibly childish. It is so short-sighted and myopic that it only really works once, because as soon as someone understands you're doing that, you're never going to be able to pull it off again. But the other thing is that, and there's no long-term plan to it. It doesn't manifest a understanding of long-term consequences or anything like that. It's completely tactically inefficient. It causes more problems than it solves, which is Kate Peter in a sentence, ladies and gentlemen. But also just to think of love as a tool to achieve an end. I mean, that is one of the most sacred things in the entire world. Like, not lust or attraction, but like actual genuine love. To look at that instead of saying like, oh, that is a very beautiful thing, like to grow, for there even to be a chance of something like a rose to grow from this chaotic concrete is just such a redeeming story. It's so hopeful. It's so beautiful. And to just look at it and be like, no, I'm going to crush it. Like, I got something to accomplish here. Like, I'm going to crush it. You got to be a sick person. Kate Peter is a YouTuber who used to work with Aidan Kearney until 2029. She's Mafia Masshole 2019. She's Mafia Masshole. Kate and Aidan had a falling out, depending on which side you hear. It was either about money or because Kate wanted to go out on her own and Aidan wouldn't let her. Kate then started becoming kind of a niche YouTube streamer about like trolling First Amendment auditors like Chili DeCastro. And then Kate covers like weird internet people like Cyrax. That's where she really thrives, like trolling First Amendment auditors and like trolling weird internet people for the lulz. Kate also does like some other stuff. I think she like benevolent. This is the one redeeming quality that she has. I think she's really intent on like hunting people who hurt children. So she like will dress up as like an underage child and go into like chats and try to bait people to talk to her and to report them. She's like one of those what do they call them? They do like hunters, the people who do like stings on people they think are hurting children, and she's like a vigilante kind of like that. So the one redeeming part of Kate Peters' existence, in my opinion, is that she does that kind of like, she'll kind of like, I think she has this network of online friends that's deeply established, and I think the First Amendment auditor stuff and the CIRAC stuff is actually cover for what she really does, which is hunt dangerous predators. Now that stuff is done in quiet, but I think that's why all of her friends like have these fake online accounts, and like it's just this wide network that spans like the US and maybe internationally. It's because what they're really doing behind the scenes is hunting dangerous people, but that's very dangerous work. I mean, like you catfish them and stuff like that. I have a very complex picture and understanding of Kate Peter as a human. I think the analysis of the system would be that she's useful but a liability. Because, yeah, okay, like you need someone with no emotion who will just go into a chat room, pretend they're a young girl, and then bait a predator, and then set the guy up, and then get him arrested, okay? That's what Kate Peter can do effectively. And you got to be able to move in plain sight because you need like a support network and all that. So Kate Peter is like a perfect low-level operative for doing that kind of stuff. But escalating her up the chain to do actual like PR work or like PI work or actually be any kind of central cog in the wheel becomes incredibly dangerous, because the very skills that make her useful in terms of like getting into dangerous worlds and holding very dangerous predators accountable make her a liability when those tactics get applied in the public arena. They shouldn't be, and that's kind of how I would sum Kate up. So yeah, there is a lot of context there, and yeah, you know. And I listen. If anyone, for someone like Kate, when you're confronted with someone like me, first of all, this is just one of many different stories I'm covering. But when you're confronted with someone like Towel, you kind of have to go on the attack. I mean, what are you gonna? You can't beat me on citing the record. I understand the facts better than Kate. I understand the overlapping socio-political dynamics at play better than Kate. I have better connections in the government at all levels and on levels that I don't think Kate even understands exist. You know, so, and I open lots of doors just because I'm me. I'm not tooting my own horn. It's just very easy for me to be like, hello, I'm Grant Smith Ellis. And they'll be like, oh my, that Grant Smith Ellis? I'll be like, yes. They'll be like, oh, well, tell me about these 17 things I read about in your lots of coverage. And I'll be like, sure, let's talk. I'm a towel. Anyway, it just blows my mind that the house of cards that has been built up here is so precarious. Because to me, I would have made a judgment call very early on if I were the powers that be, like limited purpose deployment of Kate Peter. Like, don't let her get too close to anyone. She will find out information and use it to protect her position. Don't let her, wheel and deal, etc. Like, just deploy her for a limited purpose, a compartmentalized purpose. Don't let her know what she's doing. Okay, like that's what you could do. But instead, I think Kate Peter became privy to far too much information and just caused chaos. That's my opinion. I'm a towel. It is a very sad situation. So the other case involving TurtleBoy, this is a restraining order violation. This has to do with Aidan Kearney staying outside a Karen Reed trial when he should not have. He was told that Lindsay Gattani, who had a restraining order against him, was there. Aidan left the courtroom but stayed outside the building. When Lindsay left the building with the O'Keefe family and witnesses, the Aidan stayed in the bushes and filmed her. So the reason why we're talking about Kate Peter is that this Aidan Kearney has tried to subpoena Paul O'Keefe because Kate Peter told Paul O'Keefe that day that Lindsay wanted to go to court to support the O'Keefe family. But then Kate told Lindsay that the O'Keefe family wanted Lindsay to come to court to show support for Lindsay. And in reality, it's very possible that Jen McCabe wanted Lindsay there to make Aidan not be able to be there, and no one told Lindsay or the O'Keefes that. Kate Peter was just being a little manipulative. That doesn't have any bearing on Aidan's, my opinion, on his criminal liability for this case, but that's why we have to talk about all this, because Aidan Kearney and Kate Peter have somehow gotten Paul O'Keefe subpoenaed related to the criminal trial in Dedham District Court for Aidan that's going to be starting at 9 a.m. And we don't know, the reason why we have to talk about that is we don't know if Aidan's case is going to go right to trial because Paul O'Keefe has requested a hearing on his motion to quash the subpoena that Aidan issued to Paul to force Paul to testify as a witness in Dedham District Court during the pendency of the Reed case. So Paul's going to have to leave his brother's murder trial related to the death of his brother, go across the street, and then wait to be called as a witness in the Aidan Kearney criminal case. Oh, it's tormenting, ladies and gentlemen. It is just tormenting. I know a lot of just over 35 minutes. And listen, you know what we're going to do for the next 35 minutes? You're going to watch me ask questions to Karen Reed because I need to breathe. As you can tell, the reason I only cover the Aidan Kearney cases when they intersect with the Reed case, and today it does. I am very, very personally attached. I'm not going to deny it to the Aidan Kearney case in the sense of Lindsay. I'm not. It's very obvious. It would be an abdication of my duty. Now, I didn't mean to violate the canons of journalistic ethics. I have never gone into a story where I was like, oh, I want to like talk to this person more like on a personal level. I don't do that. I help a lot of people in my work. I've met thousands of people. I don't just enter into people's lives. That's not what I'm trying to do. It is not a dating pool. I am working. It is very important to me. And the people that I'm working with are often very vulnerable. And that's just not what I'm doing. This all was not intentional. I had no idea. That's why I used the Casablanca quote, like, of all the courthouses in all the world, she had to walk into mine. I had no idea when I saw Lindsay walk into that courtroom in December or whatever it was of 2023 for the first time that things would play out the way that they did. I will talk more about it another time, but there was one moment in like March where she was like, when you were walking the witnesses into court and you stuck the middle finger up, I knew exactly what you were doing. Like on 2/26/2024, I walked both groups of witnesses in. It was actually the day Aidan was charged with violating the order. And while I was on the stairs, I wanted the protesters to focus on me, not the witnesses and the family, the O'Keefe family. So I just stood on the stage, flipping them all off, and stood on the stairs of the courthouse, flipping them all off. Now, the media got really mad at me because they were like, we can't use the shot now. And I was like, I know. And then second, I got fired from Jurist. Well, I basically was going to leave because they were trying to impose terms. Like it was very much an attack on the First Amendment. And I was like, no, I'm not doing that. So I had to leave the journalistic outlet that I was volunteering for. I was bigger than them, though. It was funny. Like, they get, I think, like 1 million views or something per year. I was getting like 10 million views a year back when I worked for them. Now I'm at like 130 million. I am 130 times bigger than that publication. Sorry, don't mean to insult it. It's just how it is. But anyway, they got rid of me because I flipped them off, but the Karen Reed fans off. But Lindsay said to me, like, I knew what you were doing. Like, no one else figured it out, but she was like, I knew what you were doing. Like, I got what you were doing when you did that. And that really was what it was. And I'll also never forget the day Kate Peter brought me over to Lindsay's apartment for the first time. I don't remember why she did it, like, or what the reasoning was, but I remember she brought me over there, and then Kate had to leave early that day. And I'll never forget the look in Kate's eye when she got up to leave that day. The first day I was hanging out with Lindsay, and I could see it, like, she couldn't stop herself from leaving. Kate had to, like, go deal with some administrative thing or something, but I saw in her eyes as she was walking out, like, either she could sense the energy in the room or she was just like, oh no, because I saw in her eyes, she was like, oh no, what have I done? And I was like, what have you done? I don't know how this has happened. Oh, goodness, ladies and gentlemen. Lindsay Kearney is the named victim, ladies and gentlemen, in the criminal case that will be taking place. Literally, Aidan Kearney's first criminal trial is at the top of the hour, 9 a.m., and Lindsay Kearney is the named victim. Lindsay Kearney is a wonderful human being. She's a nurse. She used to be with Aidan, but they had a falling out. Aidan told Lindsay Kearney about Karen Reed's direct connection to former U.S. Attorney Josh Levy. Aidan then also faces felony charges because he went over to Lindsay's apartment on December 23rd, 2023, pushed her over a couch allegedly, recorded her illegally allegedly, and witness intimidated her allegedly. He got felony charges for that, and then on December 26, 2023, you remember Aidan went to jail for 60 days. It was because of that incident at Lindsay Kearney's apartment. All right, so that's Lindsay Gattani. Now, on 2/26/2024, after Aidan got out of jail, there was a restraining order in place. Aidan tried to go to the Karen Reed trial. Lindsay Gattani was there. Aidan showed up. He left the courtroom but stayed outside on the lawn of the Registry of Deeds across the street. Lindsay, when she was leaving the court, was with the O'Keefe family and friends and witnesses. They looked back, and Aidan was in the bushes recording them in violation of the restraining order. So that's what we got going on. Now, what... Yes, wow, that is intense. Who do we got? Yeah, you're so right. You are the best, Metro West. Julie G. Yes, hi, Julie G. Absolutely right. Kate Peter raised money at one point as well for people who were protesting. And Kate didn't even set up the protest, and then she deleted the Facebook post where she raised money and never disclosed what happened to it. People paid for their own lunches happily, and Kate was telling people she paid for their lunches. Crazy stuff, ladies and gentlemen. But yes, we're going to watch this video of Towel asking some tough questions. We're only going to watch 30 minutes of it. We got to get ready for 9 a.m. I don't even know how I'm going to cover all this stuff, but I'm here with you. We're going to do it together. It's going to be one of those days. Oh, sorry, I didn't mean to take your towel comments down. It's going to be one of those days where we learn together, we grow together, we sit here in astonishment and just watch it all unfold. There's nowhere I'd rather be. I have my energy drinks. I have bottles of water. I will get lunch in a few hours. We are good to do this. I couldn't even eat this morning. I was literally so nervous. And if I'm this nervous, imagine how the victims feel, the witnesses feel. Let our thoughts be with Lindsay Gattani this morning, ladies and gentlemen. Let us empower her energetically as she stands up, the first victim, ladies and gentlemen, to stand up on the stand against Aidan Kearney in a criminal trial. Ladies and gentlemen, let's watch Towel ask questions to Aidan and Karen, though. Karen, why'd you go back to Fairview before going to Jen McCabe's? Karen, why'd you hook Aidan Kearney up with the FBI? Well, that was Mr. Yannetti, wasn't it, Karen? Don't poke me.
Karen, keep going! Keep going!
Oh, she took a different way. Oh, my dear God, he fell. Richie, are you okay? Gonna take the plea, Karen? Do it. All right. Good morning.
Hey, Karen, are you prepared to spend the rest of your life in prison, Karen? How's it feel to be known as a cop killer, Karen? How does it feel to be known as a cop killer? You're going to prison, aren't you, right? Do you have any remorse, Karen, for what you did to the O'Keefe family? Do you have any remorse, Karen, for what you did to the O'Keefe family, huh? Will you denounce your supporters harassing the O'Keefe family? Will you denounce your reporters harassing the O'Keefe family, Karen? Shame on you, Karen. That's what people say. Karen, anything to say, Karen? You're going to spend the rest of your life in here. Don't touch me. Don't touch me. Karen, you're going to spend the rest of your life in prison. Right, Karen? How's it feel to be known as a cop killer, Karen?
How's it feel to be known as an asshole?
Known as a cop killer, Karen. How's it feel to be known as a cop killer, Karen? How does it feel? How's it feel, Karen? How's it feel?
Karen, how did you manage to walk into Josh Levy's office in November of 2022? Do you know him? Does your father?
Hey, Karen, how's it feel to be a cop? How's it feel to be a cop killer, Karen? How does it feel to be a cop killer, Karen? Shame on you for what you did to the O'Keefe family. Shame on you, Karen.
How was the trip to Mexico with Melanie Little, Alan Jackson? Karen, why did you go back to the house that night before you called Jen McCabe? Sorry. Karen, do you disavow TurtleBoy? Free press, Tom.
100%. Got it.
Don't block the free press. Don't block the free press, guys.
The free press? Really? Yeah, we love you, Karen. Thank you. Break that red cloth on your butt.
These are your fans.
Good job, guys.
Don't block the free press.
I can walk with it right now.
You're gonna get banned from.
Get away with.
That's her dad right there.
Listen.
Free press.
You guys are standing.
Free press. Free press. Yes, it does.
Patriot Karen Reed.
I thought you were a law student. Say hi to the feds.
She already met them. We're good there. Trust me.
That's how Aidan became an informant.
Nope.
Karen, are you sharing a room with Alan Jackson at the Omni?
Don't need no reason.
Come over this way, Ava. Walking this way. There we go.
See how that works?
Attorney had said it was ongoing.
What about
and
now?
it clarified some ARP issues. If I take him at his word, that would be a very dangerous endeavor of mine. But I've seen a letter from Marion on Leah Foley's letterhead.
So you do believe it is ongoing?
I don't know. That's just the actual data
Come on, back
that I
up.
have.
What do you think about a gag order against your attorneys and you are the only one that can talk? Would you like
Guys,
that?
give her
or-
some room, please. Give her some room, please.
I like talking. I like to reveal the truth. Yes. Yep. I think I'll be back here.
Come on, guys, keep it moving.
Gotta keep it moving. Let's go.
You said that in terms of what you've been told, you have not.
That is true. That is true.
There's only so much room on the sidewalk. Let's go.
The Canton police just put out a statement confirming the federal investigation's over. Any comment, Karen?
Guys and girls, please give us some room so we can get the car. Thank you very much.
Hello, Trooper. Karen, does Alan go scorched earth all the way? Is that what he does?
Really? Really? Am I going to do this for you today? Brent. Stop. When I think you have half a price. There you go. Grant.
Hey, it's not my fault you didn't become
Grant.
chief.
Grant. Grant.
I'm in a bad mood.
All right, well, don't take it out on people that are going through worse than you.
Fine. He attacked me. How was your day, Chrissy?
My day is going good as long as you're
One question.
respect.
I'm being respectful. People were mad at me for talking to you, Chrissy. I was like, Chrissy's nice.
Yeah, I am nice as long as you respect Karen and her
One
family.
question.
I swear to God, if it's not on my question, I'm gonna...
That was not out of line. I actually feel bad. Good morning. Hey, Karen. Karen, are you sharing a room with Alan Jackson at the Omni?
Karen, how are you feeling today? Doing well.
I tried making it sunny for everyone.
Yeah, thank you. This is good marathon weather, not so much for the cold.
Morning, how are you?
We're good guys.
Kurt, right?
Karen, why'd you say it was all your fault at the scene that morning? If you had to predict who's going to file lawsuits against you, Jen McCabe, Colin up. Oh, actually, I do have a question for you. I have a question for you. If, and this is an interesting question, if Kate Peters sent you that rumor about Colin Albert selling drugs that was false, do you have a contribution claim against her as a co-defendant if you get sued?
I don't know what that means.
I know you don't. Bradle, play dangerous games sometimes, Mr. Bradle. It concerns me. Careful. We're going to jump it forward a little bit. But listen, folks, I need some help in the chat. I'm not going to play the TurtleBoy video. Can someone please just put in, and I will look too. We just need instructions on how to watch the TurtleBoy hearing. I know someone, Diana Natale, I think, listened to it. I'm so glad you found it. But just a reminder, folks, please don't give TurtleBoy content like views from here. We can watch it, like if we need clips, but don't link to it. It's not anything against you, Diana Natale. It's just, why would we link to his feed? But if you can tell me, Diana Natale in particular, or anyone who can watch that video, how can we watch today's TurtleBoy trial? I need some towel help here, so we have to work collaboratively. So Diana, if you watched, I mean, you are the person who watched it, could you please tell us how TurtleBoy said we can watch the trial? All you typed was, TurtleBoy said, here's how you can watch the trial, which is counterproductive because, first, I don't want to send anyone to watch TurtleBoy's videos, and two, it's just the one piece of information we need is, what did he say? Is it on a Zoom? Is someone going to be doing a live feed? Sorry, I don't mean to be frustrated, but we literally have 17 minutes, and Diana Natale got the answer, but we don't actually have the answer. We just have a link to a long, convoluted video. Okay, so please, someone who can put this together for Towel. I don't want to get frustrated. How did TurtleBoy say we can watch the hearing today? I can't believe this. I'm literally just blown away. I can't believe this. This is not the day for this. Now I'm in a very bad mood. All I needed to know was how to watch it. It was the most crucial piece of information. I just don't understand. Why would you do this to me? All right, I'm going to do it myself. I don't want to. That's what I'm saying. I don't want to actually watch it on the stream. Can someone please just tell me what TurtleBoy said about how people can watch the stream? I am way beyond watch today's hearing. I don't want to watch this. I actually can't watch it because if I play it over the computer, then you all are going to hear it. All right. This is just, all right, hold on. I'm going to go find this link now. We're going to keep listening to Karen while no, I can't believe it. Oh my goodness. Why would you link to TurtleBoy's live stream? Oh, all right. I'm not playing this. I don't, that's it. We're banning links to TurtleBoy content. If you see a link to TurtleBoy's content, even if it's in good faith or well-intentioned, just delete it. You just sum up what you hear on there and we'll watch clips. But I'm going to listen to this while you watch this Karen clip here. I'm not playing this on stream.
I'm me.
Yeah.
Nice to see you.
You can put it on us.
No.
My handprint is on.
Those are my dad's clothes. He doesn't own it.
Exactly. I don't even own these. I borrowed these from Mr. B. Exactly.
Oh.
What's the coldest it gets for you?
No, this is ridiculous. All right, I don't mean to get frustrated, but I just spent my time watching the video about TurtleBoy. I spent my time watching the video about TurtleBoy, and all he said was he doesn't know if there's a pool feed or anything like that. All right, we're going to take a look on the Glare. Don't worry. Thank you for that, Lock KR up. Don't worry. I didn't mean to get frustrated with Diana Natale. Diana, what I realized was she was sharing a live that had started like 3 minutes ago, and Aidan had started saying, oh, here's how you can watch, but all he ended up saying is you can't actually watch because he didn't know how people could watch it. So here's what we're going to do. We are going to bring up a bunch of different things. We're going to get into our preparation mode. We're going to pause our Karen interviews. Thank you, Karen. It was great to see you, but we're getting into preparation mode, ladies and gentlemen. We have just a few minutes to go. No. Diana Natale, you did nothing wrong. I got a little bit overly frustrated because all I was trying to find out was if TurtleBoy had said something like, "Oh, here's the Zoom link," or no, you did nothing wrong. I got frustrated because I was trying to find out if he had actually provided information. But the one thing is, Diana Natale, I do think, even if we find something interesting on TurtleBoy's content, we shouldn't. The one thing he wants is attention, right? So we, even like if it's like breaking news, I think we should sum up what he's saying and not link to it. Anything else you can link to, I don't really care. But like TurtleBoy content in particular, we can clip it, whatever. But I don't think we should give him a rub. And please do not feel bad, Diana Natale. You are so on it. You find so many different things from around the internet. The only reason I got a little flustered there was I couldn't play the link you sent on stream because it would have played TurtleBoy's audio, and I didn't want to give him a rub off this stream. So I went and listened to it on my phone, and it turns out we don't have the information, but that's okay. That's okay. And I appreciate those of you joining. This is a blue wall of towel, friends. There's just no possibility you can mess with the chat. It's literally where they hang out. It's part of why I feel guilty, but this is a very intense day. So Diana Natale, please don't take that as a comment on you. It was definitely more of a comment on TurtleBoy. Without pre-screening, TurtleBoy clips really don't get played here, but sometimes they're very relevant. Okay, hold on. We have the Zoom info from Denham District Court. Hold on, ladies and gentlemen. Hold on. The Zoom info is hold on. Thank you so much. 668-8217. Now hold on, ladies and gentlemen. 33884. Now, Lisa, can you just double check that for me? No, Emily Joyce, nothing is wrong. Don't worry. It's just we are in last minute preparation mode for the start of the John O'Keefe and Karen retrial and also the Aidan Kearney hearing. One of the biggest things we had to do was and this is partially Towel's fault, and I feel very guilty about it. One of the things that was making me so nervous is we didn't know how we were going to be able to access the hearing. No, don't worry. We have it. Oh, okay. TurtleBoy did mention a Zoom. Oh, that's right, Diana Natale. He did. So this was very helpful. And look at this, folks. Can we just take a moment outside of Towel's anxiety and say to Diana Natale and Lisa that we appreciate and love them as Super Towels. They are doing excellent on the ground reporting. They were helping Little Towel. And the one thing is, and this is just something we'll talk about in general, TurtleBoy loves like getting attention. So we'll find ways to get summaries of TurtleBoy's content and things like that without linking to them. But Diana, you did absolutely the right thing, and please forgive Little Towel. I am just nervous. I think you can sense it in my voice. It's not necessarily just about the procedure and all this and the technicality of it. It's about how complex this is to stream and do. And it's also about the fact that this is clearly a trial with a named victim who I care about very much. And there is, if I were in that courtroom, I just want to let you know, there have been hearings like RO extensions and stuff where I've been there with Lindsay and I literally just broke into tears. Like I remember distinctly one time I was just crying in the back row of the courtroom. So it would not have been good for me to be there. And second of all, I may just start crying today. I'm not going to guarantee you I can get through listening to Lindsay take the stand and not cry. Not because it's just going to be very hard for me. I know we are here for each other. This is a day where you're going to have to be with Little Towel. I'm very nervous about this because I know it's not about necessarily the case. It's just her. Okay. So I am going to be in Little Towel mode. And we just have to get through it together. Now we have the Zoom info here. Let me see if I can get this going. So I'm going to I'm going to bring up the Glare stream because even if we just have to use the Glare stream, that's a little bit easier. And actually, watch these Karen clips for a second. I'm going to call the district court and I'm going to see if I can get permission to broadcast this. Hold on. Just listen to this for a second.
It doesn't get anywhere near 30. There it is. There it is. I like it. I like it. Keep rocking it. Nice to see you. Happy
Morning. How are you?
Hey, Chris. Good morning, guys. Hi, buddy. You ready, guys?
So cold.
It's nice weather we're having.
How you doing? Happy New Year. Go ahead.
Ain't coming on, Josh Levy. Moving on, Karen.
Morning, Neil. Morning.
How are you, Nick? How you doing? Good morning, boss.
You're not going to start.
The unwanted idiot.
Who's up first today? Gallagher? On the witnesses, Gallagher? Okay, excellent. We're going to find out why Michael Lank responded at 9 o'clock when the state police were taking over the investigation today. We'll see.
Do you speak to accused rapists this often? Is that a habit?
I'm really confused.
Do you speak to accused rapists this often? Is that a habit, Mr. Jackson?
Yikes. Wow.
Hey, don't insult Lindsay's credibility, Mr. Jackson. We have an accused rapist here who's an idiot.
He's an accused child molester.
Your victim was a child, Mr. Kearney?
Sources are telling us. Where's he going? Where's he going? Look at him. What's happening? Look at him. Look at him. Look at him.
Look at this
You can
accused
smell- you can
rapist.
look at this child molester.
Good morning, Miss O'Neill.
Oh, you smell great today, Grant.
You smell like weed, you moron.
Really cheeky.
You got this, Karen.
Sorry about that, bud. There we go. There we go.
Good morning. All right, friends. So here's what we got going on. I have, unless there is a pool feed or another channel broadcasting the audio, we are not going to be able to broadcast the direct audio. Okay, so the only thing we can broadcast. So I need folks to go on the look right now. We'll do the Karen trial if we have to, but we need another channel that is broadcasting the Aidan hearing. I can only broadcast it if it is on another channel. So I'm going to take a look right now, ladies and gentlemen, at the Glarer. I heard he might be having it, and then I can broadcast that. So Luisa Ramirez, you are confirmed on the jury, by the way. I was able to confirm that. You are spot 7 on jury number 2. We do have a test jury, but since we have so much going on right now, everyone's got to kind of pause their little towel brains, and we have to let Little Towel be a Little Towel. This is one of the most stressful moments I've ever done in real time. We are going to get ready. If we have to just go to the Karen Reed trial, that's what we're going to do, ladies and gentlemen. But I think what I'd like to do is go to the Glarer. If the Glarer is covering, yes, if anyone can, please check. I actually need your help. We are going to have to do this together. If anyone can check, I have the hearing, I think, on the Glarer. We are starting with the TurtleBoy case, so I don't want to just hear Will yelling. Let me see if he actually has it up. Hold on. We are going to start with the TurtleBoy case. I want everyone to understand, but the Karen case is going to be playing. We're going to go watch the Karen case later, but we are going to start with coverage of the TurtleBoy case. Now, I don't see the hearing, the Aidan Kearney hearing having started yet. Okay, ladies and gentlemen, I don't see that having started yet. I am watching the Glarus channel right now, and we are going to go to the Glarus channel. But simultaneously, what we're going to do, because I am a super towel, is we are going to get ready to go to the other stream. The big moments are here. It's coming up on 9 a.m. I want everyone to compose themselves. We are going to be little towels. We're going to do this together. I know we can get through it. I'm more talking to myself than anything else right now. All right, so we are going to do two things. One, we're going to actually get the Karen cam up. This is going to be hellacious, ladies and gentlemen. So let's go over to the other stream. This is going to be hellacious, but we're going to do it. Watch me do it, ladies and gentlemen. I am a little towel. Oh, goodness, the glare is going to do it. Oh, my goodness, the glare is going to do it, ladies and gentlemen. I can't believe he's doing this. Okay, so we are going to have TurtleBoy coverage. Ladies and gentlemen, we are going to have TurtleBoy coverage. I repeat, this is going to be the most intense split screen. We may have to actually compromise how we do this split screen. Hold on, are you ready for this, ladies and gentlemen? Are you ready for this? Little towels. I have, ladies and gentlemen, I have coverage. Here we go. Hold on. Look at it, ladies and gentlemen. The glare is actually doing it. So we're going to be able to do live screen. We're going to be able to do this. We're going to be able to do this. This is going to be one of the most interesting things I've ever put together. I'm going to get the Karen cam for you right now. Hold on, little towels. Let me go get the other stream. Wow, we're going to actually be able to pull this off. We're going to get coverage of the Aidan Kearney case and the Karen Reed case simultaneously. ladies and gentlemen, these are the moments. It is about to be 9 a.m. I'm able to inform you we have full case coverage. I hope Diana Natale is still here and I haven't hurt anyone's feelings as a result of my anxiety. Please note that I have moments like that. They are literally just panic attacks. They are not comments on you personally. Towel loves you. Towel is just overwhelmed. It is simply a reflection of me, not you in any way, shape, or form, and I would feel horrible if you felt that way. So towel hugs to you, Diana Natale, and hello, Cookie Bram Lol. And ladies and gentlemen, yes, of course, hello, Crime Cricket. Please extend your special super towel hugs to the Towelette Dewdrops, who is in the hospital with food poisoning. Our thoughts are with Super Towelette Dewdrops, as always, ladies and gentlemen. So yes, we have up on the screen, you can see we're waiting for the TurtleBoy hearing to come into session, but simultaneously, little towels, I'm going to get the Karen Reed hearing. It looks like we're going to go Karen Reed until TurtleBoy comes into session. So I want you to monitor closely. Now, don't panic. If you see us switch over to TurtleBoy, the Reed hearing, I'm going to pause it exactly where we left off. The Karen Cam's going to keep running. Don't worry about that. You're going to get a live look in, ladies and gentlemen, to the Karen Cam, okay? But we have to be a little bit selective here because I figure out exactly how I'm going to do the dueling hearings. This is the first time I've never covered two trials on the same day at the same time. I'm not even really sure what we're going to do. So we're going to, on the fly here, we're going to experiment with how to do this. So the first thing I want to do, little towels, is I have the Karen Reed hearing here. You can see it. And it looks like we might be starting with this. So what I'm going to do is I'm going to turn the TurtleBoy coverage into picture-in-picture, all right? And we're going to have that right down here by the defense table near Karen. And then what we're going to do is we're going to grab this. We're going to bring our fan. Our fan is the fan. I'm sorry you have to watch the fan, but I have to do some real-time towel editing. We're going to bring the fan like that, all right? Hold on, I'm going to get John centered. Give me a second. So we want it like that. Yeah, and we can have captions on. Oh, we're going to be able to dual watch this because I can turn captions on. Oh, yes, this is going to be glorious. All right, so hold on. Let me just, all right, stop being a little towel. You're bothering me. All right. That's fine. And then how about like that? All right, there we go. Now we go up like that. Just shrink this a little bit. Go up like that. Look at this, little towels. I think we're going to be able to pull this off. Let me just drag this down here. All right, how about like that? Perfect, little towels. Perfect, perfect, perfect. Now let me get the Karen. I can't believe this is going to work. I am blown away. Thank you so much to Diana Natale and to Lisa Towel. Oh, yes, Diana Natale, you're still here. I was so worried I hurt your feelings. Please just know it was my anxiety, and I feel like I'm being chased by a bear in the woods. Now, ladies and gentlemen, I would just like to let you know, if a bear starts chasing me, please get some sticks and defend me. I don't know what I would do. I feel like there's a bear chasing Little Towel in the woods. I can't get into horse racing announcer towel mode. I can't get into David Attenborough towel mode. I literally feel like a bear is chasing Little Towel in the woods. And you might be saying, sir, there is no bear chasing you in the woods. You are okay. Well, I don't know about that, ladies and gentlemen. I feel like the bear is coming for me. I need to run very far away. Ladies and gentlemen, I don't know what to do with myself. I am a towel being chased by a bear. And you might be saying, sir, don't worry. There is no bear chasing you. Everything is okay. No, ladies and gentlemen, it is not. I am being chased by a bear. You don't understand. The towel bear, it is a bear that has a towel. It is chasing me. I am running as fast as I can in my brain, and my body is telling me that I am in the woods and a bear is chasing me. That doesn't actually have anything to do. Nope, Amber Am, I can't. I must be focused. I must be a cogent, erudite, and ready towel. And all we need to do, little towels, is get onto the Karen Cam, and it looks like we're going to be able to do dual coverage, where when the Aidan Kearney case goes live, we're going to turn the volume up, but I'm going to be able to close captions running on the Karen case and the Karen Cam running. Ladies and gentlemen, I am truly a multifaceted towel. Oh, this is glorious. Nowhere else, ladies and gentlemen, can you get someone who can do this kind of dueling coverage. I think I'm one of the few people that's able to do this. I'm not tooting my own horn. I am just a towel. Oh, goodness, I'm going to need a lot of your support to get through this today. Everyone is taking deep breaths. I think we're all excitable little towels. But you have me with you, ladies and gentlemen. The Karen Cam is about to come live. We have, oh, goodness, this is going to be a day. We are going to start with coverage of the Reed case as we wait for the Aidan Kearney case to come into session. But let me tell you right now, ladies and gentlemen, you're not going to miss your Karen Cam. We got our zoomed-in Karen Cam. There it is for you, little towels. You love it. We got our second Karen Karen cam, ladies and gentlemen, and we got our Hank cam. Oh, Lordy, we got the Hank cam, ladies and gentlemen. I am a towel. Now, we're going to move this up here. I'm going to give you the picture-in-picture of the TurtleBoy hearing. Ladies and gentlemen, as soon as the TurtleBoy hearing goes live, I just want to let you know we are going to cut into that. We're going to do a little picture-in-picture action here, little towels. I don't know where we're going to do the picture-in-picture. For now, we're just going to put the glare over the fan. Oh, the glare is the Stay Puft Marshmallow Man. Ladies and gentlemen, I put it all together. The glare's calling is to be the Stay Puft Marshmallow Man and block us from viewing the fan. Oh goodness, the Zoom's coming into session. Hold on, little towels. Hold on. No, it's not. No, it's not. False start. Stay here. Hold on. Stay here. We got the Karen Reed case. Let me turn the subtitles on the Reed trial. I got to turn the subtitles on. Subtitles are thus on. Let me jump us forward to live. We don't have the Karen cam yet. Now let's go over to the TurtleBoy hearing, little towels. Let's go over to the TurtleBoy hearing. It's not in session yet. We're waiting for it to start. The first case up is not TurtleBoy, ladies and gentlemen, so we're just waiting for it to begin. Little towels, I'm monitoring, and you know what? I can also call in here, little towels, and I can monitor it simultaneously. I can't broadcast it, but as soon as the Karen case goes live, we are then going to turn over. You can see the Karen cam's ready. My name is Grant Smith Ellis. I have never been more prepared to do something in my entire life than I am to cover these dueling hearings, ladies and gentlemen. I have everything set up. I have closed captions set up on the Karen cam. I have the TurtleBoy hearing. As soon as the TurtleBoy hearing goes live, we're going to go away from the Karen audio, or we're going to switch the Karen audio down. You're going to get subtitles and live action, and then you're going to get the audio from the Aidan case. Ladies and gentlemen, I think we're ready to do this. We all put our collective towel heads together, and we pulled it off. We did it, ladies and gentlemen. Alana, the super towels from around the world, Mandy Strong, Brooke, Ange Wittick, Peony, and Rose, you're here for these historic moments. The cases are about ready to come into session. I may as well have settled down to the point where I can get into horse racing announcer towel mode. It's only a question of what's going to come into session first. And as I mentioned, ladies and gentlemen, as soon as the coverage of the Aidan Kearney case begins, we will switch over from the Reed case. Do not get concerned when that happens. I promise you, you will still see subtitles for the Reed case, little towels, during the entirety of the day. This is going to be special towel picture-in-picture action. Nowhere else can you see these kind of images, ladies and gentlemen. Nowhere else can you chat with the towel friends. Nowhere else are people this prepared on the fly because of all the wonderful towel friends, even through towel panic attacks, to be ready for these dueling coverages. Oh, ladies and gentlemen, I can't believe we're going to pull this off. We did it. We did it. We had no idea how it was going to play out, but the super towel spouse, Mandy Strong, is here. I'm going to press a pressure point between my thumb and my first finger. I think, ladies and gentlemen, though, a little bit of anxiety as we head into these historic moments is definitely warranted. We've never seen Aidan Kearney and Karen Reed on trial at the same time. I've never covered two trials happening at the same time, 50 yards away from each other. Oh, little towels, we're here. This is it. We're about to come into session. Both streams are live. We are here. As I told you, do not get concerned. When we go over to the Kearney case, you're still going to see captions for the Reed case. That's going to be very prominent up on your screen. Then, ladies and gentlemen, when there are pauses in the Kearney case, or if the Kearney case happens to not be in session, or whatever it may be, little towels, what we will then do is just continue watching the Reed case. Yes, oh my goodness, this is one of those moments. This is one of those moments. Now let's see if the Kearney case is up. Hold on. Nope, it's not up. I don't see, at least we're not hearing any audio.
Stephanie Slaughters.
Nope, nothing yet. Nothing yet. Monitoring, folks. Monitoring, folks. Neither court is in session. I have one eye on the world going by my window. Oh, ladies and gentlemen, it might be starting. Oh, nope. It was a false start. It was a false start again. Oh, little towels. The world is watching. What is going to happen? I hope you're seated. I hope you have your coffee. I hope you have your tea. I hope you have your whatever you need to get through this day, because we're not in session yet, but we're fully set up. My anxiety is going down because we are fully set up, ladies and gentlemen. The Karen cam's ready. The The Aidan coverage is ready. I'm not broadcasting it directly. I'm covering the Glares coverage. And, ladies and gentlemen, we are about ready to come into session. I can't believe this is all happening at once. You are on the right feed. I'll tell you what, ladies and gentlemen, if you're waiting, it is just past 9 a.m. We are about to watch Aidan Kearney and Karen Reed on trial at the same time. It is going to be a very back and forth day, ladies and gentlemen, with Little Towel as your announcer, but I'll be here with you to take you through every single moment of the developments. What we're waiting for in particular, the Reed case is about to come into session. We're going to focus on that. But as soon as the hearing in the Kearney case, maybe an oral argument, whatever it may be, starts up, we're going to go right over to that. I'm also going to be monitoring on my own to give you reported developments from the courtroom as I hear them, Little Towels. So we're still waiting for everything to boot up. We have, the Karen cam is about to go live, Little Towels. We're going to start with coverage of the Karen Reed and John O'Keefe case. I'll break in as soon as we're ready to go over to the Aidan Kearney case. Everybody ready your towels. Try not to lose your ever-loving towel minds. I am a towel. Wait a minute. Come on now. Come on. It hasn't turned on yet, Little Towels. Give us a second. There it is. We just got teased, ladies and gentlemen. We're about to start, though. Are you ready? Are you ready? I stuttered a little bit there because my excitability levels are off the charts, ladies and gentlemen. It's almost time for towel lunch, too. I get to eat my lunch around 11:30. Oh, we're going to have so many breaks today. We're going to have so many competing things. You are at the place to be, Little Towels. You don't want to be anywhere else. I don't want to be anywhere else. Hank Brennan doesn't want to be anywhere else. We are going to do this, ladies and gentlemen. We're going to do it as Little Towels. We're going to do it for justice. We're going to do it for Lindsay. We're going to do it for John. Ladies and gentlemen, I've never been more ready for something to start in my entire life. We obviously saw a little false start there with the John O'Keefe and Karen Reed retrial, but as soon as that, it looks like that is what's going to start first. So I'm going to take the glare. He's actually going to go, oh no, I grabbed the wrong one. No. I'm going to grab the glare. All right, come on, the glare. You go for a little jaunt here. Go, look at him hopping along like a little glare. Hoppy, hoppy, hop. Look at him hopping along, little glare bunny. We're going to put him over there. We're going to shrink him down. There you go. Hoppity hop. Hop, hop, hop. And as soon as Aidan's case comes into session, we will make Glare hoppity hop 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 right back to the main screen. But for now, we're ready to go. I don't know. I've had a lot of cheeseburgers. I might want to get a special chicken lunch. Oh, by the way, so if you want to support Towel Stream today, yes, Towel is managing a lot. Towel is waiting for the end of the month when so many of your gifts come in, which are wonderful. But Towel needs some help, definitely to get through the day. We're going to do some Towel lunches. Ladies and gentlemen, we're going to, Towel's going to get a very nice grilled chicken sandwich, I hope. So if you like this stream, we're a couple hours in. If you want to support this public information service, remember, it's completely independent. It is viewer supported. There's no ads here. YouTube runs their own ads, which we love. We support YouTube. But there's no ads here. There's no sponsors. It is user supported. You can like, it costs nothing to like this stream, to subscribe. You might have had a towel membership gifted to you. Did you check your towel emojis? You might be able to make it rain such towel emojis. Free Chloe. Also, ladies and gentlemen, you can send donations if you want to support Little Towel. I saw the donation that came in yesterday for Little Towel's Red Bull Fund. Oh, I hear ice cracking. You have joined the Super Towel fold. We are so lucky to have you, my dear friend. I'm so grateful that you have joined us. So are your new Super Towel emojis. Did you know that we have emojis such as towel emojis? We have the Red Stay Puft Marshmallow Man emojis. We have the Superman, the Super Batman emoji for Murder by Maestro. And then we also have a bunch of free Chloe dog emojis. We have a Leslie with a zipper mouth emoji. We have a Justice for John emoji. And we're coming into session emoji. They're off. Oh. Was now open, you may be seated.
Hi, good morning. So I just saw a transcript that was placed here on maybe reference this morning, and there's a motion to limit Dr. Rentschler that I just got that I'm not prepared for. So that we'll do later today, okay? All right. So the Commonwealth's motion to call witnesses in rebuttal. I've read everything. Ms. Little, I appreciate you getting your opposition to me. I think I had it by Saturday morning, so I appreciate it. I read all the cases on it. Does the defense want to be heard any further on this? Okay.
With regard to Dr. Crosby and Ms. Coon, as the
Speak into a microphone. Speak into a microphone.
With regard to Dr. Crosby and Ms. Coon, the Commonwealth has been on notice that the defendant intends to present a defense regarding the arm injuries, that this was caused by a dog bite. They have been on notice of that, not just for months, but for years. That was presented at the first trial. The Commonwealth does not have a right to rebut information that they have been on notice of from the start of the case. So their decision to wait for rebuttal to call these two witnesses is improper, and we're asking the court to exclude their testimony. As it relates to Dr. Welcher, the scope of his testimony, our request is that that be limited to very specific information, specifically responding to the new testing that ARCA has done. As the court knows, the Commonwealth has proposed a number of new testing ideas, as well as information that is greatly outside the scope of what ARCA intends to testify to. And so we're asking that the court limit their testimony from engaging in new testing that has nothing to do with what ARCA has testified about at this trial. With regard to Dr. Welcher's testimony, the court has made very, very strong rulings that Dr. Wolf, as well as Dr. Rentschler, are not allowed to speak to the credibility of Dr. Welcher himself. And so some of the information that the Commonwealth proposes is to directly attack the testimony of Dr. Wolf and Dr. Rentschler. And under the court's rulings, we're asking that the court limit that scope as well.
And I told you I would.
Thank you.
All right.
That's all, Your Honor.
Thank you. Mr. Brennan, do you want to be heard?
Regarding DNA evidence, evidence cannot be rebutted until it is introduced, because the defense has a number of potential ideas of areas of testimony. Does not compel the Commonwealth to try to anticipate or deflect attacks, especially if they're meritless. And so the issue of dogs and dog DNA does not become relevant until the defense calls a so-called dog expert. They raise the issue, it's proper grounds for rebuttal. There are three witnesses, Ms. Hartnett, UC Davis, and Dr. Crosby. If Dr. Lapisada is precluded from testifying about dog bites, we would not call Dr. Crosby as a witness. However, regardless of what Dr. Lapisada says, we would ask to call Ms. Hartnett and to call the witness from UC Davis. It is an issue that directly affects the assessment of Dr. Russell, the very expert they chose to call in their case in chief, and so we can now, from my perspective, properly rebut it. The second issue regarding Dr. Welcher, limited to the new information. You will see from the testimony, or have heard, most of the testimony is new, but we understand it's limited. We don't expect Dr. Welcher to have a direct comment on the credibility of any witnesses, but he will address the tests, how he believes would be the proper procedure, and there'll be a number of issues that have been raised on direct examination, but he will not in any way have a comment on the credibility of the defense experts.
All right. So the case law supports me allowing this motion. I'm allowing the Commonwealth's motion. So the motion for rebuttal witnesses is allowed. Mr. Brennan has said he will not call Dr. Crosby, depending on the testimony that comes in. So, all right, Jim, I'm just going to give you this.
Thank you.
All right, so the motion regarding the testimony of Dr. Lapisada. So the Commonwealth is moving specifically to exclude, there's a motion to exclude irrelevant photographs. We'll deal with that after the main motion to exclude certain testimony. So if we start on page 7 of the report, that's where you want me to start, Mr. Brennan?
Your Honor.
Okay, page 7 of your report. I have some questions. So, Mr. Jackson, Dr. Lapisada cannot opine about the investigation of the case, the law enforcement investigation. She does that throughout her report. So she can't opine to that. But when we get to page 7, what do you say is out, Mr. Brennan? I mean, I've gone through it. I know what I think, but it's the Commonwealth's motion.
I think that her opinion about no object being present to cause a pattern injury is appropriate.
And where are you on page 7, the first paragraph?
Yes, photographs and descriptions of the site. It is the...
Right, I might have a different page 7. So my page 7, okay.
Top paragraph.
Okay, yep.
Dr. Lapisada proposed opinion that photographs and description of the site where Mr. O'Keefe's body was found show no object capable of producing a pattern injury, I think is appropriate. His body was found on flat, grassy ground, probably frozen and covered with a minimal amount of snow. I agree is appropriate. It is the next paragraph where it begins in the middle of the sentence. It is logical to conclude that Mr. O'Keefe was injured elsewhere and his body was moved to the front line. There is no basis in fact for that. It's an improper opinion.
Yeah. So I told you that on Friday, Mr. Jackson.
We're not seeking that.
Great. Okay, so that's out. And Mr. Jackson, again, the medical examiner erred in her diagnosis of hypothermia. Again, that's the improper critiquing of the expert. She can say,
pause,
wasn't
folks. The Aidan Kearney case is being caused. I cannot play it, but I'm going to report on it for you live. Okay, I cannot actually say what's being said, but I'm going to report on it live. Okay, we're pausing. Aidan is asking for a judge trial. Aidan TurtleBoy Kearney is moving for a judge trial. Has waived his right to a jury trial. His open case for violating an RO. I am reporting live now. Okay, so the waiver is being read. The waiver is being read in the Aidan Kearney case. He is waiving his right to a jury trial, ladies and gentlemen. He is doing a judge trial. Okay, the matter has been held over to trial. Aidan Kearney has signed a document waiving his right to a jury trial. That is the first update on today's Aidan Kearney case. Okay, we're going back to the Reed case.
Hypothermia, obviously. Okay, so same with the first sentence of the next paragraph, the Wisniewski spots were misidentified. Great, all right, so we can probably do this much quicker then. All right. All right, so page 8 is fine. So now we go to page 10. So this is the dog bites. So if you want to pick it up at, what does the Commonwealth say about this?
At this point, there's no basis provided that she has the training expertise, methodology to provide an opinion regarding a dog bite.
What's the offer of proof on this, Mr. Jackson?
It will be more extensive when I establish the foundation testimony. Basically, she's not only done autopsies involving dog bites, the wound pattern recognition related to the source of those dog bites. She's also taught classes on wound pattern recognition, source of coming up with diagnoses concerning the source of specific pattern of wounds. She has a methodology that she uses. Medical school classes, if I didn't mention the courses.
What does she teach? Is this in her CV? Because I didn't see it.
It will be in her foundation that I will lay in front of the jury.
All right.
I don't see any opinions unless and until the foundation is properly laid, but she has extensive experience, not only with specifically with autopsies that she's conducted herself, but supervising autopsies of others that deal with pattern recognition, the methodology involved with pattern recognition.
How about dog bites?
Dog bites specifically, 5 autopsies. I believe she will indicate that she's done 5 autopsies as they relate to dog bites.
Okay.
A medical school class specifically on the issue of wound pattern recognition, which that class includes dog bite recognition.
All right, so we'll need a short voir dire of her on this before she testifies.
Because the court doesn't believe that I can lay the foundation in front of the jury and forego a voir dire. I won't ask any ultimate question until we go to sidebar, but I think we can short circuit that.
She's very specific about the dog bites here. So if she's seen 5 autopsies with dog bites, I'm not inclined to give it to you. Okay? Seen only 5 in her 40 years or whatever.
It's not that she's only seen 5. She's performed 5 autopsies.
Okay, so that's why we need a voir dire. So we need a very short voir dire.
She's also been qualified on the issue of dog bite wound pattern recognition in federal court as well.
Okay.
So she has a plethora of foundations.
Has that been provided to the Commonwealth in advance of today?
None of it has. So here's the difficulty, whether it's a voir dire or it's in front of a jury, I have absolutely no ability to research and cross-examine her on dog bites. She can say she had 1 case or 50 cases, that she testified in state or federal court, or she took a class. I can't verify it, I can't contradict it. I have no ability to prepare for this witness about her basis, methodology, and experience in dog bites. What I have is her showing a couple pictures that she pulled from a book, and then she has some Google or Shutterstock research in her report. And so the idea that she has a history or basis is going to be uncontested, because there's nothing I can do to contest it, and that's not appropriate. I should be able to research, get transcripts, vet, and be able to approach the witness on whether or not she actually has the reliability and education and experience. I can't do that if we call her an access in front of the jury or a voir dire.
If we want to compare apples to apples, Dr. Wolf, Aidan Wolf, was allowed to specifically testify to the wound pattern, his interpretation of wound pattern recognition back then. That was nowhere in his report. That was objected to by the defense. Mr. Alessi, wins a sidebar, strenuously objected, said this is nowhere in the reports, we didn't have any notice of this, and the court said, overruled, he's allowed to testify to the pattern of recognition, at least in his mind, he can cross-examine him on. There is no requirement that the Commonwealth have every single case that Dr. Lapisada has ever dealt with, dealing with.
No, we had an expert on dog bites who I allowed to testify as to dog bites based on, we had a whole, as you know, it was Mr. Leslie, I think 3 days with Dr. Russell on the voir dire. This is new to me. I'm going to have a short voir dire on to what she can testify to.
I have no problem with voir dire. I just wanted to short circuit it.
So, all right. So let's go on to page 17.
Commonwealth has an objection to the 3rd line. Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting his arm. She is not qualified as a reconstructionist or biomechanical engineer. She has tried in other courts and been rejected. She does not have the experience, the background, or the ability to do that properly.
What do you say, Mr. Jackson?
Your Honor, I believe she does, as a medical examiner, have the experience, and it's the qualification, it's the specific job of, and the qualification of a medical examiner to opine on pattern injuries. If the foundation is laid, especially as it relates to motor vehicle accidents, and now we're not talking about dog bites, which are a more defined subset of her overall experience. Now we're talking about motor vehicle incidents and accidents that she has specifically seen thousands of.
Okay.
Multiple thousands.
So
if she does have the qualification to say, if the proper foundation is laid, that the wound pattern that I see on Mr. O'Keefe's arm is inconsistent with anything that I've seen in terms of a motor vehicle accident.
Let's just find out how many motor vehicle accident autopsies she's done during that voir dire. What I have a question about is taillights are typically made of durable polycarbonate or acrylic plastic. I would keep that out. I'd be inclined to allow in the injuries on his right arm do not correspond to injuries that could have been produced by plastic pieces impacting his arm. But let's hear about that.
I wouldn't ask for polycarbonate. I have no intention of asking about that.
And also the last sentence, I think it's okay, and we'll see with voir dire. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes, assuming she has experience with autopsies of motor vehicle accidents. But I would keep out the part as would be expected from pieces of shattered taillight. Was there more on that?
I object to that because this is now yet another witness that is coming in under the guise of some type of specialty, but really for accident reconstruction.
All right, so let's see what she says on voir dire regarding her experience with accident victims. I think she gets more into the accident reconstruction on the next page that I don't think is proper.
Which I am not seeking to choose.
All right, so that whole first paragraph on the next page, you're not seeking to introduce? Yeah.
At least the first, we're starting with the first sentence. Yes, we would be seeking to introduce that. Pedestrian injuries produced by contact with motor vehicle include a component tissue crushing force as the car profile protrusions connect. That's basic. I believe that she does have the qualifications to opine about that. That's pretty standard, and that should be admitted.
She has absolutely no experience in accident reconstruction or the injuries. She is not a biomedical engineer. They have one, and he's going to testify to it.
Yeah, I have that as out, Mr. Jackson.
The reason that I believe that it's appropriate is because you don't have to be a biomechanical engineer to understand when you see, for instance, a known pedestrian accident, what are the results, especially if you've seen hundreds or maybe even thousands, what are the results that you typically see in the wound patterns? For instance, crushing forces, broken bones, fractured bones, crushed soft tissue, things of that nature, internal bleeding. That's the province of medical exam.
Okay.
That's exactly what they are trained to identify and to opine on.
Okay, so
I wouldn't get into things like, for instance, what she doesn't have the experience to do is say, when a car is involved in a rollover collision, these are the mechanical forces that are exerted on the body during a rollover, and the G forces that are subject, that the body is subject to in a rollover, things of that nature. When a car is impacted head-on by another car, there are a number of G forces that are put upon the body, etc. Those are biomechanical issues, have nothing to do with her expertise, and I wouldn't be seeking anything like that. But once the body is removed from the car, and then it's on the autopsy table, that's where her expertise begins to fly.
Okay.
She can talk about, and I believe she has the experience and the qualifications to talk about, what the body suffers at the hands of a vehicle pedestrian incident or accident.
okay, so the first two sentences are out. The third sentence, she can testify that Mr. O'Keefe had no bruising on his arms or torso. And she can testify, and she cannot say that would have resulted from the impact with the SUV rear profile. She can say Mr. O'Keefe did not have bruises on his legs. She cannot say from bumper contact, but she can say as shown by dissection of leg tissue and muscle at autopsy. And she can't testify to anything else in that paragraph.
Your Honor, is the court ruling that she cannot say anything about the human body contacting a motor vehicle? That sounds like what the court's saying.
No.
I think that's too narrow a ruling.
It is. You can put this in, what I said you could put in, can come in, and the rest cannot. We could.
And just for point of clarification, if I ask her, would you expect, I'm just going to make it a hypothetical, would you expect if his legs were contacted by moving you expect to see bruise or contusion.
What do you say about that?
I object. One, it's leading. Secondly,
Well, I'm not asking the question.
Secondly, this is asking to have Dr. Lapisada do accident reconstruction. She's not assessing the wound. I'd ask you to consider the case of Commonwealth vs. Tompkins, appeals court. I think we provided at 105 Mass App 1124, 2025 case. And a similar attempt was made to try to use Dr. Lapisada as a biomechanical accident reconstructionist. The trial judge did not credit her proffer and found that she failed to meet the requisite criteria pursuant to Daubert Lanigan. And so recently it's been found by at least another court that she's not competent to do this. Because she's a medical examiner, does not allow her to come in and start endorsing or vouching for the ARPA witnesses. They already have witnesses to do that. And so not only on page 18, going back to page 17, about the pattern injuries or corresponding injuries to a light, she would only know that if she had the training experience.
I'm sorry, where?
You said on page 17 you would allow Mr. O'Keefe's pattern injuries on his right arm do not correspond to injuries that could have been produced by regular fractured plastic pieces impacting his arm. That's not her role as a medical examiner. That is the role of a reconstruction or biomechanical engineer. And she clearly is not competent, at least as cited by the appeals court, to have that type of opinion. So there's one thing to assess wounds, there's another to try to correlate or draw a distinction between the wounds in a car collision. It is essentially giving an opinion to the jury, he didn't get hit by a car. That is the core fundamental theory of the defense. This is simply trying to bootstrap another witness to give that opinion. That's improper.
All right. Sure.
Mr. Brennan's going to cite the Tompkins case. He needs to cite the Tompkins case. That dealt with a situation in which the witness was called and she was asked by the lawyers, specifically in that case, the people that called her, the lawyers that called her, to opine about blood-stain pattern recognition, blood spatter evidence on the driver's seat versus the passenger seat, and what her opinion was about who actually was driving the vehicle. It was a rollover collision in which people were ejected from the car. She was then asked to opine about blood-stain patterns in the driver's seat and whether that was more or less consistent with the blood, the originator of the blood, one particular individual, was he more likely in the driver's seat or the passenger seat at the time of the bleeding, and was it before or after the rollover? Very, very different set of facts. And of course, that is a biomechanical engineer's province. And the court was correct in saying, I'm not going to credit her testimony on that issue, but that's what she was asked. She opined on it, and the court said, I'm not going to credit her testimony.
All right, so
this type of analysis and wound pattern recognition, which is what she's being asked to do.
So let's see with her voir dire this morning.
Okay.
She actually was allowed to testify about blood spatter. It is the reconstruction testimony that she was not allowed to testify about.
I read the Superior Court judge's decision. I have not read the appeals court rescript, so I need to do that. I'd like to get going, but there are photographs of inside the garage. You intend to put this in through Dr. Lapisada?
No, not through.
Through whom?
If I could yeah. With regard to these photos, well, ultimately, the Lapisada will be shown them, correct? That they'll be introduced through our investigator who took the photos. We intend to call that investigator after Dr. Wolf testifies.
And what will that investigator say? These are photographs.
So he will testify to two subject areas. One would be he took measurements from the street to the various entrances to 34 Fairview. I just have to testify about what those measurements were. And then where he took several photographs, we have pared them down to, I think, 3 or 4, just of one establishing shot showing the garage from the street, and then a couple of photos showing the side entrance to the garage, the pedestrian entrance to the garage, which also shows the interior of the garage, including a step and a...
For what purpose? How are they relevant?
I'm sorry?
How are they relevant?
So the defense is presenting a loading defense in this case. We are alleging that the police did not do a thorough investigation. They did not really investigate anyone other than Karen Reed. The Commonwealth's own evidence including the testimony of Ian Whitman, is consistent with John O'Keefe after what they claim to be the trigger event in Dr. Welch's initial report. John O'Keefe walking in a westerly direction, which would be from Fairview Road to 7.4 meters, which is approximately 84 feet. That is consistent with him entering the house. It's consistent with him entering the garage. The police did not take photos of the garage. They didn't investigate, is there a hard surface in the garage? Is there a ridge-like surface in the garage? And these photos are introduced on that road mission to say that there was evidence in the house. If the police only went in there, they would have seen that. And that may have sent them in a different direction. So it's relevant for that purpose.
Do you want to weigh in on this?
These are not only relevant and not material, it's misleading. They are not seeking to have measurements from the flagpole to the door. They're trying to seek measurements from the driveway to the door. There is no evidence whatsoever John O'Keefe was ever on, near, or anywhere by the driveway. The evidence is that he was at the flagpole. While the data showed there was a turn westward, it didn't show movement westward. It did not. If there was a measurement from the flagpole to the garage door, that is something that I think would be appropriate. From the driveway, totally irrelevant. There's no evidence, no witness, no substantive evidence in this case that John O'Keefe went in the house, went near the house, was dropped off. They're relying simply on the fact that there were 37 steps. They have no idea what direction or where. What they want to do to argue this is to show inside the garage and then posit the theory that somehow John O'Keefe was killed in the garage, it was colder than it was in the regular house. That would account for the temperature on the battery. They have no evidence to support that. You can't use Bowden as a panacea. You can't just say Bowden, they should have done what we want them to do. It is what is reasonable. The police went into the house. They spoke to the occupants of the house. There was no evidence that Mr. O'Keefe went into the garage. You might as well take a photograph of anybody else's garage in America and put it up in front of the jury. So this is going to create a mistaken, baseless argument that this evidence somehow shows that Mr. O'Keefe was A, in the garage, and B, he was injured in the garage. That's why they want to show it to Dr. Lapisada. Couldn't some of these angles have caused the injury? Total speculation, no relevance at all, and it is just prone for an opportunity to mislead this jury. This should not come in.
If I may respond in 4 ways. First of all, Mr. Brennan just informed this court that there was no evidence of movement of the phone. I'd like to quote his own witness. At 12:25:30, the device's bearing shifts to a westerly direction, as location records also show the device moving west from the roadside toward the house. So that was false. Secondly, with regard to, we should be measuring from the flagpole, our theory is not that he entered the house from the area of the flagpole. Our theory is that he was placed at that flagpole, and as Mr. Brennan correctly points out, there's no evidence that they introduced as to where he was on the road prior to walking into the house in that westerly direction. Our theory is as good as his. He cannot prove anything to contradict our theory. The third thing is that Brian Nagel and Heather Maxson saw Karen Reed in her vehicle alone. The passenger seat was illuminated and empty. John O'Keefe was nowhere in the area of that vehicle. He was not in that vehicle. There's only one other place that he could be, and that is in the house. So finally, the fourth point, Your Honor, this court has continually always done, as the court should, a 403 analysis. The probative value we have established through their own witnesses. They called all these witnesses, and they established the foundation for the admission of these photos. There is no unfair prejudice. I would argue that any time there's exculpatory evidence or a case that advances the defense theory, that's by definition going to prejudice the Commonwealth's case. This is not unfair prejudice. He is allowed, Mr. Brennan is allowed to cross-examine this witness and to make whatever arguments he wants to make about the likelihood of the garage being involved or not. But he does not and should not get the benefit of the fact that his investigation, the police investigation, didn't do what we just did. And this evidence should be admitted.
the argument is purely rhetorical. There's not one fact he offers. The witnesses that saw the car saw it in front of them. Nobody ever got out. A light on doesn't mean that he wasn't near the car. It means they didn't see him in the front seat. So there is no evidence that Mr. O'Keefe went anywhere near the house, on the breezeway, in the door. It is speculative. It is baseless. They want to take that baseless argument and then bootstrap it to Dr. Lapisada to further speculate that something in the garage that could have caused the injury. That is not Bowden. That is not a due process right. That's not 403. It's empty. It's no factual predicate whatsoever.
Okay. So
The only other thing, just to put a cap on this, the location data circles, again, Mr. Brennan's own evidence, he introduced it, puts John O'Keefe in the house.
all right, so I'm going to allow you to do the measurements. These photos will mark for identification. The photos are not admissible. So, all right, Chrissy, can you just mark those, please? All right, let's bring the jury over. We will do, Mr. Jackson, how long will you be with Dr. Wolf?
Probably 20 minutes.
All right, and depending
Yes.
on that. All right, so during the morning recess, we'll do the voir dire of Dr. Lapisada. All right, let's bring one over, please.
All right. Hello. Hold on. Hold on.
Wait while others join.
Okay. Okay, so hold on.
Your call begins.
Folks, we have a lot. Oh, I don't need that. We have a lot going on, folks. I am covering the Aidan Kearney case. I think I was the only person who was able to be on the Zoom and actually was live for it. That was a little embarrassing because it was one of the weirdest Zooms I've ever been on. They just let me into the courtroom. I don't know why they did that. So I was able to just apparently talk. They muted me. Thankfully, I had to mute myself, but they turned the speaker down. I was just talking. Now, I was following the rules, which was great. I'm sure they, in some sense, were thrilled that Little Towel was following the rules. We are not, unless we get a pool camera person in there, okay, or unless another feed broadcasts it, we cannot broadcast the raw feed. But I was in there. Hello, it's me. I'm a Little Towel. I was listening, ladies and gentlemen. We are waiting for the Karen Reed trial to come back into session. I was listening, and I heard Aidan waive his right to a trial by jury, and he's doing a bench trial. I was in the courtroom. I was listening to it, and I was following the rules. I listened to everything that happened. I listened to the waiver, and then I reported it to you. Now, unbeknownst to me, it wasn't a regular webinar. I was just in the courtroom Zoom, so I was just talking. But, I didn't do anything wrong other than forgetting to mute. But I wouldn't have known that because all of the Zooms we normally do as media, we're muted. We're not like participants, we're just observers. This was a direct line into the court, and thankfully they turned the speaker off, but I did what I was supposed to do. I listened, and then I reported to you what I heard. So that is what they're giving us permission to do as of now. Now, that can change. If another feed, ladies and gentlemen, covers that case, then yes, we can broadcast that. The only thing I'm not allowed to do is give you the direct feed. So I'm not doing that. I have no intention of doing it, but I am allowed to listen to the feed and tell you what's happening. We could get very surreal moments, ladies and gentlemen, during today's stream where I am describing to you what I'm hearing occurring in the Aidan Kearney case. Now, hopefully, there's going to be a pool camera person that goes over there. But if there's not, you are going to have Towel as literally, this is something I couldn't even do if I was in court. You don't understand. This is incredible. I'm going to be able to describe to you everything I'm hearing in real time. So I'm going to be on the Zoom on my phone listening. And then in real time, I'm going to be like a radio announcer relaying it to you. So I'm going to be saying, okay, this is what the witness is saying verbatim. This is what the question was verbatim. That could be one of the coolest things we've ever done. Now, ladies and gentlemen, I hope we have live coverage. I hope someone sends over a pool camera to Dedham District Court for the coverage of Aidan Kearney's bench trial that is going to be taking place today. But we can't confirm that. All I can do, ladies and gentlemen, is tell you that right now, I know it's going to be fascinating. This is going to be a lot of heavy lifting. I want to thank everyone who's been supporting Towel. I'm going to get my Towel lunch soon. This could be one of the wildest days you have ever seen in the history of the TurtleBoy Aidan Kearney cases and the Karen Reed and John O'Keefe case, we are going to see incredible split screen moments together, ladies and gentlemen. The jury's just being brought over now. Judge Cannoni announced. As soon as we're back into session, I'll let you know. I'm not making you watch The Fan. But just incredible moments, ladies and gentlemen. And I obviously will, I now have a direct line into the courtroom. Hold on. No, and I can tell you, folks, the second that we are ready to go. Now, hold on. I'm talking about on my phone. This might be the Karen Reed microphone being live. Let me just show you that we're still on The Fan. Everybody relax. We're still on The Fan. We are live. There is nothing going on just yet. Okay, here we go. They're off.
Justice of the Norfolk Superior Court and for the County of Norfolk. You are near, hear your tenant, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. You may be seated.
Jurors. So we appreciate your patience. We were in here trying to streamline things, so we got a lot of work done this morning, so thank you. I do have to ask you those same 3 questions. Were you all able to follow my instructions and refrain from discussing this case with anyone since we left here on Friday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case? Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here on Friday? Everyone said no or shook their heads. Right. Can we have Dr. Wolf, please?
I'll remind you, you're still under oath.
All right, good morning.
Good morning.
All right, Mr. Jackson, whenever you're ready.
Thank you, Your Honor. Dr. Wolf, thank you for joining us again this morning. I'd like to draw your attention to a picture.
Yes.
I'm going to show you. Do you remember seeing that photograph?
Yes.
You were shown this photograph last week, is that right?
Correct.
By Mr. Brennan, correct?
Correct.
Do you recognize the photo as the same photo that you were shown last week?
Yes.
Under questioning by Mr. Brennan?
Yes.
And what does that appear to be a photo of, just generally?
It appears to be a photo from the test dummy from the 29 mile per hour impact test.
Does that appear to be a true and accurate photograph of the condition of the dummy following that 29 mile an hour crash test?
Yes.
With the court's permission, I'd like to enter this as next in order, please. If you could hand that to the court order.
Exhibit 218.
Permission to present that, Your Honor?
Yes.
Is this the photograph?
Yes.
Dr. Worth, first of all, what caused the damage? Well, let's start with the most basic. Which arm is this, left or right?
This is the left arm.
What position was, you called this dummy Rescue Randy, is that right?
Correct,
What
yes.
position generally was Rescue Randy in upon impact during this test?
He was oriented such that the right side of his body and his right arm would be contacted by the vehicle.
What caused the defects in the damage to the sweatshirt as we see it here?
That was due to the interaction from the Rescue Randy sliding on the pavement surface to his position of final rest.
Is that sometimes called road rash?
Yes.
Did you see any road rash in any other place on Rescue Randy in this photograph?
Doesn't appear so in this photograph, no.
Can we highlight the face? What about there?
Sorry, I thought you were talking specific to the clothing. Yes, as I mentioned on Friday, there were signs of road rash to the body of the dummy itself, on the face and on the torso and arms.
Can we zoom in on the sleeve a little bit? Do you see any staining on the sleeve as well as the defects, the holes and the tears?
Yes.
What is that staining from?
Again, just from that sliding contact with the pavement, so it's just likely debris and kind of a film from the pavement surface being deposited onto the material.
With regard to John O'Keefe's sweatshirt that you reviewed photographs of, did you see any other defects other than the right arm and the fact that it was cut off of him medically?
No.
Any other indication or any indication whatsoever of anything that you see consistent with road rash?
No.
Okay, let's go back to the full frame. The second image I'd like you to take a look at. If we can have the lights for just a second. Do you recognize what's depicted in that photograph?
Yes.
How do you recognize it?
It is the backside of the test dummy from the 29 mile per hour full-on impact test.
Which arm is next in order, Your Honor, with the court's permission?
Bit of 219.
Permission to display?
Yes.
Does that appear to be the right arm of Rescue Randy as he's face down?
Yes.
Is that following the impact?
Yes.
Do you see any? Were you shown this photograph by Mr. Brennan on cross-examination?
No, I was not.
Can we highlight the right sleeve just a little bit, please? Do you see that defect in the sleeve?
Yes.
Do you also see some artifacts above that defect, above and to the left?
Yes.
Can you tell what those are?
They appear to be fragments from the back window of the test vehicle when it shattered.
Does there appear to be any additional, let's go back to the full frame. Does there appear to be any additional defects on that particular sleeve?
There appears to be some material transfer, likely from the pavement, and also some road rash.
Does that appear to be transfer from the pavement?
I think that might be a shard of glass from the back window.
What was the condition of the back window after this test?
It was completely shattered.
The defect that we're looking at, that large gash, was that from road rash sliding on the pavement?
Yes.
We can go back to the full frame, please. I'd like to show you an additional photograph. Do you recognize what's depicted in that photograph?
Yes.
What is it?
It is the front side of the test dummy from the 29 mile per hour full-on impact test.
Does that appear to be a true and accurate depiction of the condition of Rescue Randy in that sweatshirt after that 29 mile an hour impact?
Yes.
Move for the admission of that photograph, Your Honor, is next in order.
Okay. Exhibit 220.
Permission to display?
Yes.
Can you describe what we're looking at in this photograph?
This is mainly showing the upper body of the test dummy from the 29-mile-an-hour impact test, showing the road rash to the front side of the body.
Were you shown this photograph on cross-examination?
No.
What caused the holes in the bodice of the shirt? In other words, the part that covers the chest and the torso?
After the impact, the dummy was projected and sliding on the pavement surface. So again, this is consistent with the front side of the body sliding, making sliding contact with the pavement, creating those abrasions and holes. And again, that asphalt material transfer that you see on the front.
Can you go back to the full frame, please? Do you see additional road rash? Take a look at his right arm. You see additional road rash on Rescue Randy?
Yes.
On both the fabric and the arm itself?
Correct.
Go back to full frame. And can you see his face as well in this photograph?
Yes.
Are those the chin and nose defects that you saw?
Yes.
Are the defects in the shirt that you see here consistent with the condition of the shirt of John O'Keefe as you saw it in the photographs?
It is inconsistent.
May I approach, Your Honor?
Yes.
Another photo that I'd like to show you. Do you recognize what's depicted in that photograph?
Yes.
What is that? We can take this down.
It is the rest position of the test dummy after the 29-mile-per-hour impact test.
Were you shown this on Friday?
No.
Is that a true and accurate depiction of the condition of Rescue Randy just from a different angle after that 29-mile-an-hour impact?
Yes.
Move for the admission of that photograph.
Okay. Exhibit 221.
Permission to display that photograph, Your Honor?
Yes.
Is this an overview of the entire body of Rescue Randy after that impact?
Yes.
Take a look at his torso, the exposed portion of his torso. Do you see road rash on his exposed torso?
Yes.
Do you also see that the road rash that you earlier described on the bodice of the shirt, the front of the shirt?
Yes.
And what about, let's go back to the full frame. Is there also road rash on his jeans?
Yes.
We could go back to full frame. Have you ever heard a phrase, knocked out of your shoes?
Yes.
Where are the dummy's shoes?
They're still on his feet.
And this is at an impact of 29 miles per hour, correct?
What's the form of the question?
Sure. What was tell us one more time, what was the speed of this impact?
This was a full-on 29-mile-per-hour impact.
We can take that down. May I approach?
Yes.
Take a look at that photograph and tell me if you recognize what's depicted in it.
Yes.
What is that?
It is the back of the test Lexus after the 29-mile-per-hour impact test.
Is that a true and accurate depiction of the condition of that Lexus following that 29-mile-an-hour impact?
Yes, and I should be more specific. It's post the 29-mile-per-hour impact with the test dummy, not just the arm.
Understood. Thank you. The collision that caused the damage to Rescue Randy that we've just been looking at?
Correct, yes.
Okay. Move for the admission of that photograph, Your Honor.
Okay. Exhibit 222.
Permission to display that?
Yes.
Is this the photograph that we were just talking about?
Yes.
And this is the condition of the vehicle after that rearward impact with Rescue Randy, correct?
Correct.
Did the subject vehicle photographs that you looked at, were those consistent or inconsistent with this photograph?
Those photographs were inconsistent compared to the test.
Was there anything consistent about the shirt that you were shown on Friday, the left sleeve that you were shown on Friday with John O'Keefe's actual sweatshirt?
Was any of that consistent with?
Correct. Was that consistent or inconsistent, now that you've seen all the photographs, with the condition of the shirt that John O'Keefe was wearing on January 29th?
The test clothing was inconsistent compared to that of Mr. John O'Keefe's.
Thank you. You were asked on cross-examination several times about the weight of the hybrid 3 arm. Do you recall that series of questions?
Yes.
You were asked how much lighter the hybrid 3 arm was than the static estimate arm, correct?
Correct.
I want to make sure we're clear about this. The hybrid 3 arm is the physical arm that you attached to the ATD and did testing with, correct?
Correct.
The statistical estimate arm is something in the ether, right? It doesn't exist?
Sustained.
How would you describe a statistical estimate arm?
It's probably from taking a sample of the population and getting an average and a high and a low.
Okay. Is that a physical arm you can touch and feel?
No.
Okay. Do you have any information based on everything that you've reviewed at all about the actual weight of John O'Keefe's right arm?
Nothing in terms of a weighed measurement of the arm, no.
Okay. What was the percentage that Mr. Brennan gave you in terms of how much lighter the hybrid 3 arm was than the statistical estimate arm that he gave you?
From what I recall, I think the percentage was 26%.
Did you calculate that yourself, or did you take Mr. Brennan's word for it?
I believe I took his word for it.
Do you recall what the weight of the hybrid 3 arm was exactly?
9.38 pounds.
What is the difference, if you can calculate, what is the difference between what was the statistical estimate arm, the number that Mr. Brennan gave you?
I think I heard him say 11.8, but I also think he said at one point 11.6, so I'm not sure of the final number he landed on.
Sustained estimate. Ask the question. Stop striking the end.
Does 11.86 sound right?
Yes.
Okay. Let's use 11.86. Do you have a calculator with you?
I do.
With the court's permission, could Dr. Wolf use a calculator if he needs to?
Yes.
Thank you. What's the difference between 11.86 and 9.38? Just in raw numbers?
You're looking at just the difference between those two?
Subtract
okay.
9.38.
Yep. 2.48.
Does that mean there's a 2.48 pound differential between the statistical estimate arm, the heavier arm, and the 9.38 arm from the hybrid 3?
Yes, that's the difference in pounds.
All right. How would you calculate how much lighter? What's the proper way to calculate how much lighter, in terms of percentage, the 9.38 arm is?
You would want to do a percent difference calculation.
Divide 2.48 by 11.86? how would you tell the jurors how you would calculate that percentage difference?
You would subtract the 11.86 minus the 9.38, and then you would divide by the sum of those two and divide by 2, the average of them.
Can you do that calculation?
Yes. Okay.
And what's the number?
23%.
Not 26%?
Sustain.
Is 23% smaller or larger than 26%?
Sustain. Let's move on from that, Mr. Jackson.
What is the number that you get if you were to divide 2.48 by 11.86?
.21.
In percentages?
21%.
Thank you. Was the hybrid 3-arm 21% lighter by that calculation than the 11.86 estimate arm?
Yes.
On cross-examination, Mr. Brennan asked you several questions related to kinetic energy formula, correct?
Correct.
You referenced that. Did you reference that formula in some of your answers?
Yes.
May I approach?
Yes.
We are at sidebar. Ladies and gentlemen, we are at sidebar. I am in 2 courtrooms at once. I am listening to what's going on in Dedham District Court, and I am live streaming the Karen Reed trial, ladies and gentlemen. These are absolutely incredible moments to watch live. There's the O'Keefe family. My name is Grant Smith Ellis. I have a live patch in to Dedham District Court in my earpiece. Aidan Kearney has waived his right to a jury trial. He will be pursuing a bench trial, ladies and gentlemen. I am not allowed to broadcast the audio of the Aidan Kearney case. We're waiting for trial to come into session. I have a direct line into the courtroom. I have never experienced moments like this. It's incredibly surreal. There is Miss Peggy O'Keefe. Thoughts of towels around the world are with her. So it looks like Eva says it's going to start at 11 to 1 today, and Wednesday 11 to 1. All right, ladies and gentlemen, the trial for Aidan Kearney is going to be from, are you positive on this, Eva? It's going to be today from 11 to 1, and then on Wednesday from 11 to 1. Hello, Super Talent Spouse Mandy Strong. I got you on the jury list, the mock jury list, and then I also got POG 3909. All right, so we're waiting for 11 a.m., ladies and gentlemen. The Aidan Kearney case is going to be tried. I have direct access into the courtroom. I'm going to be able to relay to you live everything that's happening. Only a 4-hour trial, ladies and gentlemen. Only 4 hours. 11 to 1 today and 11 to 1 on Wednesday. Oh, my word, ladies and gentlemen. That is going to be a quick trial. I'm waiting for Super Towel Eva to give me confirmation. Looks like this cross in the John O'Keefe case is going to continue in just a few minutes. Everybody get ready. We have a big dual screen moment coming at just 11 a.m. My name is Grant Smith Ellis. Towel needs your support today. We're doing this together. Here we go, ladies and gentlemen. Keep going, Alan Jackson. We want Hank. We want Hank, and I'm a multitasking towel doing the incredible. I can't believe I'm in 2 courtrooms at once. This is the greatest moment of my towel life. I didn't think this was possible. It's like I'm Hermione. Oh my goodness, ladies and gentlemen, I'm a time-traveling towel. Come on, Mr. Jackson. Come on. Let's go. Just a few seconds now. Here we go, ladies and gentlemen. AJ was a little lackadaisical. I am a towel in 2 courtrooms at once. Of course, I've never done this before. It is like I'm Hermione in Harry Potter.
May I inquire?
Yes.
You're looking at something that's been identified, a document that's been identified as 3 X's, XXX. Do you recognize that? Oh, you're not looking at it. Sorry.
Not yet.
You see it now?
Yes.
Do you recognize what that is?
It is the formula for kinetic energy.
With that, Your Honor, may we display the formula? We don't have to cut the lights. I think it'll be very obvious.
Yes.
Can we bring the lights back up and see if that's visible? Can you still see that, Dr. Wolf?
Yes.
Your Honor, is that okay?
Yes.
Great. You said this is the formula for kinetic energy, correct?
Correct.
You were asked a series of questions about whether the weight differential in the hybrid 3-arm would make a significant or material difference in your testing as it pertains to the velocity of the vehicle that you were testing. You remember those questions?
So watch the formula. Ask a different question.
Just foundationally, were you asked about weight differential of the hybrid 3-arm?
Yes.
Were you also asked about whether it would make a material difference to the testing if you didn't adjust for the velocity?
Sustained.
What were you asked in terms of, what was the question that was posed to you about the weight of the hybrid 3-arm versus the velocity of the testing?
That there would somehow be an influence on, I think, wanting to make a reduction to the velocity of the vehicle.
Does that make mathematical sense to you?
Sustained is to that point.
Would that have a material difference? With the weight of the arm at 2.48 pounds, would that have a material difference in the testing that you undertook?
No.
Why is that?
Well, to start, that's one of the reasons why we went above and beyond the 24 miles per hour to impart significantly more kinetic energy to the arm. So if you look at that equation, it's a quadratic equation because you're squaring the velocity. So if you double the velocity, you quadruple the amount of kinetic energy. So you get a significant increase in small changes in speed because of that speed differential.
Did you do a test with just the hybrid arm contacting the taillight at 24 miles per hour?
Yes.
Did you also do a test with that hybrid 3-arm contacting the vehicle at 29 miles per hour?
Yes.
I'd like to talk about those two tests. Okay? Can you explain to the jurors what they're looking at? I want to start with going from left to right. What does the E sub K mean in that formula?
So that stands for kinetic energy, which is the amount of energy that an object has when it's in motion and has a velocity to it.
What is the 1/2 on the other side of the equal sign?
Just a constant.
And what does the M, as in Mary, stand for?
So that would be the mass, in this case, the mass of the arm.
And what's the V, as in Victor?
That would be the velocity of the arm as it's accelerated.
Why is there an exponent at the top of the V?
Because you're squaring that. So you're basically multiplying the velocity times itself. So it would be velocity times velocity.
Is this a formula that's traditionally used in accident reconstruction?
Yes, it's very common.
Is it sort of one of the foundational formulas? When did you learn this formula?
Probably back in high school physics.
I'm going to ask you, if you wouldn't mind, to walk the jurors through a calculation dealing with the 24-mile-an-hour test using the 11.86-pound statistical arm as an assumption of the weight of the arm.
Okay.
You understand?
Have whatever's easiest.
Okay. Whatever's easiest. If you assume the mass of 11.86, that's the statistical arm weight, and you assume the V for velocity is 24 in miles per hour, I don't care about the units, doctor. Just assume 11.86 and 24. Can you calculate this quadratic equation?
Yes.
What do you get? I want to do it step by step. What's the result of squaring 24?
So again, you're not concerned about the units.
I do not want to talk about units.
Just okay.
If you mention the word joules, my head will explode.
That's I didn't know if you wanted Newton meters, foot pounds. Okay.
Stop it.
So
Immediately.
just 24 squared.
Correct.
Is 576.
Do you always, in this calculation, do you always use the exponent first? Do you always do the square first?
Sustain.
What's the first thing that you do in solving for this equation?
You would want to square the velocity, but it's ultimately all going to be multiplied. But yes, you would square the velocity, multiply by itself.
What's the next step after you get 576?
Again, assuming we're not concerned about units, you would multiply by the 11.86.
Can you do that for me and tell me the answer?
How many decimal places do you want? Nearest whole number?
2.
Okay. 6,831.36.
What's the next step once you get that number?
You would multiply by 1/2 or 0.5.
Can you do that for us, please?
That'd be 3,415.68.
What does that represent in terms of the energy into the taillight? I realize that we're not dealing with the proper units, but does that represent anything as it relates to the energy that's imparted on the taillight?
That would be the energy to the arm.
Okay.
That's being transferred.
Understood. 3,415.68. Is that right?
Correct.
And that was at what mile per hour?
24.
Let's move to a different equation.
Okay.
Now I'd like you to presume different numbers.
I don't know what the question is.
Can you do the same calculation using the 9.38 pound arm that you actually used in your testing for the mass?
Yes.
And can you use the velocity of the actual test you did of 29 miles per hour?
Okay. And same thing, not worried about units?
Correct.
Okay.
What's the first thing you do in solving that equation?
So if you square the 29 miles per hour, you will get 841.
What's the next thing you do?
You multiply by 9.38.
What's the number?
7,888.58.
And what's the next thing you do in the equation?
You multiply by 1/2 or 0.5.
And what's that final number?
3,944.29.
That would be the number or the amount of energy imparted on the arm at 29. Is that right? 29 miles per hour?
So ask it differently.
Sure. What is that 3,944.29 number? What does that mean in terms of the kinetic energy?
That would be the kinetic energy that the arm has if it were moving at 29 miles per hour and weighed 9.38 pounds.
One final calculation. What is the percentage difference between 39.44.29 and the other test that we just did, or the other calculation, 34.15.68?
So in terms of a percent difference, again, when you're subtracting the two and then dividing by the sum divided by 2, so that's basically the average of the sum, it is 14% difference.
Which of the two tests, the two energy equations that you just did, which represents the higher kinetic energy imparted to the arm? The 24-mile-an-hour test, that's the hypothetical, or the actual test at 29 miles an hour? Which one?
The 29 mile per hour speed with the arm weight of 9.38.
What does that mean, Dr. Wolf, in terms of the testing that you did with the lighter arm, 9.38 pound arm, at the 29 mile an hour test, as it compares to the hypothetical 24 mile an hour test?
It would be more force and more energy in the 29 mile per hour impact test.
Even though you used a lighter arm? Potentially. And what was your opinion and conclusion as it pertained to the subject taillight using the 29 mile an hour test? What was your opinion and conclusion as it pertains to the subject taillight? Was that consistent or inconsistent with the damage that you saw on the 29 mile an hour test?
It was inconsistent.
Thank you, Your Honor. That's all I have.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
So you just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
It's sustained. Ask the question again.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216-pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, the 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less. True?
Correct.
The truth is you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head, and to calculate the force, he adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
So you have one paper, one study. I know the answer to this, so let me ask. You have one paper, one study to support that it is appropriate to use the 50 percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that? Well, answer that question, please.
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection.
Sustained.
Are you confused how the number 11.8 would come up?
Objection.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that. Could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about 5?
It sounds about right, but again, I don't have the percentage off the
So
top
if
of
you
my head.
take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50 percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay. Now when you have 216 pounds, 5.48%.
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you where did Brennan get those numbers from, you said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8 or 11?
11.
As I just mentioned, last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony, 11 pounds. Your prior testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And when you testified under oath and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right? And so when you feigned confusion on Friday about this 11 pounds, so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so...
Well, we just did the math, didn't we?
Yes.
Okay. And you used a calculator to help you, didn't you?
I did, yes.
The calculator works?
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
Ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical, because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force, because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Yes.
I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct, yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints?
No.
You didn't explain it to the jury that there's a difference in weight matters?
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass, so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests, Are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your world, in your profession, that suggest or state that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rensler. Can I finish, please?
No.
Okay, so no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Mm-hmm. Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
With less force, if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human that pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium, so when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large, you used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in tests A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use to test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new?
Correct.
The extra large you put on Randy was new?
Correct.
Did you consider that he wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever? Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decide to come in and give an opinion, did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever without even studying?
Pause. It's a pause in the feed. It's not us. It's a pause in the feed. Hold on. Hold on. Hold on, friends. Hold on. It's a pause in the actual law crime feed. This has happened before. I'm going to jump forward, little towels. We're going to... It jumps live. Oh, I got it back. Hold on. Hold on. I got it back. The big moments here. We're getting ready for the Aidan Kearney trial to start as well. And, of course, the law and crime feed goes down. Hold on. I'm going to go to the backup feed. I'm going to go to the backup feed. Stay with me. Don't worry. I have it up here. It's going to be less than 5 seconds. I am an on-task towel. Oh, looks like it might be coming back for us, little towels. That's generally how this works. I get the backup.
Every single time you take the stand and give an opinion to be supported, valued, vetted.
Yes,
every single time.
And again, Dr.
Rencher, you offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024.
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else is, right? I'll move on.
The objection sustained.
I'll move on.
The objection sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So we're going to see you at sidebar.
Ladies and gentlemen, we are at sidebar. We're waiting. We are waiting. I'm in the room waiting for the Aidan Kearney trial to begin. These are moments. These are scenes. Ladies and gentlemen, we are waiting for both to begin. We are at sidebar in the John O'Keefe and Karen Reed trial, and you didn't miss very much of Hank Brennan's cross. There was just, it wasn't even you. It was the actual law and crime feed just stopped, and this has happened before. There have actually been times it buffered for 2 to 3 minutes, but what I do is I have a backup audio feed and we switch over to that. It normally takes me about 10 seconds, so no matter what, we always have options. I don't know how this is going to work, ladies and gentlemen. I don't know how exactly everything's going to play out, but I'm monitoring closely, ladies and gentlemen, and I'm waiting for the Aidan Kearney trial to start. I may have to literally read to you or say to you things as they're happening in the trial. I may be verbatim. My plan is, as things are said into my ear in the district court, I'm going to read them to you. Now, this is, we're going to mute the audio on the Reed hearing. I'm sorry. We're going over to the Kearney case. It's from 11 to 1. If I have to say every word to you that I hear read over my ear, I'm not allowed to broadcast it, but if I have to repeat the prosecutor's opening argument verbatim, I will do it, ladies and gentlemen. I am in 2 courtrooms at once right now. I have like 6 different earpieces on. I cannot believe this is even humanly possible to do at one time, but I swear to you, ladies and gentlemen, in the interest of justice for Lindsay Gattani, for John O'Keefe, I'm going to do this. And what's going to happen is any time that we spend covering the Aidan case, we're going to pause. We're going to come back and watch that part of the Karen Reed and John O'Keefe case later. We're going to know exactly the cue points where we miss off. So you're going to see the captions from the John O'Keefe and Karen Reed case running, but you're not going to hear it. We're going to note the cue points, and then instead of a recap today, we're going to watch the parts that we missed. We're going to go get in the other feed. We're going to rewatch the feed, and we're going to do that part later today. This is going to be the juggling act we talked about, ladies and gentlemen. We talked about how this is going to be happening. We all prepared for this. Little Towel is probably not going to get his lunch until 1 o'clock today. Oh, no, and then we have to go right into lunch. All right, Little Towels, what we're going to do is whatever we miss during the O'Keefe and Reed case, during the 11 to 1 trial for Aidan Kearney, we are going to go back, okay, Little Towels, during lunch from 1 to 2, and then get caught up on the O'Keefe and Reed case. Then, after there's no more Aidan Kearney case today. It's from 11 to 1 today and 11 to 1 Wednesday. We, ladies and gentlemen, are going to watch the end of the Karen Reed and John O'Keefe case till 4. Then we're going to go back. Anything that we missed from that 11 to 1 segment, we're going to watch at the end of the day. So if we can't get caught up on lunch on the developments in the O'Keefe and Reed case between 11 and 1, we'll get caught. So, for example, at 1 p.m., we're going to watch probably from 11:15 to 12 p.m. Then at 4 p.m., we're going to watch from 12:15 to 1 p.m. and get completely caught up on the O'Keefe and Reed case. Everybody follow? We're all on the same page. I am thrilled, ladies and gentlemen. I have never been more excited to be a towel. This is one of those days where you truly have to bring your towel, ladies and gentlemen, because there is so much going on that we are going to be doing for the first time ever dual coverage. And it's not just dual coverage. I have to literally sit in one hearing with it in my ear and relay to you what's happening because we're not allowed to broadcast it. Now, it might be the case, ladies and gentlemen, that someone somewhere somehow gets a few things. If anyone acts, ladies and gentlemen, no one seems to have that. We do have the O'Keefe family up on the screen. Of course, our prayers are with them. But ladies and gentlemen, there is there's so much going on, and I am being a good little towel. I'm monitoring as hard as I can, as best as I can. There's so many things going on simultaneously, and we are at sidebar in the John O'Keefe and Karen Reed retrial. You may notice your comments are a little lagged. That's because literally some of you, I'm sorry about that. We're leaving so many comments that little towel is literally completely overwhelmed. Oh, WD-40, God bless you. Oh, what a kind comment. It's going to take a little while to get caught up on the stream comments, but what a kind super towel comment. Let me just say, God bless you right now. We're about ready, ladies and gentlemen. Oh, we're about ready. Oh, goodness, this is quite a day. Ladies and gentlemen, we are very behind. I'm so sorry. The comments are still loading on the screen, so I brought them up on my phone. We are waiting for both of these cases to return to session. John O'Keefe and Karen Reed trial is in recess, and we're waiting for the Aidan Kearney case to be called into session. I do have my earphone connected, my earpiece. I am going to become a 1940s sports radio announcer. Yes, ladies and gentlemen, you should see me right now. I have like 6 different earpieces in. I have 44 different things going on, and I somehow am in 2 courtrooms simultaneously. It is like I'm Hermione in Harry Potter. Oh, goodness, ladies and gentlemen, I feel bad for Towel Computer. He has been pushed to his very limits, but I'm here with you. And remember, folks, as far as I'm aware, we do not have permission to broadcast the Aidan Kearney hearing unless a court pool reporter goes over there with a camera and films it and broadcasts it. Now, as far as I'm aware, there is a court feed. I'm in the courtroom. I'm listening. There's nothing going on right now, but as soon as court comes into session, I'm going to hear a lot of ruckus and commotion. Ladies and gentlemen, I can... only pray that things are going okay, and we continue. Oh, I'm hearing something. Stay with me, little towels. Stay with me. I don't know if we're coming into session. It was scheduled for 11 to 1. It's past 11 a.m. Your comments are going to take a while to load up because there's literally so much data coming across this poor little towel computer today. But we are working, ladies and gentlemen. I'm waiting to hear what happens in the Aidan Kearney case. We are still at sidebar in the John O'Keefe and Karen Reed trial. You haven't missed anything there. Oh my word, ladies and gentlemen. You had so many comments that we are probably like 5 or 10 minutes delayed in the comment feed. I have never seen this before. My computer is normally very good at this kind of thing, and we are waiting. These are the moments, ladies and gentlemen. We have 500 people watching. Oh my goodness, that's incredible. We are waiting for the Aidan Kearney case to be called. We have been told it's scheduled to go into session sometime between after 11 a.m. So around 11 a.m., ladies and gentlemen, as soon as I hear the case get called, I'll let you know. I also have multiple different live streams running, so if any of the other streams pick up the Aidan Kearney case, we're going to go right over. Hopefully, in a matter of minutes. Okay, the sidebar is going to end in 20 seconds. We're going to stay with the Reed and O'Keefe case, ladies and gentlemen, until I hear the Aidan Kearney case get called. Then we're going to mute the Reed and O'Keefe case, and I'm going to give you real-time transcription. Towel will do a dramatic reading of the things going on in the courtroom in the Aidan Kearney trial in Dedham District Court. These are scenes. These are moments. You are here, ladies and gentlemen. I'm thrilled to be with you all. I hope you are all ready. I'll let you know as soon as we are in session. Don't worry, Hank Brennan's about to resume his recross of Daniel Wolf. This is glorious, but Towel has to multitask. Everyone get ready. I also need a cheeseburger. Come on, Hank. We're ready for you.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there? Correct. And so while or plastic that shatters from a taillight might not impale clothes of the skin, would you agree if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy in the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point. What I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained.
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Would you agree with that?
It would move with the vehicle until it got pushed out of the way, just moved to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if I
say
understand.
Drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of the taillight if the taillight broke, correct?
Just moving at a common velocity?
The operative word here is push. And so do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against?
Breaking news, ladies and gentlemen, the Aidan Kearney case has been called. Breaking news, the Aidan Kearney case has been called. Okay, here we go. Who is planning on calling Paul O'Keefe, says the judge. Motion to quash is based on the reason. 3 reasons. Lawyer for Paul. First, relevance. they issued a subpoena that was requested, an unlimited scope of emails, phone records, text messages between 4 different people who have nothing to do with the underlying case. So let me ask Mr. Bradle, are you seeking this information or are you seeking the witness? Both, Your Honor. Well, the witness is here. And you're saying that, by the way, I hope you don't crosstalk. We're just trying to get the bottom line here, Mr. Bradle. The relevance of the person as a witness. He's a percipient witness to the day? Yes, correct. Why do you need his records? Counsel says, I accept that he may be a percipient witness. So you're contesting the document part. Well, contesting the document, but I'm also requesting for the relevance of my client as is the victim in the across the street trial every day, the brother of my victim, and that's 24/7. We don't want to interfere with his ability to support his family across the street. I totally understand that, says Judge Pomerol. It's simply, if he's a percipient witness, he's assigned as a percipient witness. As far as the documents, is there anything to support that? Yes, Judge, I just want to, says Bradle, let you know that my email... I said we would agree to narrow it to the 30 days prior to the day of the incident. My question, says Judge Pomerol, do I have to figure out the documents right now? Is that really necessary? Bradle said you want a short offer proof? Go. So we contend that there was a conspiracy among certain people to trigger a restraining order violation. Who is your first witness, Mr. Bradle? That's going to open the door to that. That would be our second witness. So, Judge Pomerol, the percipient witness, we're not going to quash it. As far as the documents, they're going to bring him back Wednesday. I don't see how you're going to prevent him from being a witness on Wednesday. I recognize and appreciate that. They don't have a theoretical right to ask him questions. However, I believe that there are other witnesses that stand for the same proposition. I understand. The motion to quash is denied, at least as it relates to the client's attendance as a witness in this case, for further review. At least, and then now it's set aside for further review of the documents Wednesday. 11 until the end of the day if needed. Okay, Paul's lawyer will be there until the duration. We'll get the ruling right now. Okay, thank you. Thank you. Okay, hold on. Hold on. So Paul O'Keefe has lost. Okay, so the judge is now considering other matters. He's still on the Kearney case. Paul O'Keefe has lost his motion to quash the subpoena in the Aidan TurtleBoy Kearney case. However, what's the next? Commonwealth motion. There's a bunch of pretrial motions being heard. The state filed a lot of motions. Some are not germane to a bench trial. Mr. Cosgrove, why don't you start with the ones you want me to hear? Okay, says Judge Cosgrove. Prosecutor Cosgrove, I have a motion to prevent the defendant from influencing the jury. I have no objection to being anyone in the courtroom, but just no T-shirt signs that show support for one side or the other. We agree to that, says Mr. Bradle. Next one. Commonwealth motion in limine to prevent a collateral attack on the validity on the underlying RO or these proceedings. Bradle objects. There's an objection. The issue there, Your Honor, is that hold on. This court, Your Honor, you might recall that we filed a motion to vacate the entire order. Your Honor came back sua sponte and said that because of the nature of how this transpired, you made a ruling that every courthouse in the Commonwealth of the state of Massachusetts was exempted, and we think that, it's sort of redundant in this trial that we were in the position where it was relevant to the idea that this order shouldn't be covering a courthouse because modified by you because of the potential abuse. So in that sense, I would argue it's relevant. Judge Cromwell, I don't think I used any of those words. I didn't use the words abuse. I just said it wasn't necessary. For obvious reasons, the courthouse, in particular, since your client comes to the courthouse. In light of what you said, Judge, says Bradle, we would not move. Audio going out. Hold on. Next one, Commonwealth's motion in limine to prohibit prior or subsequent bad act evidence. Judge considering it. Oh, Judge allowed by agreement. Now, next motion from the state to prohibit irrelevant hearsay. This has to do with a witness who previously submitted an affidavit, in my view, replete with information, hearsay, mind reading, improper testimony, not just the rules of evidence. We can just go on a case-by-case basis. Okay. Judge says we're going a case-by-case basis with the hearsay. Question-by-question basis. That does it for the Commonwealth, says Cosgrove. Your Honor, we have an omnibus motion, says Bradle. One filing. Pretty simple. One paragraph. Number one, all set. Two in words and no inducements. Cosgrove confirms. Sequestration request from the defense for witnesses in the case. Number four. This has to do with the jury. Hold on, the audio is going in and out for Bradle. And fourth, number five, involves my client. Any alleged other bad acts that have been other than the violation of the restraining order, I would anticipate some testimony about the nature of the relationship, but other than that, I wouldn't expect or ask or even myself bring up any other bad acts. Judge Cosgrove, I don't anticipate bringing up any bad acts. Yeah, I feel if that's the case, I would approach the court at sidebar before bringing it up, says Judge Cosgrove. Now 7 voir dire questions. Bradle discussing his proposal for voir dire questions. 7 prejudicial references. Bradle has number 8. The last one. A little bit of a explanation. So before we move on, this says Judge Pomerol. They're discussing if any of the other ones need more discussion. So, Judge, we contend that, says Bradle, plaintiff here, cutting in now, is someone who, and Mr. has information that would show information about, and this is on video, where Ms. Kearney got a order on a prior person and somehow found him, I believe it was in Mansfield, in a parking lot, and they were at the same location together, and there was a restraining order in place at the time, and she sat in the car with him while the restraining order was in place, and this is on video. Police came to the scene, arrested the man for the violation of the order, and so the issue is a couple of different evidentiary issues. Number one is my client's state of mind. That's why he went across the street, we contend, asked with a policeman, and a policeman told him where to go because he wanted to get this documented in the days prior. Judge Pomerol, why do you want me to allow this this video? And state says you're objecting. Judge Pomerol, you're objecting, state? Yes. The volume cutting in and out. Judge contemplating. I believe that was denied. Oh no, Cosgrove response. From the Commonwealth's point of view, this is a very simple and straightforward issue. Lindsay Kearney sought a restraining order from the court. After a hearing, while the defendant was represented by counsel, the court heard evidence until the conclusion of that hearing where a restraining order was issued. Following the issuance of that order, the defendant was required to stay 100 yards away from Ms. Kearney. On February 26th of 2024, Ms. Kearney had made plans to join a group of witnesses and family members of the O'Keefe family at a pre-trial hearing for the Karen Reed case across the street. The plan was that they would assemble out in the parking lot behind the Registry of Deeds and they would proceed as a group across the street through the protesting crowd, and they would walk up through there, up the stairs, and into the courthouse. Essentially, that's what happened. Ms. Kearney parked in the rear, far rear of the Registry of Deeds parking lot, met up with a bunch of people, proceeded across the street. Got upstairs, gained admission to the courtroom along with members of the O'Keefe family, some of the witnesses to the case, got in the courtroom, heard he was already seated. After a short period of time, Mr. Kearney proceeded to look in Ms. Kearney's direction, obviously was within 100 yards of her. At that point, Your Honor, Mr. Kearney was approached, got up, went downstairs. From there, I can't tell the court exactly where Mr. Kearney went. One thing's for sure, he was still within the area, and in effect within 100 yards of where Ms. Katani was and he knew she to be. Rather, he waited outside instead of leaving, knowing the Commonwealth would suggest that Katani was inside. And when that was about to happen, as Katani was leaving, Mr. Kearney approached a police officer who was there by the crowd and so forth. The evidence will be that Mr. Kearney approached the police officer and says, I want this on record, pulled out his cell phone, reported the conversation. Commonwealth will play the conversation for your honor. The Commonwealth has a different view of what the police officer told Kearney than Kearney's testimony. Kearney then proceeded across the street to the Registry of Deeds parking lot. He waited. And as he knew it happened, Katani came out. At that point, Your Honor, if there's not a violation before, there certainly was at that point. He puts himself about 30 yards away from the courthouse steps, standing in front of the Registry of Deeds. Katani came out. He made no effort to remove himself further to the 100-yard area. Rather, Miss Katani, as Miss Katani proceeded down the ramp, the evidence will show that Mr. Kearney moved along with her. By the time she turned down the street and turned to her car, the evidence will show he was even closer to her. From there, Miss Katani proceeded to her car. Mr. Kearney, Miss Katani returned to her car and found that it had been damaged. One of her friends called the police. Police officer Kozak was dispatched to the location of the report. He spoke with Miss Katani, who at that point was very concerned about the damage to her car, and proceeded to investigate. He left. Katani got in her car. She left to pick up her children. And when she got in her car, she realized that Officer Kozak had said nothing about the 209A violation. She briefly informed him she had a 209A order. So she called the police and reported the 209A order violation. And she was told that she needed to come down to the police station. That would be the Commonwealth's evidence, Your Honor. That was opening statements. And we're asking, as a result of that evidence, that you find that Mr. Kearney deliberately violated the restraining order by placing himself within 100 yards where Miss Katani was, based on the facts coming into evidence. And that would be the Commonwealth's position. Thank you. Do you have an opening? Mr. Bradle. Mr. Bradle, on behalf of Mr. Kearney. May it please the court. When you grant a restraining order in favor of someone, it grants in that person a responsibility. And it's prone to abuse. And in this case, Your Honor, the only abuse that was going on was abuse by the victim of Mr. Kearney. Mr. Kearney was incarcerated for 60 days under a bail revocation after her allegation of events on 12/23/2023. Miskatani was enlisted. We contend, and the evidence will show, that there was a conspiracy between and among the O'Keefe family, the McCabe family, those who are witnesses in the Karen Reed case across the street. And these folks are enlisted. They have never met before. She had never come to a hearing before. And Mr. Kearney had just gotten out of jail for about 3 or 4 days. And this was his first time going back to his job at the courthouse, reporting on the Karen Reed case. This case, we contend, Judge, we know someone went to the gas pump. There's no reason to go to where you know the person is going to be. The evidence will show that Ms. Katani knew that Mr. Kearney was out of jail, and the evidence will show, and he got into the courtroom at 1:50 p.m. or 2 p.m. And we have video that shows Miss Katani walking into the courthouse with the O'Keefes and the McCabes. Now, Jennifer McCabe and Paul O'Keefe. She's walking in with him. We have evidence that will show that when they got upstairs, Jennifer McCabe said to Miss Katani, tell them you're with the O'Keefes. Tell them you're part of the O'Keefe family. Words to that effect. Again, you'll see from video and photographs that she commonly and continuously holding a piece of paper. She's got the restraining order out. Her testimony will be that as soon as she walks in the door on the first floor, she opened up the order and showed the court officer. She was waving this order around from the minute she walked into my client's place of work. And she's trying to get him out of there. How do we know she's trying to get him out of there? How do we know she's isn't just a good faith observer of the case? Here's what the evidence will show on that point, Your Honor. She's talking about getting home to get my kids. So she lives in Medfield, which is about 30-minute drive away, and that will tell the facts, Your Honor, to flush out Mr. Kearney out of the courtroom for the McCabes and the O'Keefes and the Alberts. And the evidence will show all that. And she has to get back to get her kids. So if she wasn't here as a good faith observer, she was here at their behest to try to effectuate an RO violation. And then she had to get home to her kids. So unexpectedly, the evidence will show that hearing was over at about 2:10, only about 10 minutes long. Everybody will testify it to Your Honor that they were there expecting a pretty substantial pretrial hearing that was going to be good hearing to attend. And this was a 10-minute thing. But Mr. Kearney, before I get to, let me tell you more about, the evidence is going to show that in this courtroom at about 1:50 p.m., Mr. Kearney and his girlfriend, Meredith O'Neill, are sitting in the courtroom. And you can see that Mr. Kearney, Ms. Katani comes in, and the evidence will show that Meredith O'Neill sees her and says, get up, we got to go. And then Mr. Kearney turns around and looks, and he sees her, and they get up. And there's going to be evidence from the government that he looks back and says the F word or something like that. Miss O'Neill gets up, and Mr. Kearney gets up, and you're going to see this on the video. It's 19 seconds. They're out of there in 19 seconds. Katani comes in and sits down. Where does she sit? Right behind Paul O'Keefe. Right amongst all these people that she's never met before, or maybe she just recently met them, and she's never been to a hearing before. Now she has an RO. Now Mr. Kearney's out of jail. Now here she is. So Mr. Kearney, then Miss O'Neill, get up, get out. Mr. Kearney leaves, and you and I appreciate the Commonwealth that's saying he did the right thing. He got out of there. And then Mr. Kearney goes downstairs, and he's approached by a woman who tells him she's very excited, and she informs him that Jennifer McCabe upstairs told Lindsay to tell the court officer that she's part of the O'Keefe family, and she reports that in a very excited way to Mr. Kearney. And then Mr. Kearney leaves, and he goes downstairs, and he goes down the steps, okay, and then this is key. Judge, the Commonwealth is going to try to contend that this 100-yard business is some kind of a crow fly thing or whatever they did, and trying to figure out the Mr. Kearney, and people are not crows. They don't know what 100 yards is like. Mr. Kearney, the evidence will show, he thought where he was, and it was right about 100 yards. And nonetheless, Your Honor, putting the numbers, whatever the numbers is, aside for a second, Mr. Kearney was down the stairs in front of the Superior Court, and then our officer, hold on. And he does not want to get jammed up by this in any stretch in the imagination. So he's live streaming what's going on, trying to document it. He walks up to Officer Crump. Officer Crump's a little busy at the intersection, but he says, I have this woman. This woman has a restraining order on me where it's the effect of, and I have to get out of here. Where should I go? She's in the courthouse. She's in the courtroom. Where should I go? And then the officer Crump says, go up there for now. The steps, go up there for now. And just incidentally, we have a video of it, of Mr. Kearney's live streaming, and they both kind of talk, just to give you a heads up on the evidence, they both kind of talk at once. But when you slow down the video a little bit, you can hear him say, go up there for now. So it's a little bit hard to hear at first, but we'll get it to you and you'll hear it. But Officer Crump says, go up there at first. What's the significance of that, Your Honor? It's not your closing. I'm sorry. The issue, though, Judge, is that the government has told Mr. Kearney, go somewhere, follow directions. The evidence will show that the government tells him where to go, and he follows directions. He stays up there because he wants to report to Crump what happened and document what happened. And he doesn't want to leave because he doesn't know where Mr. Kearney is going to go. And he has this thing in his head that she is just... He doesn't want to walk somewhere and run into her alone. He doesn't know. He just wants to stay with the police. Stays with the police. And then, this hearing's over in 10 minutes. So, in 10 minutes, over 100 people come out of the courthouse. And you'll hear from yourself in the video. Everybody's got black hair, black sunglasses, black coats. It's, who are these people? Mr. Kearney is live streaming. He's talking. He doesn't see her, and she doesn't see him, is what the evidence is going to show. This is an accidental contact. This is an incidental contact. This is no contact. This is after the fact, manufactured. This is post hoc thing, Judge, where the group walked by. Mr. Kearney is live streaming. He's talking. He's outraged about what happened. You'll see this. You'll see bits and pieces of it. He's just going on and on about how she came in there and all that stuff. He does not testify that he does not, that he does have, he's going to testify that he doesn't want to see this person, doesn't want to hear her. Get the hell away from her. Then this contact is manufactured later. Lindsay, no contact. So what happens is, Judge, and I know someone put their phone on, so it paused. Hold on. Why would people join and not mute their phone? And it shows that this group that contains Miss Kearney walks out of the courthouse and walks around the side of the Registry of Deeds between this building and the registry, and they walked behind the building. Meanwhile, Miss O'Neill, who walked out with Mr. Kearney, she let Mr. Kearney, and she walked over to another location across the street, and this and that. But then Miss O'Neill, in the same area, but she wasn't with Kearney. So she went to the back parking lot behind the registry, and she saw the Alberts happily joking. Kearney's back there, call 911. Someone's not muted on the Zoom. It's infuriating. Mute. Don't go on this court Zoom if you don't know how to mute. Why are you doing this to us? Please stop joining her just seeing she's supposedly terrified of. So that's when this 911 call happens. Some newfound friend of Miss Kearney calls 911 and says, the car is vandalized. Oh my God. We have to stop this. Stop talking on the Zoom. Oh my God, get off the Zoom if you can't mute your microphone. A cracked taillight, ironically. Oh my God. Get off. That is a Zoom for reporters. Get off it. So he takes photos, he documents the scene. No one said anything about a restraining order violation. You mute your phones. No one said a word about it. Oh my God, get off the Zoom if your phone's not muted. You are ruining a criminal trial you don't understand. Get off the Zoom if your phone's not muted. So Miss Kearney saw that Miss Kearney tried to contend that the police, that she saw him yelling at her, is a complete fabrication. Liar, just attacking the victim. Liar. Oh my God, mute your phone. In this case, we'll probably call 3 out of 5 witnesses that show, that all swear and that all show. Oh my God. Mute your phone or get off the Zoom. Get off the Zoom. Get off the Zoom. You are talking into a criminal court. You are broadcasting during a live trial. Get off the Zoom if you can't mute your microphone. You're interrupting a criminal proceeding. We need to report on this. Get off the Zoom if you can't mute your microphone. So this is just an uninterested officer. So you have officer, then you'll have the officer hear some evidence about Ms. Kearney following in and making statements about it. And can I just have one moment, Your Honor? Okay. You'll see, Judge, a progression of events where get off the Zoom. She knows Mr. Kearney. So all the evidence, you're just going to show that Miss Kearney is doing this because not of an accident, or she is going to him and trying. And how do we know that? Because that's her plan and it's no mistake. And how do we know that? We're going to show that she's doing it. She's doing it now. That's what the evidence will show. And to help the O'Keefes and Alberts, and the entire thing is a fabrication. Ms. Kearney made an absolute to good faith obligation to comply, where she went in bad faith. she stayed where Aidan stayed where the government told him to stay, and he had no idea. No contact, no idea. Only learned later that there was contact. He tried to act like she ended up like saying, "Oh," he said, the evidence in the case will show this is nothing more than an abominable lie and a conspiracy, and it's an attempt to manipulate this court in a restraining order. And I would ask you to find him not guilty. Thank you. Okay. Stop talking. Your phone is unmuted. Stop talking. Oh my God, we can hear you talking on the Zoom. The court clerks are instructing people to mute their phones now. It's incredible to me that you would join a criminal trial with your phone unmuted on a line for people who are reporting. All right, the opening statements have... We're calling the first witness. Okay, there's just some discussion about housekeeping right now. Witnesses are about to be called in the Aidan Kearney case. Opening statements are done. This is incredible. All right, judge stepping off. Brief recess after opening. We're waiting for We're waiting for the witnesses to be called. For the love of goodness, folks, text your friends. Please, if they got on that courtroom Zoom, if you continue to talk on that courtroom Zoom, one, it is a blatant disrespect of the court. Two, no one can report on what's going on. We cannot broadcast this. Stop talking. We need to be able to hear what the lawyers and the judge are saying. That's why there's a courtroom Zoom. You have no idea how difficult it is to report while listening into a Zoom and then relay words that are being said in real time. Please, if you are on that Zoom, I'm not talking to Telestream viewers, please text your friends. Tell them, first of all, don't sign on to that Zoom if you shouldn't be. Second of all, if you are signing on, mute your microphone. For the love of God, mute your microphone. You're going to drive Towel insane. Please stop. I'm sorry, D-Nice. I got to breathe. Ladies and gentlemen, I have to breathe. This is a very unique experience. I am relaying what's happening is I am hearing in my ear the Aidan Kearney case being broadcast live in real time. We have just heard opening statements. Prosecutor Robert Cosgrove laid the foundation for why Kearney should be found guilty. It seems like we are in front of Judge Pomerol. A bunch of preliminary motions were decided in a rapid flurry very quickly, ladies and gentlemen. Paul O'Keefe will be required to attend district court on Wednesday. Will be heard before O'Keefe takes the stand as to an ongoing criminal case for as to an RO violation by Kearney. So, ladies and gentlemen, we have just finished opening statements in the Aidan TurtleBoy Kearney case. I am listening. I am literally listening in right now. I'm in the courtroom. I'm in two courtrooms digitally. I'm providing you real-time coverage. We will go back and rewatch where we left off in the Hank Brennan case, in the Hank Brennan recross, ladies and gentlemen. Oh goodness, ladies and gentlemen, so much going on. A subpoena. So Paul O'Keefe lost his motion to quash the subpoena. He will be required to testify on Monday. A motion will be heard. Phone a motion related to phone records will still be heard. A phone records motion. A phone records motion is under advisement. All right, so that's the first update. Now I have to do the second update, Towel Friends, because I'm literally the only person able to do this. Oh, for opening statements in the Aidan TurtleBoy Kearney District Court trial as to violating an RO held by Lindsay Gattani have just concluded. I was able to relay the full opening statements in real time, and we now await the first witness in the case. Oh, goodness, ladies and gentlemen. That was quite an experience. I've never been through anything like that in my entire life. We're on morning recess in the John O'Keefe and Karen Reed case. I'm trying not to scare D. Nice's dog. I apparently got a little bit overwhelmed. I cannot believe I just had to sit and transcribe for you in real time opening. I didn't know we were going right from pretrial motions to opening arguments. I was like, is this opening statements? Is Judge Pomerol hearing this? And we were right away into it, ladies and gentlemen. And I know I got a little bit loud there, so I apologize ahead of time. We don't know the full list of witnesses. The state is calling their witnesses in the Aidan TurtleBoy Kearney case, ladies and gentlemen. If you're just tuning in, we cannot actually broadcast the Aidan TurtleBoy Kearney case. It is verboten pursuant to court order, but what we do have the ability, folks, to do is have me relay to you everything that's said in real time live. It's actually kind of incredible that I have the ability to do this, but I have such a keen ear. It's very soft, but I can hear everything that the lawyers are saying, and by virtue of the fact that I can hear everything the lawyers are saying and the judge, I can relay it to you in real time. So I apologize ahead of time for the fact that your comments are a little bit delayed. I think we have pushed Towel Stream to its very, very apex today, but we are going to do it. I'm not going to get to eat my lunch because, ladies and gentlemen, we're about to start the Aidan TurtleBoy Kearney case. Obviously, one of the witnesses is going to be Lindsay Catani and then some of the police officers, but we are ready, folks. We are ready. I'm sitting here. There's a sequester order in place. I think it got approved, and then a bunch of Bradle lost a bunch of motions in the pretrial process. He lost like 6 of his motions. The state won all their motions. All the bad character evidence is excluded as to Lindsay. Oh, ladies and gentlemen, just an excellent series of arguments there. Great job by Special Prosecutor Bob Cosgrove. But this is hard, folks. This is a very unique way. This is not really the most accessible form of access to the court I've ever seen. I mean, I like it for its purposes, and I'm sorry I got so frustrated, but I cannot tell you how frustrated I was when people were talking on that Zoom. That is incredibly inappropriate. I did it by accident earlier and instantly muted myself, not while things were going on, but that people were joining. It's a very special kind of Zoom. It is a direct line to the court. It's not for passive or just recreational consumption. It is because people who are listening to that feed are taking notes on it. They're reporting on it. Okay, we're coming back into session in the Aidan Kearney case. Court is back in session. You may be seated. Quiet, please. Back on the record, Commonwealth v. Aidan Kearney. As a reminder to those joining us on the telephone, please have your phone muted. Sir, can you raise your right hand? Do you solemnly swear that the following testimony you will give is the truth, the whole truth, and nothing but the truth, so help you God? I do. Please introduce yourself to the judge, please. My name is Cole L. He's employed. He's a court officer at Norfolk Superior. How long have you been there? 5 years. Directing your attention to February 6, 2024. Are you of whether or not there was a hearing in the Karen Reed case that date? There was. And what was your particular assignment? I was assigned to the judge. And when you say the judge, what do you mean? In what courtroom? The main courtroom. Want to ask you a little bit about the people going in and out of the courthouse of Norfolk Superior Court. I have a photograph. Could you tell me if you recognize both locations generally? What do those photographs show? There are main session door, front door, main session, hallways in the back door, and the back door. Question. Is that a fair and accurate depiction of the courthouse? Yes. No objections to introducing as evidence. So marked. Could we have photo 9, please? Number 9, please. Looking at that photograph projected on the screen, can you describe it? That's the front door. What's the purpose of that? There's a security screening area. The courthouse is designed so that people can come in the front door and then they can go through the screening. When they walk up, how do they get from there to where the Karen Reed case is? So you walk through the front door, and then on the left-hand side, there's a staircase. You walk up, and then at the top, there's a courtroom. So you proceed up the stairs. Is there any other way to the courthouse, to the courtroom? No. There's an elevator. Where's the elevator? It's directly to the left of the entrance. You don't actually see it, but it's behind the security desk? Yes. Right to the lower end of the court? Okay. So if one walked up the stairs and parts of the stairs, wherever the main session is, it would be at the top of the stairs to the right. Could you please put the next photo on the screen, please? Can you identify that? Those are the courthouse doors going into the main courtroom. Going into the main session? Yes. Is there any other way to get into the main courtroom? Not for the public. What does this picture show? This is where spectators sit in the court. Where were the spectators located? Left and right benches in the court. Objection? Overruled. And in terms of departure from the courthouse, is there an area that the public is directed to go to? Same way they came in? Yes. Now, is there also a rear door? There is. Number 12, please. Can you tell us, first of all, where somebody would exit from this photograph? So they would go from the clerk's office. Okay. If you walk down that corridor, straight ahead, you'd go to the back of the courthouse. And are those doors we see in the photograph? Yes. Exhibit 13, please. Is this a close-up photo of the doors? Yes. Now, why would somebody not be able to walk out this? Oh, we have an alarm. Is that exit blocked? Yes. Is there video cameras of each entrance and exit? Yes. Would that court personnel can monitor? Is that one of the locations? Yes. All right. So on the day in question, I think you indicated you were assigned to the judge, the courtroom 25? Yes. Are you familiar at all with the defendant, Aidan Kearney? Yes. Have you had occasion to see him in court prior to the day in question? Yes. Do you see him in court today? Yes. Can you point out where he's seated? Thank you. Will the court accept the record identifying the witness as the defendant? Yes. Or the defendant as Aidan Kearney? Yes. And on that particular day, did you see Mr. Kearney? Yes. At what point did you see him? It was during what court was in session of the Reed trial. Can you recall what he did in connection to entering the courthouse? So he came through the The doors we saw, yep. And then was he alone or with someone else? All right. He was with someone. And the fact that he took Do you have a recollection of what you saw Mr. Kearney do? I don't. Oh, Miss Katani. I don't remember what she looks like. Where did Miss Katani sit? Right-hand side of the courtroom. And shortly after you observed Miss Katani come in, did you observe anything with respect to the defendant? Yes. Mr. Kearney was on the left, on the left side of the courtroom, and then got up and left. Did you see him? Yes. No further questions. That was just a witness establishing the foundation. All right, Bradle's going to ask questions on cross. Bradle stands up. Officer Delano is the witness. Bradle says, good afternoon. Are you a court officer? Yes. And you were working on the day in question? Yes. And it was a Karen Reed hearing that day? Yes. That was a trial hearing, wasn't it? Yes. Were you anticipating a quick short hearing or kind of an all-afternoon thing? I don't know. It would be unusual for a hearing like that to be like a 5-minute, 10-minute thing, right? Witness seems to say, I don't know. Officer, when were you first asked to jog your memory about this case? Probably recently. So more than a year after the incident? Yeah. So it would probably be helpful with video, right? Yeah. I'd like to have a video possibly played. It's 19 seconds. Well, I don't know. Go ahead. If I have an objection, I'll raise it, says the prosecutor. Bradle says we did provide this video. Oh, then prosecutor says, okay, then if Bradle has provided it, I apologize. Then we're fine to play it. Okay, no objection. It's a short video. Your Honor, may I play the video? Yes. It's a 19-second video. It's a video of Aidan getting told or whatever that Lindsay was there and then leaving. This is the most interesting way to cover a court case I've ever experienced in my entire life. I'm relaying to you in real time what's happening on direct. Let's back up. About 15 seconds in the video. Now, okay. You see that? Yep. Pause. Okay, right there. Do you see that? Pause. Bradle is not very good at operating technology. Tim Bradle's on cross of a court officer. Now, are you positive what side they were on? Yes. So, that's, does that look like the layout of the court, the video of that hearing that day? Yes. Can you see yourself in the area anywhere? Not that I can see. Oh, it plays. Hold on. He might change his answer. We're watching the video now. It has no sound. Possibly. Is that you on the left? Yeah, possibly at the end. So you're kind of in the backside of the audience, correct? Yeah. You're not really near the judge right then, right? No. And you, at that point, did you have an awareness of where Mr. Kearney was? I knew he was on the left side at the time. All right, let's play and see what happens. Okay, so the video is playing again. This is a very, very unique way. Okay, so the video is playing. Do you see the gentleman just jumped up there? Yep. Yep. To the left? Yep. Do you remember him? So the hearing does start. You see someone in a red dress as well? Do you recognize her? Could you hit play, please? We're going to go back to the Reed case so you can watch the captions. But I'm going to keep commenting on everything that happens in the TurtleBoy trial. Can we see the timestamp? Was it 5:14? What is it? I'm sorry? 5:04? 4:45 to 5:04 was basically the entire time that they are there, right? And an officer, the event that causes them to get up is Lindsay Gattani walking in the courtroom, correct? Yes, and that was right when they got up, wasn't it? And got right out of there, didn't they? So no one had to tell them to get out of there. I don't know. I don't know. Pause. Now, did you see when you saw Mr. Kearney come in? What happened? Was he on the left-hand side? Courtroom? Yes. And you're here today with a colleague officer as well, right? Yes. Who's that? What's her last name? Yeah. Did you ask Officer Eugene if she was working that day? Do you see her anywhere in the video? I don't know. Do you know where she was stationed? Could it have been on the other side? Yeah. Anything on redirect? No redirect, Your Honor. Oh, wait. Hold on. There might be one. I think that witness is done. We might have another witness. Hold on. There's a motion argument going on in the Reed case, but we're going to watch this later. Unless there's no witness on the stand. Where's the witness? Okay, next witness. Introduce yourself to the court, please. This is another court officer. How are you employed? What do you do? I'm a court officer. How long have you worked at the court? A long time. Witness details your history of working as a court officer. She's speaking very softly. And at what point in your work for the trial court were you assigned to Norfolk Superior Court? July. Before that, where did you work? So I'd like to direct your attention to the date of February 26, 2024. Were you working that day? Yes. And what there was, if I'm not mistaken, a hearing in the Karen Reed case that day? Yes. Were you assigned for a particular courtroom that day? Yes. Just wait for the question, witness. And why were you in the Karen Reed hearing? I was assigned to the court. I was to provide security. And when were you told about that hearing? That assignment? That day. So, your chief said you would be assigned to that trial? Yes. And your chief contacts you in some way and tells you you'll be assigned? Yes. Just basic questions about how the court officer gets assigned right now in the Aidan Kearney case. Let me back up a little bit. Did you subsequently learn about a person with the name Aidan Kearney? Yes. And were you ordered to go to the courtroom? Yes. I was downstairs, and I walked upstairs, and I entered the courtroom. When you got upstairs, what did you see? Oh, stop talking on the Zoom. Miss Catani was sitting on the far right. Where was Mr. And they came in, and then Mr. Kearney was sitting on the left. Were they alone? People are not muting their... Are you familiar with the defendant? Yes. How did you come to be familiar with the defendant? Stop talking on the Zoom. Stop talking on the Zoom. Get off the Zoom. We're waiting to hear, ladies and gentlemen. Okay, so now we're looking at an exhibit of Kearney and courtroom on that day. With that hearing, with the respect to whether the motion was granted, do you remember? I don't remember. Court bar says quiet. Court officer says quiet during the sidebar, please. sidebar going on right now in the Aidan Kearney case. Hold on. This is very, very intense. We're going to catch up on the Reed case during lunch in just 45 minutes, but I'm relaying in real time the Aidan Kearney case. The second witness is on the stand. It is a court officer, so the first two witnesses were court officers. Okay, you can proceed. Did you see Mr. Kearney in Superior Court that day? Yes. Asking a question about Mr. Kearney in court that day. Did you observe what happened after that? He was in the court. He got up and left. Do you know how long he was in the courtroom? About 10 seconds. Did you see him speak to anyone? I don't know. Going back to Ms. Gattani. So this court officer spoke with Ms. Gattani. Do you remember in terms of time when she spoke to you? Ms. Gattani spoke to me before Aidan Kearney left the courtroom. Boom, there you go. Court officer testifies. Gattani spoke to her before Aidan Kearney left the courtroom. A court officer, I'm still waiting for the court, it's very hard to hear. At the conclusion of the hearing, what do you remember Ms. Gattani doing? She left. How did she leave? She walked outside. She walked down the stairs. I didn't see her after she walked outside. Okay, thank you very much. No further questions. Bradle up on cross. And we're waiting for Bradle's cross to begin. May I inquire? Yes. When were you first asked to try to recall what you remembered from that day? I don't know, a couple months ago. So this happened in 2024, right? So, about, you said a week and a half ago? Yeah, a week and a half, not a month and a half. Week and a half ago? Yeah. And about a year and a half went by? Yeah. So do you remember what happened? Yeah. If it's an irregular incident, I remember it. Do you remember a little bit of it, but maybe not everything? I remember most of it. You were in the courtroom when Ms. Gattani arrived. I don't recall exactly where I was. I know that I may not have been in the courtroom when she arrived. She had a piece of paper with her, didn't she? I didn't see it. Maybe she did. Did you go with her downstairs? No. When she arrived, she was up. When I first saw her, she was upstairs. Oh. No, on the ground level right inside of the door. In the front lobby. That's pretty near the metal detector, yeah. Had she come in through the metal detector? Yes. And were you there for, pursuant to Officer Rose saying wait here for her? Oh, so this officer was told to wait for Lindsay to arrive. And I did that. And who told you that? My supervisor, my chief. And then, so, was Mr. Kearney already there at that time? I don't know. So you meet up with Ms. Catani pursuant to your supervisor's instruction. Yes? Yes. And was Ms. Catani with a group of people? Yes. Were some of those people O'Keefe family members? And the McCabe family? Yes. I don't recall. So you go out there. You go up the big staircase. And isn't it true that there's a group congregating, waiting, and kind of filing into the courtroom? I don't recall. Well, would you say, what do you recall? About the second you got up there. About when you got up there. That second floor lobby. What do you recall? I just recall a lot of people. And they were standing around. I just don't remember if they were filing in. Was there also a court officer stationed at the door that was helping everyone in? Yes. So let's think about this. The hearing in the Karen Reed case, very, very, very highly watched case, and people wanted to get into that courtroom, right? Courtroom is full, right? Don't you think that there was probably a court officer right at the door monitoring who's coming in and where to sit? I don't know. So, Miss Catani is seated right next to Jennifer McCabe. Correct. And Miss McCabe told Miss Catani, tell them you're with the O'Keefe. You're part of the O'Keefe or with the O'Keefe family. I can't recall that. Miss Catani said just that to the court officer who was stationed at the door, right? She didn't say it to me. I would have remembered if she said it to me. She didn't say it to me. So you were with Miss Catani at the threshold of the door? I was at some point, but I don't know if I was there the whole time. Did Miss Catani say word to the effects of, I'm with the O'Keefe family? I don't remember that. Next question, objection, next question. Did you go into the court? Until that point, had you heard about the restraining order? No. Why were you on the lookout for Mr. Kearney? How did you learn about him? I knew from my prior involvement with this case as a court officer about him exactly. And you enter the courtroom. Had you had any discussions with Ms. Catani about the order, about what she wanted to have happen? I don't think it came up until we got into the courtroom. Did you know Mr. Kearney Did you know Mr. Kearney was in there as you were walking Ms. Catani in? I don't recall him being in the courtroom when I walked her in. Your memory is that Mr. Kearney came in after? I don't recall the exact order. I just walked her in. So do you remember Ms. Catani walking in? Yes, where did she go? She went and sat down on the right. She was with the O'Keefe family? Yes. And some of the other witnesses. And I wasn't aware of them by face, but she was sitting among them. Do you know the O'Keefes? I know of them from work. I know them. Do you know who the O'Keefes are by sight? Now I do, yes. Yes, I recognize that person. Do you know Jen McCabe by sight? Not really. Do you know the Alberts by sight? Not individually. So, can you say whether she walked in with them? She walked in with a group. Audio cut out. They walked alongside the ramp or they walked alongside the building and entered the building. Crosstalk. This is so frustrating. I can see why they didn't want this televised. Who was the court officer at the door when you arrived? There were multiple court officers at the door. Ma'am, I'm going to show you some pictures and some still photos to you, and then I'm going to ask you about them. Okay? Bradle putting up exhibits. This is the same testimony from two court officers, basically. So apparently one court officer was in the court when Aidan left. One court officer walked Lindsay in. And we're still in some kind of oral argument in the John O'Keefe and Karen Reed trial that we'll listen to during the lunch. I don't know why Bob Alessi is wearing black gloves. What is that a picture of? It's a picture of the courtroom that day. Can you tell us if that's a picture of Miss Katani in the courtroom? I can't see everyone's face. I don't know. Does that refresh your memory about who was in the courtroom and in what order? No, I can't see people's faces in the picture. How about if we watch this? How about this gentleman? Do you recognize him? I don't know. Now, do you see the court officer by the door in the picture? Do you agree with me that the court officer is near the door? Yes. Oh, I can see why they don't want this broadcast. It's their own court staff having to testify. Do you see that? Do you see the photograph of the courtroom? Yes, I do. Can you ascertain from the photograph that that's a photograph of excuse me? It doesn't work that way. It's either yes, no, or not sure. I'm not sure. Just for purposes of identification right now. It's either front, left, second, back. Can you see the rows of benches? Yes. So I'm going to direct your attention to, do you see this woman right here? Is that Miss Katani? Yes. Is she in the second row of that photo? Yes. Is Mr. Kearney in that photograph? I don't know. I invite your attention right here. Is that Mr. Kearney? Yes. Is he seated and also walking out in these series of photographs whenever this is? Yes. Are you in the photograph? I don't know. Nothing further. Redirect? No redirect, Your Honor. That witness is done. Next witness coming up in the Aidan Kearney case. Megan Albert is being called. Megan something? Folks, quiet please, says the court officer. This is fascinating, folks. We are on the third witness of the Aidan Kearney case. We're not being allowed to broadcast it. No one can cover it except I'm the only one who can cover it, and I'm reading you a transcript verbatim as it's happening. I'm listening to it. Good afternoon. Can you introduce yourself to the court, please? Megan Nallon. Spell, please. Mallon. Could you spell your first name? Meghan. Thank you very much. Miss Mallon, are you employed? Yes. Tell us what you do. I'm married. I want to direct your attention to February 26, 2024. I was headed to... What is... Come on. I was going with my family to the Karen Reed trial. My brother, my other brother. I wonder if this is Megan McCabe with a new name. It's Colin's sister. So this is Colin. This is the woman who has the video of Aidan Kearney violating the order. She's taking the stand. Wow. Why were you going? We were there to show support for the O'Keefe family. Was there a plan to what you would do when you got there? Yes, we met in the back of the parking lot. And then we gathered together to walk in. Did you know then who was going to be there? I knew of Lindsay Gattani. I didn't know she was going to be there. Were you expecting her to be there? I didn't know if she was going to be there. After you met her in the back parking lot, what happened next? We headed towards the courthouse. So we walked past the Registry of Deeds, and was there a crowd outside? Yeah, there was a crowd, but we walked into court. Could you describe generally the scene? A lot of yelling, a lot of angry people. A lot of people screaming things, just yelling obscenities. But you cross the street as a group? Yes. How did you get into the courthouse? We walked up the handicap ramp, and at that point we were waved into the front door. Yeah. So what happened then? Then our group went in, and then the next group went in. And now at that point, had you been introduced to Miss Katani? Not at that point. Now, so you came in, we went through the metal detector, and then we went upstairs to the courtroom. And then we sat on the right side of the courtroom. All right. And the courtroom was jam-packed? Yes. So we were held back as the courtroom filled. You were held outside the courtroom. Was there anyone with you? No. So at some point you were led into the courtroom? Yes. Did you go in? Yes, I went in when I was led in. And where did you sit? On the right side. Towards the front. At some point did you observe Miss Katani arrived? Yes, she entered and sat on the right. About how long after you entered? I don't know. Do you recall where she sat? Yeah, towards the front, I believe, in one of the first two rows. Now, are you familiar with the term with the defendant? Yes. How are you familiar? He has covered the Karen Reed trial, and from the so you've seen his various coverage? Yes. Do you know what he looked like? Yeah. Did you see him in the courtroom that day? Yes. And how would you describe him? I saw him outside the courtroom, trying to get in. Where were you when you saw him? I was at the top of the stairs behind him. Yep. I was at the top of the stairs behind him. What did you observe? He was trying to get in the courtroom. Yep. At some point, did you see him leave? Yes. Was that before or after you saw Miss Katani? Before. When you entered the courtroom, do you know if he entered the courtroom or came in alone? With some people. He was sat to the left, on the left side. Yeah. At some point, did he move from where he was? And tell us what you observed. He, after the stood up, said something, said something. I didn't hear what he said, but it was along the lines of the F word or something like that. So he got up at that point? Yes. Yes, I saw him walk out the door. After Mr. Kearney left, did you leave? After maybe an hour later we left. It wasn't long. And at the conclusion of the session, what did you do? We walked out of court together as a group and walked downstairs. And you say that was the people you walked in with? Yes. Yes. Miss Katani was in the group? Yes. And how did you leave the courthouse? We walked out the main door and then walked down the ramp and walked towards the parking lot. Did you have your cell phone? Yes. At some point, did you make a decision to do something with the cell phone? Yes. I noticed that on the walk-in they were screaming at us, so on the way out, I had my cell phone. So, at some point you took out your cell phone? Yes, when we got to the bottom of the court stairs. And did you start recording? I eventually... Okay. Do you remember who was behind you? No, I don't. I believe my brother Colin was right behind me. Do you have a specific memory? Yes. Yes. I remember walking out. As you were walking out, what was it that you were trying to record? The crowd. They were yelling. And were you particularly looking for Mr. Kearney when you were recording? No. So you weren't focused on Mr. Kearney when you were recording? No. You were trying to record the crowd? Yes. So you go out, and what did you do? I walked down to the right, and then walked towards the Registry of Deeds parking lot. I was between the district court and the Registry of Deeds. And I was... Was there a crosswalk? Yes. Down the side alley. Could you describe the side alley? Is that the alley of the street between the district court and the Registry of Deeds? Yes. Now, at some point, do you stop? Yeah, yes. At that point, walking down the street, I stop and turn around. And you turn around. Yes. We turn halfway. I want you to start, once you start videoing, what do you do then? We head to the back where we all had originally parked, and then we got in our cars. What happened while you were at your cars? At that point, attention was drawn by several people to that her car was damaged. And did you observe the damage? Yes. And what was the damage like? I advised them to call the police when I saw the damage. Now, did you call the police? I just suggested I didn't actually call the police. I have... No, I don't know. I don't know who called. Were you there at the point that the police officer arrived? No. So at that point you went home? Yeah, I went home. Okay. One moment. Okay. A video is preparing to come into evidence. Your Honor, we'd like to play this video that this witness recorded. No objection, says Mr. Bradle. Okay. Video is being played right now of Aidan violating the order. It's being played right now in district court, ladies and gentlemen. All right. So would it help if I directed? Okay. Can you play this? Okay, it plays. Okay. Now we're going to put it up on the slide, and I want to just have you, if you could. Okay. And the video up on the screen. Yes. Is this the video? Yes. Lots of screaming. Not really. More like yelling in the background. The video lots of yelling. Oh, goodness. Lots of screaming now. The video seems to include people yelling. It's lots of yelling. It's playing in the district court now. Lots of screaming outside the Superior Court. You can hear the video being played right now in district court, folks, in the Aidan Kearney trial. Don't worry, we're going to catch up on all of these with this witness testimony in the Reed case. You can hear chanting echoing throughout the Dedham District Court during the Aidan Kearney trial. The state's case in chief during the Aidan Kearney trial is going on. We are blacked out from covering it. We're only allowed to describe it to you. Right now, a video is playing of the moment that Aidan was caught on video outside the Registry of Deeds near Lindsay Gattani. Ladies and gentlemen, this could be the evidence that sees him convicted. Here we go. These are the moments, ladies and gentlemen. I'm listening right now. I hear the video. Okay, now the group of witnesses, including Gattani, are away from the protesters. The video is still playing. Oh, no, you can still hear some yelling in the video. The video is still playing. This is the primary piece of evidence in the Aidan Kearney trial other than Lindsay Gattani's testimony. I think a sequestration order is entered as well, by the way. So, not that I have anyway, but I won't be talking to Lindsay during this trial. I'm expressly prohibited by court order from talking to Lindsay Gattani. Okay, now we hear more yelling. The primary piece of evidence in the Aidan Kearney case is being played right now. I'm listening live, ladies and gentlemen. I have my towel headphones on. The video that's being played includes lots of Karen Reed fans in the background. This is clearly the witnesses leaving the case, leaving the Aidan Kearney, leaving the Karen Reed case on 2/26/2024 after the hearing ended. It's at least 2 minutes now, ladies and gentlemen. It seems that this witness filmed the entire walk. It seems from the courthouse steps all the way across the street and then down the side street. I'm still listening right now. My name is Grant Smith Ellis. We're reporting live on the Aidan TurtleBoy Kearney case, which is in session right now in Dedham District Court. I can report to you that the main piece of evidence in the case is being played right now. 3 Commonwealth witnesses have taken the stand. This is Colin Albert's sister, and the court has just watched a video of Mr. Kearney violating the order, allegedly, that was in place on 2/26/2024. Now, obviously, you see up there, ladies and gentlemen, there is... Oh, hold on. Question from the prosecutor. Question from the prosecutor. Did you film this video? Yes. And were you able to identify that video as, including Mr. Kearney at varying parts? Yes. Objection overruled. What I'd like to do is play and stop the video at a certain point. And then I'd like to slow play the video to indicate what is now the point where I'd like you to the point where I'd like to cue the video is based on my acuity, so allow me some time to cue it up. I have no objection. What are you requesting, Mr. Bradle? I'm requesting that the video not be played in slow. Well, Mr. Bradle, pause. They're debating about whether the video should be played in slow motion in the Aidan Kearney trial. Hold on. Oh, they're at sidebar. Sidebar. Hold on. Okay, the video is now being played. So can you identify, it's a little bit hard to see, but can you identify this part of the video slowed down? Yes. And at this point, can you see? Yes. Yes. Can you, is that Mr. Kearney in the video? Yes. Can you identify Mr. Kearney? Yes. It's incredibly hard to hear. This is incredibly frustrating. Now, I'd like to take a marker and set a marker at this point. Okay. Now, I'm showing you a photo. Does this photo fairly and accurately depict the frame from the video in question? Yes. Yes. Cosgrove introduces a picture still frame from the video when Aidan is clearly in the bushes. No objection. Objection, foundation. Overruled, appreciate the objection. So that comes in. This is not looking good for Aidan. This is a judge trial, a bench trial too. All right. So, can you all right, they're playing, it sounds like they're playing the video again. This Aidan Kearney case is very frustrating to cover, but I see why they didn't want a lot of coverage on it. It's very sensitive. All right, so they're watching the video again. Now we seem to be watching the video in slow-mo, the specific part where Aidan was violating or allegedly violating the order. It's a little bit difficult to tell exactly what's going on because the witness they don't always describe what section of the video they're playing, but the witness has been identifying various and slow-mos of the video. Bradle, Aidan Kearney's lawyer, keeps trying to object to this evidence coming in, but it is not working, ladies and gentlemen. Every single objection Bradle has attempted to levy has failed. And so now we're watching the video, I'm pretty sure, of Aidan violating the order in slow motion. Just incredible moments. I can't believe that I'm in two courtrooms simultaneously. I'm sorry, we're going to have to wait for about 7 more minutes for the opportunity to get caught up on the Aidan, to get caught up in the Reed case, because we're going to have to do that at lunch, ladies and gentlemen, because I am in the Aidan Kearney courtroom digitally right now. I don't know if we're watching a video or at some kind of sidebar, but I'm listening very closely. So, the first 3 witnesses in the Aidan Kearney case have indeed taken the stand. Little Towel is listening closely. We might be having some kind of sidebar. We could also be watching a slow-mo video. It is a little bit tough to discern because it's very hard to hear what's going on in the court. Okay, here, Bradle. I think that was no further questions from Cosgrove. I'm not sure, though. Stay with me, ladies and gentlemen. I've never had to literally monitor a trial from a Zoom before. This is incredible. All right. Not really sure what's going on here. Waiting to see exactly who's going to step up to the mic next. I think that might have just been the end of Cosgrove's direct. 1 second. Without characterizing, just tell us, what do you see? Mr. Kearney's to the left of the tree in the video. Okay. Does this... Wow, they had a long sidebar. Do you recognize this as a still from your video showing Mr. Kearney in that position? Yes. Objection. Overruled. What do you recognize the photo to show? It's a still from the video. Does this fairly and accurately depict the video in a still frame? Yes. Okay, no further questions. I think no further questions. Hold on. Bradle rose for an objection of some kind. Now, at the risk of at the risk of asking the obvious, is Mr. Kearney in the same position as earlier in the still photo? He moved forward. And as we are looking at this picture, what part of your group is moving in which direction? Now, as we move to the right, as you move to the right filming it, Mr. Kearney is walking towards you. Yes. Now, when you look at this picture, Mr. Kearney moves left to right. Yes. Mr. Kearney is walking towards the district court. He's following in the direction you're going. Yes? Correct. Now, not a different direction from the way you were, and Ms. Katani was moving, or the same? The same direction as Katani and I were moving. So, now, again, can we look at the slide only if we can? Okay? Only if we can. Oh, hold on. I'll get you back to the Karen Reed case. Apparently, we have... So, Mr. Kearney, can you describe where Mr. Kearney... Can you describe how the camera has moved at this point? Yes, as I walk, the camera pans to the right. And does Mr. Kearney? I'm going to show you this photo. Is that a photo you previously seen before? Yes. Does that photo fairly and accurately depict what's up there on the screen and what you've seen before? Yes. Previously, you identified Mr. Kearney. Yes. Now, the location I'm pointing on the circle, is that Mr. Kearney? Yes. Objection, Your Honor. Bradle's making an objection. No. Bradle's objections overruled. They go ahead with the picture evidence. They now display on the screen a picture. All right, ladies and gentlemen, this is incredibly frustrating. We are going to watch this voir dire, actually, and I will report what goes on with the Aidan Kearney case. It's coming to a close for the day. We're going over to the
education, training,
case.
Background, and experience, which is going to take a minute.
Yeah, no, just focus on the foundation for the dog bites and focus on the foundation for what's been termed to be perhaps biomechanical engineering evidence, those two areas. And if there is support or methodology in Dr. Lapisada's resume to point to exactly where that is. Okay? And I expect this whole voir dire should take no more than 15 minutes.
I'll do my best, Your Honor. Doctor, could you please state your name for the record? Spell your last name into the record, please.
Yes, Dr. Elizabeth Lapisada. That's spelled Laposata.
Dr. Lapisada, what do you do for a living?
I'm a medical doctor subspecializing in forensic pathology.
Dr. Lapisada, I'm going to move very, very quickly past the bulk of your training and experience over decades. I'm going to ask you a couple of quick questions. Where did you get your medical degree?
University of Maryland School of Medicine.
And do you have any subordinate degrees to your medical degree?
Yes, I have board certifications in anatomic and forensic pathology.
How long have you had those board certifications?
Like 35, 40 years.
Have you ever worked as a medical examiner in any capacity?
Yes, I have.
Have you ever worked as a chief medical examiner for any agency or governmental agency or state?
Yes, I have.
Describe that for the court, please.
I was a chief medical examiner for the state of Rhode Island for 12 years.
How many autopsies would you say in general that you have conducted yourself?
Over 3,000.
How many autopsies in your experience as a supervisor in one capacity or another would you say you've supervised over your tenure?
Over 7,000.
Of those 7,000 that you have supervised, have any of those dealt with motor vehicle incidents?
Many.
Have any of those dealt with motor vehicle and pedestrian incidents?
Many.
Give me an idea, if you have a number in mind, how many motor vehicle pedestrian autopsies you have been involved with, either directly or from a supervisory standpoint.
Hundreds, over 500 at least.
Do you have a significant background and training in the cause and manner of death?
Yes, I do.
Is that the main goal or the main job or duty performed by a medical examiner?
Yes, it is.
Is it also significant in terms of supervising other subordinate medical examiners who may work under your charge?
Yes, you have to make sure they're doing it right.
Is there a methodology that you have employed and that is standard in the industry to employ, including differential diagnoses and inferential thinking in terms of coming to conclusions related to manner and cause of death?
Yes.
Can you explain that for the court in brief, please? I know you probably have a very lengthy explanation. Okay. Do it as briefly as you can, with being as succinct as you can.
Certainly. To determine cause of manner and death, we look at scene investigation, autopsy findings, police and witness statements, and medical history. And using that information, we come up with a differential diagnosis or a list of things that might have happened to that person to cause them to die. And from that list, then we see where all the science and all the data, which one it supports. So we've looked at several different things. I always told my staff, I said, how can we be wrong? What else could this be? So you have to make what in medicine is called a differential diagnosis and then see what the facts support.
Did you employ a differential diagnosis in this case?
Yes, I did.
Do you have to be at the scene in order to understand or analyze information that you get in a police report or photographs or things of that nature?
No, then we use the police investigation and scene investigation, crime lab reports, photographs taken by the crime lab, by the police at the scene.
Have you qualified as a expert forensic and anatomical pathologist in other courts in Massachusetts and other states?
Yes, I have.
Approximately how many times would you say you've qualified?
Hundreds.
I want to talk for a specific for a second about a specific area of interest for the court. Were you provided information and photographs of John O'Keefe's arm and his arm injuries included with the rest of the autopsy information that you received?
Yes.
Were you asked to make a determination about the nature of the wounds specific to his right arms? I know that there's other injuries to Mr. O'Keefe, but I'd like to relegate your attention to the right arm.
Yes, absolutely. That's what the forensic pathologist does.
Without telling me what your opinion was, were you able to come to an opinion or conclusion about the source of those injuries?
Yes, I was.
What methodology did you employ to come to that opinion or conclusion, or those opinions and conclusions?
My experience and knowledge and training, along with the appearance of the wounds on the right arm, which fit a pattern, and then knowing that it fits a pattern, then I can try to look for, okay, what is the item that caused this pattern? And that would be part of the differential diagnosis that I've used for many, many years in making diagnoses and determinations.
Have you ever been trained in pattern recognition?
Yes.
In what capacity?
Oh, as a forensic pathologist and medical examiner, a large amount of our work has to do with recognizing pattern injuries, because that's so important, because it gives us an idea of what might have caused that injury. And then that's clearly of a lot of importance to the police and the investigators as they're trying then to say, well, what could have caused that injury? And so the forensic pathologist could say, well, I think it was X or Y. Then they can carry out their investigation armed with that information as to what might have caused the injury on the body.
Is there such a thing in the world of pathologists as medical literature or academic literature that deals with pattern recognition?
Yes.
Are you familiar with some or most of those publications?
Absolutely.
Have you ever yourself taught classes on pattern recognition?
Yes.
At what level? High school, graduate school?
At the medical school level.
How often have you taught courses on pattern recognition?
Oh, at least a handful.
When was the last time you taught a course in pattern recognition?
Let's see, last month.
Do any of the courses that you've either taken, well, let's take them one at a time. Have any of the courses that you've ever taken dealt with wound pattern recognition as it relates to animal wounds?
Courses that I've taken?
That you have taken.
It's part of our basic training and understanding of a forensic pathologist. The board exams we take test for that. Those injuries are described in our basic forensic pathology and medicine textbooks. They appear continually in our medical and scientific journals.
Is that an important skill set to develop, wound pattern recognition as it pertains to animals as a forensic pathologist?
Absolutely.
Do any of those academic courses that you've either taken or reference works that you just referred to, do any of those deal with dog bites and claw marks specifically?
Oh, yes, they do.
In the course or courses that you have taught related to wound pattern recognition, have you ever taught on the subject of dog bite wounds and the recognition of dog bite wounds?
Yes, I have.
When was the last time you did that?
Let's see, it would be in the course in the medical school. Would have been several years ago.
Doctor, with regard to staying with dog bite wounds specifically, have you ever performed an autopsy that specifically dealt with dog bite wounds, known dog bite wounds?
Yes.
So you've seen them in person?
Yes, I have.
Have you ever been qualified in any court in the land, state or federal court, on the issue of wound pattern recognition as it pertains to dog bites?
Yes.
When was that?
The last one I can recall was a federal case involving questions of a police dog.
Did you engage, in that case, did you engage in a differential diagnosis to determine, in your opinion and conclusion, your expert opinion and conclusion, the source of the wounds that you saw?
Yes.
Did the court qualify you to speak on that issue in court?
Yes.
Did you, in fact, testify in furtherance of your opinions and conclusions in that case?
I did.
I want to turn for a second to motor vehicle accidents or motor vehicle incidents. Do you also, some of the same questions, have you also performed autopsies on known motor vehicle pedestrian incidents?
Yes.
How many times would you say you've performed an autopsy on those issues?
Hundreds, maybe even 1,000.
Is that a relatively common occurrence, as sad as it may be, motor vehicle pedestrian incidents in the field of forensic pathology?
Yes, it is, unfortunately.
Have you performed autopsies personally as well as supervised autopsies on motor vehicle pedestrian incidents?
Yes.
And what methodology do you employ in furtherance of coming to opinions and conclusions regarding cause and manner of death specific to motor vehicle pedestrian incidents?
Well, we look at the scene investigation. We look at what the motor vehicle looked like. We look at the hospital records, the autopsy, and then trying to understand how the injuries that the pedestrian sustained, what those mechanisms were, and how the injuries show that that person interacted with the motor vehicle.
In doing so, in coming up with injury mechanism analysis, is it important to look at and analyze the actual vehicle that is allegedly involved?
Yes, you want to look at photographs of that or see it in person.
Is that part of the normal methodology that is employed in the field?
Yes, you must look at the photographs. You must see what the vehicle looks like.
Do you also look at the other side of that handshake? In other words, look at the body of the individual that was, in your case, killed, the decedent, in order to marry the two and determine whether or not the cause and manner of death had something to do with the motor vehicle impact?
Absolutely.
Describe that for us, please. What are some of the things that you look for that's part of the normal methodology that a forensic pathologist employs?
Well, when we examine a fatality from a motor vehicle, we want to try to understand what led up to it, how the impact occurred, and then what happened after. So we would study information about the injuries to see if we can relate them to certain pattern injuries that would be on the car. There are also evidence of transfer of energy and injuries that can result from the transfer of energy. So using the body, looking at the scene and the vehicle, understanding the motions of the vehicle and how they would have produced or would not have produced certain injuries on the body.
I'm going to take them one at a time. With regard to animal wounds or dog bites, were you able, in this case, using differential diagnoses, using inferential thinking, and using the skills that you've developed over decades of your education, training, and background, were you able to, without telling me what the conclusion is, were you able to come to a conclusion or opinion as to whether or not the wounds that you saw on John O'Keefe's right arm were consistent or inconsistent with a dog bite or claw marks?
I was able to come to a definite scientific conclusion.
And is that conclusion to a reasonable degree of medical certainty?
Yes.
Is it to a reasonable degree of scientific certainty?
Yes, it is.
Is it consistent with the training and methodology that you've employed over decades?
It is.
I'm going to ask you the same series of questions with regard to the motor vehicle incident. Did you review the autopsy report in an effort to look at John O'Keefe's entire body and all of the injuries that he sustained, not simply his right arm?
I looked at everything.
In doing so, were you able to come to an opinion or a conclusion as to the mechanism of injury and whether or not his injuries in total were consistent or inconsistent with a motor vehicle incident or impact?
I was able to come to a scientific conclusion.
And without telling me what that scientific conclusion is at this point, Did you employ the same methodology that you explained to the court earlier concerning differential diagnoses, inferential thinking, and decades of training, the education, training, and background that you've described for the court in coming to your conclusions about whether or not the cause and manner of death was consistent or inconsistent with a motor vehicle impact?
Yes.
Your Honor, is there any area that I have not covered to the court's satisfaction consumption?
So I'll let Mr. Brennan ask questions. I may have a couple of questions.
Thank you.
Good afternoon, Dr. Lapisada.
Good afternoon.
If we could start with dog bites.
Yes.
Did you have any specific training in wound pattern recognition regarding dog bites?
Yes, it's in our literature standard textbook. It's standard information that is needed to be a forensic pathologist.
When did you receive training regarding pattern recognition of dog bites?
Beginning when I took my board, started in 1983.
And what did that entail?
It entailed reading literature. It entailed reading the standard forensic pathology and medicine textbooks. And it is a sub-part of understanding pattern injuries. Dog bite injuries are described in all our journals and all our standard forensic textbooks.
Other than reading about it when you were studying for your boards, did you have any practical experience where you were engaging in the field in pattern recognition analysis regarding dog bites?
Yes, yes. I've had many cases where there have been dog bite injuries.
When you were studying for your boards, were you doing that, or after you completed your boards?
I'm telling you that it's such a basic part that during studying for boards, it's a section that we study. And I, of course, had many cases since then.
Did you receive any education past reading literature for the boards, where you took classes, seminars, where it taught specifically wound pattern recognition regarding dog bites?
It's all part of wound pattern recognition. It's usually included in literature. If there are lectures about patterned injuries, it's a subset of pattern injuries like hammer injuries, like gunshot wounds, like baseball bat injuries. There's a huge number of types of patterned injuries that are part and parcel of what a medical examiner has to understand and diagnose.
Do you remember taking any specific classes or any specific training about wound pattern recognition relative to specifically dog bites?
Yes, it's in all the literature that I keep up with.
Did you take any training or did you attend any classes that involved wound pattern recognition of dog bites?
Yes, it's often included in our seminars and case reports.
Do you list any of those classes or seminars on your resume?
That I took? No.
Can you identify one of those classes, where it was, when it was, who taught it, what the name of it was, regarding wound pattern recognition relative to dog bites?
I can't give you a specific time and date.
Can you remember the name of the last class or seminar that you took or completed that has to do with wound pattern recognition relative to dog bites?
I can't recall.
Is there anything in your report that identifies any of your specific education or training on wound pattern recognition as it relates to dog bites?
It's in my CV. It's basic knowledge that a forensic pathologist has to have.
I will ask you about the CV, but Dr. Lapisada, I just wanted to ask you about your report first. Is there anything in your report that points to any specific training?
In the report that I wrote on this case?
In your report relative to wound pattern recognition as to dog bites. Is there anything in your report that identifies that for us?
In my report, I put together the case of what happened to Mr. O'Keefe.
Okay. As far as your experience, though, do you ever make any note in your report about your specific experience and training about wound pattern recognition for dog bites in your report?
No, it's not appropriate.
In your CV, is there any way you can point to us where you had specific training for wound pattern recognition relative to dog bites, where we can see that on your CV?
No, it doesn't say dog bite training specifically, no.
Do you have anything on your CV that specifically talks about wound pattern recognition for animals?
Those are usually classified within other pattern recognition.
Do you have anything specific that would alert us in your CV that you've had such specific training on wound pattern recognition for animals?
Other than I've passed my board exams and have practiced for 40 years.
Have you provided a list of cases where you have testified in court specifically about wound pattern recognition of dog bites?
I don't know if I have given a list. I don't keep those kinds of lists.
You mentioned one case about law enforcement dogs in federal court. When was that case?
Several years ago.
How long would you say, if you had a guess?
How long was it ago?
Yes, please.
A couple years, around COVID time.
Did you testify in that case about law enforcement police dogs?
I testified about an individual who had injuries, and there was a question as to whether Canine Caper, who was the dog's name, inflicted any injuries on this person.
And this was in Boston federal court?
Springfield, yeah, Boston, right.
Is there a difference between law enforcement dog bites and domestic dog bites?
They have the same kind of dog jaw.
So you would say
they're taught differently, obviously.
Would the wound pattern recognition be the same or different if you were looking at it from a law enforcement dog perspective or a domestic dog perspective?
The dog would be the same.
Do you have any other cases that you've testified about wound pattern recognition relative to dog bites?
I've testified in hundreds of cases. I can't say that I remember any particular ones.
Would you be able to identify any of those for us today?
No, too many.
I'll ask you about accident reconstruction experience. And I mean this respectfully, you don't have a biomechanical or a biomedical engineering type background, do you?
No, I'm not a mechanical engineer.
And you're not certified by ACDAR or any of those type of organizations, are you, Doctor?
No, I relate the injuries on the body to the motor vehicle.
Have you ever been to a car collision scene and investigated a car collision scene firsthand?
Yes.
And when you've done that, do you have a chance to look at all of the physical materials, the properties?
Well, when I go to a scene of a motor vehicle fatality, I look at the pieces that are scattered around. I look at the body. I look at blood stain patterns. I look at damage to the car. And then the body would go back for the examination at the medical examiner's office. And there would be further examination of the scene by accident reconstructionists and examination of the automobile by specialists who could figure out what motor vehicles do. So it's a part of correlating the injuries to the vehicle.
You've never written an accident reconstruction report yourself, have you?
No, that's not what I do.
I understand. In this case, what materials did you look at? Because I don't think in your report it mentions the materials that you studied. What materials did you study as the basis for any potential opinions regarding accident reconstruction?
Well, so you would like for me to tell you everything I studied in this case?
Yes.
I have my list here. Should I read
That's fine by me.
Okay. I studied the autopsy report, neuropathology report, toxicology, and associated paperwork from the medical examiner's office. I studied 104 autopsy and neuropathology photographs, 70 additional autopsy photos taken by Trooper Watson. I studied Mr. O'Keefe's medical records from the Canton Fire Department and EMS run sheet. I studied the Good Samaritan medical records that also included 35 photographs of the body. I looked at evidence of Mr. O'Keefe's clothing, blue jeans, t-shirt, sweatshirt, boxers, and sneakers. I'm sorry. I looked at photographs that were taken at the crime lab of various pieces of plastic, black, red, and clear. I studied photographs of the outside of Ms. Reed's SUV as it was parked at the police garage. I studied the Canton Police report, incident report, about 100 photographs taken by Canton Police of the outside scene. So that gave me a very good idea of what happened to Mr. O'Keefe.
Were you involved in a case, Cromwell versus Daniel Tompkins?
Remind me about that. I've been involved in hundreds of cases.
Yes, you have. This case was in Franklin County Superior Court. It was a case where you had an opportunity to present testimony and regarding blood spatter, which you have been qualified expert for. I'm sorry.
Well, that doesn't quite say what I did, but I remember the case you're talking about.
Did you attempt, or was there an attempt to have you qualified to talk about accident reconstruction in that case?
No, I'm not an accident reconstructionist.
And do you remember whether or not there was an attempt that was denied to try to have you talk about accident reconstruction in that case?
I have no idea. I'm not an accident reconstructionist.
Okay. Do you have anything on your CV specifically that offers any background on accident reconstruction or accident reconstruction type classes or seminars?
I don't think so.
All right. Thank you, Dr. Lapisada.
No, you're welcome.
So can I just ask Dr. Lapisada about, you said you've been involved in autopsies with dog bites.
Yes.
How many?
I've done thousands of cases, probably 50 or so. It's not always the cause of death. And then I've supervised maybe 75 more where that dog bites were involved in the case.
When was the last one?
Let's see, probably 2 years ago.
Okay. Any questions based on my questions? All right. You are all set. I'm going to ask you to step down, Dr. Lapisada. We'll get to you sometime this afternoon.
Okay. Thank you, Your Honor.
I do want to give everybody a break, including counsel. Can we do less than 5-minute arguments on this?
What do you mean? We can just go all day, Judge Canoni. I'll stay up overnight.
I'll make this very brief.
Okay.
Dr. Lapisada is eminently qualified to speak to both the issue of wound pattern recognition as it relates to dog bites, specifically, as well as cause and manner of death as it relates to vehicle pedestrian incidents or impacts. The doctor has an incredibly impressive resume, just a touch of which we reviewed during the course of this voir dire for her qualifications. But with regard to the dog bite specifically, she talked about the differential diagnosis that she undertakes and undertook in this case. She talks about the inferential thinking that she undertook in this case. She talks about how that is the proper methodology in the scientific community and specific to the forensic pathology community in order to come to a determination about wounds and the source of wounds, i.e., was it a dog, was it a another animal? Was it another source? Was it lacerations versus abrasions, things of that nature? She's obviously done, as she indicated, thousands, if not climbing real close to 10,000 autopsies that she's either supervised or that she's conducted herself. She actually has, notably, as per the court's last question, she's actually undertaken personally somewhere close to, I thought it was probably 5 autopsies herself dealing with dog bites. They're not always the cause of death, but sometimes it's attendant to the injuries that led to a different cause of death. But she's undertaken at least 50, or that's what she estimates, 50 of those autopsies herself. She's seen dog bites, she's seen dog wounds, she engages in pattern recognition. She also teaches classes on pattern recognition as it pertains to dog bites, and she's eminently qualified to speak to that in this particular case. She has been able to come to an opinion and conclusion as to whether or not the injuries to John O'Keefe's arm are consistent or inconsistent with dog bites, and I expect that she would then give that opinion and conclusion to a reasonable degree of medical certainty and to a reasonable degree of scientific certainty. As it relates to her differential diagnosis and her ultimate conclusions concerning the automobile impact, obviously many, many, many more autopsies dealing with that because it's more common. She also engaged in the exact same differential diagnosis. She has training. The subfield of, or the sub-issue of vehicle pedestrian impacts is included and subsumed within much of the medical literature that she's been taught on, going all the way back to the 1980s, dealing with her boards, and she's consistently passed her boards. She's consistently kept up with the literature. She's consistently engaged in autopsies herself, so she has firsthand training. She also trains other medical professionals, other doctors, other medical examiners, and she supervises other medical examiners. She's been the chief medical examiner for an entire state. I cannot imagine somebody more eminently qualified to talk about the 2 subjects that she's been called to talk. Well, she's called to talk about several other subjects, but these 2 subjects that's before the bench right now than somebody with Dr. Lapisada's qualifications. I will submit on the voir dire that we just completed.
All right, thank you, Mr. Brennan.
I do not think that Dr. Lapisada has articulated the experience the way it's been summarized. She could not provide any specific training other than her boards and her references to literature. She could not articulate one single class or seminar that she took that pertained to differential diagnosis of dog bite injuries. She has no specific memory of having any type of experience in differential diagnosis as far as being in a training, seminar, or advanced education. She has the experience of a medical examiner who has seen what she believes to be dog bites in the past. She has no publications or references that she has studied the issue of differential diagnosis or pattern wound recognition relative to dog bites. If we look at the standard Dr. Russell employed, Dr. Lapisada does not have any of the merit to be an expert in dog bites. While she has taught, we did not hear about anything in particular that she has taught about specific pattern wound recognition analysis regarding dog bites. She is an experienced medical examiner, has a wealth of experience, past experience in autopsies, but she has no experience that is a basis for her as an expert in being a dog bite expert. Particularly, she mentions one case that she's testified in federal court that we've heard of today, and she has nothing whatsoever in her report or resume to establish that she has used, studied, and knows this methodology. In fact, her CV and her report don't have any basis for one to look at and see that she has any specific experience in dog bites. And so Dr. Lapisada, from the Commonwealth's perspective, should not be able to give an opinion regarding or about whether or not the wounds on Mr. O'Keefe were caused by a dog. She simply does not have the training and experience and education and methodology to make her a so-called dog bite expert. Regarding accident reconstruction, she said it best. She is not an accident reconstructionist. She saw some of the materials in this case, but it is a fraction of the materials in this case. She is not in a position to give an opinion whether or not the wounds are consistent with broken taillight. There is nothing we see on her CV. There's nothing we see in her report. There's nothing we heard on direct examination that she has any experience in breaking glass, breaking plastics, and the causation of wounds. It also overlooks the fact that the opinion that would be offered would extend beyond just the wounds on the arm. It would extend to a general opinion that he was not involved in a collision, and that's improper. There's no predicate or basis for it. And so based on her testimony and absence of being able to provide any education or experience, she should not be able to testify about either of these two matters.
Okay, thank you. Okay.
Mr. Brennan suggests that she's only been qualified in one court, federal court. The federal government, the federal judge that was handling that case, qualified her as a dog bite expert in that case. That is not a small thing. That is, matter of fact, it's a very big thing for Dr. Lapisada and her credentials. In addition, she indicated, contrary to what Mr. Brennan just suggested, she indicated that she has been training on wound pattern recognition as it pertains to dog bites for her entire career, not just when she was studying for her boards, since she's been studying for her boards. And it's been constant and consistent throughout her entire career. She's made these differential diagnoses. She's seen the autopsies. She's seen the wounds during autopsies firsthand, probably 50 or more. She's supervised another 75 or more autopsies dealing with known dog bite wounds. She has the credentials. The court will recall that, for instance, Dr. Isaac Wolf was called to testify by the Commonwealth. He had absolutely nothing, no credentials whatsoever to talk about wound pattern recognitions. He was a neurosurgeon, and yet he was allowed, over Mr. Alessi's objection, to talk about and to discuss his opinions and conclusions as to the wound pattern on the back of John O'Keefe's head. Certainly, Dr. Lapisada brings much, much, much more to the table than Dr. Isaac Wolf. I'm not comparing them. They're apples and oranges. Dr. Lapisada is she doesn't have to be a sole dog bite expert to be expert in dog bites. She doesn't have to be Dr. Russell. She just has to have that level of knowledge, that level of skill, that level of expertise that's beyond that of the average layperson in order to opine as an expert on a particular issue. She certainly brings that to the table as it pertains to dog bites, and I think her skill and her education, training, and background certainly speaks to the fact that she has that in spades with regard to motor vehicle pedestrian incidents.
All right. Thank you. All right, I'll get your ruling as soon as I can. So we're going to start back up at 2:20, and I expect to go straight through the rest of the afternoon.
All right, you heard it. Folks, my name is Grant Smith Ellis. I'm here with you. Don't worry, I did not abandon you. I would just like to note that was extremely intense. I have never done anything like that in my life. How did I do? I don't know if you all turned in, but I was the only person who was able to do coverage of the Aidan Kearney case involving Lindsay Gattani as the named victim. We had 3 people testify this morning, ladies and gentlemen. It was 2 court officers and Colin McCabe's sister. Not Colin Albert's sister. He doesn't have a sister. It's Colin McCabe's sister. Ladies and gentlemen, that was absolutely bombshell. I reported each, as the testimony was being said, I was saying, here's what the attorney says, here's what the witness says, here's what the judge says. That is the only way we were allowed to cover it. We were quite literally, ladies and gentlemen, prevented from broadcasting or in any way, shape, or form the Aidan TurtleBoy Kearney case. I negotiated the best that I could, ladies and gentlemen, and by negotiated, I mean I immediately caved into the court's stuff and said, okay, thanks for letting me be on the Zoom. I'll make do with what you gave me. Oh, goodness, ladies and gentlemen, what a morning. I was being a little towel. Now, my lunch is about to arrive, so we have a few things going on here, little towels. Number one, do you want to hear my reaction? I think Aidan Kearney is going to get convicted. He chose to go with a judge trial in Dedham District Court, but he got Judge Pomerol. Judge Pomerol knows Aidan inside and out. I think Aidan Kearney's heading for a conviction, ladies and gentlemen, in Dedham District Court. The trial, can we find out, ladies and gentlemen, I think Eva Towell was here earlier, is Aidan Kearney's criminal case continuing today after the afternoon recess, or is Aidan Kearney's case not picking up again until Wednesday at 11? Super towels. I also have food coming in, so what I need to do is, give me 1 second. Hold on. Why do I have just a video of a courthouse? Oh, that's from my Twitter video earlier. We need to rewatch some of that, ladies and gentlemen. All right, super towels. So we are going to rewatch some of that stuff that just went down. Give Little Towel a second here. I have to just bring it up for you on the screen, Little Towels. I have done a lot. I have pushed my Little Towel computer to the limit, but let me just tell you, we need to figure out what happened with the mistrial. We have 40 minutes. My chicken and rice, I got very special towel chicken and rice because some of you were like, Grant, you can't just eat red meat every day. So, a couple things. One, let me go over on my phone because my computer is so overloaded that it took like 10 minutes at one point for your comments to get loaded up, ladies and gentlemen. So let me just very quickly head over here. And I'm going to check on the YouTube to see what you all are saying. Did I do a good job with the TurtleBoy coverage? That was extremely difficult. I've never covered a case like that before in my life, ladies and gentlemen. I've only had one energy drink today as well. I'm going to need some towel help. Oh, I did well. Were you able to tell what was going on in the case? Alana, Wicked Uma, Leslie, all my towel friends are here. Val, Crookie Ramlaw. Oh, ladies and gentlemen, I had no idea you were all hanging out with Little Towel. I couldn't look down for hours. That was one of the most intense things I've ever seen. Ladies and gentlemen, I do need some towel help though. So if someone could help Towel figure out if the Aidan Kearney case is coming back into session at 2 p.m. or whether or not it's going to be Wednesday at 11. If we could have the rest of the day off from the Aidan Kearney case, that would be absolutely wonderful. But that's okay. If we absolutely need to cover the Aidan Kearney case today again, we will. I am a towel. I will not let Lindsay get me down even though she's sequestered and I now can't talk to her. She is in a wall, a cone of silence. She has the cone of shame on, even though that's a loving cone of shame. I'm not shaming her. She's just sequestered. And I can't talk to her. Oh, goodness. I feel so weird. I've never been court prohibited from talking to Lindsay before. Oh, thank you, ladies and gentlemen. I did, oh yeah, no, Doc V, no, that's not what slowed the stream down today. What slowed the stream down today is that Little Towel was simultaneously trying to watch the Glares feed to see if he had coverage of Aidan's case, and then I was at the same time broadcasting the Karen cam, and I was broadcasting a 1080p feed of the trial itself. So don't worry, Little Towels. We are getting a new streaming computer at the end of the month, hopefully. I got a lot of donations for it. I've talked to Murder by Maestro. We think we found a very good, well, I think I found a very good desktop box. It's a very small one. It's just built for video processing. And by our next trial, which is probably either going to be the Koberger case in Idaho or Donna Adelson down in Florida, I hopefully will have a much better dedicated streaming box. So please don't get frustrated with Little Towel's computer. This computer has served us so well, ladies and gentlemen. We owe so much to Towel Computer. It works so hard for us. Where would we be without Towel Computer, ladies and gentlemen? Just give it a little bit of grace. You know what I'm saying? Sometimes you just got to give Towel Computer a little bit of grace. Yes, I know. I'm going to the mistrial motion right now, ladies and gentlemen. I'm going right now. We got 40 minutes and I got to go get my chicken. My chicken is downstairs, ladies and gentlemen. You don't understand. So I have to go right to when the mistrial motion happens. So that's we got to go right to the moment that it happened, all right before there's the objection. Whenever that happened, that moment happened. So when we're not going to get to finish our Hank Brennan Arca cross because we have to just watch for the mistrial moment. Was it right here? Let's watch for it, ladies and gentlemen. We're going back to earlier this morning in the John O'Keefe and Karen Reed trial. I was broadcasting the TurtleBoy hearing.
Typically, if there's a taillight that shatters, so you have the taillight coming in, it's hitting the arm and it's moving forward into the arm. Would you agree with that?
Yeah,
I'm going to allow it.
In reference to the greater damage, we're talking about damage to the arm?
Do you agree with that phrase? By the arm.
Jumping forward.
It's going to move with the arm.
Okay, that was a little bit weird. So why did it just jump? Maybe the feed went down? All right, hold on. There's a little bit more questioning here. Hold on.
Forklift is going to be pushed, like this says, by the arm, by the broken taillight, isn't it?
It's going to move with the arm.
Okay, so that's a little weird. So let's jump forward. I guess there was some kind of questioning that the feed didn't catch, the law and crime feed, and then there's a long delay, and then when we came back, I saw Bob Alessi in those black gloves as I was reporting the TurtleBoy case, and like, what is Bob Alessi doing with black gloves on? He looks like a moron. What the hell is going on in the Karen Reed case? My goodness, ladies and gentlemen. Yeah, it looks like the law and crime feed got interrupted. I can't, that's just so you know, folks, that I went back on the actual law and crime feed and I confirmed that they don't have it. It's all gone. They dropped out. Miss Lisa, hello. We're about to see the Karen Reed defense move for a mistrial and lose. I'm excited. We're on lunch. The court's coming back at 2:20. I need to go get my chicken from downstairs. You all watch this and I'll watch it with you on my phone.
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to cross-examination or recross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness. Is there a reason?
This is a separate issue, and I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Alessi?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, in this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked the first document, and I want to get the specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday. And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ for identification.
Give me a minute to read this, Mr. Alessi.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes in the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court Reporter. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning, so I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor.
Okay.
The first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely,
Mr.
Your Honor.
Leslie.
So here is the back of the hoodie.
All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist, and I'm going to get to back to this in a moment. But I would like to do it and certainly entertain any of your Honor's questions, but in a logical order.
Sure. So I'm not. What about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right. Thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here in the logic. So, and I'll do it quickly. So Mr. Brennan Jackson goes up. We have no idea that this was going to happen. Goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt. To my knowledge, the first time the back has been referenced of the hoodie sweatshirt. Shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said when you said obviously cut by the criminalist? Do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What
we
have is two documents to show that.
Right. So the second one, when was that provided?
these, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe is the only one, to my knowledge, not put into evidence. Not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to YYY, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see. Point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various... Let me just get a check on this, Your Honor. I'm not...
Right. Mr. Brennan, you should come up and look at this as well.
Thank you. And I'm
So, Mr. Leslie's statement.
yes.
Right, so this is why.
Can I get the check?
Labeled cuttings.
Pardon me?
Your labeled cuttings.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing just one? Let me just make sure I get it.
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, just a second. It may have printed the wrong page. I can do, Mr. Wolf, can you print the back? And then, Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now. We wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
we have some kind of reading session?
It'll take 2 minutes because it has to go.
All right, so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can we print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see.
And I'm going to show the Commonwealth.
Jumping forward at the same time so we can see Hank.
This is a mistrial with prejudice, but I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right, so let's move along from that.
Right, that's right, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury. to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right. Thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury there to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 2022. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those 3 days? Now I see a 4th day. 5/11, 5/11/2022, 5/12/2023, and 6/18/2023. Those are the 3 dates?
Your Honor, on or about May 18th, when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's good.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instructions for Your Honor.
All right, so I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things. One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what happened.
Yes. Yes.
These holes in the
Yes.
back.
Yes.
Thing. So that's number one as part of the stipulation, and then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in. It's what I said, Mr. Alessi.
She was upset.
Okay. All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, instead of not drawing inferences, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
All right.
Just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but if we're going to put it into a bag or something like that, it might need to have it marked. But we don't need to do that right this second.
All right, so let's watch what happens when they get back. Keep talking. Oh no, and then and then they do this voir dire of one of the experts. Oh, so hold on. Or one of the experts couldn't testify or something? We're going to watch that too. We only have a little bit of time before court comes into session at 2:20. Your TurtleBoy update, by the way, the TurtleBoy trial is going to happen over 2 days. It started this morning, ladies and gentlemen, and there were 3 witnesses, 2 court officers, ladies and gentlemen, and then also, so it's 2 court officers, and then Colin McCabe's sister, someone who had filmed Aidan Kearney that day. And now I am just looking for the moments if we actually got to see Bob Alessi hold up that shirt. I think it happened at a certain point. Hold on, ladies and gentlemen. I guess it was after the voir dire of this expert. So let's just get caught up on whatever this voir dire was that happened, and then we should be ready as court comes into session at 2:20. Yeah, I don't see that last thing as a big deal, by the way. It was just mistake about where the holes in the shirt came from. Curative instruction, mistrial denied. Move on. So let's figure out what this witness needed to come to do a voir dire for.
The court and jury in the case now is here to the truth, the whole truth, and nothing but the truth, so help you God. Thank you. Thank you.
All right, good afternoon.
Good afternoon.
Go ahead, Ms. Giannetti, whenever you're ready.
Thank you. Good afternoon, sir. In a good loud voice, would you please state your name and spell your last name?
Sure. My name is John Tedeman. It's Tedeman.
Do you work, sir?
I do.
What do you do for work?
I am a private investigator.
Do you work for someone else, or do you have your own firm?
I have my own firm.
What is the name?
Forum Investigations.
And that's F-O-R-U-M?
Correct.
I'd like to ask you a little bit about your education and work history. You're from this area?
Yes, Boston proper.
I'm sorry?
Yes, from Boston.
Where did you attend high school?
The Roxbury Latin School.
When did you graduate?
1996.
Where did you go to college?
I went to Princeton University.
What year did you graduate?
2000.
What did you do after graduation from Princeton University?
I became a federal agent.
Where?
The agency or the location?
Oh, I meant the location. Sorry.
I started out in Los Angeles, and then I was back in Boston.
And what years were you a federal agent in Boston and Los Angeles?
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April.
Sorry, we got to go back to the moment Alessi held up the shirt.
All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf.
Let's listen to the curative.
Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll...
So sorry about that. We're just going to jump forward one more time to this investigator. Apparently he got sick or something, so let's just figure it out and get ready.
Odometer that measures feet and inches.
And if we could, Mr. Wolf, could we display
I'm going to jump back just 1 second.
2002 through 2008.
And what agency did you work for?
I worked for the Inspector General for the Social Security Administration, Office of Investigations.
And what type of work did you do in terms of investigations?
We did fraud investigations, identity theft, credit card fraud, fugitive operations, all sorts of things, anything involving a Social Security number, basically.
And why did you leave in 2008?
I went to law school.
Where?
Suffolk.
What year did you graduate from Suffolk Law School?
2013.
And what did you do after graduation from Suffolk Law School?
I've had a small solo law practice and worked as a real estate broker.
And what type of law did you practice?
Mostly real estate law.
When did you start Forum Investigations?
In April of 2024.
Are you still practicing as a lawyer?
Not very much, no. I still have my license, but my bar card, but I don't practice much.
All right. How did you become involved in this case?
I was contacted by somebody from your office last Tuesday, I believe, the 3rd.
Okay. And was it explained to you why you were brought in at this late juncture?
Yes, it was explained that there was another investigator who had a health issue and would not be able to testify. So would I be able to help out with a small assignment?
And what were you asked to do?
I was asked to travel to 34 Fairview Road in Canton and take some measurements and photographs.
Did you agree to do that?
Yes.
When did you go?
On June 3rd. I believe I arrived about 5:30 at 34 Fairview.
Okay, and when you say June 3rd, we are talking about last week,
Yes,
correct?
last week, yes.
Whom did you see when you got there?
One of the homeowners, an older gentleman, greeted me when I pulled in the driveway.
All right, and it was not the Albert family, correct?
It was not.
Did that individual give you permission to enter onto the property?
He did.
What did you bring with you?
I brought an iPhone as a camera, and I brought a wheeled measuring device.
All right, can you describe what a wheeled measuring device is?
Yeah, it's like a handle with two wheels at the bottom, and in the middle there's like a little odometer that measures feet and inches.
And if we could, Mr. Wolk, could we display the photo of the front of 34
so
Fairview
basically,
that's already in evidence with the court's permission?
One of the defense investigators. So the other another investigator was brought in at the last minute and measured Fairview Road. Okay, thanks. I appreciate that. What we're going to do is court to come back into session. So if you missed the update, ladies and gentlemen, Aidan Kearney did go through day one of his criminal trial today. 3 witnesses took the stand, 2 court officers, and Colin McCabe's sister. And Colin McCabe's sister introduced video of Aidan Kearney allegedly violating a restraining order by standing in the bushes outside of Norfolk Superior Court. It was a very interesting day. The only person who had, and I feel a little bad, I know you all like watching the Karen Reed case, the only person who had coverage today, ladies and gentlemen, of that Aidan Kearney case basically was me in real time, because we weren't allowed to cover it. We weren't given permission to broadcast it. So I had to listen in, ladies and gentlemen, and as I was listening in, I was relaying to you all in real time what I was hearing from the feed. It was the most interesting way to cover a trial ever. Now, I've also said that that case is very important to Little Towel. The named victim is Lindsay Gattani. So I know some of you went to other feeds and got caught up in the Reed case. That's fine. We just got basically fully caught up during lunch. We are back to real time, ladies and gentlemen. We didn't miss a thing as far as I know. Now, I do not know whether Aidan Kearney's case, I think it's done for today. I think we're coming back Wednesday. So we're going to keep an eye on that, ladies and gentlemen. And then we're also going to go over to other Karen Cam screen. We are about to come back in session after lunch in the John O'Keefe and Karen Reed retrial. The Reed defense lost their motion for a mistrial. And by the way, ladies and gentlemen, send our special towel prayers out to the Super Towel Jew Drops, who is in the hospital overnight with food poisoning. We love you, Super Towel at Jew Drops. And also, ladies and gentlemen, before we come back into session, can we send a special? You know what it's going to be, ladies and gentlemen. I think it's day 6 now of keeping track. Oh, goodness, Towel Friends. Are we about to see 5-1? Oh, Towel Friends, I think we're about to see it. 5-1, ladies and gentlemen. Look at that. You did it. The Super Towel Friends did it. Look at it on your screen, little towels, as we get ready for court to come back into session. Ted, pink down to his underwear Daniels, can eat his heart out, ladies and gentlemen. I broadcast 2 trials simultaneously. We are fully caught up. I got all the Towel Friends hanging out in the chat. And ladies and gentlemen, I am thrilled to announce to you that Ted Daniel can eat his heart out, ladies and gentlemen. 24.4 thousand for Little Towel stream, to 14.4K to Boston for Boston 25. It is now 5-1, ladies and gentlemen. We have decimated pink down to his underwear Daniel, ladies and gentlemen. We have decimated him. We have explained to Boston 25 that we are bigger than their entire network. And yes, ladies and gentlemen, today we might very well overtake Al Jazeera Arabic. Oh, ladies and gentlemen, what would it mean? Do you know what it would mean if Towel Stream is bigger than the Qatari national broadcaster in Arabic? Oh, ladies and gentlemen, This is a big day to be a towel. If we just get 1.4 thousand more views, we will have taken over the Qatari national broadcaster. Yes, ladies and gentlemen, we will officially be declared as larger than the state of Qatar. I never thought this would be possible, ladies and gentlemen. Towel Stream World News has indeed, forget about Reuters, forget Sky News, forget about Boston 25. We are going for Al Jazeera Arabic. I have no idea what they're broadcasting. I have no idea what they're talking about. Probably the boarding of the ship that was off the coast last night with Greta Thunberg on it. But needless to say, don't take any insights about the flotilla that I wanted to launch related to that flotilla. Their flotilla did not have kangaroos or pandas or spork-waving deckhands or koalas or Brewski the Irish territorial acquisitionist, who's actually a setter, or peacocks or pandas. See what I'm saying, ladies and gentlemen? Murder by Maestro, I have wonderful news. We have beaten Pink down to his Ted Pink down to his underwear Daniels. I have another announcement. I am not a communist. And I'm not calling Ted Daniel a communist. I'm saying he has free Karen Reed sympathies, and that is why he is Ted Pink down to his underwear Daniels. Furthermore, Murder by Maestro, this is wonderful news. We are almost bigger than the country of Qatar, the state broadcasting network of the country of Qatar in Arabic. Oh my goodness, ladies and gentlemen. Towel Stream is going to potentially take over Al Jazeera Arabic on my list of most highly popular streams on X right now. Oh, Man Bear Pig, what have you broughteth upon the world? Ladies and gentlemen, Man Bear Pig has broughteth ruin on the world. We are about to take over the country of Qatar. I don't know what I should do. I should schedule some kind of meeting with the sheik, and I should say, we, Towel Stream, this one man with a computer, are bigger than your international network. Would you like to give me some kind of medal? Lunch is over now. That's why I'm doing my absolutely unnecessary rant about how we're bigger than the country of Qatar. I don't know if we're actually bigger than the country of Qatar. I'm going to make a post that says, ladies and gentlemen, we are about to return from lunch in the John O'Keefe and Karen Reed retrial, and I am almost bigger than the country of Qatar. Ladies, gentlemen, and fellow towels, after a wild morning, we are about to return from lunch in the John O'Keefe and Karen Reed retrial. TurtleBoy's first trial is halfway done. Karen lost another mistrial motion, and Towel Stream is almost bigger than Qatar. Is almost larger than Qatar. There we go. Good timing, ladies and gentlemen. Let's get ready for court to come back into session. You see Judge Cannoni. Here we go.
All right. I appreciate the court personnel waiting so that we could have that voir dire. It was helpful. All right. So my rulings are very similar than they were this morning. So first of all, on the Darbert analysis regarding Dr. Lapisada being able to testify as to the dog bite wounds, I find that she is not qualified. I'm not satisfied that the Darbert requirements have been made. Specifically, not just the experience, but the reliability of the methodology she used and how it was applied. So based on that, she cannot testify to the dog wounds. And I want to take a minute to differentiate this testimony with Dr. Russell's. I found that Dr. Russell was an expert, qualified to testify as to dog bite wounds, mainly from her experience in the ER, coupled with her being an ME. Dr. Lapisada does not have that experience. I found that Dr. Russell's methodology was reasonable and was sufficient, and I found that it was appropriately applied. Remember that Dr. Russell was published in the area here. So regarding pages 10 and 11, all of the text on Dr. Lapisada's report on pages 10 and 11 that start with the injuries on Mr. O'Keefe's right arm are excluded. Now moving on to the testimony regarding not being consistent with a motor vehicle strike, I find that Dr. Lapisada's opinion on these not being the result of a motor vehicle collision exceed what is within her scope of expertise in some regards, not in all. In some regards, significantly, like I said this morning. So on page 17, the first sentence is in. The second sentence, tail lights are typically made of durable polycarbonate or acrylic plastic. That is out. I know the Commonwealth objected to, but I'm letting in. Mr. O'Keefe's patterned injuries on his right arm do not correspond to injuries that could have been produced by irregular fractured plastic pieces impacting the arm. She cannot say tail light, but she can say that based on her experience. His arm had no tissue bruising from impact. That also comes in the next sentence. Neither did his skin show any array of irregular, unpredictable, randomly scattered cuts and scrapes at various angles and depths. That's within her realm of expertise as a medical examiner. The next page, though, I may have said this morning that first sentence, importantly, in review of that and review of the Tompkins case, that first sentence stays out because to me it seems like that sentence depends on a biomechanical analysis, factors such as speed and force and the position of Mr. O'Keefe. So that's, oh, I'm sorry, page 18, the next page regarding the same subject matter. And portion of the next sentence is also out. This results in bruising or bleeding under the skin. That's out. But Dr. Lapisada can testify that Mr. O'Keefe had no bruising on his arms or torso. And that's it for that sentence. In particular, Mr. O'Keefe did not have bruises on his legs as shown by dissection of leg tissue and muscle at autopsy. That's it for that. And the conclusions are problematic to the extent that is consistent with this ruling and what we discussed on Friday. So that's it. That was just the text of her report. I have not begun to go through all of there's no PowerPoint with this, Mr. Jackson, right?
There is no PowerPoint.
All right. Do you intend on displaying any of these photographs?
I'm sorry?
Do you intend on displaying any of the photographs that are in her report?
Yes. I have to go through it now with the course.
All right, so you likely not get to that today. We've done important work, but we've wasted an awful lot of the jurors' time today. So I want to bring them in. And
my suggestion, we have to finish with that.
Right, we're going to do that now. So that'll give you an opportunity to pull your thoughts together.
Right, and I expect what I would do is my intention. I will go through a that will take me a good amount of time. I will go through the part of her initial analysis that will not include any of the photos, but I may be overnight to actually go through the court's ruling. It's very specific, and I want to be as
okay. So
that as possible.
Let me know what you intend to put in. All right, and there's a lot of text describing the photos that is out, right? It's just hearsay.
I mean, we've had Dr. Welch's PowerPoint.
That was not objected to. There's a big difference.
Yes, it was objected to.
So we'll deal with this tomorrow, with the photographs tomorrow.
I just want to let the court know, not waste the court's time.
Okay, thank you. And we're bringing the jurors in. Did the Commonwealth want to respond in any way?
No, thank you.
Okay. And there's a motion on Dr. Rentschler. We will give that, I haven't read it yet. We'll give that no more than 5 minutes tomorrow morning each side. This jury, you can tell just by looking at this jury, they're fed up. So.
John, the only thing I want to put on the record is, with regards to the court's ruling, I do want the record to reflect that is obviously it's over the defense objection.
Sure.
And I just want to make for the record a quick comment. The Commonwealth waited until June 5th to even bring this up, to file a motion regarding Dr. Lapisada. They had a report, and all reciprocal discovery was done in March 6th, 2025. That's document number 45.
Yeah.
And the Commonwealth was ordered to file whatever motions they wanted to, whatever motions in limine they thought were appropriate by March 7th, and they did not do that. They were supposed to be heard on March 18th.
Okay, so the jurors are coming in. We're going to mark the report and the CV for identification.
I just need to know the point I can make it.
You just made it.
I made it ish. I wasn't
Okay.
myself,
Okay.
But the point is,
Go ahead, real quick.
the point is, the Commonwealth has not explained the delay
So-
in making this motion. They have, and we're playing by the same rules, Judge.
So the basis of my ruling was not late disclosure. Okay? Late disclosure. Commonwealth says they're part.
That's not the court's missing the point. It's the opposite. We got late disclosure. We got late disclosure that they were objecting. They've had since March to object. They moved the motion in limited time, and then they come in just before Dr.
All right.
Lapisada testifies, and now they're sort of sandbagging this and getting the court moves against this. So I want to make sure that the record is imminently clear.
Very clear. Mr. Brennan, do you want to respond real quickly?
Your Honor, we can always object even during the proffering of testimony. There's no foundation. It's a foundational issue.
And that's consistent with what my rulings were when I allowed other witnesses to testify that the defense could object if the foundation weren't properly laid. So, bring them in, please.
Oh, that is devastating for Karen Reed's defense, and she knows it, ladies and gentlemen. My name is Grant Smith Ellis. We're just waiting for court to come back into session. As you can see, the Karen cam is going to come live any minute now. I think we're done for the day in the Aidan Kearney case, by the way, so I'm willing to declare at this point that we are just going to stick with Karen Reed coverage from this point on, so I know everybody's excited about that. The Aidan Kearney trial will resume on Wednesday. It's only halfway done. My name is Grant Smith Ellis. Our towel jury is basically getting fed up. I can see folks in the chat. By the way, you will get your towel jury assignments. I have the list. I did get Super Towel Mandy on there, and let's go.
Extraordinarily patient with us today. We're going to go straight through until 4 o'clock, and we're going to make every effort to not leave you waiting out there as long as you have, as long as we did today. All right, Ms. Giannetti, is your witness ready? Mr. Tedman, whenever you're ready, sir.
Thank you. Thank you, Your Honor. Sir, before the lunch break, you had identified 3 entrances to the front of 34 Fairview, leaving aside the 2 garage car doors. Do you recall that?
Yes.
May I have that last exhibit displayed, please? Not that one, the one that we discussed right before court. There it is. Maybe zoom in on that a little. Okay. What do you see on the screen at this point, sir?
I see the 2 rightmost entrances to the house, excluding the main front door.
Okay, which would be obviously to the left of this photo. Particularly with regard to the 3rd entrance, the one in red. Could you describe that?
Yes, so it's if you're facing the house from the street, you're looking towards the west. So that door goes directly into the garage facing north.
Okay, so basically from the street, you don't have to enter the house, you can go into the garage directly.
That is directly into the garage, yes.
All right, and as we're looking at the house from this point, are we looking at it from the vantage point of Fairview Road?
Yes.
And that is a westerly direction toward the house, sir?
Correct.
In the course of doing your further work that you were asked to do in this case, did you peer inside the garage?
Yes, I did.
Did you see concrete steps and a ridge there and a hard concrete floor?
Yes.
Sustain. Jurors disregard that answer.
You mentioned that you were asked to do some measurements. Can you describe what you were asked to do for the jury?
Yes, I was asked to measure from basically the mailbox area of the driveway to the various entrances to the house.
Did you take those measurements?
I did.
Okay, if I'd like to take them one at a time. First, did you measure from the end of the driveway next to the mailbox all the way to the main front door, which is not depicted on this photo?
Yes, I did.
How did you measure it?
I used my wheeled measuring device, and I walked directly across the lawn to the front door, well, to the bottom of the front steps, and then used it to go up the front steps straight to the door.
And what was the measurement, if you recall, from the mailbox area near the end of the driveway to the main front door on the left?
I believe it was 65 feet 9 inches, but I have notes if I
I think you got it right, sir.
Okay.
Next, did you measure from that same location near the street, the end of the driveway next to the mailbox, to the second front door, which is actually depicted in the exhibit that's on the screen?
I did.
And how did you measure that?
I walked along the edge of the driveway on the asphalt right next to the grass towards the house from the mailbox and the edge of the street towards the house. I took a left onto the brick walkway, proceeded along that walkway, then took a right to the walkway that you can see right there, heading directly to the door, and went up onto the little decking area, and then those 2 steps directly to the doorstep.
Okay, so you walked essentially almost the whole length of the driveway?
Yes.
Before you took the left to get to where the steps start, going to that second front door?
Yes.
And then went up to the door itself?
Yes.
Do you recall from your memory what the measurement was?
I believe it was 70 feet 1 inch.
And finally, did you measure from that same end of the driveway near the street next to the mailbox to the red side door, which is the pedestrian entrance into the garage directly?
I did.
How did you measure that?
I did the same thing, walking directly from the where the mailbox and the driveway intersect, basically, all the way up the driveway, took the same left onto the red brick pathway, took a right to go towards the front door, went up the 1 step that you can see, and then instead of going up the next 2 steps, I took a right directly towards the garage entry door.
So essentially the same path of travel, it's just you didn't go straight into the second front door, you took a right to go into the pedestrian entrance to the garage.
Correct.
And what was the measurement that you discovered having done that?
I believe it was 78 feet 3 inches.
Now, finally, could we have displayed the map of Cedar Crest, Fairview, and Chapman? There it is. Sir, are you able to see the street names from where you are? And if
yes.
not, could we have the top street magnified so that the witness can see it? Okay, you see that?
I do.
What do you see that to be?
Cedar Crest Road.
Okay, if we could have the connecting street where the, that's it.
Fairview Road.
All right, and finally the one down the bottom?
Chapman Street.
Okay, if we can get the whole map back up. Having seen those 3 street names, does that orient you as to what this is a map of?
It does.
And what is that?
This is the surrounding area of 34 Fairview Road, the neighborhood, basically.
Okay, and it includes the 2 connecting streets on either end?
Correct.
Does the red dot symbolize anything for you?
It looks to be where 34 Fairview Road is located.
Okay, and if you're on Fairview Road to the right of that red dot as it exists on that exhibit, and you're looking toward Fairview Road, what direction would you be facing?
I'd be facing west.
If I may have a moment, George?
Okay.
Further questions? Thank you very much, sir.
Thank you.
Questions?
Yes.
Hank.
Good afternoon, sir.
Good afternoon.
You had a wheel to measure?
Correct.
And so there's like a tape measure, and when you wheel it out, it gives a straight line?
No, it's two wheels with a meter in between them, and you roll it out in front of you.
I see. Your first measurement was from the driveway to the front door?
To the main front door to the far left, yes.
And that was about 63 feet?
I believe it was 65 feet, something like that.
65?
I have my notes, yes.
So suffice to say, if you were to leave the front door and come back to that spot, it would be an additional 65 feet back, right?
Yes.
The second measurement was from the bottom of the driveway to the middle door on the side?
Yeah, the second front door, yes.
Did you say that was about 70 feet?
It was, yes.
Okay. And again, if you were to come back, that would be an additional 70 feet?
It would.
And the last one was the door near the garage. Did you say that was further, around 80 feet?
78 feet, 3 inches, I believe.
Except one way?
Correct.
And back is another 78 feet?
Correct.
When you measured these, was it from the asphalt of the driveway or to the left of the mailbox as you're looking at Fairview?
It was to the right of the mailbox on the asphalt, as close to the mailbox as I could get.
Did you happen to take any measurements from the flagpole to the front door as far as distance?
I did.
And what was that?
I do not have the exact measurements. I'm not sure.
Do you have it in a report that you could
I
look
don't.
at?
I don't. No, not with me.
How about the flagpole to the middle door on the side? Did you take any measurements of that?
I'm not sure I took that one.
How about the flagpole to the furthest away door, which would be the door next to the garage? Did you take any measurements of that?
I think I took a direct measurement to that, yes.
Right. And what was that number?
I don't know.
Do you have a report you could share with us?
I don't. No, I'm sorry.
It's okay. Did you ever measure if you were at the flagpole area, how long it would take to walk up the street? Or how far it would be to walk up the street, up the driveway to any of those doors? Did you ever measure it that way?
I did.
And what was the distance if you were going to start at the flagpole, walk up the street, up the driveway, down the walkway to the front door?
I'm not sure that distance. Not positive the distance.
Was it over 80 feet?
It was.
And if you did the same route up the street, up the driveway, to the middle door, would you agree that would be well over 80 feet as well?
Can you repeat the question? How?
Sure. From the measure from the flagpole, up the street, up the driveway, to the middle door, that would be well over 80 feet?
Yes.
Same to the door next to the garage?
Yes.
Thank you for your time.
Thank you.
All right, you are all set, sir. Thank you very much.
Thank you.
Okay, Mr. Jackson.
Thank you, Your Honor. We would ask the court to ask Dr. Elizabeth Lapisada to join us.
Okay.
You tell me, sir, the evidence here for the court and jury in the case now and hearing the truth, the whole truth, and nothing but the truth, so help me God.
I do.
Good afternoon, Doctor.
Good afternoon, Your Honor.
May I inquire?
Yes, and Dr. Lapisada, please speak right into that microphone,
I
okay?
will.
Thank you.
Doctor, can you please state your full name and spell your last name for the jurors?
Yes, Dr. Elizabeth Lapisada, spelled Laposata.
I'm going to ask you, you have a softer voice. I'm going to ask you to pull that microphone right under your chin, if you don't mind. It's pretty adjustable.
Better?
That's better.
Okay.
That's better. Doctor, can you tell the jurors what you do for a living?
Yes, I'm a medical doctor and I subspecialize in forensic pathology.
Can you summarize your professional background?
Certainly, I graduated in 1975 from Bucknell University with a Bachelor of Science in Biology. I went to University of Maryland School of Medicine, where I graduated in 1979 with a Doctor of Medicine. I did my internship and fellowship at Johns Hopkins Hospital in Baltimore, where I studied anatomic pathology, which is the study of the diseases of the body. I then did my subspecialty fellowship in St. Louis in forensic pathology, which is understanding causes of death and injuries to the body.
Currently, are you a professor?
Yes, I am.
And tell us where you work.
I own my own independent consulting practice, and I'm also an associate professor at Brown University School of Medicine.
How long have you taught at Brown University School of Medicine?
Since 1993.
And how long have you been a clinical associate professor of pathology either at Brown or before that?
Oh, gee, then that would have been since at least in the late 80s. I've been associate professors at the universities and medical schools where I've worked.
Doctor, at Brown University, let's take Brown first. What do you teach there?
I teach the second-year medical students. I teach a lecture in diseases of the heart, cardiomyopathy, and myocarditis. And I've been asked to give some specialized lectures in toxicology and forensic pathology.
Are you responsible for training medical students in the field of forensic pathology?
When I was a chief medical examiner, yes, we would have medical students, residents, come into the office so they could learn about what we do to understand cause and circumstances of death.
When you first got your medical license, did you then undertake to get certain board certifications and the like?
Yes.
Before we get to those board certifications, did you begin a practice in forensic pathology in some way or another?
After I finished my medical school and my anatomic fellowships and forensic pathology fellowships, then I was working in medical examiners' offices where I was examining deceased people to understand how they died.
When you get a medical license, is that statewide or is it nationwide?
Usually you get a state medical license.
And do you hold a state medical license?
Yes.
How many?
I have an active medical license in Rhode Island where I have my consulting practice, and I have inactive license in Maryland, Delaware, Missouri, Pennsylvania.
And you've been previously, at least before they were inactive, you were licensed in all 5 of those states?
Yes.
You already told us a little bit about your college. Did you mention Bucknell University? Your Bachelor of Science degree?
I think I did, yes.
At some point after you graduated from the University of Maryland School of Medicine, did you complete any residencies?
Yes, I did my residency at, excuse me, at Johns Hopkins Hospital in Baltimore in anatomic pathology.
Forensic pathology is different from anatomic pathology, correct?
Yes.
Did you also do any kind of residency in forensic pathology?
Yes, I did a fellowship in forensic pathology.
And what is the difference between, if you can sort of take us through that little by little, what is the difference between forensic pathology and anatomic pathology?
Anatomic pathology is sort of hospital-based pathology where we understand diseases of patients who are in the hospital and try to make clinical pathologic correlations to see if their diagnoses were correct, if the laboratory tests actually showed what we find at post-mortem. And then forensic pathology deals more with understanding why the body stops functioning at a particular time. So that would be cause of death, and that can be sudden unexpected death or death due to violence.
And in forensic pathology, is that often associated with testimony in court cases that may deal with either on the civil side or the criminal side, coming in and testifying about things like cause of death and manner of death?
Yes.
What types of cases did you work on during your forensic pathology residency?
Oh, sudden unexpected natural death, gunshot wounds, knife wounds, sudden infant deaths, blunt force trauma, skeletonized remains, decomposed bodies, strangulation, the whole gamut of ways people can die unnaturally.
And what type, to contrast that, what types of cases did you work on during your anatomic pathology residency?
There you're mainly dealing with natural diseases and understanding heart disease or how somebody gets pneumonia, or looking at the brain to understand if a stroke was present. And that's especially important then to the doctors who are treating those patients, that they can see if the diagnostic tests were appropriate or if their treatments worked.
You mentioned fellowship a little earlier in your testimony. What is a fellowship?
A fellowship is after you've done your internship and residency. A fellowship is more specialized training, and I did that in forensic pathology.
So that answers my next question. You do hold a postgraduate fellowship position, correct?
Yes, yes.
And that was in forensic pathology specifically?
I'm board certified in anatomic and forensic pathology.
Were you a research associate at the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Law?
Yes.
I'm sorry, School of Medicine?
Yes.
Old habits. What about postdoctoral research fellow? Were you ever a postdoctoral research fellow?
Yes, I did. I had an NIH research grant where I worked on, how alcohol affects the heart.
Where was that?
That was at St. Louis University, and then when I was on staff at the hospital of the University of Pennsylvania in Philadelphia.
What about postdoctoral research fellow at dealing with the cardiovascular division of the Department of Medicine at Washington University?
Yes, that's where I did research on how alcohol affects the heart.
Was all this in furtherance of your broad education and training as a pathologist?
Yes.
I think you indicated that you have served as a chief medical examiner in answering one of the previous questions. Can you tell me a little bit about that?
Yes, I was appointed chief medical examiner for the state of Rhode Island in 1993, where I was responsible for all unexpected, unnatural deaths or deaths that involve violence in the state of Rhode Island. So I had to supervise the office, made sure I have adequate staff, made sure my forensic pathology staff were doing a good job, made sure I had an adequate scene investigative staff, so running the whole office.
Is that the highest appointment in the OCME's office?
Yes, it is.
In that position, did you oversee every single medical examiner in the state of Rhode Island?
Yes.
Did you also hold a position as the co-chair of Child Fatality Review Committee in the state of Rhode Island?
Yes, as part of being chief medical examiner.
Tell us a little bit about that. What was that appointment?
Well, there's a big concern about infants who die and children who die. So those are reviewed specifically by a group of doctors from the pediatricians and also then the medical examiner's office. So we look at every child and infant death.
How long did you serve as the chief medical examiner in the state of Rhode Island?
For 12 years.
Starting when and ending when?
Starting in 1993 and ending in 2005.
As the chief medical examiner for Rhode Island, did you ever have the responsibility to work on any mass disaster cases?
Unfortunately, yes.
Okay, tell us a little bit about that. If you could start with the Egypt Air issue.
Yes. Excuse me, I'm so sorry. In 1999, the Egypt Air 990 took off from New York airport, and it crashed off the coast of Massachusetts, and 2,065 passengers died. And because of the force of the airplane going into the water, all the bodies were fragmented. So all the fragments were brought to my medical examiner's office. They actually vacuumed the ocean floor, and we had 2,600 some fragmented remains from that airplane crash, and that involved working with FBI, TSA to identify those individuals and understand exactly why they died.
What was your role and the role of your staff that you supervised in dealing with those other government agencies, the FBI, the NTSA, other entities, in terms of the fatalities that you did review as a medical examiner, or the chief medical examiner of Rhode Island?
Well, I dealt with families from around the globe who had relatives on that flight, and then the FBI was looking into what may have caused the crash. The Egyptian government, who owned the airplane, was also there and interested in understanding what happened. And we were also, tasked with identifying everybody who was on the plane and to see if that matched the passenger manifest list. So were there people on the plane who shouldn't have been on the plane? So that sort of thing.
In terms of matching that manifest, were you the head of the department for the medical examiner's office that was responsible for trying to figure out who was on the with the tragic station nightclub fire?
Yes.
In what capacity did you deal with that?
Again, this was a nightclub that burned down. It burned down very rapidly with a very hot fire, and that was in Rhode Island, and there were 100 fatalities from that. So those come to the medical examiner's office. I had my investigator at the scene throughout that time of recovering the bodies, and I was charged with determining the identity and the cause of death.
Were you successful, or your staff successful, in determining the identity of most of those individuals who perished?
Yes, all of them. We worked around the clock for 3 days to get that done.
And you were the head of that task force. Before you became the chief medical examiner in Rhode Island, did you previously work as a medical examiner under somebody else?
Yes.
Tell me about that. What was your first post as a assistant medical examiner?
My first post was after I did my fellowship training in St. Louis, Missouri. I was an assistant medical examiner for the city of St. Louis.
Were you ever an assistant medical examiner in Philadelphia?
Yes. So after St. Louis, I moved to Philadelphia, where I was on staff at the hospital of the University of Pennsylvania, and I ran the autopsy service there at the hospital, and I was also an assistant medical examiner for the city of Philadelphia. After that, I was an assistant medical examiner for the state of Delaware, and then I came to Rhode Island as I was chosen to be chief.
Dr. Lapisada, can we put dates on that? Assistant medical examiner in St. Louis, from when to when? Do you remember?
Oh my, let's see. May I look at my CV?
Sure, with the court's permission.
Yes. Okay. Yes, from 1983 to 85, I was an assistant medical examiner for the city of St. Louis. Then in 87 to 91, I was the assistant medical examiner for the city of Philadelphia. 91 to 93, assistant medical examiner for the state of Delaware. And then 1993 to 2005, I was chief medical examiner for the state of Rhode Island.
Thank you for that. Dr. Lapisada, have you held any faculty positions as in the field of forensic pathology that qualify you as an expert in this case?
Yes, every medical examiner's office I worked in, I also had faculty appointments to teach medical students and pathology residents. So I had faculty appointments at Washington University School of Medicine in St. Louis, at the Hospital University of Pennsylvania, in Philadelphia, and in Rhode Island.
Let's talk about those one at a time. Describe your teaching responsibilities at Brown Medical School, if you wouldn't mind. And that, by the way, that's from 1994 to present, correct?
93 to well, as a medical examiner, it was 1993 to 2005. And there I would teach the medical students. We had rotations through the medical examiner's office, and also the pathology residents would rotate through the medical examiner's office, where I would teach them how to do a medical legal autopsy, how to understand cause and manner of death, especially non-natural and traumatic deaths.
With regard to your teaching responsibilities specifically, are you still teaching?
I'm teaching in the cardiovascular section now, but since I'm not chief of the medical examiner's office, I obviously don't have students rotating through there anymore.
Were you a lecturer in the role of medical examiner? Did you do a seminar in that regard at or associated with Brown University School of Medicine?
Yes.
Did you do some sort of a forensic pathology rotation for pathology residents from 1994 to 1995 in that capacity as well?
Yes, we would have the pathology residents who were at the hospital studying anatomic pathology come to the medical examiner's office so they could understand the discipline of forensic pathology.
What is cardiomyopathy?
Cardiomyopathy is a muscular disease of the muscles of the heart.
And what is myocarditis?
Inflammation of the heart muscle.
Did you ever teach or lecture on those issues?
Yes, I teach every year. I teach the second-year medical students about those heart diseases.
Have you ever taught anatomy and physiology to EMTs?
Yes.
Or in the EMT setting?
Yes.
And what about a class known as the 2-hour primer on forensic pathology?
I've taught a lot. I don't recall that particular one.
How about pathology residents morning conference in 2009?
Oh, yes. I give lectures to the pathology residents at the medical school at Brown Medical School in forensic pathology.
You also mentioned that you were an adjunct professor for biomedical forensic sciences and forensic anthropology in the Department of Anatomy and Neurology. Is that a division of the graduate school, Boston University School of Medicine?
Yes, I taught in the master's program in the medical school at Boston University School of Medicine for a master's in forensic science, where I taught a 40-hour course on forensic pathology and another 40-hour course on medical legal death investigation.
Were you actually the course director in that position?
Yes.
And were you also a course director in medical legal death investigation from 2006 to 2013?
Yes.
And what about a course director in forensic toxicology from 2006 to 2012?
Correct.
Did you direct the studies in biomedical forensic sciences, GMS, from 2012 to present?
Yes.
Describe that. What is that?
The graduate medical sciences?
Correct.
Okay, yeah, I would review and be on the board to examine projects that the students were doing to get a master's degree.
Were you also an assistant professor in the Department of Pathology and Laboratory Medicine at University of Pennsylvania School of Medicine?
Yes.
Okay. Without going into every single class that you taught, did you teach from 1987 to 1991, attending staff medical pathology?
Yes.
What is that, just a general outline of what that teaching course was?
That's when I was at the hospital at the University of Pennsylvania. I ran the autopsy service, so I taught medical students and pathology residents about autopsy practice.
I want to ask you sort of broadly, can you describe your major teaching and clinical responsibilities when you were at University of Pennsylvania School of Medicine in the field of forensic pathology? What were your main clinical and teaching positions?
Well, I ran the autopsy service there, so I taught the medical residents and medical students autopsy pathology, and I was also a assistant medical examiner there, so I taught and started the forensic fellowship in forensic pathology.
Have you ever been qualified as an expert witness in forensic and anatomic pathology in state and federal courts?
Yes.
How many times would you say you've qualified as an expert?
Over 40 years, maybe several hundred.
How about in Massachusetts?
That includes all of them.
Okay. Have you ever qualified? Let me list a couple of states. In Massachusetts?
Yes.
California?
Yes.
Connecticut?
Yes.
Delaware?
Yes.
Florida?
Yes.
Illinois?
Yes.
Maryland?
Yes.
Minnesota?
Yes.
Missouri?
Yes.
New York?
Yes.
Pennsylvania?
Yes.
Rhode Island?
Rhode Island, yes.
Have I left anything out?
Did you say Massachusetts?
I did.
Okay, then
we
you're
started
fine.
with Massachusetts.
Okay, you're fine.
What types of topics have you qualified to testify about as an expert forensic and anatomic pathologists?
Really, anything that has to do with circumstances and cause of death. So it doesn't really matter, like, what type of injury or a sudden unexpected death. Usually it involves examination, study of information from the scene, information from the autopsy, police and investigation and medical records, and we put that all together and figure out the circumstances as to how someone died and why their body stopped functioning. So that's the basis of forensic pathology.
Dr. Williams, excuse me for just a second. You want to make me approach for one brief.
Dr. Lapisada,
Yes.
I'm going to ask you to step down and you can go back with the court officer into that back room.
Okay, certainly.
And jurors, rather than send you downstairs and back up the stairs to come back in 5 minutes, I'm gonna sit here, you all can sit here, we're just gonna be in recess for 5 minutes while we sit.
May I inquire?
Yes.
Thank you. Dr. Lapisada, you mentioned several topics about which you testified and qualified as an expert. Testified about it as an expert in several different states, several different courtrooms. Have you been qualified as an expert by those courts in those topics about which you just discussed?
Yes.
Do you hold any specialty certifications in the field of forensic pathology?
Well, I'm board certified in forensic pathology.
What about the American Board of Pathology?
Yes, the American Board of Pathology puts forth examinations that are a 2-day examination in the various disciplines of pathology, and if you successfully complete those examinations, then you become a diplomat of the American Board of Pathology in whichever subspecialty you're in, and I became a diplomat in the subspecialty of anatomic and forensic pathology.
What about a certification in basic blood stain pattern analysis, the International Association of Identification?
Yes, I had a week-long course in understanding blood pattern analysis.
Can you tell us a little bit about the National Registry Emergency Medical Technician certification that you hold?
Yes, I took training to become an EMT.
Have you received a number of honors and awards in the field of forensic pathology?
I have.
What do those awards include?
May I look at my CV again? Sure. Thank you. I've had teaching awards from Brown University School of Medicine. I was featured in a book by Faces of Public Health as having run a good medical examiner's office. I was nominated for Woman of the Year in Rhode Island for my work as chief medical examiner in improving the office and handling those two mass disasters. I was honored by Victims' Rights and Services Awards because I've always been aware of the fact that as a forensic pathologist, I am the last doctor this person is going to have, so I try to help the family understand what happened. I was honored for my work in the mass disaster in Egypt Air 990 plane crash. Let's see. I was Outstanding Woman in Public Service for Providence, Rhode Island. I've gotten teaching awards from Brown University School of Medicine. I was elected to the Board of Trustees in the Delaware SIDS Foundation and the Philadelphia SIDS Foundation. And then we're back to my medical school.
If you could pull the microphone a little closer to your chin.
It's very hard because the chair doesn't push it.
Oh, the chair doesn't move. Okay.
Well, I got it. I moved.
We'll make do.
Okay.
Thank you, Dr. Lapisada. What is the American Academy of Forensic Sciences?
That's one of our medical associations that is specific to forensic sciences.
Have you ever held a chaired position there?
Yes.
What position was that?
I was voted into a fellowship position.
Were you the chairman of Forensic Science Research, the Forensic Science Research Committee?
Yes.
What's the National Association of Medical Examiners?
It's also called NAME. It's another international association of forensic pathologists.
Were you a member of that organization?
Yes.
And at some point, did you get elected to the board of directors for that organization?
Yes.
And ultimately, did you become a fellow for that organization?
I did.
What is the American Society of Clinical Pathologists?
That's a society that is for people who practice anatomic pathology and understand how to interpret laboratory results and biopsies.
Did you become a fellow in 1991 until present for that organization?
Yes.
What's the difference between a member and a fellow?
A member is a lower level, and then you can be promoted to fellow if the board of directors feels that you've contributed in your field.
And were you associated with the College of American Pathologists?
Yes.
Were you a fellow there as well?
Yes.
What about the World Association for Medical Law?
Yes.
What about the American Association for Clinical Chemistry?
Yes, I'm a member.
Rhode Island Medical Women's Association, what is that?
Well, it's basically what it says. It's women doctors in Rhode Island.
Were you elected to the board of directors for that organization?
Yes.
Ultimately, were you elected as the president of that organization?
I was.
Rhode Island Medical Society, what is that?
It's an organization of doctors who practice in Rhode Island.
Are you a council member there?
Yes.
And what about the Massachusetts Medical Legal Society?
Yes, I was a member there. They have disbanded since.
It doesn't exist anymore?
No.
When it was up and running, you were a member in good standing?
Yes.
Good, good. Pennsylvania Association of Pathologists, what about that?
Yes, when I practiced in Pennsylvania, I was a member of that organization.
Did you, in addition to be a member there, did you also hold a chaired position? Were you the chairman for the Committee on Forensic Pathology?
Yes.
Have you served on any editorial boards of any scholarly journals or
Yes.
publications? Tell me about that.
I've reviewed articles submitted for the Journal of Forensic Sciences and the National Association of Medical Examiner journals.
Did you also hold an editorial position for the American Journal of Forensic Medicine and Pathology?
Yes.
Is that one of the medical journals that is used throughout the country by other medical professionals, other medical examiners?
Yes.
It's a resource?
Yes.
And a text?
Correct.
Have you authored any peer-reviewed publications in the field of forensic pathology?
Yes, I have.
Can you tell us about some of those publications?
Let's see if I can here. Yeah, I've written chapters in textbooks about medical legal death investigation and forensic pathology. I've published articles involving alcohol metabolism, some drugs, cocaine. Let's see. Alcohol metabolism in the heart, I mentioned. So I published 22 papers, and I've written several chapters.
You already said that you're board certified, double board certified in anatomic and forensic pathology. Is that correct?
Yes.
Now that you've gone through your education, training, background, publications, teaching positions, and chairs that you've held, I want to ask you a really simple question. What does a forensic pathologist do?
Yeah. We are the last doctor that the dead person has, and we figure out what happened to the body to cause their death. And we sign the death certificate that says how the body came to die and also indicates the circumstances under which the death occurred.
Are medical examiners also tasked with determining both manner and cause, not just one or the other?
Both, yes.
What is the manner of death and how is it distinguished from the cause of death?
The cause of death is what happens to the body to cause it to stop functioning. And the manner of death refers to circumstances under which the death occurred. So there's hundreds of thousands of causes of death or why the body stops functioning, but there's only a few manners of death, which would be natural, accident, suicide, homicide, or undetermined.
Those 5 main categories of manner of death, is that the responsibility or one of the responsibilities of a forensic medical examiner to determine that the death fits into one of those 5 categories?
Correct.
What does it mean when the death is deemed undetermined?
Now, when the manner of death is undetermined, that means at the time the death certificate was signed, there was not enough information to put it into either accident, natural suicide, or homicide. So at the time the death certificate was signed, there was not enough information to put it into one of those other categories. It doesn't mean that if more investigation takes place, then you might be able to put it in one of those other categories.
If a manner of death is deemed at a particular time undetermined, at that time, it's because it lacks sufficient additional information. Is that correct? What types of information does a medical examiner, forensic pathologist consider in making these determinations between natural accident, homicide, suicide, undetermined?
Well, first you have the findings from the examination of the body. So that's sort of a starting place to see what happened to the body. Then you need to also look at the scene investigation. You need to look at any police reports and witness statements, and also medical history of the deceased. And using those 4 sources of information, and using your training and experience, you can either say this is a natural death, this is a self-inflicted death, it's a suicide, it's an accidental death, it's a homicide, or if all that information doesn't allow you to put to a reasonable degree of medical certainty into any one of those categories, then you have to leave the manner undetermined. And if more information becomes available later, then you can change that death certificate.
What if no more information comes available later?
It just stays as undetermined. There are cases where there's just not enough information to put it in one of those other categories.
Without getting into what they may be, did you reach any opinions and conclusions in connection with this case?
Yes.
What materials and information did you consider in reaching your opinions and conclusions in this particular case?
Yes. I have my list of materials I reviewed. I reviewed Mr. O'Keefe's autopsy report, the report of the examination of his brain, the toxicology report, and the entire medical examiner file. I studied 100 and some autopsy photos, including photographs of the brain, and then there were 70 other photographs at autopsy taken by a state trooper who was at the examination. I reviewed Mr. O'Keefe's medical records from Good Samaritan Medical Center and the EMS run sheet. I reviewed photographs of Mr. O'Keefe's clothes that were taken at the crime lab. I reviewed photographs of pieces of tail light, hard plastic, clear, black, red. I reviewed photographs of the outside of Karen Reed's SUV. I reviewed the Canton Police Department incident report on the death. I reviewed 100 and some photographs taken by Canton Police of the outside of the house at 34 Fairview Road in Canton. I reviewed some photographs taken by the real estate agent who was going to sell the house of the inside.
In total, putting them in categories, did you review the forensic autopsy?
Yes.
Did you review all of the files associated with the medical examiner's office in this particular case related to the autopsy of John O'Keefe?
Yes.
Did you review the scene investigation through police reports and other things?
Yes.
Photographs as well?
Yes.
Did you review the police reports that were associated with the initial investigation in this case as well as follow-ups?
Yes.
Did you review witness statements and things of that sort?
Yes, if they were included in the police report.
That was my next question. Those witness statements would be included in the police reports that you otherwise reviewed, correct?
Yes.
What about Mr. O'Keefe's medical history as much as you had of it?
Yes, I reviewed his medical history.
And what about hospital records?
His medical history was in the hospital records.
Understood. What method did you use or methodology did you use in forming the opinion that we'll get to in just a few minutes?
Well, in order to arrive at a conclusion of how somebody dies and what the cause of death is, we have to put all our facts out, and then we say, how could these facts have come to be? So it's called like a differential diagnosis. So like if you go to your doctor and you have a white blood cell count, then the doctor would say, well, how many ways do you get this white blood cell count? So that's a differential diagnosis. And then you go from that list and pare it down by getting more data till you come to one final diagnosis. So that's the process of determining how somebody dies and the circumstance around it.
Is it fair to say that you have a pretty significant background, training, and experience regarding coming to the conclusion of cause and manner of death?
40 plus years.
And how many autopsies in total?
Well, myself, I've probably done over 3,000, and then I have observed and reviewed maybe 7,000 more.
So that's in total over 10,000 autopsies if you were to estimate over 40 years?
Probably.
In addition to just autopsies, how many death investigations, separate and apart from autopsies, have you been involved with?
Well, the autopsy usually has a corresponding death investigation with it.
Do you have experience in examining and identifying wounds, not necessarily the cause and manner of death, but wounds that are associated with someone on whom you're performing an autopsy or you're supervising an autopsy?
Yeah, so looking at the injuries on the body and understanding what caused them is a huge part of forensic pathology.
Have you ever conducted or overseen any autopsies of individuals involved in vehicle-pedestrian collisions?
Yes.
How many times, if you had to estimate?
No, hundreds.
100 or hundreds?
Hundreds.
When was it that you first started training on the issue of wound pattern recognition that helps assist you with coming to your conclusions, whether it be auto pedestrian incidents or otherwise?
Yeah, well, understanding wound patterns and injuries is a big part of forensic pathology because we want to identify what caused a particular pattern. So understanding that whole complex bag of injuries begins when you start your forensic pathology training, which was when I started back in '81.
In addition to the cause of death, which might be whatever, a gunshot, something, does the pathologist also undertake an examination of the rest of the body that's not so obvious, other wounds, etc., that might tell a more defined story?
Yes, we look at the entire body, we look at the clothing, we look at the outside of the body, then we do the internal examination in order to understand not only why the body stopped functioning, which is the cause of death, but also things that could have contributed to it or helped to understand the circumstances around how that death occurred.
When you say the body, you mentioned the clothing. Why is the clothing important? Is that part of the body for a forensic medical examiner?
Oh, yes, it is. You always have to look at the clothing because it has materials on it that may be important as to how injuries occurred. So it's every time you do an autopsy, you have to always make sure you have the clothing. Many times it would have been taken off at the hospital, but then I would always ask my staff, tell the police, we've got to get the clothes, have to look at the clothes.
What is a gross examination?
A gross examination is not actually like gross, grotesque, but it means like without microscopes. It means just looking with your naked eye.
Is it important to look at a body, a deceased person, when you're conducting an autopsy from head to toe for outside obvious wounds that you can see on the gross anatomy outside?
Oh, yes, and also to collect any trace evidence that may be present on the body.
Are forensic medical examiners trained to do that?
Oh, yes.
Are you trained to do that?
Absolutely.
In addition to a gross examination on the outside of the body, is it also important to look on the inside of the body?
Yes.
Are there wounds and injuries that might be hidden by the dermis, for instance, the skin, that might not be so obvious on a gross examination of a body?
Yes, you have to look inside the body.
And what's the mechanism of doing that?
Excuse me. We make surgical incisions in the body so we can examine the brain, the neck, all the organs in the chest, all the organs in the abdomen, and depending on the case, we may make incisions in the arms and legs to look for evidence of injuries.
What about x-rays? Are x-rays an important part of an examination in an autopsy?
Yes, they're usually done before the autopsy is started, and we look for changes in the bones or any foreign material that might be present in the body, like a bullet.
Dr. Lapisada, have you ever exercised wound pattern recognition in your position as a forensic pathologist? Or do you do it every time?
Oh, all the time.
Have you ever taught any courses or given lectures on wound identification and wound pattern recognition?
Yes, it's part of understanding blunt force trauma, sharp force trauma, gunshot wounds. They all make injury patterns on the body that the pathologist can then relate to what caused that injury.
With regard to the case that's before us, what injuries did you observe with regard to Mr. O'Keefe's head, specifically?
I observed that he had evidence of blunt force trauma to the back of his head.
Are those injuries consistent with a particular type or pattern of patterned injury?
Yes.
Describe that for us, please.
There in the back of his head, a little bit to the right-hand side, was a horizontal tearing of the scalp, and that's called a laceration. And surrounding that were linear scrapes that were vertical in orientation. So that is an injury pattern. And then you have to think, well, what could cause that injury pattern? And so then you go from there.
Did you also, in addition to looking at, by the way, how did you make that assessment about the injury? Was it photographs?
Yes.
Is that a normal way for a forensic pathologist to make an assessment? Is that an acceptable methodology to make an assessment of a wound pattern by the use of anatomical photographs?
Oh, absolutely.
Have you done it before?
Oh, hundreds of times.
What is a coup contra coup injury?
Now, it's a very interesting, peculiar injury to the head. When you have a blow to the head, the blow can either be the stationary head and there's a blow to it, or you can have the head that's moving and gets the blow. So looking at a pattern of coup contra coup helps the forensic pathologist differentiate that. A coup contra coup injury examines the coup, which is where the impact occurred, and then we look at what's 180 degrees opposite that impact, and that's called the contra coup, or like opposite the coup. And that injury pattern helps us determine whether a person was just having a fixed head and somebody hit it, or whether the head was just standing and went down to the ground. The coup contra coup of a falling or being pushed backward has injury patterns where the impact occurred, but then there's also injury patterns 180 degrees opposite from that. And that happens because the brain is floating in cerebral spinal fluid, and when the head comes down, the brain is a little bit behind, so you get the bang on the back of the head, but then because the brain is floating, it hits the inside of the opposite side of the head. And so that makes the contra coup pattern, and that tells us that there's been a fall backwards and hitting the head.
Is that consistent, a coup contra, just in general, a coup contra coup injury, consistent with a linear acceleration of the head by a fall, an unbroken fall straight back?
Correct. There's also some angular force in that as well.
Understood. In order to determine whether or not Mr. O'Keefe suffered from a coup contra coup injury, can that be done by a gross examination, or does it have to be surgical?
We would look at, well, first we look at the outside, but then we have to look at injuries to the scalp, and we look at the skull, see where the skull fractures are, and in particular to look at the brain and see where the damage is to the brain. And there should, in a fall backwards, you have damage to the brain at the site of impact, but you also have damage to the brain 180 degrees opposite from that. And that tells you it's a fall backwards.
In the case before us, dealing with John O'Keefe, were you able to look at the scalp and the injuries associated with the scalp from a gross perspective?
Yes.
Were you also able to look at the skull and possible fractures that Mr. O'Keefe suffered on his skull?
Yes.
And what about the brain? Did you have evidence of a dissection such that you could see the brain and determine whether or not there was a coup contra coup injury associated with the brain?
Yes, I had a full examination of the brain available.
Were Mr. O'Keefe's head injuries consistent with a coup contra coup injury?
Yes.
Could you describe that, specifically his head injuries, to the jurors, please?
Well, as we say, he has a pattern head injury on the back of his scalp, where there is a tearing of the scalp, and then vertically above that, there is some little areas of scraping to the skin. So that tells me that Mr. O'Keefe went backwards onto something that had a little ridge, but it also had some irregularity to it to cause the different scrapes before you get to the tearing of the scalp. Then when we look at the skull, he had a massive skull fractures that originated starting in the back of his head. They came around to the front. They went under the base of his brain, under the skull, under the base of the brain, and it came into the front of the skull at the orbital plates and fractured that, and that caused some bleeding in his upper eyelids. When the brain was examined inside the brain, I could see that the brain had become swollen and parts of it had herniated or moved down the area where the spinal cord is, and that's called brainstem herniation, and that is why the brain stops functioning and why your body stops functioning when you have a severe head injury.
You indicated that the wound pattern suggested a ridge or ledged surface.
Yes.
Could you explain that in more detail, please?
Yes. So if I were looking at it, I would see the break in the scalp. Then I would see several sort of irregularly placed scrapes of the skin that kind of look like pencil marks. And so that means that something with granularity he hit first, then it moved up a little, broke the scalp, and then moved on a little bit above that.
Would you expect to see that if Mr. O'Keefe had fallen backward onto a perfectly flat surface?
No, it has to be a surface that has some small ridges in it to make those little vertical patterns.
Dr. Lapisada, what is ecchymosis?
Ecchymosis is a medical term for bruise.
Did you see any ecchymosis on Mr. O'Keefe that he suffered as a result of the coup contra coup injury to the back of his head?
He had a bruise on his brain at the back of the brain and at the front of the brain.
What would the outer let me rephrase that.
Yeah.
What would you see around his eyes regarding ecchymosis?
Yes, when you have, when the brain slaps forcefully against the base of the skull, the delicate bones above the eye break, and that's again the coup contra coup, where the brain slaps forward, and when those delicate bones are broken, there's bleeding, and that bleeding then goes right down into the upper eyelids, so it kind of looks like you have black eyes, but there's not been any punch to the face. It's only come from the skull fracture. That's sometimes called raccoon eyes, because you look like a little raccoon.
Did you see any skin injury to either one of Mr. O'Keefe's upper eyelids?
Yes, he had a small kind of slit-like defect horizontal on his right upper eyelid.
Would the ecchymosis on its own produce that type of injury, that laceration over his right eye?
No, the blood seeping down into his upper eyelids was from the skull fractures.
Was the laceration above his eyelid on the right side a separate injury altogether?
Yes, it was.
Based on your training experience, do you have an opinion as to whether or not what that eyelid laceration might be consistent with?
Some application of force which broke the skin.
Could that be from an object?
Possible.
Could it be from a fist?
Possible.
Sustain us to the floor, Mr. Jackson.
Give me some possibilities of what might cause that laceration above his right eyelid.
So it's not possibilities.
Give me, in your opinion, what you believe could have caused or produced the injury to the upper right eyelid.
So I'm going to see you at sidebar here.
Ladies and gentlemen, my name is Grant Smith Ellis. I'm sorry for the delay. I tried to go find the witness, some oxygen bottles. I failed in my quest, ladies and gentlemen. I am deeply concerned that this witness is going to collapse, ladies and gentlemen. Yes, I am deeply concerned that this witness may not be able to keep going. My name is Grant Smith Ellis. I'm back with you. I'm sorry I missed the last break. Ladies and gentlemen, I have thrilling towel news. Ladies and gentlemen, Towel Stream is officially bigger than Al Jazeera Arabic. Ladies and gentlemen, we have surpassed Al Jazeera Arabic on, look at this, 30.6K on Twitter, on X, to Al Jazeera's 30.1K. We blew away Ted Daniels and Boston 25 News, coming in at a paltry third place with 17.7K. Ladies and gentlemen, Towel Stream is 6 times as big as Sky News and officially bigger than Al Jazeera Arabic. I'd like to take this moment to say hello to the towel friends in Germany and in France and in the UK and in Italy and in South Africa and in Australia and in Mozambique and in Somalia, hello Mogadishu, and in Intraria and in Egypt and in the USA, all 50 states, and in Canada. Now, I don't know about the penguins in Antarctica. We're working on it. And I want to say hello to the towel friends in Mexico and Guatemala, Nicaragua, Costa Rica, Panama, Honduras, Brazil, Argentina, Chile, Australia, New Zealand, Singapore, Vietnam. Ladies and gentlemen, it is a worldwide towel phenomena. You're here for it. We are officially bigger than Al Jazeera Arabic today. Hello, towel friends in the Arabic world. I would just like to say we are bigger than Qatar. I'm a towel.
May I inquire?
Yes.
Thank you. Dr. Lapisada, you just mentioned that the laceration above the right eyelid was consistent with the application of force, correct?
Correct.
You said it could come from some object, is that right?
Correct. It was fairly small. Could be is some sort of object.
Is it also consistent with a fist?
Sure, a fist is an object.
Okay. Your Honor, at this point, I hate to do this again. May we approach? This is probably a good time. We talked about it at the sidebar.
Can you do anything to fill up the jury's time for the next 10 minutes and then we can do this?
Not without what we discussed at sidebar.
Alan, you're pushing it.
A minute. Okay.
Another sidebar. Really? Oh, thank you, towel friends. Towel friends, while Alan Jackson torments the jury, looks like we're probably going to be done for the day after this sidebar unless the lawyers have to stay for an argument. Towel friends, we are officially bigger than the country of Qatar. I would like to say hello to the towel friends across all 7 continents. We are in 97 countries now, ladies and gentlemen. Might have been 94 at the last count. I've gotten confused. There's a lot of towel friends. We towel friends from around the world, we say hello to Miss O'Keefe and the O'Keefe family.
We're still on track. We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited today. So if you've taken half an hour more to get in here, whatever time you normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use. I'll see you tomorrow.
Yes.
Stay here, folks, because there might be an oral argument. The lawyers might be talking to Judge Kearney, so stay here.
Thank you, Your Honor.
Jurors need some time to exit, ladies and gentlemen. My name is Grant Smith Ellis. I'm going to stay with you until we see exactly what's going on. Oh, goodness, what a day, ladies and gentlemen. Towel Stream has taken over, has beaten out Al Jazeera Arabic for the first time. Ladies and gentlemen, going from, we are international towels. Someone is a charlatan. I agree. It is this doctor. The doctor's breathing a little bit heavily. I'm a little concerned. We're back. We're back. I told you we're back. I'm a towel.
All right, so can you argue the Commonwealth's motion that I received this morning regarding Dr. Rentschler? Can we just do that now? Okay. No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll... So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're,
the stomach lining is a bigger issue, and then some photographs too, whether it's like the car that's probably already in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything, and they are extremely inflammatory.
I'm not looking to introduce. I'm not looking to get those.
All right, the photos on page 6, I believe, are already in evidence. So this is,
that's a Lucas machine.
Right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it. She will explain what effect it has on an increase in stomach lining, attendant to the restricted spots for lack thereof.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
Right. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood staining on fabric around the puncture?
Yes.
She's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. Doesn't mean it didn't happen. I just don't recall it. So I just need to know the source. All right.
Pull that out.
No objections to the photos. You do have an objection to the captions that go with the photos.
Okay. 13A and 13B?
Yes.
Yep, so 13B's out because of the dog bite. Let me see. All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood stain coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page figure 3 in the report.
What page?
I don't have page number. Hold it up.
Page 5.
Page 5. It shows the cross section of the brainstem.
That's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is graphic. This is no more graphic than the supplement.
I disagree, but why does she have to use this photograph?
It furthers her determination of the contact injury. It supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
There is a contention that the coup contra coup is. Yes, that is the contention. I don't think there's any controversy. That's what the.
I thought that's what Dr. Wolf testified to, no?
Consistent. I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated.
Okay. No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I'm looking at this figure 5. So these spots.
Yeah, I think that's already in evidence, isn't it?
It is, but that's not the. Mr. Leslie's saying it's only a chunk at this point, is that right?
I recall it was up, and I usually don't put up chalks, but okay. Excuse me?
Mr. Lessie. Can you say it again? Thanks.
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, my understanding is it's marked as an exhibit only. It was used as chalk, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think. We'll know. Okay. What are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9, which is attendant to these two photographs are attendant to the Lucas machine.
So you're saying 9 in evidence or 9 on the form? 9A and B. Is there an objection to these, Mr. Brennan? Going to the Lucas compression device. There's one on someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay. All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Lapisada.
I would guess I probably am going to finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Lapisada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are of the case. It's improper opinions, it assumes facts, not evidence, and it properly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues for the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are. Each slide that we have any objections to, there's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be, you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a closer look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either. Okay.
4 documents. These are documents that are intended to Dr. Lapisada's opinion and conclusions concerning the dog bites.
Okay, so
I'd like to have those identified for the record.
yes. So we'll make that part of the record. I need a clean copy of Dr. Lapisada's report and her resume for the same purpose.
And her resume.
Yes.
Okay. I'll have those 2 by now.
Okay.
Just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half. 2 hours. I'm being corrected. 3 hours. 4. She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right. So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial today.
I understand. All right.
I have one more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to use 2 hours.
Okay. All right, that would be for everything, including Dr. Wrench,
Sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those 2 witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last minute. It all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at some point. We had something happened with Dr. Lapisada that were going to be different. We heard that at sidebar.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett.
And Ms. Hartnett. Okay.
So that's the scope of Dr. Welcher, or the scope of the rebuttal witnesses for the cop.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right? Okay.
And nor Dr. Crosby.
Or Dr. Crosby. Right.
That's what
Yeah.
I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the curative instruction that was given to the court today. We're going to come tomorrow with, and ask to be heard on that. And we can, so we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Lessie.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on that. Don't want to keep the staff later today. But
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
All right, folks. My name is Grant Smith Ellis. I am a towel. I'm here with you. Look at me. I'm a towel. Goodness, folks, what a weird
thank
day.
you so much for watching the Kearney trial
thanks.
with us,
What a
though.
weird day. Folks, that was a weird, very weird day. Weird in every sense of the term. Strange, ladies and gentlemen. Simply strange. Simply strange. Now, my name is Grant Smith Ellis, and you know what time of the day it is, ladies and gentlemen. It's your favorite time of the day. It's Towel's favorite time of the day. We're going right into a recap. On a day where not a lot happened, I think Judge Cannoni summed it up. The Reed lawyers wasted a lot of people's times. Karen Reed lost another mistrial motion. It was a nonsensical motion. They did the quick curative instruction. Hank Brennan finished up his cross of Dr. Welcher, of the first ARCA witness, and that was about it, ladies and gentlemen. It was a dud of a day for the Karen Reed defense. It was a very strange day. It was just a very strange day in the John O'Keefe and Karen Reed retrial, ladies and gentlemen. But I'll tell you what we're going to do. We're going to do a few things. One, ladies and gentlemen, if you are just joining, I would just like to announce to the world that Towel Stream, ladies and gentlemen, has somehow become one of the most viewed news platforms on X, at least as to who Towel follows. Oh yes, Z Travels, I did. I know my chat is getting caught up, so hold on. My chat's about like a minute and a half behind. It was a long day for Towel Chat. Even Towel Chat, ladies and gentlemen, needed some time to get caught up. Towel Chat was saying, Towel, you are covering so many things at once. I cannot put all of the Towel Chats on the screen. I don't know if this is even possible. So let Towel Chat get caught up, and then we're going to do our recap in just a few minutes. We're all going to breathe. We're all going to talk. That was a weird day. Aidan Kearney's case, of course, day one of that trial is done. And ladies and gentlemen, I am thrilled to announce to all the towels around the world, ladies and gentlemen, yes, all the towels in 94 countries or 97 countries, whatever it is that we're at now, ladies and gentlemen, we are bigger than the country of Qatar. We can let, not just Qatar, the Arabic version of Al Jazeera, ladies and gentlemen, I am thrilled to announce that Towel Stream is indeed officially bigger than the country of Qatar. Now, that was a bad day for the Karen Reed defense. Come in here, recap crew. Get your recap shoes on. Ready your recap loafers or loofahs or whatever they're called that you wear when you're relaxing for Towel Recap. You made it through a weird day. We covered day one of the Aidan Kearney and Karen Reed trial, Aidan Kearney case related, Aidan Kearney and Lindsay Gattani trial, with Aidan Kearney, of course, having been accused of violating a restraining order. It was a really bad day in court. The court staff testified against Aidan Kearney in his case. The court officers testified for the state. One of the McCabe's, Megan McCabe, testified and had a video of Aidan standing in the bushes, walking directly towards Lindsay after he'd been told to leave. Aidan's one argument was that this might have been incidental contact. That's what his lawyer argued in the opening, even though the incidental contact of Aidan Aidan being in the courtroom during the RO violation hearing. Aidan was alleged to have been in a Karen retrial courtroom, been told Lindsay Gattani was there, and then told to leave, but went outside, stood in the bushes, and then walked towards Lindsay and a group of people as they were leaving the hearing. Aidan's argument is that it was incidental contact. Aidan Kearney, I think, is heading for conviction in district court, ladies and gentlemen. That was quite a day. Now, look at your towel comments are finally caught up, and I just want to take this opportunity before we do our recap. We always take a 5 or 10 minute break if you're new to Towel Stream. I just want to say today was the first day ever that we beat out Al Jazeera Arabic. Ladies and gentlemen, even though Boston 25, you could tell Ted, pink down to his underwear Daniel, was saying, listen, Grant, that towel keeps saying on his stream every day that he's beating us out on X. You cannot continue to let Towel beat us out, Boston 25. Towel is now saying he's bigger than our entire network. Do you understand? This is not okay. Well, you know what, ladies and gentlemen? Ted Daniel can eat his pink little underwear based heart out. He is at 18.6 thousand. We are at 33.2 thousand, ladies and gentlemen. And yes, Aidan Kearney's trial will continue Wednesday at 11 a.m. Paul O'Keefe has been called as a witness by Aidan. Lindsay Gattani is expected to testify because she didn't testify today, and there's only so many witnesses the state can call, and it's only a 2-day trial, ladies and gentlemen. It'll be wrapped up by Friday. Kearney, of course, waived his right to a jury trial. Yes, hold on. There is a motion on the floor to call Dr. Lapisada, Dr. Hypa. I don't know how to pronounce that word. Can I have some phonetic pronunciation of hyposada? I don't know what that is. It seems like it's some kind of disease. We have a motion on the floor from the Honorable Towel, Iowa travel nurse. Motion on the towel floor from Iowa travel nurse. I have put the motion to call Dr. Lapisada, Dr. Hyposordia from, I'm going to say, the Honorable with a U, because we're pretending to be British. A with 43 A's or nay, and I don't know which one of you is going to become a horse again, but I'm going to put a few extra H's in there so that you really have to embrace your horseness when you vote nay. Okay, I have moved the poll. Iowa travel nurse. The poll has been moved. You need 30 votes for the poll to have a quorum of towel voters, because we tried to do this within a minute. So, ladies and gentlemen, I'm thrilled to announce that the newest towel poll, as we wait to begin our recap, is should we rename Dr. Lapisada to Dr. Hyposada? I'm not really sure what hyposada is, but we're going to learn. The vote, you are just dominating this poll, Iowa travel nurse. You have a lot of towel friends on your side. It is very obvious. Also, if you're here for towel recap, thank you, Lynn Hennis. And I just want, hypoxisada. We're going to have to work on my towel enunciation. I put the wrong emphasis on the wrong syllable. Hypoxia is a lack of oxygen. Cinnamon Buns is here. Aggie K is here. Lynn Hennis is here. Lisa is here. Just Being Nosy. Macy. Angela Powell. Oh my goodness, ladies and gentlemen. The recap crew is here. All right, Mario Narwafal, you've made your point. I may be bigger than Al Jazeera Arabic, but I have lost out to you. But you know what? I fought the good fight, ladies and gentlemen. Hypoxic is short of breath. Well, she was certainly hypoxic. The word of the day, ladies and gentlemen, is hypoxic. Yes, the word of the day is hypoxic. Now, my name is Grant Smith Ellis, and if you're just joining, I'm working hard. I covered 2 trials at once today. There wasn't much that went on in the Karen Reed trial other than the mistrial motion, which the Karen Reed defense lost. So how we're going to do this is, ladies and gentlemen, we are going to start up our recap with, I think, the most apropos way to do it, which is describe Towel's exclusive insights into the coverage from Dedham District Court. I heard every witness testify. I heard opening statements from State Prosecutor Robert Cosgrove and Aidan Kearney's misdemeanor RO violation. And then we're going to rewatch the moments from Hank Brennan's arc across that led up. We're going to watch the court TV feed, so hopefully it has it all. We're going to watch the moments from from Hank Brennan's arc across that led up into that crazy moment where Bob Alessi lost his mind, wore black gloves, pulled an OJ trial moment, and still lost his mistrial motion. Right. We need to have breathing masks to listen to Dr. Darth Vader. Oh, the memes are gonna pour in, ladies and gentlemen. It was a bad day for the Karen Reed defense. It was a bad day for TurtleBoy. TurtleBoy's heading towards conviction, ladies and gentlemen, in Dedham District Court. I listened to that trial. He chose a bench trial, and he got Judge Pomerol. You don't understand. He got the chief judge of Dedham District Court for his bench trial. Judge Pomerol knows everything about Aidan in this whole case. Aidan screwed. There is no way Aidan is avoiding conviction in front of Judge Pomerol. Judge Pomerol was literally, I think, the judge that sent Aidan to jail for 60 days on a bail revocation. You don't understand. Aidan must have done something very, very wrong if Aidan waived his right to a jury trial, signed the document, and then walked into court and got Judge Pomerol. You don't understand how bad that is for Aidan, ladies and gentlemen. Now, yes, he might not be going to prison on a misdemeanor conviction, but Aidan Kearney could be very much, folks, heading towards a guilty conviction, in my opinion, sometime this week in Dedham District Court. It's bad, folks. It's bad. And Aidan's one argument was, it's so funny, Aidan's argument is that Kate Peter told the O'Keefe family that Lindsay wanted to come to court to support them, the O'Keefe family, and Kate Peter told Lindsay that the O'Keefe family wanted Lindsay to come to court so they could support her. That's Aidan's argument, that because Kate Peter tried to manipulate the O'Keefes and Lindsay, and I think it was probably to try to help Jen McCabe, but I don't know, and I don't care. It's irrelevant anyway, because Aidan, it's immaterial to the charge Aidan's facing, because Aidan quite literally was told to leave by the court officers and remained outside in the bushes and then walked towards Lindsay on video while she was walking to the parking lot. Now, ladies and gentlemen, we'll go over why it was such a devastating day for Aidan Kearney, but also it's just kind of interesting that, like, why was Kate Peter being so manipulative? Kate Mafia Masshole Peter. I have no idea. Like, why? And now I think people are starting to realize it too. I think they're starting to say, like, why did Kate Peter drag Paul O'Keefe? Obviously, Aidan subpoenaed him, but why did Kate Peter have to say one thing to the O'Keefe family and one thing to Lindsay? Why couldn't Lindsay and the O'Keefes just talk to each other and say, hey, we want to mutually support each other, and gone to court? Why did Kate have to play this weird game? Oh, folks, a lot's going on, and I'm your little towel. Dud of a day? Well, dud of a day in the Karen Reed trial, but interesting day in the Aidan Kearney case. All right, now listen, I know, I agree. Aidan and Kate. Did you know Aidan and Kate Peter used to be colleagues until 2019, until they had a falling out? I think they share a similar, my just opinion is they have a very similar dark triad kind of like thing going on. But yeah, all right, let me, what are we going to look at here, ladies and gentlemen? We got to get the Court TV feed up here. We got to get the Court TV feed up because we got to get prepared to do our recap. But I think the way to do our recap is to bring up one of my favorite towel images of Aidan and Lindsay in court for one of the hearings. I'll show you it. It's actually probably the way that I'm going to lead with my, it's the way we have to lead with this recap, ladies and gentlemen. We would be remiss to do anything but, my dear towel friends. All right, so let me find this image for you here. It's actually a pretty epic image, the image of Aidan and Lindsay. And the best part is I put in the middle of the image the text message. Oh, have you all ever seen this special leaked text message here? I'm going to make this the entire screen so you can see this. So if you've never seen Lindsay Gattani, I know the towel chat is going to be covered for a second, but have you ever seen Lindsay Gattani? That's her on the right in black. She's such a boss, ladies and gentlemen. Sometimes there's just people in life who you're just like, she is a boss. And I'll tell you right now, Lindsay Gattani is a boss. Now, so Lindsay's on the right, okay? And then Aidan Kearney, he's like somewhere between 4'8" and 5'4". I don't know, he might be a little taller. Sometimes I think Lindsay's taller than him. Lindsay's, guys, she's pretty tall. She's like 5'2". But anyway, compared to Aidan, she's tall. Anyway, here's a text message from Karen Reed on March 3rd of 2024. Down at the bottom, she says, Aidan is a risk. I have been so careful to lay low, and he blows it all up. Last month, so in January, February 2024, they took my phones that I've had for 2 years. It had tons on it, and that's all from this Lindsay mess. I can't expose myself to that anymore. Tell us how you really feel, Karen, ladies and gentlemen. Tell us how you really feel, Karen. But yes, I think that's going to be the perfect screen for our recap, my dear towel friends. That is going to be the perfect screen for the recap to start. But yes, there you go. Aidan Kearney and Lindsay Gattani in court sometime last year. What a wonderful picture. There you go, ladies and gentlemen. There you go. All right, so one thing that I want to take a look at, though, folks, as we get ready to do a recap, we're all going to take a deep breath. We're going to get ready to do this. Oh, I love you too, Angela Powell, and I agree, Lisa. Lindsay is beautiful. We can't talk for a while because she's sequestered, so I don't know what's going on, but she is beautiful. Okay, so what I've heard is that there was, TurtleBoy had there was a documentary crew with a live, with a video camera recording the hearing today. There was no live feed, so when there is footage up, we'll of course save that, and then watch it. But also, ladies and gentlemen, Wednesday's hearing, very likely no broadcast because the networks won't cover Aidan stuff. They don't like to give him play, and I understand that. So, but Cosgrove is the prosecutor in the felonies too. Absolutely, ladies and gentlemen. And yes, ladies and gentlemen, definitely put hearts in the chat for Lindsay. We all support Lindsay Gattani. Lindsay Gattani is the first named victim to bring Aidan Kearney to criminal trial, ladies and gentlemen. It could be heading towards a conviction as soon as this week. It's Judge Pomerol. That probably is not going to work in Aidan's favor. So if you want to show your support for Lindsay Gattani, she obviously can't see this. She won't be able to talk about the case or anything for a few days until after the verdict or after she testifies, whatever the sequester order says. But ladies and gentlemen, hearts in the chat for Lindsay Gattani. I think it is fine to say that we all appreciate Lindsay Gattani being the first named victim to bring Aidan Kearney to criminal trial. Do you know the type of stones it takes to go through with bringing Aidan Kearney to criminal trial, and then Aidan Kearney waiving his right to a jury trial, and then ending up with Judge Pomerol, who jailed Aidan last year, I'm pretty sure. Oh, ladies and gentlemen, Lindsay Gattani is very special, and we're just going to take a moment to say that as we get ready to begin our recap. Oh my goodness, it's none your business. Oh my goodness, none your business. We are just professing how we all think Lindsay Gattani is a very beautiful and sweet human being, and you are a wonderfully fluffy towel, none your business. It's great to see you. All right, recap. I know everybody's excited for the recap. We are not just going to sit here and listen to Towel and all of the Towel friends talk about how we all think Lindsay is beautiful. Now, listen, I realized we could sit here for at least like 20 minutes and we could all flood the chat with how we all think Lindsay is beautiful. But why would he waive his right to a jury trial? I have no idea, Stacey Gardner. Especially on a case like this. Why would you ever roll the dice? It's such a bad life decision. Yeah, it's Judge Pomerol. Pomerloe. Pomerol. O-L-E. Yeah, Pomerol. It's a hard name to spell. It's a harder name to say, but it's Judge Pomerol. So Judge Pomerol, he is a boss, and I'm telling you right now, Aidan, I know the dynamics of this. Like, barring some very weird, like, hitch in the law that I've never seen before. I'm not a lawyer. I'm just a towel. But he's heading for a conviction. It's a very open and shut case. Judge Pomerol's own court officers were in there on the stand testifying against Aidan. You don't understand. Oh, goodness. Yes, ladies and gentlemen, look at all the wonderful hearts in the chat. If you are excited for Aidan Kearney being convicted, ladies and gentlemen, you know you have to put it in the chat. Now, also, we had a motion from the Honorable to Iowa Travel Nurse as we get ready for our 4:30 p.m. or so recap. It's very possible Towel did not stay hydrated. Iowa Travel Nurse, I am thrilled to announce that Dr. Lapisada is now named Dr. Hypoxia, Dr. Hypoxisada, and the vote is 90% to 9%. 9% of people are indeed horses. Now, ladies and gentlemen, before we begin today's recap, let's make a poll about Aidan Kearney's chances of conviction. What will Aidan Kearney be found guilty after choosing a bench trial in the Lindsay Gattani District Court case? In the Lindsay Gattani case. Ladies and gentlemen, I think this is going to be a very, in the Lindsay Gattani case, in the Lindsay Gattani trial, ladies and gentlemen. in the Lindsay Gattani trial. Yes, we're calling it the Lindsay Gattani trial. Yes, 100%. He screwed himself. No, I am a doofus. Okay, who is going to vote number 2? Who is going to call themselves a doofus? I baited you into it. Will Aidan Kearney be found guilty after choosing a bench trial in the Lindsay Gattani trial? Ladies and gentlemen, if you want to select no, you must proclaim yourself to be a doofus. I don't think anyone is actually going to proclaim themselves a doofus, but you never know. I'm not saying the people who support TurtleBoy are not the smartest people in the world, but I think they're all wonderful. Sometimes they are the type of people who would be like, I support TurtleBoy so much, I'm going to call myself a doofus. Oh, happy day, ladies and gentlemen. We are all seeing, the backstory there with Kate Mafia, Masshole Peter is complex, and it's unfortunate, LLA, but it takes a certain person to ever have wanted to work with TurtleBoy. He was writing those dirty blogs a long time ago. You guys are trying too hard to tie, you guys trying to herd me into poll questions. Nunya just wants to say, Nunya just wants to pretend to be a horse. Oh, goodness. All right, who's ready? Nunya, by the way, did you hear that Towel Stream is bigger than Al Jazeera Arabic? Yes, my dear friend, 33.1K on Twitter to 31.9K. At Towel Stream is officially bigger than the country of Qatar. Someone call the Sheikh. I will enter into negotiations. We will annex Kuwait. Don't tell Kuwait. They're going to get really scared, ladies and gentlemen. I was just kidding. I have no intentions of annexing Kuwait, and I am not a communist. What would you do? Listen, what would you do if your stream was bigger than the Arabic version of Al Jazeera, which is, at least for today on X, which is literally the country of Qatar's state broadcaster? What would you do? You would be like, oh my goodness, I am a towel. This is hilarious. And that's exactly what I'm doing. But we are going to do our, I want to pretend to be Cupid and maybe get 2 people together for a nice dinner. Let's all use it. We'll do it. Ladies and gentlemen, we're all rooting towel on. It's gonna happen. I can do it. I can get over the fact that I am emotionally a moron, and we'll celebrate it. It's a beautiful story. It's like Casablanca, but if the situation didn't work out that way, it was flipped a little bit. You got to follow me. I know what I'm talking about. I am a fluffy towel. All right, we got to do our recap though. All right, who's ready? What do we got here? What do we got? Macy has said something. Yeah, no, but Macy, not on Judge Pomerol. Judge Pomerol was the judge who sent Aidan to jail. Lisa, there is nothing wrong with people who get caught up into these various circles. And I'm not even saying that every piece of coverage that Aidan has ever done, dating back 10 years, was malicious. I'm sure some of the things he was covering, he thought he was really helping people by exposing people who hurt animals or other things like that. I don't think we can really knock that. But in terms of some of Aidan's behavior on a personal level and the people he's hurt, I think anyone who sees the light and says, listen, with that, even if there's a cult of personality around Aidan or whatever it is, I'm willing to stand up and say that was wrong. Similar with Kate, this morning I saw people in this chat saying, I am so grateful that people are finally talking about how it was Kate Peter who'd been being manipulative, in my opinion, who was dragging Paul O'Keefe into this instead of just having Paul O'Keefe and Lindsay mutually say they wanted to support each other. They could have just talked, okay? And they could have said, yeah, the O'Keefes would love to support Lindsay. Lindsay would love to support the O'Keefes. We'd love to have you at court. But no, Kate Peter had to manipulate Paul by saying that Lindsay wanted to go to support the O'Keefes and manipulate Lindsay by saying that telling Lindsay the O'Keefes wanted Lindsay to go so they could support Lindsay. You see what I'm saying? And then when you hear when the floodgate breaks, when the levee does thus finally break, ladies and gentlemen, we can then look at what has actually been occurring, stripped away from the polemical facade, stripped away from the cult cult of personality, stripped away from the loyalty test, stripped away from the high school cliques, and we can talk about the reality of these cases. And yes, this may have been a dud of a day where we wasted a lot of the jury's time in the Reed and O'Keefe case, so I'm extending this delay until we start the recap because it's going to be a very short recap. But that just means I might get to go out and see the sun. Do you understand? I forget what the sun looks like. None your business. Can you and I go on some kind of a cruise? I think we should actually make this ship happen. I haven't seen the sun in like 40 days. I'm starting to forget what the sun looks like. I do want to send a special towel thank you, though, to those towel friends who helped Towel get lunch today. I got a special towel kebab from a local restaurant in Belmont that's very apparently good. I had never tried it before. They had a buy one, get one free special where I got a free french fry if I bought a meal. So I got like $7 off. I'm very economical. I do not order food unless I can get 15 to 20% or more off the price in the Uber Eats app. I have standards, ladies and gentlemen. Anyway, so thank you to the towel friends who helped with that. I'm so grateful. All the towel friends who've been coming in through the chat. We're going to do our recap. You've already heard basically the Aidan Kearney trial recap. He screwed is the recap. And it was a dud of the day. Alicia B., I think what it really was it was Jen McCabe who wanted Lindsay to come to the hearing so that, like, if TurtleBoy was there, then he'd have to leave because Lindsay was there. But, like, it's still even, like, that just shows, like, why Kate didn't have to be manipulative. Like, if Lindsay and the O'Keefes had just talked, it wouldn't have mattered that Jen wanted Lindsay to go because Lindsay would have just gone to support the O'Keefes. You know what I'm saying? So that's the manipulative part. And because Kate was manipulative, now Paul O'Keefe's going to have to testify in this trial for Aidan for Aidan's violation of the RO. But I also think because Lindsay Cattani stood up and is so brave, and do you understand, ladies and gentlemen, it came out during testimony today that when Lindsay Cattani walked after Lindsay and the group walked by Aidan Kearney and they got back to Lindsay's car, the car was damaged. Ladies and gentlemen, while Lindsay was in the trial with the O'Keefe family, someone damaged her car in the on-court property. Like, folks, this woman was brutalized all the way back then, and today she became the first named victim to bring Aidan Kearney to criminal trial. And Aidan Kearney rolled the dice with a bench trial and got the very judge who sent him to prison, to jail, last year, I believe. So there you go. What was the question? Yes, Lindsay and TurtleBoy did date for a little bit in the fall of 2023. And then what happened was Aidan leaked information to Lindsay about how Josh Levy and Karen Reed had a direct connection. And then eventually Lindsay and Aidan, Aidan was very, in my opinion, very in love with Lindsay. But they fell apart. And so Aidan eventually found out Lindsay got subpoenaed, and then because he went over her house on December 23rd, 2023, Karen told him not to go. Karen Reed told him not to go to Lindsay's that night. He went anyway, and because of that, the context is that Aidan had been indicted in October of 2023 with charged in October of 2023 with 16 felonies. On December 20th or 21st of 2023, those charges were bound over by a grand jury and indicted in Norfolk Superior Court. Right after that happened, Lindsay got a subpoena for another grand jury, which only could have been about Karen Reed and Aidan conspiring to torment those witnesses. So Aidan went over Lindsay's house on Friday, December 23rd, 2023, I think it was a Friday, to try to find out what the subpoena was about, and allegedly told Lindsay not to cooperate with the grand jury. Aidan, as a result of that incident, allegedly pushes Lindsay over a couch, wiretaps her illegally, allegedly, and then witness intimidates her, allegedly. Aidan, over that weekend of December 23rd through the 26th of 2023, gets a bolo with PC to arrest issued for him, okay? And then Aidan is brought in, and his bail is revoked on December 26, 2023, because of what happened with Lindsay. Lindsay is the reason Aidan went to jail. Then Lindsay also had an RO taken out against Aidan under 209A of the Massachusetts statute for domestic intimate partner violence. And then when Aidan got out of jail on February 23rd, 2023, a few days later on February 23rd, 2024, a few days later on February 26, 2024, Aidan Kearney went to a Karen Reed and John O'Keefe trial, okay, and Lindsay went with, unrelated to Aidan, Lindsay, who is entitled to go wherever she wants, and Aidan must leave when the order was in effect. Aidan must leave if she's there, regardless of whether he's there first or not. And Lindsay went to the hearing because she was told by Kate Peter that the O'Keefe family wanted to show support for Lindsay by Lindsay coming to the hearing. Well, simultaneously, Kate Mafia Masshole Peter had called the O'Keefe family, or texted or something, and said to the O'Keefes that Lindsay wanted to go to the hearing to show support for the O'Keefes. All right, now regardless of what was in Lindsay's mind, whether she wanted to show support for the O'Keefes or whether she thought the O'Keefes wanted to support her, that's irrelevant. Lindsay gets to the hearing that day. She walks in. Jen McCabe is strangely tactically next to Lindsay as they're walking in. And that's why I think, because Jen McCabe and Kate are very close friends, so I think Kate might have been trying to protect Jen McCabe without telling either Paul or Lindsay what was going on. But anyway, no, all right, we do not facilitate any trolling. We just don't facilitate any trolling. I don't want to see it. I'm not interested in it. It just isn't, I'm just not interested. But in any event, so I'm kind of, I'm there that day, the 26th of February, 2024, and I'll show you the video of them walking in, Lindsay and next to Jen McCabe and the witnesses and the O'Keefe family. But anyway, Aidan also was in the courtroom that day, and this is where the charges start, or the origination of the allegation in the criminal complaint starts. So Lindsay walks into the courtroom and has the restraining order with her, and Aidan notices Lindsay is in the courtroom, and then Lindsay hands the restraining order to a court officer. This was the testimony we heard today. And then Aidan at that point gets up out of the courtroom and leaves. But Aidan doesn't actually leave the whole area. He goes downstairs, leaves the courthouse, and then walks across the street from Norfolk Superior Court to the Registry of Deeds, whereupon Aidan proceeds to stand on the grass of the Registry of Deeds. Well, later, after the Karen Reed hearing ends, it was only 10 minutes or so, as Lindsay and all the witnesses and the family are walking out, Lindsay walks down the ramp with them, and there's a video of this from one of the other, I think it was a McCabe family member who testified today. They're walking through the crowd, and they're walking down the street between the district court and the Registry of Deeds to go to the parking lot, and Aidan is clearly on the video walking closer to them, and Lindsay's in the crowd with them, and Aidan walks closer to them, and he's filming them. Now, it's pretty clear, ladies and gentlemen, that this was after Kearney had been told and knew Lindsay was in the courtroom. So there's no incidental nature, there's no incidental anything about this contact, in my opinion. Then Aidan Kearney proceeds to walk towards Lindsay and the group as they're walking towards the parking lot of the Registry of Deeds, and that's the basis of the criminal charge. But just to give you context, we heard testimony today that at the end of the ramp, or at the end of the parking lot when they got to their cars, Lindsay Gattani found her car had been damaged. So there you go. And hello, Murder by Maestro. It's great to see you. Yes, we are going to get some kind of cruise so Towel can see the sun. It is I feel sorry for the bush. I thought you were going to say I feel sorry for you both, Murder by Maestro. And I was like, I do feel sorry for myself, but not really. I feel more sorry for Lindsay. She's got it tough. Towel's trying to help. All right. Yeah, and that's the thing. It's so ridiculous, Tom Grist. The only reason I can think he would go with a bench trial is if for some reason he thought like the judge that it would get assigned to would be favorable to him. But I'm telling you, Aidan has got to be losing his mind because that judge, Pomerol, who got the case, is not friendly to him. That judge, I don't know. I don't think that's like a one-person thing, Carolyn Phillips. I don't know the answer to that question. And I don't think it's really about me. Like, I can want one thing, but it's really like what fate will allow and like what she wants. So, I don't know. It's not up to me. And I think true love isn't really about ourselves. It's about other people. And so that's why it's such a difficult concept to, I guess, really grapple with. Anyway, I just think it doesn't matter what I want. It's not really about me. And that's what I've learned through this whole saga. It's really helped me mature as a person. We know that Dewdrops was very sick, murdered by Maestro, and they are they were in the hospital with food poisoning. We're hoping they're home resting with Kiki and Riri, and we're of course going to check for an update early tomorrow morning. Did you all find that overview of Aidan's case helpful? And then Carolyn Phillips, of course, had to come in with a really tough question. But yes, I hope that overview of Aidan's case was helpful, because now we're going to do our recap. We're basically ready. How long have we been going for? Only 9 hours? Oh, come on. We're going to be done with this in like an hour. Oh, by the way, folks, you want to hear who's on the mock jury? I think start with dinner, share a cheeseburger, harmless. Metro West Granite, we need to catch up. I don't know if we've ever had a cheeseburger. I think she likes chicken nuggets. She really likes honey mustard. And I really like honey mustard. Getting that girl to eat is a battle. But she likes chicken fingers, and she loves honey mustard. She absolutely loves honey mustard. And that's how I knew. I was like, listen, I love honey mustard. I go to Mama Goo's in Cambridge. I literally love honey mustard. You don't understand. All right, so listen. Stop it, all of you. This is not a romance novel. This is coverage of a criminal case. What are you all doing? Yes, but we can say our prayers for Dewdrops, who we hope is going to let us know tomorrow that she is back from the hospital and okay. Oh, Courtney Myers started a membership parade as towels on his love soliloquy. Oh, Laura, Kim Vest, Yalessi, Debbie Prescott, Heather Botsky, Chi-Town Felon, Tuesday's Dead, Anders Gustafsson, TJ, and Bella Chris. Thank you so much to Courtney Myers. Enjoy your wonderful memberships, my dear friends. You now have unlocked access to Super Towel emojis right as we get ready to start our recap. Oh, ladies and gentlemen, it is a membership parade. Oh, goodness. All right. Oh, God bless you, Courtney Myers. Courtney Myers shared with us they were at an infusion today, and you have support and love from towel friends worldwide, Courtney Myers. Super big towel hugs to you, and you unlock emojis for so many people, they get to make it rain emojis. Our mock jury. Okay, so if you missed it, ladies and gentlemen, we are doing a mock jury, ladies and gentlemen. We are doing a mock jury. You got to get ready. I'm going to make we have a full we have two mock juries. So if you hear your name called and you are still ready, get excited because you made the list. Marie 623TX. It might be Marie 63TX or 623TX, but you know who you are. Kim Cordeau, Alicia B, Christina, Eva, Colleen Henry, We Say Howdy Here, Rachel McIntyre, Irene Grillo, Rita P. from Canada, Ange Whittick, Sarah L. Shenanigans. That is jury one. Oh, you enjoy your bedtime, Courtney Myers. You enjoy that rest. You earned it, my dear friend, after your day. You are a Super Towel warrior. Our jury number 2, ladies and gentlemen, Deaf Otter, Tiger Lily Girl, Chastity, Artworks 2, Dewdrops, Jack D, if she can do it, Jack D65, Sun-Eyed Girl, Luisa Ramirez, Curly Girly, POG 3909, Mandy Strong, and Z Travels. Ladies and gentlemen, if you volunteered and you didn't hear your name called, you just let me know. We'll figure it out. And one of the potentials is I go by Steph Yo, who we call Steph, if they're able to do it. Oh, ladies and gentlemen, I'm going to have to go through my phone. Towel just got a very kind donation. God bless you, my towel friend. From me to you, I give you a big Super Towel hug, not just because of all your support, but because your vibes are immaculate, and I love leaving wonderful comments saying thank you. Towel just wants you to know, if you can hear this, my biggest fluffy towel hugs to you, my dear friend. Oh, ladies and gentlemen, we have a great jury list. We have people ready to serve. Now listen, if you're wondering, how does this jury list work? Okay, so one moment before we begin our recap. I know you're going to get frustrated. It's a short recap anyway, so we have time to do this. If you are on our mock juries, ladies and gentlemen, yes, Carolyn Phillips, I believe in that now. It's like the movie Real Big Fish, and it's also, you just got to leave it all out on the field. Sometimes it's embarrassing. Sometimes it's not going to work out. It's not possessive. It's not a crush. It's not necessarily even just physical. You just have to hope that it's all going to work out because you left it all on the field. You said how you felt, and it's better to have loved and lost than to have never loved at all. That's the lessons I've learned in life, ladies and gentlemen. But yes, the way that our mock jury is going to work, up to 34,000 now. We are still beating Al Jazeera Arabic. We are pulling away, ladies and gentlemen. The way that our mock jury is going to work, you all, on the day that closing arguments are done and the jury gets charged, the day that the jury goes into deliberations, the very moment, so even if they only deliberate for 2 hours, it doesn't matter, you will all go into a one-off chat room. It'll be no username, no sign up required. We're going to have to figure out how to do this in chat. There's only going to be 12 of you who go into the chat room, okay? There's going to be a 4-person. I'm going to select a 4-person for each jury. I haven't done it yet. It's not going to happen until after closings. When you all go into the jury room for deliberations, it's going to be an anonymous chat room. You can pick whatever username you want. You don't have to identify yourself or use the same name as chat. It doesn't matter. No sign up, no app required. I'm going to find a solution for this in the next few days. You all go in there, you chat with your 4-person, you come to a verdict on all 3. However the verdict forms are read in the Reed case, you all are going to vote like that. So you can vote split you can do a split form, however David Yannetti proposes it. And then you're going to come back and tell us your vote, and you're going to tell us the number that you voted. So maybe you all couldn't come to 12-0 on murder 2. Maybe you could. Maybe you were 12-0 on all 3 counts. Maybe you were 9-3 on one count, 12-0, 12-0. We want to know. And then we want to hear reports about your deliberations. So, yes, I think we know how a lot of you are going to be voting. I was almost a juror once, and the other time I got dismissed by phone. Yeah, I think I got dismissed from jury duty one time. I was very sick, and I still am. And the lawyers were like, "Why are you here?" No, now I remember. I didn't even get called up. I filled out a card, and I was so far back that the jury got seated before they got to my number. But yes, I'm not sure exactly what's unreal, but there's a lot of things in life that are unreal. I agree, but I'm thrilled about our mock juries, ladies and gentlemen. We're going to have one of the best experiences I think possible. So, all right, let's do our recap. Who's ready? Who's ready? Oh, goodness. Yeah, it is quite a trial. All right, I'm ready to do the recap. We're going to watch Hank's Cross. We're going to watch, we're going to talk about the TurtleBoy case, and that is going to be our day. Let me pull up the Court TV feed, actually, while we're doing this. Oh, goodness. Even I'm starting to get a little sniffly. And I'm not even around David Yannetti. What have you done, David Yannetti? You've even managed to get me sick, and I'm not around you. Hold on. Metro West Granite, what are you saying me for? Are you saying you want to volunteer? We'd love to have you. But I'm not sure what you're volunteering for. All right. So let me grab we're not going to start a recap just yet because I have to actually queue up the beginning of Hank's recross of Wolf from Arca. So all we're going to watch is Hank's recross of Wolf from Arca, and then the mistrial argument, and then that's it. We're going to do the summary of the TurtleBoy case, and that's it. So let's see. Do they have Brennan's cross nicely queued up for me? I bet they do. Sometimes Court TV is nice like that. Let's see. Okay, yeah, but what about Hank Brennan recross? All right, I got it, ladies and gentlemen. You know we love Hank, ladies and gentlemen. We enjoy watching Hank do his thing. All right. Let's do it. What's going to be the cue point for the recap? We're going to try to keep it relative. I'm trying to keep no more than an hour or so. So let's go for 4:48:00. So that gives us 20 seconds. All right. Show the Staredown. Yeah, Colleen Henry, if you can show the link, send the link one more time, I'll play the Staredown during the recap. But yes, absolutely, folks. We are getting ready for the recap. Hello, my name is Grant Smith Ellis. If you saw today's day 1 of the TurtleBoy District Court trial involving named victim Lindsay Gattani, and day 30 of the John O'Keefe and Karen Reed trial. You saw a dud in the Karen Reed and John O'Keefe trial, and Aidan Kearney make a devastating tactical mistake by selecting a bench trial, getting Judge Pomerol, the chief judge of Dedham District Court, one of the judges who was involved in the decision that saw Kearney sent to jail last year for 60 days on a bail revocation, in charge of Kearney's trial, solely in charge for an RO violation alleged to have occurred on 2/26/2024 outside of the Karen Reed and John O'Keefe trial as to named victim Lindsay Gattani. Ladies and gentlemen, we heard evidence today in that Aidan Kearney trial covered exclusively on Towel Stream. We heard evidence presented that from court officers, ladies and gentlemen, testifying that Aidan Kearney was in the area and told to leave, left or was told to leave because Lindsay Gattani was in the courtroom. And then we heard testimony from, I believe it was Colin McCabe's sister, one of the McCabes, Megan McCabe, that she was filming a video, Megan McCabe, walking out of the court with Lindsay that day, ladies and gentlemen. And after Aidan Kearney had been told to leave the area because Lindsay was there, because a restraining order was already open against Mr. Kearney, and held by Lindsay, Mr. Kearney stayed in the area, and then on video, ladies and gentlemen, on video, Mr. Kearney walked towards Miss Gattani and her group as Miss Gattani and her group of friends and supporters of the O'Keefe family and witnesses were walking to the parking lot. And then, ladies and gentlemen, we heard heartbreaking testimony that when Lindsay Gattani and the group of witnesses arrived to Lindsay's car, it was damaged. Someone had damaged Lindsay's car, ladies and gentlemen, while Lindsay Gattani was inside Norfolk Superior Court supporting the O'Keefe trial, supporting the O'Keefe family. Just devastating, ladies and gentlemen. Just a devastating day. My name is Grant Smith Ellis. You can see the picture right there. It's Aidan Kearney on one side from a pit last year, Lindsay Gattani on the other. Oh my word, ladies and gentlemen. So just a bad Aidan Kearney's trial. One other development is that Paul O'Keefe will be subpoenaed as a witness in that trial. Paul O'Keefe will be testifying sometime Wednesday after 11 a.m. Aidan Kearney is calling Paul O'Keefe as a witness, apparently because a woman named Kate Mafia Masshole Peter, for no reason whatsoever, messaged Lindsay and Paul on that day of the O'Keefe and Reed retrial in question, 2/26/2024, and told Paul O'Keefe that Lindsay wanted to come to court to support the O'Keefe family, but told Lindsay, this is Kate Peter, by the way, Kate Mafia Masshole Peter, but told Lindsay that the O'Keefes wanted Lindsay to come to court to show support for Lindsay. So I don't know why Kate Peter did this. Kate Mafia Masshole Peter, who used to be a colleague of Aidan Kearney until 2019 and just has a bit of a weird reputation in the O'Keefe and Reed case, in my opinion. But ladies and gentlemen, for some reason, Paul O'Keefe is now a witness in this case. But the case is only halfway done. Aidan TurtleBoy Kearney trial, day 1, Dedham District Court done. Day 2 scheduled to start Wednesday, 11 a.m., right at the conclusion of the Karen Reed and John O'Keefe trial. I think, ladies and gentlemen, based on the testimony I heard today, based on the fact that it is Judge Pomerol, ladies and gentlemen, I think it is very likely that Aidan Kearney is heading for a conviction in Dedham District Court, which would mean Lindsay Gattani, ladies and gentlemen, was the first named victim to bring Aidan Kearney to criminal trial, and it could be that Lindsay Gattani will be the first named victim to get a guilty verdict against Aidan Kearney. Now, I don't know why Aidan Kearney made the decision to go with a bench trial, ladies and gentlemen. It was a shocking last-minute tactical maneuver that funneled Mr. Kearney right into the palms of Judge Pomerol. I didn't mean to do that. It just happened, ladies and gentlemen. But that said, there was also developments in the John O'Keefe and Karen Reed trial. Yes, ladies and gentlemen, the news of the day is that Karen Reed has confirmed she only has 2 witnesses left after Hank Brennan won his motion to prevent Karen Reed's strange forensic pathologist from testifying about dog bites, because there's no dog DNA in the case, and the doctor in question didn't even really know about dog bites. Dr. Lapisada got her testimony limited, and then we found out at the end of the day, ladies and gentlemen, that the John O'Keefe and Karen Reed retrial is going to be done in the next few days. Alan Jackson needs just an hour and a half more with Dr. Lapisada. Hank Brennan needs 30 minutes on cross. Then Alan Jackson needs 3 to 4 hours with Dr. Rentschler from ARCA. Hank Brennan's going to need an hour or so on cross, so that takes us into Wednesday, okay? And then Hank Brennan needs 2 hours for his rebuttal case, and there won't be a Sir rebuttal from Reed. So we're looking, ladies and gentlemen, Wednesday afternoon at the latest, maybe Wednesday towards the end of close of court for Brennan to be done with rebuttal. That means Thursday, ladies and gentlemen, expect closing arguments and the charging of the jury in the John O'Keefe and Karen Reed retrial. I hope you can collect yourself. I hope you can ready and compose yourself because it is going to be an intense week. Is Aidan Kearney going to get convicted? Is Lindsay Gattani going to stand tall, ladies and gentlemen? And will Karen Reed be heading into an orange jumpsuit? And will the world yell out in unison, "Get in the van, Karen"? Well, my name's Grant Smith Ellis. I'm a towel, and we're going to find out together. Now, let us take a look, ladies and gentlemen, because I have a very special towel recap prepared for you, as I mentioned earlier. We are ready to begin with Hank Brennan's excellent recross of Dr. Daniel Wolf from ARCA. Then we're going to watch one other big moment that happened. The Karen Reed defense is so desperate, they lost yet another mistrial motion. Yes, ladies and gentlemen, Hank Brennan asked a line of questioning about whether holes in John O'Keefe's shirt were caused by the accident on the night of 1/29/2022. Turns out that they were caused by a forensic analyst cutting the shirt or something like that. Needless to say, there was a curative instruction. Bob Alessi lost his mistrial motion, and that was the day that was in the Aidan Kearney, Lindsay Gattani, John O'Keefe, and Karen Reed trial chaos. I threw down. I did everything I could to cover both trials for you at once. We were a cogent, erudite, and informed little towels, and now we're going to watch Hank Brennan do his recross. We're going to watch the mistrial arguments, and then we are going to be done for the day. My word, ladies and gentlemen, it was a dud of a day in the Reed and O'Keefe trial, but Aidan Kearney could be heading towards conviction. Oh, my word, ladies and gentlemen. Oh, my word. Oh, and then there was a question as to whether Paul O'Keefe has to bring his phones and records. That motion was not decided. As of now, all Paul O'Keefe has to do is show up to testify as a witness. The ruling on the phones and any messages between Paul and Kate Peter and et cetera, will be decided on Wednesday. It's really more embarrassing for Kate Peter than anyone else, ladies and gentlemen, but Kate Peter is also a person who, unfortunately, started a rumor that some of the Reed witnesses sold narcotics when that was completely not true, and no one had ever said it before. Kate spread that to TurtleBoy as a way to troll him. So, I don't know, ladies and gentlemen. History has a weird way of coming around, and the dam has thus broken when it comes to, I think, Kate Peter's behavior, in my opinion, in some ways. But let's listen to Hank Brennan's stellar recross, then let's watch the mistrial argument, and then we will be done for the day. Take it away, Hank.
May I, Your Honor?
Yes.
Good morning, Doctor.
Good morning.
Doctor, did you have a chance to speak to anybody from the defense this weekend?
Not over the weekend, no.
After you left here Friday?
On Friday, I let them know that I was returning back home, and then I let them know last night that I had arrived, yes.
Did you receive any new information or have any conversation before you came in today?
No.
Now, when we asked you about weight last week, you did not go into any calculations about the difference between the standard arm, 11.86, and the 9.38, did you?
I don't believe we did, no.
In fact, when you testified last week, at the end of the day, you were asked questions by Attorney Jackson about the weight of that arm, correct?
Yes.
And when you were asked about the weight of the arm, Attorney Jackson asked you if you were asked a lot of questions about the difference in the weight of the arm, about 11.8 pounds statistically as it relates to Mr. O'Keefe versus 9.4 pounds. Do you remember him asking you about that?
Yes.
And you were asked whether you were aware whether anybody had measured the weight of John O'Keefe's right arm. And you responded, I'm not aware of that, no. Do you remember that testimony?
Yes.
And then you were asked, when you asked questions about whether or not his arm was 11.8 pounds, are you aware of anybody ever just weighing just his arm? And you said no.
Correct.
And finally, you were asked, what is that based on, 11.8? Where did that come from? Remember what you said?
Yes.
I don't know. Remember you answered Attorney Jackson and you said, I don't know where that came from.
Right, referring to, I don't know what source you pulled that 11.8 from.
Uh-huh. And so you were suggesting that that is just a number pulled out of thin air, right? Was that a surprising estimate, 11.8 to you?
I don't know that it was surprising. I don't know what your source is for it.
Well, when you engage in accident reconstruction, you never just take somebody's limb and sever it and throw it on a scale, do you?
I'm not usually doing that part of the analysis, no.
So when you're relying on body weight and different parts of the body, there is strong statistical studies that give you a guide, isn't there?
I would agree with that, yes.
Well, the number's just on the thin air. If you're doing a study and you have to figure out damage to an arm or a foot or a leg, and you have to come to an estimated value or weight, you have to get that information from somewhere, don't you?
I would agree, yes.
You just make it up out of thin air. You have to find a resource, a reliable, vetted resource. True?
I would agree.
And that's what you do.
In some instances, yes.
Well, in this case, you chose an arm that was 9.38 pounds. Where did you get the support that the 216-pound, 6'1" man would have an arm that weighs 9.38 pounds? Where did you get that from?
Well, it's conservative from the standpoint, if you think about one of the equations we talked about last week, force is equal to mass times acceleration. So if we take the acceleration data from our test and we multiply it by a lighter mass, the 9.38 pounds, it's less force to the arm. So now if you want to increase the mass of the arm, you're now talking about a greater net force to the arm. So it's conservative from a force perspective.
Put aside your story about the force perspective. My specific question is...
So it's sustained. Ask the question differently.
I'll ask you again, Doctor. Tell us where you got the 9.38 pound value from when considering a 6'1", 216-pound man. Where did you get that from so you could be statistically accurate?
It is the mass of the hybrid 3-arm. We saw the photograph that depicted the weight. Again, how you account for that when you're doing the force calculations is you would utilize the acceleration data that we measured, and then you would apply a different mass, in this case, a heavier arm. And I will note, it's the same thing that Dr. Welcher did in his drop test with the hybrid 3 head. He ultimately measured the acceleration of the head, and then to calculate the force, he adjusted the mass of according to Mr. John O'Keefe's mass of his head.
So for the third time, I'm going to ask you just a very simple question. Dumb it down for me if you can, okay, Doctor? Where did you get the source to legitimize using a 9.38 pound arm for a person that's 6'1", 216 pounds? Where is your source to say that arm is validated to use for that size man? Where is that?
Again, it's the weight of the ATD arm. That is what the 50th percentile arm weighs. As I mentioned, in our field, it's accepted to utilize the acceleration data, and then you adjust the force based upon an increase in mass.
Is that your answer?
Yes.
Mr. O'Keefe's body weight and size does not put him in the 50th percentile like the 9.38 arm. He's closer to the 95 percentile. Isn't that fair to say?
Correct.
And there is, in fact, a 95 percentile crash test dummy, isn't there?
There is, yes.
Yeah. You chose the 50 percentile, which is shorter, yes?
Correct.
Weighs less, yes?
Correct.
And the arm weighs less, True?
Correct.
The truth is, you have absolutely no study, no paper, no article that supports using a 9.38 arm for a 216-pound man who's 6'1". You have not one reference or study you can offer us right now, do you?
I don't agree with that because, again, if you look how Dr. Welcher did it, he used the 50th percentile in his drop test with the head and to calculate the force. He adjusted for Mr. John O'Keefe's mass of the head. Same thing is done in this instance with the lighter arm. We adjust for that in the calculations.
You have one paper, one study. I know the answer to this, but let me ask. You have one paper, one study to support that it is appropriate to use the 50th percentile 9.38 arm for a person who is 6'1", 216 pounds. I won't ask you again, but if you can answer this once for me. Do you have one paper, one study?
So I'll take out the commentary. Can you answer that? Or answer that question, please?
Sorry, can you repeat the question?
You have one paper. Give me a name, an author. One paper, one study that supports using a 9.38 arm, 50th percentile, when you're doing a crash test for somebody who's in the 95th percentile who weighs 216 pounds and is 6'1". One paper, sir.
I don't have a paper because Dr. Rentschler is addressing the forces and the injuries to the arm.
You talked about, however, would you come up with the number 11.8? Like it was something that is curious or foreign to you, right?
Objection. Sustained.
Are you confused how the number 11.8 would come up?
Objection. I'm going to rely.
I'm not confused. I don't know your source for it.
When you do studies, would you agree that the head has a similar weight to the arm and that the weight of an arm would be about 5.48% of a person's body weight?
I'm sure that there's various studies out there that talk about that could be one particular study.
Well, let's talk about one study. What do you think? You're the engineer, you're the expert. When you're weighing an arm by percent, what is the percent of the arm of the total body weight?
I don't know as I sit here today off the top of my head, no.
I'm sorry?
I don't know as I sit here today off the top of my head.
Well, if you don't know the percent of body weight of the arm compared to the whole body, how would you ever come up with a number for the arm?
Well, from the work that I've done with Dr. Rentschler in this case dating back to last year, it's my understanding that his calculation for the arm was approximately 11 pounds.
So you're relying on somebody else's study? You're doing an independent assessment of the evidence, and you're relying on other people's math? Is that what you're telling us?
I don't agree with that because, as I've mentioned numerous times, Dr. Rentschler and I worked as a team on this case. You can't separate the reconstruction part from the biomechanical part. It's an integral part that works together on it.
Would you agree that the arm is about statistically vetted, that it's 5.48% of the total body weight? Would you agree with that?
It sounds about right, but again, I don't have the percentage off the top of my head.
So if you take 5.48% of a 171-pound man, which is the crash test dummy you were using, the 50th percentile, what do you get?
You said 5.48%?
Yeah.
Just over 9 pounds.
Okay. Close to 9.38?
9.37.
Okay. Now when you have 216 pounds, 5.48%.
11.8.
11.8. Sound about right, doctor?
By that calculation, yes.
Okay. Now, you said you had some confusion where I'd get that number from, this 11.8. Do you remember that?
Yes.
And when I threw out that number, is that the first time you heard of that number?
The 11.8?
Yeah.
Yes.
Or 11, is that the first time you heard of it from anybody, 11 pounds? Is that a new number to you?
I don't understand your question.
Well, you're saying that when Attorney Jackson asked you where did Brennan get those numbers from, you said, I don't know. Remember that on
Correct.
Friday? Do you know where I got the number 11 pounds from?
11.8
Yeah.
or 11?
11.
As I just mentioned last year, I believe I testified in a previous proceeding that it was about 11 pounds.
Yes. Your testimony.
Gonna try to fix the feed here, sorry.
Previous proceeding that it was about 11 pounds.
Yeah.
Hold on, sorry, that was actually my fault. The feed stuck like while Hank was talking at one point, but did unfreeze, and then it was actually me. So, DJ, I just want to apologize. I inadvertently gaslit you. It was actually my fault.
Your testimony, 11 pounds. Your prior testimony, right?
Yes.
You testified before under oath in this case, didn't you?
Correct.
And when you testified under oath, and you were giving a general estimate about the pounds of Mr. O'Keefe's arm, based on your experience and your training, you said it was around 11 pounds. Those are your words, right?
Correct, yes.
Under oath.
Yes.
Right. You can't delete something that's under oath, right?
Objection.
And so when you feigned confusion on Friday about this 11 pounds,
Sustained.
so when you answered questions last Friday about wherever this 11.8 pounds came from, you weren't so confused about that because you've used 11 pounds before yourself, haven't you?
Yes, but again, I don't know where you got that 11.8 from, so...
Well, we just did the math, didn't we?
Yes.
Okay. And you used the calculator to help you, didn't you?
I did,
The
yes.
calculator works?
Yes.
Okay. You said you wouldn't calculate the difference, but you did. And so what you just went through this exercise is you divided that difference, that 2.48 pound difference, right?
Correct.
And then you divided it by 11.86. Divide 2.48 by from the 9.38.
Okay.
What percentage do you get?
26.
Would you agree with this statement about whether the arm and body weight, comparing the weight of the head to the arm, would you agree that the head and arm are actually almost identical because your arm, just one of your arms, including the hand, forearm, and upper arm, is about 5% of your total body weight? So for someone who weighs 216 pounds, that's about 10.8 pounds. Would you agree with that?
I didn't do that calculation, so I
didn't ask you. I'm asking if you would agree with that.
Can you repeat the question, please?
So ask the question.
Does the arm weight weigh the same as the head? Or the arm does weigh the same as the head, almost identical because your arm, just one of the arms, including the hand, forearm, and upper arm, is about 5% of your total body weight. So for someone who weighs 216 pounds, that comes out to about 10.8 pounds. Would you agree with that?
I haven't done the calculation, but if the math checks, then yes.
Okay. Would you agree with this statement? The heavier the object, if it gets hit center mass, that's going to be even greater force because that is more mass than just 11 pounds. So the acceleration is the same for each body part. It just depends on the weight of the body part and how heavy it is to determine the force that's actually exerted on the body. Do you agree with that?
Objection. I'm going to allow the question.
Do you agree with that?
Yes, and I think I described that a little bit earlier. Is you would increase the mass, you multiply it by the acceleration. That's going to increase your force. Force is equal to mass times acceleration.
Right. So mass has a direct correlation to force. You agree?
Correct.
So therefore, the heavier the object, if it's colliding at the same speed, will create more force than a lighter object. You'd agree with that, wouldn't you?
Correct. More force on the arm. Yes.
Right. So weight matters, doesn't it, sir?
Yes.
Force is mass times acceleration. So if the arm weighs the same as the head, you're still going to get the same force. And so inevitably, you change the mass, you change the weight, same speed, it changes the amount of force.
Correct. Yes.
Yeah. Okay. When you did calculations in this case, you never took the estimate of 11 pounds, although it didn't exactly calculate the 5.48. You never took that 11 pounds and determined the percentage difference between the mass in that arm and the mass in a 9.38 pound arm, did you?
No, I did not.
You didn't include it in any of your PowerPoints?
No.
You didn't explain it to the jury that there's a difference and weight matters?
Again, that's something that Dr. Rentschler is going to discuss.
I'm asking you because you testified, you gave opinions, you got a PowerPoint. Did you explain to the jury about the difference in force when there's a change in weight? When you did all your PowerPoint and calculations, did you break it down for them?
Well, I think it was certainly stated. I mean, I know that we went over Newton's second law, force is equal to mass times acceleration, right? So if you increase that mass number, it will increase the force.
When you were putting up your PowerPoints with the speeds, did you explain to us that there's a difference when you change the mass so that if you used a lighter arm, there would be a difference in force? Did you explain that to us in any of your slides?
I don't know that I explicitly stated it, but again, that's why we went up to 29 miles per hour to account for that difference in weight.
Were you trying to inflate the force for the speed of test so it looked like the collision had to happen at a faster speed to cause a certain amount of damage? Were you doing that intentionally?
No.
You didn't overstate the mass. You didn't use an arm that was 14 pounds that would have created the opposite illusion, right? You used a weight that was lighter than Mr. O'Keefe's estimated arm.
Right, because again, it goes both ways. If you increase the mass of the arm, you increase the force on the arm. So there's going to be more force acting on the arm.
Let's talk about your studies with Mr. O'Keefe's sweatshirt and his arm, and you gave some opinions about what you would expect for damage to his arm. When I asked you on Friday whether you had any support, any vetted journals, learned treatise, any support whatsoever about whether you should use a crash test dummy arm for these types of studies, you didn't have any support on Friday. Do you have any today that you can refer to?
No.
Putting aside the fact that you have absolutely no professional studies or journals to support that you should be using a crash test dummy's arm for these type of tests, are you aware of the expert literature in this case that the opposite, you specifically should not use crash test dummies when you're trying to do this type of analysis on clothing and a person's body? Are you aware whether that exists?
I'm not aware of those studies, no.
As a inquisitive engineer, wouldn't you want to know if there was legitimate studies in your work, in your profession, that suggests or states that you should not be using crash test dummies to determine injury to the arm as far as lacerations? Would you want to know that?
I think, again, you're getting confused between my role and Dr. Rentschler. Can I finish, please?
No. Objection.
Okay, so no comment, Mr. Brennan. Answer the question, please.
I wasn't addressing the lacerations or the abrasions to the arm, sir.
You had photographs and you were opining that you would have expected or you would not expect there to be abrasions or cuts on that clothing in your test A and B, didn't you?
There were no holes or cuts in the material, no.
I understand, but you offered opinions. Didn't you offer to the jury an opinion that the abrasions on Mr. O'Keefe's arm were inconsistent with your tests in A and B?
The cuts and the holes are inconsistent.
Sir, when you are assessing cuts and holes on clothing, you need to make sure the predicate as a basis that you're using the right properties, right?
I would agree with that.
Right. And so if there was literature directing that you should not use a crash test dummy to assess injury on an arm, would you follow that instruction or would you do it anyways?
Again, you keep saying injury to the arm. I was looking at what happens to the material when it makes contact with the taillight.
A crash test dummy's arm is harder than a human arm, isn't it?
Yes.
You push a human arm, it's like an indent. You can push in, can't you?
Yes.
And that property of pushing in, if a cloth is on it, it is easier for a cloth to tear pushing in than if it's hard. Isn't it?
I don't know that I agree with that.
Well, do you disagree with that?
Well, the hybrid arm is a vinyl flesh, so it's not rigid.
Do you disagree with what I just said?
Can you repeat your question?
Sure. Human arm, softer than the hybrid, yes?
Yes.
When you push it, you can push in, much different than the hybrid arm, which is stiffer, yes?
I don't know what you mean by much different, but there will be a difference, yes.
Well, is it a noticeable difference to you if you push a hybrid arm as opposed to a human arm?
Yes.
When you push a human arm, it indents, yes?
Correct.
And so if you push with cloth on, the cloth indents, yes?
Correct.
Which creates an easier, tear in the fabric with less force if you can push in as opposed to a hard arm. Would you agree or disagree with that?
I would agree with that.
So when you're replicating studies and giving opinions about a person's arm, a real person's arm, using a hybrid arm doesn't seem to be an appropriate standard, does it?
I don't agree with that because, again, when the taillight breaks in the test, the arm is now moving with that taillight. So it's, again, like we talked about on Friday, you'd somehow have to have those fragments accelerating at a greater velocity to penetrate that.
We're going to get to that, but I'm talking about the stiffness. Let's get back to the appropriateness of using a crash test dummy. Now conceding that a human, it pushes different than the crash test dummy, would you agree that a crash test dummy is not an appropriate tool to use when determining tears in clothing on somebody's arm? Would you agree?
I don't think I would agree with that, no.
When you used the crash test dummy in test A and B, that was the 5'9" dummy?
Yes.
When you considered tears to clothing, you bought a new sweatshirt that was similar to Mr. O'Keefe's, an extra large sweatshirt?
Don't know if I recall the exact size, but I think one of them might have been extra large.
And then you bought a second one that was medium. So when you used the smaller dummy, you weren't actually using Mr. O'Keefe's size of extra large. You used a medium sweatshirt, yes?
Yes.
Because it was a smaller dummy than the size of Mr. O'Keefe. That's why you needed a smaller sweatshirt, yes?
I think it was more or less just what we could get our hands on.
Well, you had an extra large and a medium. You didn't put the extra large on in test A and B, did you?
I don't recall off the top of my head what sizes were on each test.
Okay, could we show a picture of A to remind Dr. Wolf? And while she's pulling that up, is there a difference between, see that's how that's blue? You see that's medium?
Yes.
So the blue ones that you use for test A and B, correct?
Correct.
The smaller crash test dummy than Mr. O'Keefe, the 5'9" crash test dummy, yes?
Correct.
And then when you used Randy and brought him into the scene, you used the extra large, the gray one.
Correct.
Right, so you used a different one because it was a smaller anatomical doll than the size of Mr. O'Keefe, yes?
We used different sizes. The material blend was the same.
This was new?
Correct.
The extra large you put on Randy was new?
Correct.
Did you consider the wear and tear on Mr. O'Keefe's sweatshirt, the extra large sweatshirt he was wearing that night?
The wear and tear?
Yes, the wear and tear.
No.
Did you ever consider the differences between a brand new sweatshirt and one that had been worn?
No.
Had you ever had clothing, sweatshirt you used repeatedly, maybe put in the dryer, wears it down? Sometimes you can get holes more easily. Did you do any type of analysis on that whatsoever? Any type of analysis whatsoever on the age or whether it's stretched the same, anything like that?
No.
No variables whatsoever on the sweater, did you?
No.
Okay. Does it matter whether or not the sweatshirt is tighter or looser or how it fits the body? Is that any part of your consideration?
No.
Have you ever done testing like this before for clothing?
In terms of impacting a taillight?
Yes.
No.
So this is the first time ever that you've done this type of analysis and offered an opinion in front of a jury on this?
Specific to impacting an arm with a taillight, yes.
Before you decided to come in and give an opinion, Did you take any study or look at any journals on fabrics?
No.
Did you consider any of the variables that one would want to consider regarding fabrics before you came in and gave this opinion?
No.
Did it concern you when you were coming in to give a professional opinion about something you've never done before, whether or not you were studied in the area before you did it?
Well, I think I relayed my observations from the test, right? I certainly explained how we set up the arm, how the arm was closed. You all obviously saw the impact testing to the arm, so I'm relaying my observations from the test that we did.
Did it concern you that you were coming in to give an opinion on something you have never done before, and that you did absolutely no study on fabrics or any of other people's analysis on fabrics in cutting? Did that concern you?
No.
So you were comfortable just coming in with no experience in this whatsoever, without even studying or doing any research? You were comfortable to come in and just throw out an opinion?
No, again, and Dr. Rentschler is going to address part of this. Again, we worked as a team, so there's a synergy between the two of us.
Well, putting aside the synergy, you're the one on the stand under oath, yep?
Correct.
The other one testifying, giving opinions to this jury, yes?
Yes.
The other one asking them to rely on your experience and training, true?
Correct.
The other one asking them to rely on your judgment and your effort to be accurate, yes?
Yes.
So when you give the opinion, you have a personal responsibility to support that opinion, putting aside Dr. Welcher or Dr. Rentschler. You have a responsibility for your opinion, don't you?
I would generally agree with that, yes.
Generally?
Yes.
Well, when wouldn't you? When would it not be general? Don't you have an obligation every single time you take the stand and give an opinion to be supported, valued, vetted?
Yes, and again, Dr. Rentschler is addressing those abrasions and lacerations, which certainly correspond to the material.
Right. But you didn't wait for Dr. Rentschler. You offered a number of opinions to this jury. You personally, under your name, you came in and presented yourself as an expert in this subject. You, didn't you?
Correct.
So putting aside Dr. Rentschler, his opinions, do you stand behind your opinions?
Yes.
Okay. And you do that despite the fact you've done no study, no research, haven't vetted, and have no authority whatsoever?
Yes.
You wrote a report back on February 12, 2024?
Correct.
In February 12, 2024, do you remember talking about injuries to the arm and damage to the taillight?
Generally, yes.
Okay, that's fair. Do you remember writing in a report, it is significant to note that the injuries have been classified as abrasions and analysis of the autopsy photographs indicates minimal bleeding or lacerations of the dermis?
So the report that you're referring to is a joint report authored by myself, Dr. Rentschler, and Mr. Scott Klein. So that would have been a portion drafted by Dr. Rentschler addressing the injuries.
I see. So in this report, it has your name, Dr. Rentschler, and another person, Scott Klein, yes?
Correct.
But in the report, none of you ever differentiate which opinions you're standing behind or somebody else's, right? I'll move on.
The objection is sustained.
I'll move on.
The objection is sustained.
Did you agree with that?
Sustained.
Did you write or endorse these injuries would not result from impact with a non-damaged tail lamp cover and the amount of force required to fracture the tail light cover?
So we're going to see you at sidebar.
All right, now you know the best thing about recaps. Who's ready to time travel? Who's ready to what's going on here? Give me a little second, little towels. We are at sidebar. By the way, it is not your fault that this keeps freezing. It's just I've upset the towel stream. I have upset it greatly, ladies and gentlemen. I have made the towel stream upset. it's not freezing, but you just get to stare at Dr. Wolf's face for a little while, because sometimes I click away from the stream and it's like, no, I'm going to save computer resources by not streaming the video. But I have a plan. I've put the video back up at the front of the stream. Murder by Maestro, at the end of the month, my friend, I think we have to have a talk about ordering my streaming PC for our next trials. We need to pick what trials we're going to cover. Oh, that's Tara! And Miss O'Keefe, did you know Miss O'Keefe was informed by John DiPietro, that she is the mother of all towels? Also, Hank Brennan is a towel.
You were asked questions about impact with the taillight. And in fact, in one of your answers to me today, you talked about after a vehicle collides with a pedestrian, there's continued movement between the vehicle and the pedestrian, isn't there?
Correct.
And so while or plastic that shatters from a taillight might not impale clothes of the skin, would you agree, if your dummy wasn't restrained, when the Lexus collides with the dummy, there'd be continued contact for some time, extended contact between both the dummy and the taillight?
Well, the arm, as is demonstrated in the test, would be moving at roughly the same velocity as the vehicle.
Yes. And don't you think that the vehicle would continue to drag the arm until the body either was thrown or spun off? Would you agree with that?
At some point, they will separate, yes.
At some point, but before the at some point, what I'm asking is, at the collision, when you see all the taillights shatter, right, wouldn't the Lexus, if it continues at that speed, say 24 miles per hour, for example, it would continue to drag with that dummy's arm longer than is shown in those experiments because the dummy is restrained?
Sorry, can you repeat the question?
Yes. Would you agree that if a Lexus is backed up at 24 miles per hour and hits the dummy's arm and the taillight shatters, if the dummy wasn't restrained and moved regularly, it would extend the contact between that shattered taillight and the dummy's arm? Do you agree with that?
It would move with the vehicle until it got pushed out of the way, just move to the side, yes.
And so what you're saying is it would move with the vehicle but wouldn't touch the vehicle?
Well, in the one test, if you remember, because of the restitution effects, the arm reached a speed of over what the impact speed is. So in some instances, it actually might move at a speed greater than the vehicle.
Fantastic. In some instances, would it move slower and be dragged by the vehicle's broken taillight?
Dragged?
Yeah,
I don't know
so
if
when
I understand.
Drag, push. How about we use the word push? Pushed by the broken taillight. Could that happen?
The arm would move with the taillight until it moves out of the way.
So you're saying it would move with or faster, but never would slow down where it gets pushed by the car?
It's moving with the vehicle, sir. I don't understand your question.
Well, no. You said it moved with the vehicle. Sometimes it moves even faster, suggesting space between the broken taillight and the arm. That's what you're suggesting, right?
Correct.
So it can move with, it can move faster. Can it ever move slower and the vehicle pushes and drags against the arm?
I mean, it might be able to move a few miles per hour if it doesn't have as much of a center of mass hit, but it's still going to move out of the way because it's on a joint.
I understand, but before it moves out of the way, could it be pushed by that broken taillight? That's the simple question I'm asking you. Could it be pushed by the broken taillight?
Just moving adjacent with the taillight, just moving along. Yes.
Would you agree with this? If you have an arm struck at 25 miles per hour, significant more damage that taillight shatters, hits and moves forward into arms, parts of taillight pushed into arm as vehicle pushes forward and pushes arm out of the way. So the word push, would you agree with that general characterization that the broken taillight can, in fact, push the arm? Would you agree with that?
Generally, I guess, again, it would move with the vehicle, the arm together.
Not move with. I'm asking you if you would agree about pushing. Would you agree with that?
As long as we're on the same page about it, it's pushing the arm, but it's with the vehicle. They're moving together. So, but in essence, yes, the arm is being pushed due to the fact that there's a force on it.
And the pushing could have that arm in contact with the broken pieces of a taillight if the taillight broke, correct?
Just moving at a common velocity?
The operative word here is push. And so, do you like to agree with me or you could disagree with me? Can the broken taillight push the arm so it contacts and provides force against it? Could that happen?
Yes.
When you were showing those photographs today regarding Test F, now you used Randy in Test F, right?
Correct.
How tall is Randy?
He's 6 feet.
And he weighs 200 pounds?
Correct.
So still 16 pounds less than Mr. O'Keefe, yes?
Correct.
And you keep referring to Randy as a crash test dummy. Randy's no dummy, right? He's a mannequin.
He is, but he signifies basically what happens when you have 200 pounds of mass striking the rear of that vehicle.
I don't want to misrepresent Randy. He's not a crash test dummy, is he?
Well, it wasn't used for biofidelic purposes. It was to, again, what happens when you have 200 pounds of mass strike the vehicle.
So when you've been referring to Randy as a crash test dummy, you don't mean to do that. That's a misnomer, isn't it?
I don't know that I agree with that.
So you think that Randy is a crash test dummy? He's a certified, approved crash test dummy.
No, and I think I made it very clear that there is no instrumentation on it, right? And one of the reasons why I mentioned that is those ATD dummies are $150,000, so we're not going to risk impacting it with the Lexus and destroying that.
I can understand the cost analysis for you, but I want to be clear. He's a mannequin. It's used by firefighters and drills pulling a body, dead weight, out of a house to replicate certain scenarios. That's what Randy was made for, yes?
He can be used for those, yes.
Right. He's not a crash test dummy in the parlance of a legitimate, studied crash test dummy, is he?
I don't agree with that because, again, we use that type of dummy in all different types of tests.
There's an H395M PED, which most closely replicates John O'Keefe's size and body, isn't there?
Correct.
You didn't have that when you did your test, did you?
No.
When you do crash tests, you can put a magnetic control on the crash test dummy, so upon impact, it releases and is thrown. You could do that, couldn't you?
That is one way, yes.
Right. So that way you don't have to put the dummy on a forklift, and then it creates a different scenario than real life, correct?
That could be one way that you could do it, yes.
It doesn't impede any roll or drag when the dummy's hit. That's one reason you would do that rather than a forklift, yes?
Correct.
Also, it might show some throw, which could lead to other type of damage like holes in clothes, yes?
Correct.
But you didn't use the magnet, you used a forklift.
Because again, the purpose of the test was to evaluate, we talked a lot about those time frames, right? That 10 millisecond window. It's to look at, from the vehicle damage perspective, what happens to the taillight, right, in that interaction. And then ultimately, what is the acceleration that the arm experiences in that 10, 15 millisecond window, right? What happens 1 second after, 2 seconds after? Again, that wasn't of concern for me in my analysis.
You didn't use a magnet, you used a forklift, right?
Correct.
And when Randy went for a ride, you didn't expect him to break off the string and slide across the street, did you?
We didn't expect him to?
You didn't expect him to be thrown. You didn't expect the string on the forklift to break and then Randy to go flying. You didn't expect that, did you?
Oh, I certainly expected that.
So you expected a throw with that?
Yes.
Okay. And the street has hard concrete and it has a lot of irregularities to it, doesn't it?
It's asphalt, yes.
Yeah. In the photos that you were shown today on redirect examination, did the defense show them to you during your direct examination? Any of those?
No.
Ms. Gilman, can you pull up that last exhibit with Randy on the ground? I think it's exhibit 221. Okay. And so this is Randy, right, Doctor?
Yes.
Zoom in a little bit, please. What's that red thing near his shoe?
Appears to be a fragment of the taillight.
Can you zoom out? Could you go back an exhibit to the one before? Could you zoom in? Did you see any taillight fragments on his body or in his clothes?
I can't tell from here.
Could we have the exhibit before, please? Can you tell from here?
Yes.
In finding taillight fragments on the clothes after a collision, that's not unique, is it?
Unique? No, it's possible.
Well, according to this, it's probable, yes?
In this test, that did occur, yes.
Could we have exhibit 201D, please? Do you know what this is, Doctor? Did you see this picture in your analysis?
Don't know if I recall that specific photograph.
Do you know this is taillight shards found in Mr. O'Keefe's clothing?
Objection. Sustained.
Did you consider this photograph during your analysis before you gave your opinions regarding cuts and tears and lacerations?
No, sir.
Can you take that down, please? When you did your analysis, did you know that a drinking straw was found on the concrete on the street in front of 34 Fairview?
I don't know if it was on the concrete, it might have been on the asphalt, but I do recall a drinking straw, yes.
Did you know that there was a glass found near Mr. O'Keefe? Could you put that up, please, Cindy?
Objection. Sustained.
Did you talked about cuts and injuries. Did you?
Sustained. It sounds like it's beyond the scope.
Very well. When you did test D, did you say the peak acceleration was 780 Gs?
Your Honor, may I refer to my notes?
Yes.
Page 11 of your report.
I think I lost an exhibit. Okay.
Is that what you described it as?
For test D?
Yes.
The acceleration of, we talking about the hand?
Yes.
780 Gs, yes.
780 Gs. Okay. When you did your comparison before you gave your opinions, you showed us a scuff on the exemplar vehicle, photo 77.
Objection. Beyond the scope, Mr. Brennan.
A few more questions, Dr. Wolf. You showed us holes in Randy's sweatshirt from test F. You remember that?
Yes.
And you talked about what you would or wouldn't expect in a collision as far as holes. And did you say something like that was inconsistent with Mr. O'Keefe?
Yes.
That's what you said on redirect, right?
Correct.
Okay. Did you consider whether there were holes in Mr. O'Keefe's sweatshirt separate from the holes in the arm?
Sorry, can you repeat the question?
Yes. When you were making that opinion about consistent or inconsistent, did you ever consider whether there were holes in Mr. O'Keefe's sweatshirt other than the right arm?
Well, I know that there was cutting to the.
May I approach and retrieve the exhibit, Your Honor?
Yes.
Excuse me, stop.
I have a plan.
Did you ever look at the back of the sweatshirt to see if there was any holes to the back of the sweatshirt other than the right arm when you formed your opinion?
I don't recall.
Take a look at the back. Do you see other holes on the back of Mr. O'Keefe's sweatshirt?
It appears I see one hole.
Let me get a little closer so you can get a better look. I'll direct you to here, 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 here. Do you see more than one hole in the back of Mr. O'Keefe's sweatshirt?
Yes.
When you were forming your opinions that the collision would be inconsistent to damage to Mr. O'Keefe's sweatshirt, did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, in looking at those holes, they're inconsistent with road rash. And again, to get those kind of holes, you have to have prolonged sliding contact on a rough surface.
Did you consider that Mr. O'Keefe may have fallen or landed on his back?
Well, if you just fall and land on your back, you're not going to be sliding to get those abrasions and tearing. And again, those are not consistent with road rash.
Didn't ask that question. Did you consider?
Sorry,
Did you consider whether Mr. O'Keefe had fallen or landed on his back?
No.
Did you know about or consider the multiple holes on the back of his sweatshirt when you came and formulated your opinions?
No.
You did no studies whatsoever about the damage to the sweatshirt if he fell or landed on the cold, hard ground and had broken taillight shards in his clothing, did you?
No.
I have no further questions.
Yeah, just a moment, Your Honor.
And this is where the recess happens, because they ask for recess, and then you'll see the mistrial argument. I want to watch it happen, though. Sorry, the feed froze earlier. Oh, of course, Troy. Listen, as long as you're respectful, we're happy to have you, Troy. Some people might be a little bit, they might needle you a little bit, Troy, but you're in the lion's den. What do you want me to say?
By Mr. Brennan.
The towel's den.
Give me one name,
Hold on
very
one second.
dramatically, of someone.
Objection.
The objection sustained.
You were asked to give me one name to support using a 50 percentile hybrid 3 in testing forces on a 216-pound man. Do you remember that question?
Yes.
How about
Hold
the
on one
name
second.
Judson Welcher?
So hold on, watch this. I'm jumping forward a little bit so we don't have to listen to the Jackson bloviate.
Please rise for the jury. Right this way.
Okay, now we're going to come back into session. Hold on. This only takes a second. All right, here we go.
All right, so we're not going to do the voir dire right now of Dr. Lapisada because everybody needs a break. What we'll do is we'll take the 20-minute recess. Who's doing the director, Dr. Lapisada? Is that you, Mr. Jackson? Yes. All right. So what I would ask you to do is not do anything on your direct examination with Dr. Lapisada that involves the mention of dog bites or the evidence regarding motor vehicle experience, because we still need to have the voir dire. But I don't want the jury sitting out there any longer than need be, at least until the luncheon break. So without that, how long will it take you? Can you use the hour?
I can get for credentials, but Your Honor, half her credentials are the fact that she's an expert in dog bites and an expert in motor vehicles. I can give her education, training, background. But
Okay, is that all in her resume?
it's all in her. It's all going to be in her direct examination.
No. My question is it in her resume? Has the Commonwealth received notice regarding the dog bite stuff?
The Commonwealth has received the same resume that the court has received. I don't know specifically what her resume says about dog bites. I don't think it says dog bites anywhere in her resume. No. We have absolutely no notice. But the courses that reference dog bites are listed in her.
Say that again?
The courses that reference her teaching dog bite issue and pattern recognition, they're listed in the resume.
All right. We'll see you at 12.
All right, so now we're going to jump forward. Also, I feel very guilty, friends. Someone asked yesterday if I could set up a forwarding email. They wanted to send me a gift. If that was you, if you hear this, I'm so sorry if I failed to set up the forwarding email. I pinned it in the chat yesterday. I'm going to go actually back and read the whole chat until I find when someone asked me that, so I can remember your username when you pop up again. I promise you. Yeah, I promise you I will make a Gmail that is just to receive mail from you all. I promise you all I will do that. I feel so guilty because so many of you have been asking, how can I reach out? I don't have social media. I promise you, friends, I'm going to figure out a way for us to have a general inbox. I will set it up. Yeah, no, and you can use that. Like, if you think about what my name is and send me a Gmail, I'll get it. But yes, my Grant Smith Ellis name. But yes, we're going to work on it. We are going to figure it out. Little towels. My name is Grant Smith Ellis, by the way, and we're going to continue our recap, my dear friends. So we are going to jump forward because this is where the mistrial, this is the end of our recap though. The mistrial argument happens, the defense loses, and then we're going to see the end of the day. We're going to talk about scheduling. This case is going to be over by the end of the week, folks. Oh, umpire's bad call. It was you. Okay, Murder by Maestro. Okay, can we do this? Umpire's bad call. You can email me, grantsmithellis@gmail.com. Okay? I'll get your email, and then we can communicate directly. Umpire's bad call. I love your username. Literally, you warmed my little towel heart by popping up right there. I promise you I would have been all night been like, oh no, I forgot that person. So grantsmithellis@gmail.com. No spaces, and I will be able to communicate with you directly. Umpire's bad call. You are such a kind person, and I thought about that all day. Oh goodness! But yes, we're gonna watch the. We're gonna watch this right now, ladies and gentlemen. Now people know how to contact Towel. I have a general use inbox. Murder by Maestro reminded me I already did this. So anyway, we are gonna watch the mistrial argument. This goes very bad for the Reed defense. I saw Bailey is in the chat. Hello, Bailey. I am a towel. All right, ladies and gentlemen, I am so excited. Here we go. We're going to watch the Reed defense lose a mistrial motion. Second, they're getting so desperate with these mistrial motions, ladies and gentlemen. The Reed defense knows this jury is going to convict. The jury is literally getting frustrated because they can't get the case because they want to convict. Oh, goodness, ladies and gentlemen. And remember, there's 18 jurors. 12 of them are going to get picked for deliberation. I don't think Karen likes her chances, ladies and gentlemen. Let's keep listening.
All right, so I'm told counsel wanted to see me.
Your Honor, issues has arisen related to the cross-examination or re-cross-examination of the last witness, and Mr. Alessi would like to address the court in detail about that.
All right, so the last witness was your witness? Is there a reason?
This is a separate issue, and I'm asking Mr. Alessi to address the court on this.
Okay. What do you want to tell me, Mr. Lesky?
Bear with me a moment, Your Honor. I need to put on evidence gloves. Your Honor, the defense moves for a mistrial with prejudice based upon intentional misconduct that just occurred before the court and for the jury. And what I'd like to do, Your Honor, this regards the hoodie, and this regards questioning and representations in questioning by Mr. Brennan. And what I'd like to and need to do, Your Honor, is to have 2 documents marked as exhibits, and then I am going to use Exhibit 88, which is an evidence, which is the hoodie, which is why I'm putting on the evidence gloves, and it will become quite obvious very shortly what the issues are.
All right, so what are the things that you want to have marked?
What I would like to have marked the first document, and I want to get this specific title. These 2 documents are from the criminalist's file, specifically Ms. Maureen Hartnett's notes regarding cuttings from the hoodie sweatshirt that's in the crime lab file folder.
Okay.
So the first is the back of the hoodie. So with Your Honor's permission, I would have that marked for identification.
Exhibit YYY. Friday.
And may I see that, please? Okay.
That is the back of the hoodie, Your Honor. And if I could please have the next marked in order exhibit for identification.
Exhibit ZZZ for identification.
Give me a minute to read this, Mr. Leslie.
Yes, Your Honor.
So is it that there are no holes in the back? There were no holes on the back of the sweatshirt?
That's only part of it, but that is in fact the case, Your Honor.
Okay. I can't tell entirely from ZZZ, but if that's your argument, why for identification appears to support that.
Your Honor, may I have the exhibits marked for identification back for my argument?
Okay.
Thank you, Your Honor. Thank you, Madam Court. Your Honor, what we just saw is Attorney Brennan question Dr. Wolf with regard to the hoodie sweatshirt that heretofore has been in the plastic casing for trial. And this is the, what happened was Attorney Brennan held up the casing with a hoodie sweatshirt, went to the back of the hoodie sweatshirt. First point to note, Mr. Brennan did not show Mr. Jackson the back of the hoodie sweatshirt, didn't give Mr. Jackson an opportunity to look at it.
Can I just ask a question? I noticed that it was over here at the witness stand this morning. So I assumed everyone was aware that something was going to happen with it. Is that not the case, Mr. Jackson?
That is not the case, Your Honor. The
Okay.
first time I realized that line of question was going to be asked was when Mr. Brennan pulled the casing out.
Okay. Go ahead, Mr. Leslie.
Thank you, Your Honor. So, to do it in order, Mr. Brennan takes the hoodie sweatshirt in the casing without notice, shows it to Dr. Wolf, and shows the back of the hoodie, which has certain holes, and
I want to leave Bob frozen like that, but I'm not going to do it to him.
I'm going to limit calling them holes to do this chronologically. I'm going to refer to exactly what they are in moments.
Okay, so I need to see it. I know you've got gloves on. Where is it right now? It would help me if you held it up for me now.
Absolutely,
Mr.
Your Honor.
Leslie.
So here is the back of the hoodie.
Okay. All right, thank you.
It's very obvious that these are cutting holes cut by the criminalist. And I'm going to get to back to this in a moment. But I would like to do it and certainly entertain any of Your Honor's questions, but in a logical order.
Sure, so I'm not, what about the jurors and lunch? How long do you think this will be?
I think this will take about 10 to 15 minutes, Your Honor.
Okay. All right, thank you. Go ahead, Mr. Leslie.
Thank you, Your Honor. So I just want to get the flow back going here and the logic. So, and I'll do it quickly. So Mr. Brennan grabs the hoodie sweatshirt inside the casing, doesn't show it to Attorney Jackson, goes up, we have no idea that this was going to happen, goes up, confronts the witness, Dr. Wolf, shows the back of the hoodie sweatshirt, to my knowledge, the first time the back has been referenced of the hoodie sweatshirt, shows Dr. Wolf, confronts him, and basically says, couldn't these holes be caused, and I'm paraphrasing, from a fall backwards? Obviously positing in the juror's mind after, remember, we just saw all kinds of videos with regard to Rescue Randy and impact at 24, 29 miles an hour, more aptly 29 miles per hour, and damage to the hoodie, etc. So what then happens is Dr. Wolf is asked a series of questions, very much with the indication that somehow, in the clear implication, that these holes are being caused by road rash, and that the holes in the back of the hoodie sweatshirt, Exhibit 88, could have been or likely were caused with regard to some type of impact. Clearly presented to the jurors with that in mind in that questioning. Here is the basis for the mistrial with prejudice. Those holes in the back of the hoodie sweatshirt are clearly, unequivocally, without doubt, caused nothing to do with any type of event on or about January 29, 2022.
So do you have something you said, when you said obviously cut by the criminalist, do you have something that shows that chart that I couldn't understand quickly? Is it on that?
Yes, Your Honor. What we have is two documents to show that.
Right. So the second one, when was that provided?
These, when you say provided, you mean with regard to when did the defense get these in a discovery? Let me get the date, Your Honor.
Sure.
Notice of discovery, May 2023.
Okay, thank you.
And I will note, Exhibit YYY. The only, I believe, I'm holding up YYY, which is the back of the hoodie, I believe, is the only one, to my knowledge, not put into evidence, not turned into evidence. This is the one that it clearly shows the hoodie before the criminalist started her work with the cuts. There are no cuts to why, and if we need to, we'll bring Ms. Hartnett in to confirm.
All right, so is ZZZ in evidence?
ZZZ is not in evidence, and that is part of the basis for the mistrial. It is no coincidence that these two documents are not in evidence, because if they were in evidence, they would clearly have prevented the stunt that we just saw occur with regard to Dr. Wolf. So that is part of the intentional misconduct, Your Honor, is these are documents from the criminalist's file. It's the Commonwealth's documents. And it is very clear when you go to Exhibit ZZZ, the cuts that the criminalist made to the back of the hoodie are specified.
So where on that? Because when I quickly looked at it, I didn't see it. What does it say? Go ahead and read it to me, please.
It's item number 7. I'll read it from the top. LIMS 22-2184. Analyst MSH, which is the initials for Ms. Hartnett. Dates: May 11, 2022, May 12, 2023, and then May 18, 2023. And what she does is she's got the...
You know what? Can you bring it up to me, please?
I certainly can, Your Honor. And I can conduct my argument from right here if that helps, Your Honor.
I just want to see. Point out to me where it says, where it shows the back.
This is the back. So you can see the back of the hoodie. That's the back of the hoodie head. And then you can see the various... Let me just give a check on this, Your Honor. I'm not...
Right. Mr. Brennan, you should come up and look at this as well.
Thank you.
And I'm
So, Mr. Leslie's taking it.
yes.
All right, so this is why. I didn't see where Ms. Hartnett said that she had it on. It was showing here, Mr. Leslie says exterior front.
Can I get the check?
Pause.
Pardon me?
Unpause.
Right, but if I can, Your Honor, I want to clarify this. Yes, are you willing, Mr. Martin? Let me just make sure I get...
Mr. Jackson, it says exterior front, what Mr. Leslie was pointing me to.
Well, yes, a second. It may have printed the wrong page. I can do it, but Mr. Wolf, can you print the back? And then, Your Honor, are you comfortable using the computer at the back? Because I think we just had the wrong one.
We need to mark it, though.
Understood. We will. He's printing it right now. We printed. We wanted to have the front and the back to show all the cuttings, but what only printed out was the front. We are now printing the back. Your Honor is correct.
Okay.
If I may, Your Honor, I'm advised it'll take 2 minutes because it has to go
All right,
through.
so go ahead with your argument.
Thank you, Your Honor. So, Your Honor, what is being printed is which we will mark, will be the front of the hoodie. The purpose of Exhibit ZZZ and the one that is being printed is to show and to give the court, and we're going to request to give to the jury the complete picture and the complete true story about these holes in the hoodie that were presented as if they were caused in some manner by something else other than the
So
criminals.
that seems perfectly reasonable, and I'd be inclined to do that.
I appreciate that, Your Honor. And here is the reason for the motion for a mistrial with prejudice. On its own, to do this, and you put together all of the parts of what just occurred. You start with the fact that and if I could, Your Honor, now that I have it yet marked so I can then refer to it.
All right.
Thank you.
Can he print extra copies too, so I can have my own copy?
Absolutely.
And for the Commonwealth to see?
And I'm going to show the Commonwealth what I just printed.
Exhibit A.
Thank you, Madam Court Reporter. Sure. And here's another document, chain of custody document. Well, Mr. Brennan is reviewing that. If I may, I had to, Madam Court Reporter, the chain of custody document for these, and that's that he marked as the next exhibit in order.
Okay.
And then with Your Honor's permission, I would have Madam Court Reporter hand them both up to Your Honor so
Sure.
Your Honor can see what I'm referencing.
Thank you.
Exhibit B for ID.
Thank you.
Here's, thank you, Madam Court Reporter.
Do you need this, Mr. Leslie?
I do not need either of them, Your Honor, and I have the extra copies as well. Okay, so Your Honor, I now have enough copies for Your Honor and for the Commonwealth.
Oh, thank you.
Okay. So if I could have one set, that would be great. Yeah, thank you.
I still do not have ZZs. All right. Thank you. Okay, go ahead, Mr. Leslie.
So, Your Honor, to do this quickly chronologically, so we have a hoodie sweatshirt that was brought into the criminalist, Ms. Hartnett, with the back of the hoodie with no holes on it. The criminalist makes cuts to the back of the hoodie, makes cuts to the front of the hoodie. The exhibit, Your Honor, depicts those. There's a chain of custody document that describes the chain of custody for the hoodie and the cuts in the chronology. And of course, we have Exhibit 88, which is the hoodie. So, what Mr. Brennan did, and I'm now pulling Exhibit 88, he holds up the back of the hoodie, which has cuts in the back from the criminalist, somebody from the Commonwealth, a witness in this case, Ms. Hartnett, she's testified, and Mr. Brennan has indicated he wants her to come back and testify, which we welcome. And now what we have is we have holes in the back of the sweatshirt that were dramatically held up to and confronted with Dr. Wolf, and then the jury sees it. With the clear, unmistakable, purposeful intention of having the jury conclude that these holes could have come from events on January 29th of 2022, when in fact the Commonwealth well knows from its own documents, from its own criminalist, that those holes in the back were caused by their criminalist as part of their examination and sampling of the hoodie. What could be more egregious? What could be more misleading than that? And what could be more important for a context than the alleged collision that never occurred? That's the topic before some of the most significant and probative witnesses in this trial that the Commonwealth has been attacking from the jump of pretrial. They picked the most opportune, sensitive time to pull this stuff. This is intentional. This is irremediable. This is on the key issue of this case, whether there was any collision at all. On its own, Your Honor, on its own, this is a mistrial with prejudice. But I add to that what just happened, and I'm not going to repeat or go into other than to reference. This comes on just mere days after the Commonwealth raised the specter of absence of DNA on the same hoodie sweatshirt without having the criminalist, Ms. Kuhn from UC Davis come in. I know Your Honor already ruled on that.
Right,
and
so let's move along from
right,
that.
that's what, and I'm going to come back to this. Why is this occurring, Your Honor? Why is this happening? The Commonwealth has no case. They have no collision. They are desperate and are trying to create evidence of specters of collision where the evidence doesn't support it. So what have we come to? We've come to the manufacture of evidence. We've come to, incredibly, taking a hoodie, a key piece of evidence in this case, and holding up to Dr. Wolf, the ARCA expert, to try to make it seem like Dr. Wolf didn't do his job. You didn't account for these holes. How could you be a credible accident reconstructionist when you talk about some holes, but you don't talk about these holes? Knowing all along the holes that Attorney Brennan is trying to impeach Dr. Wolf on were caused by the Commonwealth's own criminalists as part of sampling. I don't believe one could come up with more misleading, misdirecting elucidation of testimony than this on the key issue in the case. We have irrefutable, objective evidence, and I will state that it's more than interesting that none of these exhibits that Your Honor now has marked for identification were put in evidence by the Commonwealth. Isn't it some coincidence that these are the one, and the only one of the, with regard to the hoodie, the back of it's not in, all of the rest of them are, but these aren't. Your Honor, I think there is one and only one conclusion, in that this is intentional, that it is a matter of such significance and of such misconduct and intentional that it merits the sanction of a mistrial with prejudice. The amount of effort, the amount of work, I can't even begin to think to remedy this in front of the jury, to go backwards on this. That should not befall the defense. That should befall the prosecution. Ms. Reed, again, is entitled, like every other defendant in this wonderful Commonwealth, to a fair trial. The prosecution is supposed to be held to a higher standard, to do justice, to create a fair trial. This is the antithesis of a fair trial. Miss Reed's rights under the Constitution and the Declaration of Rights have once again been trampled on, and it is becoming evidently clear the more desperate the prosecution gets because it can't prove its theory, including its own medical examiner can't support them, that they're now resorting to conduct like this. Your Honor, at some point, this has to come to an end. At some point, Ms. Reed's rights have to be protected. At some point, confidence in the judicial system, the public's confidence in the judicial system, that prosecutors will conduct themselves with their duty to present a fair trial. That has to be enforced at some point for Ms. Reed to receive the fair trial that she and every other defendant in this Commonwealth is entitled to.
All right, thank you. Mr. Brennan.
Your Honor, my brief review of the lab paperwork and looking at the hoodie, it appears that I made a mistake. And so I think what should happen is there should be a curative instruction. There should be a stipulation. The court should instruct the jury that during Mr. Brennan's cross-examination, he asked Dr. Wolf about holes on the sweatshirt or holes on the back of Mr. O'Keefe's sweatshirt. The parties agree the holes were made by a crime lab technician. This was done inadvertently but should not have been asked. The court should strike the questions and the answers. And you should instruct the jury they are to completely disregard any questions or answers about the holes in the back of the sweatshirt. And the court should allow the defense to introduce the lab paperwork.
All right. So I'm not going to allow the mistrial motion, Mr. Alessi. What I'm going to do is instruct the jurors. I'm going to put in what's been marked for identification, Y, Z, A, and B. 4 of each letters. I'm going to put all these into evidence. They can be displayed for the jury, and I'm going to instruct the jury that during the cross-examination of Dr. Wolf, Mr. Brennan asked him about holes in the back of the sweatshirt and whether or not they perhaps could have come from events or implying or something like this. I instruct you, you are not permitted to draw any inference that these could have come from the events of January 29th, 22. I instruct you further that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt on, I just put the dates aside. Chrissy, can I see those, please? It's unclear for me. Do you have a better idea, Mr. Alessi, what day these were done? Is it all of those 3 days? Now I see a fourth day. 5/11, no, I'm sorry, 5/11, 5/12, 5/11, 2022, 5/12, 2023, and 6/18, 2023. Those are the 3 dates.
Your Honor, it was on or about May 18th when the defense filed a motion to test. So that's the probative date.
So May 18th?
Yes, that's what.
Okay.
And that's 2023.
Yep. All right. That's what I'm going to do. Is there anything further you want me to include in the instruction? Your rights are saved regarding the mistrial. I disagree with you on that.
Your Honor, I'm not going to go any more into the argument, but I appreciate the opportunity to provide perhaps some further instructions for Your Honor.
So I'll hear you. Go ahead.
So the first, Your Honor, is with regard to two things.
Hold on, note this moment, folks, because Bob Alessi at the end of the day is going to try to claim that he wants another opportunity to argue the curative instruction wasn't good enough. Judge Cannoni was like, I gave you a chance to expand the curative instruction. This is what she was talking about. Bob Alessi's going to lose his renewed motion for a review of the curative instruction because she gave him a chance to argue it here.
One, I would like the opportunity to have the hoodie sweatshirt held up, because that's what happened.
Yes. Yes.
These holes
Yes. Yes.
Thank you. So that's number one as part of the stipulation, and then
I'm not wording it as a stipulation, and I'm not saying it was inadvertent. I am giving an instruction that they cannot consider it for this purpose, and I am allowing these to be placed into evidence. So it's not a stipulation. It's from me, which I think is more forceful.
I misspoke, Your Honor. I agree, not a stipulation, but just as Your Honor said, with regard to the matter Your Honor said they're not to take an inference, I would respectfully request that this be handled just like Your Honor did with regard to the rock at 34 Fairview. Your Honor said that rock wasn't present, on or about the time of event.
So I do say that when I say Ms. Harnett did this. So rewording it just a little bit.
Yes, exactly.
Mr. Brennan asked Dr. Wolf about holes in the back of the sweatshirt. I instruct you that you are not permitted to draw any inference that those holes were a result of the events on January 29th, So, all right, this is what I'm going to say. So if you're not going to listen to it, that's fine. I've already said it. All right, we can bring the jury in.
Oh, Alessi pissed Judge
That's what I
Cannoni
said,
off.
Mr. Alessi. Okay. All right, so it's what I said, Mr. Alessi. I instruct you that you're not permitted to draw an inference that the holes came from the events of January 29, 2025. Those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18, 2023.
Is it possible, Your Honor, last comment, to instead of not drawing inference, you should conclude that these holes were not present in the hoodie sweatshirt. They were caused by the criminalist.
So I can just leave that all out then and just say Mr. Brennan asked Dr. Wolf about the holes in the sweatshirt. I instruct you that those holes were made by the criminalist Ms. Harnett during the course of her inspection and sampling of the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Judge, just as a housekeeping matter, the sweatshirt's been taken out of the plastic sheet, and it might need to be remarked. The plastic sheeting was marked, but the
Court is in session.
All right. Jurors, I appreciate your patience. Mr. Lessie, why don't you hold the exhibit up for the jurors, please? All right, jurors, that's the back of the sweatshirt that was shown to Dr. Wolf. Okay, thank you. Why don't you go ahead and put it back in the bag? So, jurors, I instruct you that those holes were made by the criminalist, Ms. Harnett, during the course of her inspection and sampling of the sweatshirt back on May 18th, 2023. Okay? So, I know your lunches are here, but I think we'll...
Just jumping forward so we don't have to watch the fan.
May I inquire?
Yes.
Thank you. Dr. Lapisada, you just mentioned
Oh, hold
that...
on. That was not, we just wanted to get to the end of the day where Judge Kearney gives her instruction. AJ, we don't need to hear you continuing to talk. Oh yeah, there was another sidebar. Hold on. This is where Judge Kearney gives the instruction. Or not the instruction.
We will start. I'm going to have you show up a half hour later than we normally do because I expect to have 10 minutes with the lawyers, but we see sometimes with 10 minutes naturally in the course of any case can turn into. So I don't want you to be waiting as much as you've waited today. So if you've taken half an hour more to get in here, whatever time we normally meet, the court officers will tell you. We'll see you tomorrow morning. Tomorrow will be a full day, and we will make every effort that it's filled with as much time here in court for you without sidebar conferences, without delays for us to have hearings. So tomorrow, plan on a full day. Please do not discuss this case with anyone. Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. Be careful again with your social media use, and we'll see you tomorrow. So, Dr. Lapisada,
Yes.
you can step right up.
All right, now we're going to stay around, friends, because you're going to notice the jury walks out. This next part is, sorry,
Thank you, Your Honor.
this next part's very important because we're going to hear the discussion about how the planning for the next few days. All right, so we're going to watch a few more minutes. It's only maybe 5 minutes of scheduling. We're going to watch this. It occurred right at the end of the day. This tells you all you need to know about the coming days in the John O'Keefe and Karen Reed retrial. Pay attention here, folks. We're going to be done soon in the next few days.
All right, so can you argue the Commonwealth's motion that I received this morning regarding Dr. Renshaw? Can we just do that now? Okay. No, that's fine. So we'll do that first thing at 9 o'clock tomorrow morning. The basis of the Commonwealth's, I've read the motion. I think the motion is clear. I'll hear you both tomorrow on it. All right. And you'll take care of the photographs, whatever photographs in her report you intend to put in.
Is the court hasn't made an order yet, but it seemed like the court was leaning toward not allowing any text on the photographs.
So that was just at a quick review. I had not I just read the content, the text part for the arguments for today, the arguments that were brought up today. I wasn't anticipating everything that we heard today on this, so it took a while. I did not get to look at specifically those. But to the extent that it's hearsay, whether it considers anything about dogs, clearly the dog, things that have been excluded have to come out of the photographs. All right.
The other photos deal with gastric mucosa.
I think those have been shown, and I know the Wisniewski spots one is in evidence. The brain photographs are not coming in. The brain photographs that are different than what's already, the brain photographs in her report.
Understood.
They're-
My biggest issue is the stomach lining is a bigger issue, and then some photographs too, whether it's like the car that's probably already in, things of that nature.
So tell me what you think is more of an issue, more of what you want. So I don't think the photographs on pages 4 or 5 come in. They don't add anything, and they are extremely inflammatory.
I'm not looking to enter the, no, I'm not looking to get rid of those.
All right, the photos on page 6, I believe, are already in evidence. So this is,
That's a Lucas machine.
right, just a textbook photo of a Lucas machine.
Correct.
Is there an objection to that, Mr. Brennan?
No, thank you.
Okay. So do you want all of that in, or just the photograph that's got color to it?
I'd actually like all of it in. She will explain what effect it has on the pancreas and stomach lining, send it to the restricted spots for lack thereof.
Okay.
Page 14, I think these are all in evidence otherwise, but I would like this particular, because it's all in one spot.
Hold on 1 second. Okay, so 1 is in. Point number 1, that was in evidence, and those 2 photographs. This is all for number 1. What was?
These are all close-ups of the same photo that is already in evidence.
Okay.
The right sleeve. So I'd like to use this because it speaks to her evaluation of these particular.
All right. How does she know it's blood staining on the fabric around the puncture? I'm just curious.
The blood stain on fabric around the puncture?
Yes.
I'm assuming she's getting that from the lab. They tested it.
Okay. I don't recall testimony regarding. Doesn't mean it didn't happen. I just don't recall it. So I just need to know the source. All right.
Pull that out.
No objection to the photos. I do have an objection to the captions that go with the photos.
Okay. 13A and 13B?
Yes.
Yep, so 13B's out because of the dog bite. Let me see. All right. So if we keep out the blood staining, Mr. Brennan, is there an objection? Oh, puncture. What's the objection for the Commonwealth on 13A?
The opinion outward tearing, the opinion blood staining.
I have no issue with blood stain coming out. Outward tearing that is her opinion of what it looks like.
Okay, so we're going to have to see if she's qualified to do that, to testify to that. All right. What's the next page?
Page 53 in the report.
What page?
I don't have a page number. Hold it up.
Page 5.
Page 5. It shows the cross-section of the brainstem.
That's what I was saying. I didn't see how that was coming in.
I certainly don't want the one in that is in skull. It's highly graphic. This is no more graphic than the supplement.
I disagree, but why does she have to use this photograph?
It
furtherance of her determination of the coup injury and supports that. I didn't put it in during that conversation.
Okay. There's no contention that coup contra coup is the cause of the brain injury, correct?
There is a contention that the coup contra coup was, yes, that is the contention. I don't think there's any controversy. That's what the...
I thought that's what Dr. Wolf testified to, no?
Consistent. I don't think there's any disagreement.
Right. So I don't know why we need this photograph.
Because this shows, at least for her, this shows a bleeding of the brainstem, which talks about whether or not he's immediately incapacitated or not immediately incapacitated.
Okay. No, I understand that's an issue. Okay.
It is an issue.
Yeah. Okay. What else, Mr. Jackson?
I think you've seen this, Your Honor, and I believe it was figure 5. So there's these spots.
Yeah, I think that's already in evidence, isn't it?
It is, but that's not the Mr. Leslie's saying it's only a chunk at this point, is that right?
I recall it was up, and I usually don't put up the chalks, but okay. Excuse me?
Mr. Leslie, can you say it again?
There's only one person who can talk at a time. I'm told it's Exhibit 164.
Yes, Your Honor, and my understanding is it's marked as an exhibit only. It was used as a chart, but not in evidence.
Okay, so if it's marked as an exhibit, it means it's in evidence.
Sorry, marked for identification.
I'm told I think it's an exhibit. We can find out. If it's an exhibit, everybody's fine with it. It's in. 164, I think. We'll know. Okay. What are those? All right, so we'll have to see what's in and what's not. I'm just trying to make the best use of the time here.
The next is figure 9. Just attendant to these two photographs, attendant to the Lucas machine.
So you're saying 9 in evidence or 9 on the form? 9A and B. Is there an objection to these, Mr. Brennan? Going to the Lucas compression device. There's one on someone who's not John O'Keefe, and then this is on Mr. O'Keefe.
No objection.
Okay, so those will come in.
That's it.
Okay. All right. How much longer, and I'm not curbing you in any way, how much longer do you think? It seems like after the very lengthy qualifications, we're now moving along quicker with Dr. Lapisada.
I would guess I probably am going to finish under an hour.
Okay. Any idea, Mr. Brennan?
I guess it'll probably be about a half hour.
Okay. So we should finish with Dr. Lapisada's testimony either by the morning break or shortly thereafter. So we'll discuss Dr. Rentschler's testimony, the objections to it. Why don't you just tell me briefly, Mr. Brennan, what the objections are?
There are a number of slides that attempt to frame what the contested issues are in the case. It's improper opinions, it assumes facts, not evidence, and it improperly summarizes the Commonwealth position. There are a number of slides that provide credibility determinations about Dr. Welcher, and there are a number of slides that summarize opinions by this expert. So the improper summaries, the credibility determinations, trying to frame issues for the jury, none of that should be admissible as part of the PowerPoint. So we've articulated each slide and what our objections are. Each slide that we have any objections to, there's quite a few.
All right, so I'll look through that tonight, but the same restrictions will be you don't criticize the person, it's the data, what you saw, what you didn't see. So if it's different than that in the slides, it's going to have to come out.
Understood. I'll take a close look at it. I just haven't had a chance.
Yeah, no, I understand. I haven't read it either.
We're done.
Okay.
4 documents. These are documents that are attended to Dr. Lapisada's opinion and conclusions concerning the dog bites.
Okay, so
I'd like to have those identified for the record.
yes, So we'll make that part of the record. I need a clean copy of Dr. Lapisada's report and her resume for the same purpose.
And the resume.
Yes.
Yes. I'll have those two by Monday.
Okay.
Just finally, the redacted version of the 34 Fairview post is not marked. Could I have that marked as an exhibit now?
Okay. There was no objection, Mr. Brennan?
This was never marked as an exhibit. That's all.
Why don't we do that right now?
Thank you.
Exhibit 224.
So I would like us to be as efficient for these jurors as possible tomorrow. I'm not suggesting that today was a waste of time. Everything we did was important, but it's very difficult for the jurors to spend so much time back there. It seems that they're just about ready to get this case, and everything that we hear now is very important. So I don't think anybody wants the jurors to tune out at this point. So let's try and keep things moving along. Mr. Jackson, how long do you expect to be with Dr. Rentschler?
Hour and a half? 2 hours? I'm being corrected. 3 hours. 4? She has a better pace than I do. I don't watch my watch when I'm directing, but maybe it's going to be a whole thing. I mean, between us and cross-examination.
All right. So I told you all the other day I thought I might be in a position to regret giving you last Thursday off, and that's where we're at. So let's be as efficient as we can possibly be.
I promise you we are. It's a murder trial, Judge.
I understand. All right.
I have one more item when Your Honor is ready.
Okay. So, Mr. Jackson, do you expect that Dr. Rentschler will be the last witness that you call?
That's my expectation.
Okay. On rebuttal, any idea how long that will be, Mr. Brennan?
I'd like to keep it to 2 hours.
Okay. All right, that would be for everything, including Dr. Wrench,
I'm sorry.
Dr. Welcher?
Dr. Welcher, and then the DNA, all those witnesses. I think it should be done in less than an hour.
All right, so will Dr. Welcher be called after the DNA people?
Trying to schedule that. I expect to call him last, but it all depends on when we can get the DNA people. And Dr. Welcher will be here tomorrow or tonight, so he'll be here. So whoever's, if they're available, I'd like to get the DNA people in first. But we haven't had confirmation on the flight.
All right, because I told Mr. Lessie that he could excuse himself from this testimony if there were other witnesses first, so that he can prepare once he gets the discovery from Dr. Welcher.
Thank you, Your Honor. Could we understand from the Commonwealth the names of the rebuttal witnesses we're talking about?
They were in the motion, right?
Well, we heard some different things at sidebar today. If something happened with Dr. Lapisada, they were going to be different. We heard that at sidebar.
Oh, okay, so the motion that I allowed was Ms. Kuhn. I believe Dr. Gillespie's name was in there.
Hartnett?
And Ms. Hartnett. Okay.
So that's the scope of Dr. Welcher, or the scope of the rebuttal witnesses for the Commonwealth.
Yes, I allowed the motion. Mr. Brennan says he's not calling Dr. Gillespie. Mr. Gillespie, right?
Correct.
Okay.
And nor Dr. Crosby. as I understand.
Or Dr. Crosby. Right.
That's what
Yeah.
I think there's.
Sorry, I know.
Well, it's important to know.
You're not calling their dog expert or your own, correct?
Not calling Dr. Crosby.
Okay.
The other item, Your Honor, we want to alert you to, we will come tomorrow with a suggestion with regard to the curative instruction that was given to the court today. We're going to come tomorrow with an ask to be heard on that further. And so we're going to come in with that. What happened, what was discussed before, I'm not so sure.
You asked me to change it, was my recollection, Mr. Lessie.
We looked at it at lunch, Your Honor, and appreciate the opportunity to confer with you on it. I don't want to keep the staff later today.
And I don't want to keep the jury waiting, so file something with me and I'll take a look at it. All right. All right, so that's it. We expect to be ready to go when the jury's here tomorrow morning, probably no later than 9:15, 9:20, right?
Yes.
Okay, and we'll use a full day, as much of it as we can.
Yes.
Yes?
Yes, Your Honor.
Okay, all right, thank you.
And that was how it ended, ladies and gentlemen. Now, we are going to try to get this recap done in the next 10 to 30 seconds here, ladies and gentlemen. And if I can bring it up on the screen, we're not going to get it done in the next 30 seconds. But I do have, ladies and gentlemen, footage of Karen Reed leaving court. I'm not going to rush it because I made a promise, ladies and gentlemen. I made the promise of the promise of the promise. And I said I have a new version of the Call Me Hank clip. And let me just tell you, ladies and gentlemen, when Towel says there is a new version of the Call Me Hank clip, oh, you can bet there is a new version of the Call Me Hank clip. Now listen, we battled throughout the day, ladies and gentlemen. We have fallen behind Al Jazeera Arabic. We are at 37.6K. They are at 38.3K. We did our very best, ladies and gentlemen. We did our absolute best, but we only got to 37.6K on the Twitter. On the X. Oh, ladies and gentlemen. Now we got to watch footage of Karen leaving court, and then we have a brand new Call Me Hank clip. I know all of you are excited for the brand new Call Me Hank clip. I am an excitable little towel, and we still have about 40 minutes before I have to shut the stream off. So let me bring this up for you, little towels. Let me bring it up for you right now. I have it. I am a little towel. Here is the footage of Karen Reed leaving court. We are going to be little towels. We are going to watch it, ladies and gentlemen. Yes, indeed. I'm going to bring this over here. I'm going to bring this over here. And we are going to watch Karen Reed leaving court. She is not a towel. Hold on. We have a muted Karen. We can't have a muted Karen. Why? Oh, wait. Hold on. I got...
What do you think Dr. Lapisada gets you in terms of better testimony than last time around for your side of the case?
Dr. Lapisada is gonna find like print shirt and stuff coming back.
Is it the hypothermia situation?
Yes.
How about no dog bites from the doctor, though? Is that somewhat disappointing?
Yeah. The holes in the shirt were entirely misrepresented by the prosecutor. Were entirely misrepresented by the prosecutor, hence all the delays today. That was Hank Brennan. To make it look like they came from January 29th, and they came from May by the criminologist.
What do you think?
The poor guy almost fell over. Did someone check on that man? Is he okay? Oh, goodness, ladies and gentlemen. Goodness. Hello, Ange Whittick. It's your granddaughter's birthday. Ladies and gentlemen, Ange Whittick, your granddaughter gets a special towel shout out during the recap. Hello, Super Towel Ange Whittick's granddaughter. You are a super towel. I know you've waited your whole life to find out that you are a towel. Your grandmother is going to be absolutely thrilled. You two can both be towels together. You don't understand. It's wonderful. Now, ladies and gentlemen, we saw the footage of Karen Reed leaving court, but we have even more footage to look at because, first of all, ladies and gentlemen, I got a very special request from the Super Towel Eva, and I am not the person to turn down a request from the Super Towel Eva. Listen, the Super Towel Eva wants to see Hank Brennan's socks. I am going to bring up a picture of Hank Brennan's socks for the Super Towel Eva. Now, you may be saying to yourself, Grant, I don't really understand. Is it because socks are technically a form of feet towels? Yes, ladies and gentlemen, that is the origin of it. Okay, now we have a few more. We have a clip coming, the Call Me Hank clip. But listen, if I didn't zoom in on Hank Brennan's socks right now, Eva would be furious with me. She would never, Eva would never speak to me again. I have an ethical obligation, ladies and gentlemen, to zoom in on Hank Brennan's socks. You don't understand. So there you go, Eva Towel. You have waited. Your faith has thus beneth rewardeth, and you now have the opportunity to look at Hank Brennan's feet towels. As Deafwater knows, socks are referred to formally as feet towels pursuant to a motion of the towel universe. Now, ladies and gentlemen, on the topic of that, I think we should also take a look at my brand new Call Me Hank clip, ladies and gentlemen. It is stabilized. Murder by Maestro created it, and I am a towel. Now, you might be saying, sir, you're not actually a towel. Yes, I am. Ladies and gentlemen, I am a towel, and I have the Call Me Hank clip, and we are going to get to watch it. Now, I'm sorry to take away Hank Brennan's socks. Eva, try to calm down. I know you were very, very excited. But ladies and gentlemen, we have an ethical obligation to watch the new Call Me Hank clip. Colleen Henry is in the chat. I know your chat comments aren't loading. They're a little bit behind. It's okay. Ladies and gentlemen, we have a brand new, super stabilized, color enhanced, full screened. Hold on, I got to make this absolutely glorious for you all. You are going to see this clip in its absolute Call Me Hank glory. You don't understand, ladies and gentlemen. Murder by Maestro put a lot of effort into this. We have a color corrected, stabilized Call Me Hank clip. This is going to be one of the greatest things you have ever seen. I don't even know if Colleen Henry is going to be able to contain themselves. They might start running around in a circle, ladies and gentlemen. It is literally that good of a clip. And you might be saying to yourself, Grant, it is impossible for one clip to be that good. Well, you know what? It is actually that good. It's so good that it is getting in the recap. It is so good that it's like watching an episode of Full House and living in the 1990s when things in America were actually okay. Yes, ladies and gentlemen, it is the clip you've all waited to see. It's the clip the world wants to see. It's the updated, the stabilized, the Murder by Maestro created, the Call Me Hank clip. You as well, Mr. Brennan. Okay, sir, I will, Hank. One more time. You as well, Mr. Brennan. Okay, sir, I will, Hank. Oh, we need this one again. It's that good. You as well, Mr. Brennan. Okay, sir, I will, Hank. All right, this gets it. We're breaking a record 4 times. You as well, Mr. Brennan. Okay, sir, I will, Hank. Ladies and gentlemen, we broke a record. Oh, we broke a record. We broke a record. We watched the Call Me Hank clip literally 4 times. Oh my word, Murder by Maestro is a super towel. Now listen, little towels, I have even more updates for you, and you might be saying, Grant, more updates. How is this possible? Don't tell me that reporter Towel Christina has been on the scene and we still have 35 minutes to go and you have updates for us from reporter Towel Christina. This is not possible. Oh yes, ladies and gentlemen. Oh, you thought that was good. You are about to have the greatest end to a Towel Stream day that you could possibly imagine outside of Karen Reed and Aidan Kearney getting convicted. Ladies and gentlemen, first of all, Eva Towel, I want you to take a very deep breath. I don't know if you're going to be able to get through this, okay? I have confirmation from reporter Towel Christina that Hank Brennan wears socks, which are actually called feet towels. Now, ladies and gentlemen, you might be saying to yourself, why is this man talking about socks being feet towels? Well, listen. First of all, Hank Brennan wears socks. Second of all, socks can be towels. Therefore, ipso facto, it is a logical syllogism. It is a logical proof. Hank Brennan is a towel. Now, I know this is going to be very complicated. Oh, Luisa Ramirez has one more request, the Hank Brennan Karen stare down. But I know, first of all, some of you really, it is very important to you, ladies and gentlemen, that you see this incredibly important picture of Hank Brennan confirming that he does indeed wear feet towels, which are just socks. Now, I have to get the Hank Brennan and Karen Reed stare down. We have a very special towel request here for the Hank Brennan and Karen Reed stare down. I have it here somewhere, ladies and gentlemen. Hold on. This I didn't save the link, so this is, of course, the one thing I have to now go actually looking for. We already saw the stare down once, but if you really want to see it again, we'll look for it. But yes, ladies and gentlemen, that was certainly an interesting day. Absolutely an interesting day. If someone has the Hank Karen stare down video that they want to share quickly, we'll take a look at it. I don't have it off the top of my head here, so I don't just have the clip accessible. But I want to keep doing the Karen Reed. I want to keep doing the reporter towel updates. So we already saw the stare down during the recap. It literally happened right at the end of Hank Brennan. Okay. So I found it. Now this is one of the Karen Reed account, like attacking Hank Brennan. So no, we are not watching that one. Someone's gonna have to find. Okay. Thanks, Colleen Henry. Let's see. It is x.com/the-monkey. All right. I think this is the one. Thank you, Colleen Henry. Here, hopefully this is the quick stare down. If not, I have the right account. So here we go. This is the right one, ladies and gentlemen, and we're going to sync this with the Karen Cam later today. But here you go, ladies and gentlemen, the epic Hank Brennan Karen Cam stare down. I'll get rid of this Hank towel here. Hold on. I love that Hank towel image though, reporter towel Christina. But yes, we'll quickly watch the stare down one more time. Hold on, little towels. All right, there we go. This is the last time though. One more time because we already saw the stare down today. Here we go, little towels. Let's take a look at it. Hank Brennan and Karen Reed.
I love the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
There you go, ladies and gentlemen. Hank Brennan staring down the monster herself, Karen Reed.
I love the sweatshirt on May 18th. It's probably neater that way anyway. All right, let's bring them in, please.
Oh, goodness, ladies and gentlemen. The Hankinator. The Hankinator standing up to Karen Reed. Now, folks, hold on one second. I got to bring your comments back up. Now, we don't have too much time here, so I didn't really want to spend too much time on that, but I'm so glad we got to watch that. The reason why is we have a few more updates from reporter towel Christina, ladies and gentlemen, and we only have about 30 minutes left on the YouTube stream. Hello, so many of you towel friends tuning in. We're going to have to do a truncated close if I don't get through with all of this, and I hate doing truncated closes, but it was a dud of a day, a busy day. It was a whirlwind day. Oh, yes, ladies and gentlemen, and along with Hank Brennan wearing feet towels, I think I have another special update for you. Yes, ladies and gentlemen, it is the Arca Man with a calculator, and Randy himself, ladies and gentlemen, has made an appearance. Yes, little towels. Crash Test Randy has helped Mr. Arcaman with his calculator. Oh, goodness, reporter towel Christina, you have the absolute best insights, my dear friend. I am so thrilled we got to see an update related to Arca's calculator. Oh, goodness, my towel friends. Oh, goodness. Now we have even more. We have two more updates. The last one you're going to absolutely love. If you are a fan of the phrase, getting the Van Karen, you are going to love the last image. Now, I have one more before we get there, but I'm telling you, you are absolutely going to love this last image. Now, tell me, are you not entertained, ladies and gentlemen? Are you not entertained? Do you not see a little image there saying that Chewbacca and the Stay Puft Marshmallow Man love towels and that we all love towels? Yes, ladies and gentlemen, I am thrilled to let you know that the Stay Puft Marshmallow Man and Chewbacca love towels. Oh, this is absolutely wonderful. I am thrilled that reporter towel Christina has blessed us with this update about Stay Puft Marshmallow Man and Chewbacca. Oh, goodness, ladies and gentlemen. And yes, I think the world needs towel socks, ladies and gentlemen. That's clearly what the world needs. We need towel socks. Now, I think it's great that Hank wears feet towels. We're going to have to let Deaf Otter know tomorrow that Hank Brennan wears feet towels. Now, we got one more update. This is a big one. This is Karen, if you're a fan of the phrase, get in the van, Karen, you are going to absolutely love Reporter Towels Christina's last update. Oh my goodness, ladies and gentlemen, it's as good as you can imagine. There's Chewbacca. Ladies and gentlemen, Chloe the dog in a wig this whole time was actually an undercover van driver. Karen is going to be transported to Framingham by Chewbacca, and he's going to have a sign on the side that says, "How long till you get in the van, Karen?" That is hilarious, ladies and gentlemen. That is everything that I could ever imagine, and that is wonderful in every sense of the term. Ladies and gentlemen, it is very clear Hank Brennan wears feet towels that are socks, and Karen Reed's going to get in a van driven by Chewbacca to go to Framingham. Yes, one more week, get in the van, driven by Chewbacca, Karen. Ladies and gentlemen, the world loves the van. That is a very, very wonderful image. Oh, my word, little towels. Oh, my word. Now, we are going to cap this recap, so tune in again. I'm going to go talk to the towel friends towards the end of the stream. Tune in again tomorrow, 7:30 a.m. Eastern, youtube.com/@GrantSmithEllis. I'll try to get this recap out for you. We're going to end it at 7:05. We started at 4:48, so it was over a 2-hour recap again. I'm going to render it in 480p so that I don't have to spend 5 hours uploading it. But yes, grateful to have you with us. God bless so many of you towel friends. I'm going to go chat with the towel friends, actually. And you know where to find us. Aidan Kearney trial resuming Wednesday. Karen Reed trial again tomorrow, full day. We're getting close to closing arguments. My name's Grant Smith Ellis, and I am a towel. Perfect towel friends. Recap ends at 7:03:40 p.m. That we started it at 4:48 p.m. If you would imagine that. And I absolutely love that get in the van picture. Oh my goodness, I can see why all of you towel friends are just having an absolute wonderful day. Now, some of your comments are going to be a little bit delayed, but while they're getting loaded up, little towels, let us watch the clip that we all love. We all know and love. We're waiting for it. I have to move the get rid of the Karen get in the van image. Don't worry, we'll bring it back another day. But ladies and gentlemen, we know that Colleen Henry loves this clip. We know that Murder by Maestro helped put this clip together and stabilize it, which makes it even more special. And ladies and gentlemen, we are about to hit 38,000 on the Towel YouTube for the first time. It is truly a glorious day. Let us watch the clip in celebration. You as well, Mr. Brennan. Okay, sir, I will, Hank. You as well, Mr. Brennan. Okay, sir, I will, Hank. One more time. You as well, Mr. Brennan. Okay, sir, I will, Hank. Oh, ladies and gentlemen, we love it. We love it. And the update, ladies and gentlemen, I'll get you an update, little towels. We have a little bit of time. How much did we get to 38K on the towel YouTube? Did it happen? Did the moment happen? Little towels, did we somehow get to 38K? I'm about to let you know. I heard a rumor in the towel chat that we might have done it. Is this the moment? Oh, ladies and gentlemen, we have hit 38,000. 1,000 on the Towel X. Oh, ladies and gentlemen, we have broken all sorts of towel records. Your comments are loading up as well. Oh my goodness, what a moment, ladies and gentlemen, to cap the towel day. Oh, wow, that was incredible, ladies and gentlemen. Now, yes, thank you, Christina. Thank you, all the towels, 38K towel all the way. Now, we ended up losing out to Al Jazeera Arabic, 39K to 38K, but we blew Ted Daniel away, more than doubled Boston 25. They were at 17K when they ended. We did well, ladies and gentlemen. Towels worldwide are uniting. It is not just about me. It is about the wonderful ethos of this stream, and Towel loves you all. But I have to say this. DJ, Macy, Metro West Granite, Luisa Ramirez, Christina Shargio, Claudia Montano, Luisa Ramirez, Ange Whittick, DJ Peonian Rose, my dear friend, Macy Towel, you are such a wonderful friend. Macy Towel, I'm so glad you found a friend here. Holistic Psychology, 65 CJ5. Why are they in the towel safe? I don't know, 65 CJ5. Oh, Claudia Montano, Colleen Henry, my dear friend, Eva Towel, it was great to see you. Beth Fed. Oh, look at all the towel friends. Holistic Psychology, I know you're in there, my dear friend. Super Towel hugs to you. I see you. Debbie B, Claudia Franco. Oh, the towel friends. Cat in a Hat was here, my dear friends. We're sending our well wishes to Dewdrops, of course, and to the O'Keefe family and to Mrs. O'Keefe as we move towards the end of this trial, hopefully towards a conviction. Ladies and gentlemen, you all are such... Joe O'Keefe, it was great to see you. You are all such wonderful friends. Alicia B, to each other. Alicia B, it was great to see you. To each other, to Little Towel, you inspire me. 12 hours later, I'm still going. We say howdy here. It was great to see you. Oh, ladies and gentlemen, Funkarella was here. I saw Bailey in there. Rachel McIntyre. Ladies and gentlemen, Brenda Taylor, we have a wonderfully embracive and fluffy towel community. Heisenberg, great to see you. Love 7 Loyalty, MHA. Oh, goodness, ladies and gentlemen, it just keeps going. You all just, Laura, you got a membership from the wonderful Courtney Myers Towel. Courtney Myers, we send our love to you. I hope you are resting, my dear friend. Oh, goodness gracious. It was a beautiful towel day, my dear friends. That is part 1. Oh, Luisa Ramirez sent a cool super towel emoji. Hopefully it will load up on the stream in a second. The comments have been loading slowly at times. But Luisa Ramirez, super towel Dewdrops, Courtney Myers. I'm going to go through. It's going to take me a second to load it up here. It'll probably be easier once we say goodbye to the friends on X, because Towel's computer is definitely overloaded. I feel bad what we've done to Towel Computer. But Towel Computer, you keep fighting. We love you and support you. The towel friends around the world appreciate you. Also, I took a look at the towel poll. Aidan Kearney, 87% of the towel friends on the towel poll have voted that they think Aidan Kearney is heading towards a conviction after choosing a bench trial and getting Judge Pomerol. Oh, goodness, my word, ladies and gentlemen. Dewdrops is okay. She was in the hospital. She let us know earlier today, the super towelette, with food poisoning, but she's hopefully feeling better and at home resting now. We're going to hopefully get an update tomorrow morning about that. God bless all you towel friends who kept super towelette Dewdrops in your mind today, in your heart. I can't tell you how much that means to Little Towel. Now, ladies and gentlemen, the second part, we have a little bit of time. The second part that I like to do is I like to take a second to let folks know that you can support this stream in a number of ways. I appreciate all of your comments, your compassion for each other. The super towel emoji went up on the screen. We got to see it. I am thrilled. God bless you, Luisa Ramirez. I love that little super towel emoji. But ladies and gentlemen, you can support this stream by liking Towel Channel, subscribing. We're almost at 2,000 subscribers, ladies and gentlemen, on Towel Channel. Oh, all of 19 Towel is here. Ladies and gentlemen, if you're still here, can we send a super towel hug to super towel, all of 19? we love and we love Super Towel all of 19, and our fluffy towel universe embraces them. Wicked Uma is still here. Jeff Williams popping in at the end. Oh, ladies and gentlemen, this is just such a wonderful time. I'm so glad I chose to stick around a little bit. I had to get some of the back-end towel chat to load up so I could see you send stickers and say thank you. But ladies and gentlemen, there are so many ways to support this stream. You can like, subscribe the video, subscribe to the channel. There are ways that you can become a Towel member. There are ways you can donate to Towel if you want to help Towel. I'm going to go get some snacks after the stream ends. I definitely got a good Towel lunch today. Ladies and gentlemen, I am so grateful to have you all in my life. I'm literally going to break down because I was reading some of your comments, Macy Towel, Holistic Psychology. If I can bring solace and a feeling of camaraderie and friendship and happiness to people around the world because they met friends here and want to become like want to embrace those friendships and see them blossom, I have lived up to my towel eudaimonia. Ladies and gentlemen, it is the greatest thing. Linda A., hello, my friend. It is the greatest thing possible. And Wicked Uma, my most wonderful super towel friend, in the sense that Wicked Uma calls me sweet boy, and that's just a very touching phrase. All of you are my most wonderful towel friends. But it almost brought me to tears today, knowing that some of you have found meaning here, have found friendships here, have found literally a change in your day-to-day dynamic because of the connections you've met here. That's more than I could ever ask for. That's everything I could ever ask for. If someone asked me, Grant, what are you trying to achieve? What would be your greatest good? What are you trying to do on this earth? It would be that, ladies and gentlemen. That and nothing more. Bring people a sense of hope for a better world and allow people to realize that there are good fellow humans out there who care about them. Oh, it was beautiful. And Luisa Ramirez, thank you for that beautiful super sticker. Thank you, Karen. God bless you. I appreciate you being with us. Happy to do the reviews. God bless you, Super Towel Courtney Myers. Jack D65, I love that Super Towel Fox. He is adorable. I'm petting him right now. I almost started crying there, but the Super Towel Fox comforted me. Dee Dee, God bless you, dear friend. You're the supreme towel. I'm just helping out. WD40 says, United Towels of America, thank our leader, President Towel Grant Smith Ellis, for outstanding coverage. Thank you from the bottom of our towel hearts. God bless you, WD40. You are so compassionate and wonderful, my dear friend. Betty, FYKE, welcome to Towel Channel. Towel is so glad to have you with us. Red Squirrel, you have a wonderful username. Peony and Rose, Super Towel hugs to you. You started the day with such a kind donation. Towel loves you, my dear friend. Sis, I love your username. I love your profile picture. I love your comments. I've loved getting to know you. Thank you. I appreciate your appreciation of my work. You all work hard. I'm glad to honor it. I hear ice cracking. I love your username, and you're now a member of Towel Channel. All right, Towel friends. Third part of our closing, and Flotilla Ellis, I am a Flotilla. Okay, Olive, updates on TurtleBoy in court. The first three witnesses testified in the TurtleBoy trial. It was 2 court officers and then Megan McCabe, who had video of Aidan in the bushes walking towards Lindsay after Aidan had been told to leave the area because Lindsay was attending the Reed trial. The basic summation is that the trial will continue for Aidan Wednesday at 11. He chose a bench trial but got unlucky. The trial was assigned to Judge Michael J. Pomerol, the Chief Judge of Dedham District Court, who was the judge that sent Aidan to jail on a bail revocation last year. That's the best I can do. Hello, Liz Provo. Hello, Alana Towel. Sue, you're still here. Hugs to both of you. We're going to be back early, 7:30 tomorrow. I can't turn down an opportunity to inform Olive Towel about what's going on, though. Oh, Olive Towel, you sent a hippo with hearts. Oh, my goodness. Oh, you made me. And Alana Towel. I got to see Alana Towel at the end of the day and send a super towel hug to Alana and, of course, her service dog, who is a super towel. And I got a super towel hippo wave from Olive Towel. Oh, ladies and gentlemen, there are ways to end the day, and then there are ways to end the day. And of course, you know, there's one part of the closing that I always have to do regardless. There's no getting around it. There's nothing you can do about it. You'll never be able to stop me, ladies and gentlemen. It is simply the way of the towel. If you've really benefited from this stream, if you want to pay it forward, if you think what a towel is doing here has some meaning and impact in the wider world, there are ways you can do so, ladies and gentlemen. Did you know that you can donate and look for reasons to engage in small acts of service and kindness from a place of universal and unconditional love? Donate to homeless veterans. Say hello to someone on the street. Visit a friend or family member you haven't talked to in a while. Smile at a passerby. Donate 200 tomato plants to someone and have them designated honorary tomatoes, honorary towels, like Francis Futrell once did. Ladies and gentlemen, look for reasons to be a beacon of light and hope and make the world a better place, and hopefully inspire that in those around you. And in that way, those small acts of service and unconditional love and expressions of unconditional love will ripple outwards in the world, and instead of a soft power ethos defined by expanding, preserving, and demonstrating our power, will bring about a new soft power political order defined by preserving and expanding and demonstrating our capacity to engage in small acts of service rooted in unconditional love. It's possible. We can do it. I believe in you, towel friends. Oh, and your belief in me means so much. The hippo got on the screen. Hold on, Mr. Hippo. Hold on, I got to let all the comments load up, and then I might have... No, I think the hippo got his time to shine. Oh, tomato plants for veterans, absolutely. Oh, you're a great person, Gio. Thank you for being with us. You too, Alana, and all of 19. You're all wonderful. Towel loves each and every single one of you. Now, if you've been over on the X, you know that I'm going to say goodbye to you first. The Towel Friends on the YouTube get a few extra minutes. So you all have a great rest of your day. I'm going to be with you bright and early, 7:30 a.m. tomorrow. We'll do it all again. I'm looking forward to it. I love every minute of it. I get so much. Yes, volunteer to help homeless animals as well. I forgot. I'm going to add that to my spiel at the end of each stream. You can volunteer at local animal shelters. Donate to animal shelters. We have to help animals. They are part of our world that deserve to be protected. God bless you all of 19. And God bless you, Wicked Uma. Tomato plants for veterans and volunteering at homeless shelters. Let that be an uplifted public discourse. Let that be our legacy. This is a public information service, after all. It's designed to educate, inform, and entertain the wider public, to engender cogent public discourse, and thus ward off the usurpation of our representative forms of government. Ladies and gentlemen, it's possible. My name is Grant Smith Ellis. To the friends on X, over almost 40,000 of you. See you tomorrow morning at 7:30 a.m. God bless. Be well. Be safe. I got to go talk to the Towel Friends on the YouTube. I'm not trying to make you feel unwelcome, but you got a few minutes early on the X. They got a few minutes after on the YouTube. Towel Friends on the YouTube, we have said goodbye to the Towel Friends on X. I am now just talking to you. Your comments are finally loading quicker because Towel Computer is finally calming down. You know there is nothing that means so much to me as these few minutes we get to spend at the end of the day. Yes, I absolutely work hard, but yes, I get to sit here with you. My physical body may be breaking down, but you all give me such a sense of hope. You make me feel happy. You make me feel loved. You make me feel like I have a purpose in life. And if I've returned that to you in any way, if you found friends here, if you wake up with a sense of purpose, know that I will not abandon you. We'll find reasons to keep doing streams. We'll cover other trials. We'll do recaps. We'll do interviews. This is a wonderful community. You are wonderful people. I'm blessed to have you in my life. Cat in a hat, if I didn't say hi to you already, hello. And I could not express in words how much you all have come to mean in my life. I think I try to say it to you this much because I cannot put into words how much it means to me. Not just what the impact you've had on my life, but the ripples that you've made, the impacts you've made on other lives. It's truly a thing of, it's very beautiful. It's very precious. It's something I'm going to honor. I will never disrespect what has been created here. And I love all of you Towel Friends very much. So Sending all of you super towel hugs. We'll be back together at 7:30 a.m. tomorrow, so just 12 hours and 10 minutes from now, 7:30 a.m. Eastern. I want all of you to have a wonderful day. You know how to find me if you need me, grantsmithellis@gmail.com. You can also find me on social media. Send me a message. I see X DMs fastest. I then see like Twitter, I see Facebook, Instagram, and text messages way slower. It's not your fault, it's just my phone. I'm not being rude, I just don't see them. There's so many notifications. I'm going to try to get caught up. But yes, God bless all of you towel friends. From me to you, know how much it means to me that you're in my life, how special you are because you are you. With the towelettes, the washcloths, the soap dispensers, the flannels, the hemp towels, the beach towels, the paper towels, the microfiber towels, whatever type of towel the hand dryers, the electric hand dryers. Ladies and gentlemen, hug your towel friends virtually, though it may be, and know that I am with you always in spirit. So until tomorrow morning, I know some of you will not leave until I shut the stream off, so be well. Towel loves you. Be safe, and God bless you. My name's Grant Smith Ellis. Until tomorrow, sleep well, friends.